The certification process. Chapter 2. Begin reading. Section 2000. Certification surveys citations and responsibility. Section 1864 of the Social Security Act. The Act establishes the framework within which SAs, under agreements between the state and the Secretary, carry out the Medicare certification process. Sections 1902A9 and 33 of the Act stipulate that the same agency is authorized to set and enforce standards for Medicaid. The SA may partially redelegate the functions to local agencies. 42 CFR 488 requires the SA to perform surveys to support its certifications. 42 CFR Part 431, Subpart M, sets forth the functions the SA performs for the SMA. SAs perform initial surveys and periodic resurveys of all providers and certain kinds of suppliers. These surveys are conducted to ascertain whether a provider/supplier meets applicable requirements for participation in the Medicare and or Medicaid programs, and to evaluate performance and effectiveness in rendering a safe and acceptable quality of care. Although the regional office row is ultimately responsible for deciding whether a provider/supplier may participate in the Medicare program, certification is an SA function. After the SA completes an inspection for the Medicare program, it submits evidence and a certification recommendation for a final RO determination. When the SA certifies for Medicaid purposes, it is reporting its own adjudicative determination. Section 2002, Meaning of Providers and Suppliers. The Medicare law differentiates between providers and suppliers. The general distinction between providers and suppliers is that providers are parties who care for patients awaiting, receiving, or recuperating from treatment by intervening practitioners. The term suppliers includes those who furnish goods and services used in care and treatment. Medicaid terminology, by contrast, uses provider generically to include all healthcare vendors. See 42 CFR 431.107A and 433.37. Medicare providers and suppliers are defined at 42 CFR 498.2. In Medicare, as specified in Section 1861U of the Act, providers include hospitals, critical access hospitals (CAHs), skilled nursing facilities (SNFs), home health agencies (HHA), hospices, and comprehensive outpatient rehabilitation facilities (CORFs). Under Section 1830, 5A2 of the Act, clinics, rehabilitation agencies, or public health agencies are included as providers if such clinic or agency meets the requirements of Section 1861P4A. Community mental health centers, CMHC, are providers of services for partial hospitalization services only. Providers must meet co-PTCS or requirements for SNFs to participate in Medicare. See definitions at 42 CFR 498.2. Portable X-ray services, end-stage renal disease ESID facilities, ambulatory surgical centers (ASCs), and organ procurement organizations (OPO) are suppliers that must meet conditions for coverage to participate in Medicare. Rural health clinics (RHCs) are suppliers that must meet conditions for certification to participate in Medicare. Federally qualified health centers, FQHCs, are also recognized as suppliers of services and provide ambulatory care services similar to those provided by RHCs. FQHCs may be located in urban, as well as rural, areas. FQHCs are required to meet the same health and safety standards as RHCs, with the exception of the certification procedures. FQHCs self-attest to their compliance with Medicare conditions for coverage and are only surveyed by CMS in connection with complaint investigations. The above types of suppliers are distinguished from other suppliers, e.g., pharmacies, prosthesis suppliers, etc., for which there are no conditions for coverage or certification, and which qualify for Medicare through the enrollment process. Laboratories that examine human specimens for the diagnosis, prevention, or treatment of any disease or impairment of, or the assessment of the health of. Human beings are yet another category of suppliers and must meet clinical laboratory improvements of 1988 Act CLIA requirements. As previously stated, Medicaid does not distinguish between providers and suppliers. Section 19.02827 of the Act provides for agreements with every person or institution providing services under the state plan. 42 CFR 431.107a refers to all providers of services including individual practitioners and groups of practitioners. Section 2003. Essay identification of potential providers and suppliers. Often, first indications of interest in program participation by potential participants will be contacts with state licensing agencies. These contacts make the SA aware that a provider or supplier wishes to participate. The SA identifies, surveys, and makes certification recommendations to CMS or the SMA about providers and suppliers that are potential program participants. Section 2003A. Assisting applicant providers and suppliers. Pre-certification assistance to prospective providers and suppliers is a proper certification-related activity. It may take the form of providing them with a copy of the applicable regulations. The objective is to provide the party with information about the requirements of the certification component of the process for enrolling and participating in Medicare, including compliance with the requirements for SNFs and NFs, conditions of participation, conditions for coverage, or conditions for certification, as applicable. The effective date of Medicare participation, in accordance with 42 CFR 489.13, may not be earlier than the date on which the applicant meets all the federal requirements. Section 2003B. Initial certification kits. When an entity seeks to participate in Medicare, it must first complete and submit an enrollment application. Information on enrollment, as well as applicable forms and instructions, may be found at http://www.cms.gov/Medicare/provider enrollment and certification/Medicare provider sup enroll/index.html. Entities subject to survey and certification file either a CMS Form 855A Medicare enrollment application for institutional providers or a CMS Form 855B Medicare enrollment application for clinics, group practices, and certain other suppliers, or, in some cases, both. Prospective providers and suppliers should be aware that the initial review of the Form CMS 855A or Form CMS 855B by the Medicare Administrative Contractor MAC and its recommendation for approval must occur before the on-site initial certification survey is conducted and action is taken by the RO. CMS has established internet-based provider enrollment, chain and ownership system PICOs as an alternative to the paper enrollment process. Internet-based PICOs allows provider and supplier organizations to enroll, make a change in their Medicare enrollment, view their Medicare enrollment information on file with Medicare, or check on the status of a Medicare enrollment application via the Internet. When the MAC completes its review of the application, it either 1. Sends the SA and the RO its recommendation to approve the applicant, or 2. Denies the application. The SA must not perform a survey of an initial applicant until it has received notice from the MAC that the information provided on the enrollment application has been verified and that the MAC is recommending approval of the application. A SA may, however, start planning for an unannounced survey upon initial contact from an applicant. Note, SA surveys of initial applicants must be consistent with the priorities for federal survey work established by CMS each fiscal year. Depending upon available resources, initial surveys are typically a lower priority, and SAs generally should not perform such work unless all higher priority federal work will be completed. SAs may consult with the CMS Regional Office RO to determine whether a specific initial applicant would address an access to care issue and thus warrants an exception. The prospective provider/supplier must contact the SA for Medicare and or Medicaid certification materials for their provider/supplier type. The SA mails the initial certification materials under cover of the appropriate form letter. See Exhibits 1A1F and Exhibit 63. If the applicant has not contacted the SA before the SA receives the MAC's recommendation for approval, then the SA contacts the applicant using the phone number listed on the application. Upon receipt of the completed certification materials from the prospective applicant, the SA reviews the materials to see that they are properly completed and secures any necessary changes or additional information. It makes sure any required SNF transfer agreements are received. If a distinct part of an organization is being considered for program participation, the SA reviews the diagram or floor plan submitted to make sure the size and location of the distinct part are clearly shown. The SA works in conjunction with the RO and the MAC to gather the appropriate documentation from the entity that supports its position of being a distinct part before forwarding the package to the RO in order to make a recommendation to the RO. Both copies of the signed provider agreement or supplier approval are sent to the RO, along with the Title VI Assurance of Compliance with Civil Rights Form HHS 690. In Title Roman 19 only cases, the SA sends the Form HHS 690 or comparable form to the SMA. If the entity indicates that it is requesting a provider-based determination under the Medicare program, the SA must notify the RO immediately. Distinct part and provider-based are not synonymous terms. Determinations concerning provider-based status are made by RO financial management personnel. The SA refers questions about enrollment, MACs, payment rules, financial solvency, or Title VI clearance to the RO or the state Medicaid agency, as appropriate. For questions concerning the downloading, completion, and submission of the Form CMS 855A or CMS 855B, the provider/supplier should be directed to the CMS website or the appropriate MAC. Initial certifications involving new owners who reject assignment of the existing Medicare agreement. In the case of a prospective applicant that is planning to acquire an existing Medicare participating provider or supplier, the RO should provide pre-certification assistance to the prospective applicant, which includes making the prospective applicant aware of the consequences of accepting or rejecting assignment of the existing provider's/supplier's Medicare agreement. The RO should be consulted if the prospective applicant is considering rejecting assignment of the agreement, so that the RO can provide detailed information on the consequences of such action before the prospective applicant makes a final decision and submits an application. In the case of an applicant that has acquired an existing Medicare participating provider or supplier and has rejected assignment of that entity's Medicare agreement, that applicant is considered a new applicant seeking initial certification, and the SA must prioritize scheduling an initial survey for that applicant accordingly. This includes adhering to workload priorities identified by CMS for surveys of initial applicants to enroll in Medicare. Unless specifically directed by the RO to do so, SAs must not conduct initial surveys unless they are able to complete their higher priority workload. For initial applicants that have an accreditation option, initial certification surveys are the lowest SA priority. When an SA conducts an initial certification survey of an applicant that acquired a provider/supplier but rejected assignment, the RO must review the facts of the case carefully to determine whether the SA deviated from CMS workload priorities, as well as the SA's typical practice for initial applicants. Such deviation may raise reasonable doubt that the survey was unannounced. Section 2700A of the SOM requires all surveys of providers and suppliers other than clinical laboratories to be unannounced. This requirement applies to AO as well as SA surveys. An unannounced survey provides an opportunity to assess how the provider or supplier typically operates. On the other hand, If a provider or supplier knows the exact or approximate date of a survey, it may temporarily adjust its typical practices to enhance its compliance at the time of the survey. In doing so, it presents an unrepresentative picture to surveyors of the quality of care typically provided to its patients or residents. It is therefore in the best interest of patients and residents that surveys be unannounced. Given the lead time normally required to schedule and prepare for a full survey, if an initial survey takes place shortly after the acquisition date, such timing suggests discussion with the new owner prior to the acquisition date to arrange the timing of the survey to occur shortly thereafter, compromising the requirement that the survey be unannounced. While the new owner, like any other initial applicant to the Medicare program, will be expecting to be surveyed at some point, there must be some degree of uncertainty about just when that survey will occur, in order to permit an assessment of compliance when the facility is operating in a typical manner. The RO may refuse to accept a SA survey certifying compliance or an AO recommendation for deemed status if the survey timing creates reasonable doubt that the survey was unannounced. Each case must be assessed based on the facts specific to it. However, any survey that takes place within 14 days after the effective date of an acquisition that involves rejection of assignment of the provider agreement may warrant closer review by the RO of the circumstances of the case and the timing of the survey. However, it is also possible that the facts of a specific case may indicate that an initial certification survey taking place at a later date was announced. See Section 3210 for more information about policies and procedures related to acquisitions of Medicare participating providers or suppliers. Section 2003C, Deemed Status Providers/Suppliers, excluding CLIA. There is an alternative to SA surveys for demonstrating compliance with the applicable CO-PTCS/CF CTCS/conditions for certification. Accreditation based on a survey by a CMS-approved Medicare accreditation program of a national accrediting organization may be used by CMS to deem a provider or supplier as complying with the applicable regulatory standards. For certain types of providers/suppliers, for example hospitals or psychiatric hospitals, Medicaid will also accept accreditation under a CMS-approved Medicare accreditation program as evidence of compliance for Medicaid purposes. Section 1860, 5A of the Act provides that CMS may recognize and approve National Accrediting Organization (AO) Medicare accreditation programs, which demonstrate that their health and safety standards and survey and oversight processes meet or exceed those used by CMS to determine a healthcare provider's or supplier's compliance with applicable Medicare CO-PTCS/CF CTCS conditions for certification or requirements. The regulations which govern Medicare survey, certification, and enforcement procedures are generally found in 42 CFR Part 488. Section 488.1 defines an accredited provider or supplier as a provider or supplier that has voluntarily applied for and has been accredited by a national accreditation program meeting the requirements of and approved by CMS in accordance with Section 488.5 or Section 488.6. Accreditation under a CMS-approved Medicare accreditation program is voluntary and is not required for Medicare participation. Consistent with Section 1865 of the Act, 42 CFR, Section 488.5 and 488.6 permit deemed status certification for ambulatory surgical centers, comprehensive outpatient rehabilitation facilities, critical access hospitals, home health agencies, hospices, hospitals, clinics, rehabilitation agencies, or public health agencies providing outpatient physical therapy, occupational therapy, or speech pathology services, psychiatric hospitals, religious non-medical health care institutions, rural health clinics, screening mammography services, skilled nursing facilities, and transplant centers, except for kidney transplant centers. However, at this time, only certain AOs have requested CMS approval of Medicare accreditation programs, and those programs are only for some of these provider/supplier types. A current list of CMS-approved Medicare accreditation programs may be found at https://www.cms.gov/Medicare/provider enrollment and certification/survey certification GenInfo/accreditation HTML. The enrollment and certification requirements also apply to providers/suppliers seeking deemed status through their accreditation by a CMS-approved Medicare accreditation program. AOs with approved Medicare accreditation programs are also required by CMS not to survey initial applicants until they provide evidence that the MAC has reviewed their application and recommended approval. The prospective provider/supplier seeking deemed status through accreditation must still contact the SA for Medicare and or Medicaid certification materials for their provider/supplier type. The SA mails the initial certification materials under cover of the appropriate form letter. See Exhibits 1A1F and Exhibit 63. If the applicant has not contacted the SA before the SA receives the MAC's recommendation, then the SA contacts the applicant using the phone number listed on the application. In the case of a deemed provider or supplier, the SA does not conduct a survey to initially certify or recertify compliance with the applicable Medicare co-PTCS, CFCs, or requirements. Rather, such providers or suppliers are under the jurisdiction of the AO, not the SA, for oversight of their ongoing compliance. Unless the SA conducts a validation survey, either a representative sample or substantial allegation, validation survey at the direction of CMS, and CMS determines, as a result of such validation survey, that the provider or supplier fails to comply with one or more co-PTCS, CFCs, conditions for certification or requirements. Note that some AOs offer multiple accreditation programs for a given type of provider or supplier, but for each provider/supplier type, an AO may offer no more than one CMS-approved Medicare accreditation program. In addition, some AOs may offer only one program for a provider/supplier type, but they offer this program to their customers with and without the option of the AO recommending Medicare deemed status to CMS. Thus, it is possible for a healthcare entity to be accredited without being deemed for Medicare participation. For certification purposes, CMS considers only accreditation under a CMS-approved Medicare accreditation program where the AO has recommended deemed status. SAs must enter information on the Deemed tab within the certification kit in Aspen only for those initial applicants that are seeking deemed status on the basis of accreditation under a CMS-approved Medicare accreditation program. CMS has established a process for AOs to provide notice to the applicable CMS regional office row when it has accredited a provider or supplier under its CMS-approved Medicare accreditation program and is recommending the provider or supplier for deemed status. The RO forwards these notices to the applicable SA for inclusion in the certification kit that the SA subsequently forwards to the RO. In initial certification cases, where there is no AO notice of accreditation under a CMS-approved Medicare accreditation program for the applicant, SAs must not use other sources of information about the applicant being accredited to conclude that the applicant is deemed, and must not enter deemed status for the applicant in Aspen. An AO may not conduct an initial certification survey of a prospective provider or supplier for Medicare certification purposes until the MAC has completed its initial review of the enrollment application and has made a recommendation for approval to CMS. CMS requires AOs subject to its oversight to employ a survey process that is comparable to the process required for an SA, which may not conduct an initial survey until it receives notice from the MAC recommending approval of the applicant C-Section 2003B. Accordingly, an AO must also wait until the MAC has made its recommendation before it conducts an initial survey. The MAC gives the applicant written notice when its review has been completed. Therefore, AOs must inform providers or suppliers seeking to participate in Medicare via the AO's CMS-approved Medicare accreditation program that an initial unannounced survey will not take place until after the applicant has received notice from the MAC that it has completed its review of the enrollment application and that the MAC is recommending approval. If the MAC denies approval of the application, the AO must not proceed with a survey. Notices that the MAC provides to the SA and RO are internal communications among CMS and its contractors. AOs are not entitled to receive copies of the MAC notice from the MAC, SAW, or RO, but are expected to obtain copies of the MAC notice that was provided to the applicant. In the case of an applicant that is planning to acquire an existing Medicare participating provider or supplier, and that is considering rejecting assignment of the prior Medicare agreement, the AO must refer the applicant to the RO, so that the RO can provide detailed information on the consequences of acceptance or rejection of assignment. In the case of an applicant that has acquired an existing Medicare participating provider or supplier and has rejected assignment, the applicant is considered an initial applicant. Generally, it is not acceptable for the AO to schedule an initial survey to minimize the period of time between the termination of the prior Medicare agreement and the effective date of the new agreement. Surveys conducted either on the date an acquisition is effective or within days thereafter do not qualify as unannounced surveys, and also are inconsistent with CMS regulations and policy that require such applicants to be treated in the same way as any other initial applicant. See Section 3210 for more information about policies and procedures related to acquisitions of Medicare participating providers or suppliers. The AO is required to notify CMS whenever it newly accredits and recommends Medicare deemed status for a provider or supplier seeking Medicare participation. This notice must be sent to both CO and the applicable RO via a designated email box. See Section 1022. However, the prospective provider or supplier must also provide the SA with documentation of the AO's accreditation decision and recommendation for deemed status. This documentation is included in and becomes part of the certification packet the SA submits to the RO. Therefore, AOs must instruct the prospective provider or supplier to furnish a copy of this documentation to the SA for inclusion in the applicant's certification packet. Section 2004, Provider-Based Determinations. Distinct part and provider-based are not synonymous terms. When a location, department, remote location, or satellite is established as being provider-based, it is an integral part of the provider, covered by the provider's Medicare agreement, and therefore subject to the same Medicare conditions of participation as any other part of that provider. Unless covered by a specific exception listed in the rule, the provider-based regulations at Section 413.65 apply to any provider of services under the Medicare program, as well as to physicians' practices or clinics or other suppliers that are not themselves providers, but which the provider asserts are an integral part of that provider. Providers are not required to seek a determination from CMS that all of their provider-based components satisfy the provider-based rules at 42 CFR 413.65, but they may voluntarily seek such determinations. The RO Division of Financial Management makes provider-based determinations in response to a specific request. If a provider requests the SA for a provider-based determination under the Medicare program for one or more of its component services, the SA must notify the RO immediately so that the request can be routed appropriately to the RO Division of Financial Management. In the case of a request concerning an off-campus department, remote location, or satellite, the provider's survey and certification file about the locations included under its provider agreement must not be revised to add the new location until and unless the provider is issued a positive determination about its request. For critical access hospitals cause adding a provider-based location, also see SOM Chapter 2, Section 2256H, Off-Campus CAH Facilities, Process Requirements. Section 2005, Medicare Healthcare Provider/Supplier Enrollment. The Centers for Medicare and Medicaid Services, CMS, is authorized to collect enrollment information in order to ensure that correct payments are made to providers and suppliers under the Medicare program established by Title Roman 18 of the Act for Payment under Part O of Title Roman 1842 U.S.C. Section 1395, FA1, and 1395 GA, and Section 1833-42 U.S.C. Section 13951E, for payment under Part B. In addition, CMS is required to ensure that no payments are made to providers or suppliers who are excluded from participation in the Medicare program under Section 1128 of Title Roman 1840. Prohibited from providing services to the federal government under Section 2455 of the Federal Acquisition Streamlining Act of 1994 PL 103 to 355-31 U.S.C. Section 6101 Note. The primary use of this information is to verify the eligibility of providers/suppliers to participate in the Medicare program, which will more effectively prevent fraud and abuse. The protocol that CMS uses to ensure that providers/suppliers meet these requirements is referred to as the enrollment process. The enrollment process is also to be used for providers/suppliers that plan to seek certification for participation in Medicare based on deemed status through a CMS-approved Medicare accreditation program. An applicant must complete the enrollment application process in order for CMS to obtain certain required information before a certification survey is conducted, or, in the case of an FQHC, the RO countersigns the self-attestation. Providers/suppliers should be informed of the enrollment and certification process so that they do not have unrealistic expectations about the effective date of their provider or supplier agreement with Medicare, e.g., an applicant should not expect its effective date to be the date it submitted its enrollment application. Should the applicant have any questions concerning the enrollment process form, it should be referred to the following website: http://www.cms.gov/Medicare/provider enrollment and certification/Medicare provider sup enroll/index.html. The Medicare enrollment process is not applicable to the Medicaid program. State Medicaid agencies use their own enrollment process. Section 2005A, Approval or Denial. 2005, A1 Enrollment Denial based on MAC review. When the MAC determines, after reviewing the Form CMS 855 application, that an applicant has failed to meet the enrollment process requirements, the MAC will issue a written denial to the applicant. The RO is not involved in the issuance of the denial or in the processing of any request by the applicant for reconsideration or appeal. Reconsideration requests or appeals are handled by the Center for Program Integrity Provider Enrollment Operations Group in the CO. Additionally, when an applicant is denied enrollment by the MAC, no survey is conducted. 2005, A2 Approval or Denial of Certification based on survey findings. The SAW or RO, when applicable, all references below to SA surveys also apply to surveys conducted by the RO. Surveys applicants that are subject to an on-site certification survey after it receives the recommendation of approval from the MAC. Unless the applicant has the option of participation via deemed status C sections 2003C and 2005A4. Additionally, the applicant must be operational and providing care to patients/residents in order for a certification survey to be conducted. See Section 2008A. All surveys are unannounced. Applicant in compliance, the SA surveys the applicant and certifies or recommends Medicare approval if it determines that the applicant is in compliance with all conditions of participation, coverage, certification, or requirements, as applicable. See Section 2008D for more information on the circumstances under which the SA certifies the applicant is or is not in compliance. The SA forwards the survey results and certification kit to the RO, which determines whether and when all federal requirements have been met by the applicant. If all federal requirements have been met, the RO proceeds with the provider's or supplier's Medicare participation approval. In the case of HHAs, there is a requirement for the MAC to conduct a second verification of the enrollment information after the SA or accrediting organization survey is completed. However, a second MAC review that takes place after the on-site certification survey will only delay the effective date of the HHA's Medicare agreement if that review identifies noncompliance with any federal requirements. If the HHA is found upon a post-survey second MAC review to continue to meet all requirements, there would be no change in the initial certification effective date previously provided by the MAC to the RO. However, if the MAC finds the HHA does not meet all federal requirements during the second review, there would be a delay in the effective date of any provider agreement that might eventually be issued to the HHA applicant until all requirements are determined to be met. The RO will issue a provider or supplier agreement with an effective date and assign a CMS certification number CCN. See Section 2008. The RO will notify the MAC of the applicant's approval for participation in the Medicare program by sending the Provider Tie-in Notice Form CMS 2007 and / or a copy of the approval letter that will include the CCN. The RO will send the SA a copy of the applicant's approval letter. Applicant not in compliance, the SA surveys the applicant and certifies that the applicant is not in compliance with the conditions of participation / coverage / certification or requirements, as applicable. See Section 2008D for more information on the circumstances under which the SA certifies the applicant is or is not in compliance. The SA forwards the survey results to the RO, which will send the provider / supplier a denial letter. The RO will forward a copy of the denial letter to the MAC and to the SA. Claims will not be paid if the applicant is not approved through both the enrollment and the survey and certification processes. The applicant is issued a denial letter for noncompliance with the conditions of participation / coverage / certification. The applicant may correct the deficiencies and reapply for certification. The applicant who reapplies for certification must undergo a new survey, which is a full, standard survey, except if on the first survey an applicant subject to the Life Safety Code, LSC requirements was in substantial compliance with the LSC, the SA has the discretion to not resurvey for LSC compliance, although it must receive an acceptable plan of correction for any lower-level LSC deficiencies before it may recommend certification. And in the case of an applicant seeking to participate as a hospital, the SA has the discretion to conduct a new survey of only those conditions for which the applicant was found non-compliant during the prior survey. If the SA chooses to conduct such a focused subsequent survey, the hospital applicant must submit an acceptable plan of correction for all non-compliance identified in the prior survey, including for conditions where there were only lower-level deficiencies cited, before the SA may conduct the subsequent survey. Note, it is not possible for an initial applicant to seek CAH status. The applicant must first be certified as a hospital, and then subsequently the hospital may apply to convert to CAH status. This is technically a conversion, not an initial application. If the SA certifies that the CAH applicant is not in compliance, then the RO sends a letter denying the hospital's request to convert to CAH status. Unless the denial was based on the applicant not satisfying the CAH location requirements, the applicant may seek to be surveyed again for CAH conversion. As with initial hospital applicants, the SA has the discretion to conduct a new survey of only those conditions for which the CAH applicant was found non-compliant during the prior survey. If the SA chooses to conduct such a focused subsequent survey, the CAH applicant must submit an acceptable plan of correction for all non-compliance identified in the prior survey, including for conditions where there were only lower-level deficiencies cited, before the SA may conduct the subsequent survey. In all cases, the RO retains the authority to require a new full survey if it has concerns about a certification recommendation based on a focused survey after a prior survey identified substantial noncompliance. In cases where the RO anticipates that it will require a new full survey, it should notify the SA of this as soon as possible to facilitate planning for the full survey by the SA. If the SA continues to find the applicant is not in compliance with the conditions of participation/coverage/certification or requirements, as applicable on the subsequent survey, the above process may be repeated. However, the applicant may submit no more than 2 reapplications for certification in connection with one enrollment application, and no more than 6 months may elapse between the date of the RO's first denial of certification and receipt by the RO of a second reapplication for certification for a total of 3 certification applications. If the applicant fails to demonstrate compliance by the end of this 6-month period, the RO not only issues a final denial of certification, but also sends a written recommendation to the MAC that the enrollment application be closed out as denied. If the applicant continues to seek enrollment and certification, the RO must receive a new MAC recommendation for approval before it may process a new certification application. 2005, A3, Reconsideration of Denial. Procedure for reconsideration. An applicant has the right to request a reconsideration of an initial certification denial decision. See Chapter 3, Sections 3050, Section 3054 for reconsideration procedures and timeframes. Note that the RO may not simultaneously process a certification reapplication and a request for reconsideration. However, in accordance with Section 3054A, the applicant may withdraw its reconsideration request and reapply for certification if it has corrected the deficiencies identified on the survey. 2005A4, Deemed Providers/Suppliers, excluding CLIA. Initial survey by an AO with a CMS-approved Medicare accreditation program. The AO's CMS-approved Medicare accreditation program must provide reasonable assurance that providers or suppliers accredited by the AO meet all Medicare conditions of participation, co-Ps, or conditions for coverage/certification CFCs, as applicable. CMS evaluates and reviews AOs seeking recognition of their accreditation programs for Medicare participation on a number of factors specified in 42 CFR Section 488.8, including the AO's accreditation standards, survey and oversight processes, and their comparability to CMS standards and processes. Furthermore, 42 CFR Section 489.13 governs how CMS determines the effective date of a provider's or supplier's Medicare agreement or approval, including provisions related to certification survey findings. Accordingly, before the AO makes a recommendation to CMS that an applicant seeking initial certification and enrollment in Medicare be deemed to meet Medicare's health and safety standards, the AO must conduct a survey and determine that the applicant meets all requirements for accreditation, including compliance with all applicable Medicare co-PTCS or CF-CTCS. Applicant in compliance. If the applicant is found to comply with all accreditation requirements, the AO may award deemed status accreditation, effective no earlier than the accreditation survey end date, and recommend the applicant to the RO for Medicare certification via deemed status. The AO must inform the applicant and the RO of the results of the initial accreditation survey and of its recommendation of the applicant for certification via deemed status, including the effective date of the applicant's accreditation. If the applicant is found to be in substantial compliance but has lower-level deficiencies, then the AO must receive an acceptable plan of correction POC for such deficiencies. See Section 2008D. Once the AO receives an acceptable POC from the applicant, the AO may award deemed status accreditation and recommend the applicant for Medicare certification via deemed status. The AO may not make the effective date of the applicant's deemed status accreditation prior to the date of receipt of a POC that the AO finds acceptable. The AO must inform the applicant and the RO of the results of the initial accreditation survey, the receipt of an acceptable POC, and its recommendation of the applicant for deemed status, including the effective date of accreditation. The AO must also send its survey report to the RO. When the AO notifies CMS of an applicant's accreditation and the AO's recommendation of deemed status for that applicant, the RO reviews the AO's accreditation survey report and other documentation. If the RO accepts the AO's recommendation of deemed status, it forwards the AO's notice of accreditation and recommendation of deemed status to the SA. The SA must prepare an initial certification packet for the provider or supplier. The certification packet is sent by the SA to the RO, with the Medicare Health Insurance Agreement Form CMS 1561, 1561A, or 370, depending on provider/supplier type, submitted to the SA by the applicant, along with any other documentation required for initial certification of that provider/supplier type. See Exhibit 63 for documentation requirements. In the remarks section of the Form CMS 1539, the SA indicates that it is transmitting an initial certification kit for an accredited, deemed provider/supplier. Once the RO receives the certification packet, it proceeds as described in Section 2005A2. The RO must send to the AO in a timely manner a copy of its approval letter to the applicant. Among other things, the copy of the approval letter advises the AO of the CCN assigned to the new provider's/supplier's Medicare agreement, facilitating the AO's ability to report accurate data to CMS on its deemed status providers/suppliers. If the RO's review of the accreditation survey suggests a problem, including, but not limited to, the AO's survey report describes findings which represent substantial noncompliance with a Medicare condition, but the AO awarded accreditation anyway, or the AO's survey report indicated the applicant was required to submit an acceptable POC for lower-level deficiencies, but the AO issued its accreditation effective on a date prior to its receipt of the POC, or the AO conducted an extension survey, but the applicant is a new owner that rejected assignment of the prior owner's Medicare agreement and must therefore undergo a full accreditation survey. The RO may, consistent with Section 488.6C2, reject the AO's recommendation of deemed status. In such cases, the RO contacts the AO to discuss its concerns and ways the AO may remedy them, if possible. If the problems are not remedied, the RO may issue a denial of certification to the applicant and provides a copy to the AO in a timely manner. Applicant not in compliance. If the AO finds the applicant's failure to meet its CMS-approved Medicare accreditation program requirements represents substantial noncompliance with accreditation standards, including applicable Medicare Co-PTCS or CF-CTCS, the AO may not recommend the applicant for Medicare certification via deemed status. Rather, the AO must inform the applicant and the RO of the results of the initial survey and that it is not recommending the applicant for deemed status. The RO issues a denial of certification based on the AO's information and provides a copy to the AO in a timely manner. The applicant may, at the AO's discretion, continue to work with the AO to correct the deficiencies and again seek initial certification through deemed status. If the applicant is surveyed again by the AO, the survey must be a new survey, which is a full, standard survey, except if on the first survey an applicant subject to the Life Safety Code, LSC requirements was in substantial compliance with the LSC, the AO has the discretion to not resurvey for LSC compliance, although it must receive an acceptable plan of correction for any lower-level deficiencies before it may recommend deemed status. And in the case of an applicant seeking to participate as a hospital, the AO has the discretion to conduct a new survey of only those conditions for which the applicant was found non-compliant during the prior survey. If the AO chooses to conduct such a focused subsequent survey, the hospital applicant must submit an acceptable plan of correction for all non-compliance identified in the prior survey, including for conditions where there were only lower-level deficiencies cited, before the AO may conduct the subsequent survey. Note, it is not possible for an initial applicant to seek CAH status. The applicant must first be certified as a hospital, and then subsequently the hospital may apply to convert to CAH status. This is technically a conversion, not an initial application. If the AO advises CMS that it is not recommending the applicant for CAH deemed status, or if the RO determines that the applicant does not satisfy the CAH location requirements, then the RO sends a letter denying the hospital's request to convert to CAH status. Unless the denial was based on the applicant not satisfying the CAH location requirements, the applicant may, at the AO's discretion, continue to work with the AO to correct the deficiencies and again seek CAH certification through deemed status. As with initial hospital applicants, the AO has the discretion to conduct a new survey of only those conditions for which the CAH applicant was found non-compliant during the prior survey. If the AO chooses to conduct such a focused subsequent survey, the CAH applicant must submit an acceptable plan of correction for all non-compliance identified in the prior survey, including for conditions where there were only lower-level deficiencies cited, before the AO may conduct the subsequent survey. In all cases, the RO retains the authority to require a new full survey if it has concerns about a deemed status recommendation based on a focused survey after a prior survey identified substantial noncompliance. In cases where the RO anticipates that it will require a new full survey, it should notify the AO of this as soon as possible to facilitate planning for the full survey by the AO. If the AO continues to find substantial noncompliance on the subsequent survey, the above process may be repeated. However, the applicant may submit no more than 2 reapplications for certification in connection with one enrollment application, and no more than 6 months may elapse between the date of the RO's first denial of certification and receipt by the RO of a second reapplication for certification for a total of 3 certification applications. If the applicant fails to demonstrate compliance by the end of this 6-month period, the RO not only issues a final denial of certification, but also sends a written recommendation to the MAC that the enrollment application be closed out as denied. If the applicant continues to seek enrollment and certification, the RO must receive a new MAC recommendation for approval before it may process a new certification application. Section 2005B. Deemed providers/suppliers accept CLIA additional information. AO renewal of deemed provider/supplier accreditation. AOs conduct reaccreditation surveys of Medicare deemed providers and suppliers on a triennial basis. Upon awarding reaccreditation, the AO also makes a recommendation for the providers or suppliers' continued Medicare deemed status. The providers or suppliers' deemed status continues without interruption. When the AO notifies CMS of its renewal of accreditation and recommendation of continued deemed status, the RO forwards the notice to the SA, and the SA must prepare a recertification kit for the provider or supplier. the recertification packet is sent by the SA to the RO with the form CMS 1539 and any other documentation required for that provider/supplier type. See Exhibit 63 for documentation requirements. In the remarks section of the form CMS 1539, the SA indicates it is transmitting an accredited deemed provider/supplier update. Termination/withdrawal, removal of deemed status. The AO must notify CMS whenever a provider's or supplier's accredited status is not renewed, as well as the reason for the loss of accreditation. If the AO notifies CMS that the AO has terminated a provider's or supplier's accreditation, or that the provider or supplier has voluntarily withdrawn from the AO's CMS-approved Medicare accreditation program, the RO must remove the provider's or supplier's deemed status. Unless there is evidence of accreditation under another CMS-approved Medicare accreditation program. For example, if the provider or supplier was accredited simultaneously under two CMS-approved programs, and one AO notifies CMS of a termination or withdrawal, the provider/supplier would continue to have deemed status based on the other accreditation. However, if the notice of termination by the first AO indicates that the reason for termination was the provider's/supplier's failure to meet accreditation standards, the RO must consider this a substantial allegation of noncompliance with Medicare standards and must authorize the SA to conduct a complaint investigation. If one AO provides notice of termination or withdrawal and concurrently another AO recommends deemed status, a recertification packet including the new AO recommendation must be submitted by the SA to the RO. See also Section 3258. If the RO removes the provider's or supplier's deemed status, it places the provider/supplier under the jurisdiction of the SA and must advise the SA of the change in the provider's/supplier's status. The SA surveys the facility in order to provide assurance that the facility is in compliance with the applicable Medicare conditions. The timing of the SA survey depends on the reason for the provider's/supplier's loss of accreditation. If the AO terminates accreditation due to failure of the provider/supplier to meet accreditation standards, then the SA must conduct a standard survey within 45 calendar days of notification by the RO that deemed status has been removed. If the AO's reason for termination appears to be related to an immediate jeopardy, then the RO instructs the SA to conduct the standard survey as soon as possible. If the AO terminates accreditation due to voluntary withdrawal or failure to pay fees by the provider/supplier, the SA prioritizes the provider's/supplier's survey on the basis of the current CMS policy concerning survey frequencies and SA workload priorities, using the date of the most recent accreditation survey to calculate the survey interval. Unless the facility is a home health agency, HHA, then the SA must conduct the survey no later than 3 years after the last accreditation survey, or the RO exercises its discretion to request the SA to conduct the survey by a specified date. CMS may also temporarily remove deemed status, and therefore AO jurisdiction when a SA or federal survey team identifies condition-level noncompliance in a deemed provider or supplier during either a representative sample or substantial allegation validation survey. The RO advises the provider or supplier that its deemed status is removed and that it is being placed under SA jurisdiction. However, no change is made to the provider's or supplier's deemed status in the automated survey process environment ASPEN. Instead, the placement of the provider or supplier under SA jurisdiction is noted under the Deeming tab within the certification kit in ACO. The provider/supplier remains under SA jurisdiction until it either demonstrates substantial compliance or CMS terminates its Medicare participation. If the provider/supplier demonstrates substantial compliance to the SA, CMS restores its deemed status. Note that there is no prohibition against an AO also conducting its own survey of a provider/supplier that is temporarily under SA jurisdiction. Other AO adverse actions. The AO is required to inform CMS of significant adverse actions it takes against the accreditation status of a provider/supplier participating through deemed status. However, as long as the accreditation under the AO's CMS-approved Medicare accreditation program is not terminated, the provider/supplier's participation in Medicare is not affected. See Section 3258 for information on actions to take when an AO terminates the accreditation of a deemed provider or supplier. The AO is also required to inform CMS by close of business the next day when it identifies an immediate jeopardy situation on a survey. In such cases, the RO generally triages this as an immediate jeopardy complaint and directs the SA to conduct a substantial allegation validation survey based on the information provided by the AO. Section 2005C, Clinical Laboratory Improvement Amendments of 1988, CLIA Laboratories. The procedures for initial certification basically apply to CLIA laboratories with a few exceptions. The enrollment procedures for CLIA laboratories are outlined as follows. CLIA laboratories will be surveyed if applicable and registered for CLIA participation, whether or not the laboratory enrolls in Medicare. The enrollment form CMS 855A or CMS 855B process applies to all CLIA laboratories that participate in Medicare. This includes laboratories that have a certificate of waiver, certificate for physician-performed microscopy procedures, certificate of accreditation, certificate of compliance, certificate of registration, or are state exempt. However, laboratories that bill through the fiscal intermediary are part of an institutional provider, such as a hospital or SNF, will not need to complete the forms CMS 855A or CMS 855B. The form CMS 855A or CMS 855B will be downloaded from the CMS website http://www.cmshhs.gov/forms/ and completed by the CLIA laboratory. The SA will mail out Form CMS 116 and any other form needed for CLIA registration to the laboratory. A CLIA laboratory is only required to complete a form CMS 855A or CMS 855B if it decides to enroll in Medicare. At the time a laboratory initially applies for CLIA registration, inquire as to whether the laboratory intends to bill Medicare. If the laboratory intends to bill Medicare, send the laboratory Form CMS 116 and Form CMS 855A or CMS 855B. Questions on the Form CMS 855A or CMS 855B form should be addressed to the intermediary/carrier. The SA will send the laboratory the Form CMS 116. The laboratory will complete and return the Form CMS 116 to the SA and the Form CMS 855A or CMS 855B to the FI or carrier. The SA will enter the Form CMS 116 into the CLIA data system, and the system will assign a CLIA number to the laboratory. For CLIA laboratories, the intermediary/carrier will be responsible for all aspects of the Form CMS 855A or CMS 855B and Medicare enrollment processing. After the intermediary/carrier has reviewed and verified the Form CMS 855A or CMS 855B, it will send a completed copy of the Form CMS 855A or CMS 855B to the RO and State Survey Agency, along with its recommendation for approval or denial. See Section 2005. A for instructions regarding approvals, denials, and appeals. Processing of the Form CMS 855A or CMS 855B will not affect the scheduling of CLIA surveys since CLIA registration must occur regardless of Medicare enrollment. If a laboratory is denied for Medicare, follow the instructions for denials and take all appropriate CLIA-related actions. If the laboratory does not plan to bill Medicare, it should complete Forms CMS 116 and return it to the state survey agency. Section 2005D, Supplementary Applications. An additional application used for supplementary purposes to support the Form CMS 855A or the CMS 855B is the Medicare Individual Reassignment of Benefits Healthcare Provider/Supplier Application Form CMS 855R. The Medicare Change of Information Healthcare Provider/Supplier Application Form CMS 855C is no longer used. The CMS 855A or the CMS 855B is used to report changes to enrollment. See also Section 2003. The fiscal intermediary/carrier will send a copy of the Form CMS 855A or CMS 855B with the updated/changed information to the appropriate state agency and RO. 2005 D1 Forms CMS 855A or the CMS 855B for changes in provider/supplier information. Application changes are changes to any items on the Form CMS 855A or CMS 855B. These changes require the submission of the appropriate updated sections of the Form CMS 855A or CMS 855B with a signed certification statement. The changes will be reviewed by the fiscal intermediary/carrier. The review will result in a recommendation for approval, denial, or return for additional information. The fiscal intermediary/carrier will send a copy of the Form CMS 855A or CMS 855B with the updated/changed information to the state agency or RO that distributed the initial application. When a provider experiences a change of ownership, the current owner will check the box marked Potential Termination of Current Ownership on the Form CMS 855A or CMS 855B. Voluntary use of the Form CMS 855A or CMS 855B is encouraged for providers/suppliers that were previously certified without completing the Form CMS 855A or CMS 855B. However, these providers/suppliers may submit these changes in writing on letterhead with an authorized signature. 2005 D2 Form CMS 855R. In general, Medicare only makes payments to the individual or entity that directly provides services. However, an individual may reassign benefits to an eligible entity as defined in 42 CFR 424.80. This application must be completed when an individual practitioner is reassigning his or her benefits to an eligible entity. An eligible entity is a business organization that is eligible to receive reassigned benefits, e.g., employer, facility, healthcare delivery system, or agent. Not every provider/supplier will need to complete the Form CMS 855R. Organizations that are likely to receive reassigned benefits are hospitals, hospices, SNF, ESID, RHC, CORF, FQHC, and CMHC. The Form CMS 855R is available to applicants for downloading via the CMS website at http://www.cmshhs.gov/forms/. The state survey agency should inform the applicant that any questions concerning the Form CMS 855R should be directed to the intermediary or carrier. If the state agency receives the Form CMS 855R, it will forward the Form CMS 855R to the intermediary. After reviewing the application and making a recommendation, the intermediary will forward the package to the carrier for the carrier's review of the reassignment of benefits. Section 2005E, changes of ownership. See Section 3210 for a full discussion of change of ownership (CHOW). The following procedures apply to all provider/supplier types that are subject to survey and or certification. 2005 E1 CHOW occurs. For a CHOW, the current owners will submit a Form CMS 855A or CMS 855B citing the termination of current ownership. The current owner will check the box marked Potential Termination of Current Ownership on the Form CMS 855A or CMS 855B and complete Section 1, Provider/Supplier Information, Section 8, Potential Termination of Current Ownership, and Section 10, Attestation Statement. The new owners will complete and submit a new Form CMS 855A or CMS 855B. The current and new owners will submit the Form CMS 855A or Form CMS 855B, along with any supporting documents to the FI or carrier. The RO has the delegated authority for making the determination if a CHOW actually exists. However, the RO may delegate this responsibility to the state agency. For complex or questionable situations, the FI/carrier will forward all documents to the RO for review. Upon review of all documents, the RO will make the decision as to whether or not a CHOW has occurred. The intermediary/carrier will verify the forms CMS 855A or CMS 855B and may take one of three actions on a CHOW. Recommendation for approval, recommend for denial, or request for additional information. Verification of information from intermediary/carrier after a complete review and verification of the application, if no additional information is needed and there is no need to issue a denial. The intermediary/carrier notifies the RO/SA of its verification of information provided about the CHOW within 30 calendar days absent extenuating circumstances of the receipt of the completed enrollment applications. The notification will be written and accompanied by a copy of the completed forms CMS 855A or CMS 855B, if any changes were made to the forms. RO determines CHOW has occurred if the RO determines that a CHOW has occurred. The RO waits until it receives the intermediary/carrier's verification of information about the CHOW before completing the process. When the process is completed, the RO will notify the provider/supplier, state agency, and intermediary/carrier that a CHOW has occurred. RO determines CHOW has not occurred. The RO makes the final decision whether a CHOW has actually occurred. If the RO determines that a CHOW has not occurred, the RO notifies the provider/supplier, the state survey agency, and the intermediary/carrier that a CHOW has not taken place. The notification should explain the reason why a CHOW has not occurred. Recommendation for denial from intermediary/carrier. After a complete review and verification of the application, the intermediary/carrier may recommend a denial of the Form CMS 855A or Form CMS 855B based on one or more of the reasons for denial stated in Section 2005. Point 3. The intermediary/carrier will send the recommendation of denial to the RO/SA. For a CHOW, the provider agreement may be automatically assigned to the new owner. However, the new owner could choose to come into Medicare as a new applicant and should be advised of this option. In such a case, if the new owner accepts the assignment, it also assumes the former owner's liabilities. The new owner could also receive an outstanding underpayment under this scenario. The new owner must enroll the same as any other new applicant. See Section 3210, undergo the survey and certification process, and be issued a new provider agreement/number. The RO/SA processes a voluntary termination of the provider agreement of the former owner. 2005 E2, change in intermediary as result of CHOW. Providers who are changing their intermediary as a result of a CHOW, acquisition, merger, or consolidation should submit the information to the new intermediary of preference. This information, which is required to be submitted by Form CMS 855A, should be promptly processed by the new intermediary. However, the provider should also request a change of intermediary from the RO. If an FI receives a Form CMS 855A for a CHOW that requires a change of intermediary, it should contact the provider and advise it to contact the current RO for a change of intermediary. The new intermediary shall contact the outgoing intermediary and provide it with the submitted information. If the provider mistakenly submits the CHOW information to the old intermediary shall contact the new preferred intermediary and forward the submitted information to it. The new intermediary shall note on any recommendation for approval if a required change of intermediary request has not yet been approved by the RO. Note, CHOW determinations are the responsibility of the RO unless otherwise delegated. 2005 E3 CHOWs involving multi-regional chain organizations. When a CHOW involves a multi-regional chain organization, a lead or coordinating RO is designated. This will typically be the RO serving the state in which the headquarters of the chain doing the acquiring is located. The coordinating RO will notify all other affected ROs and intermediaries involved in the CHOW determination and processing of enrollment activities. The lead RO may decide which intermediary-wise will process the new CHOW applications. A separate Form CMS 855A is still required for each separately surveyed provider/supplier. However, they all may be processed simultaneously by the receiving intermediary when the incoming chain requests one intermediary for all the units. Each intermediary shall follow the instructions of the lead RO for CHOWs involving multi-regional chains. For a CHOW which involves multiple incoming or multiple outgoing intermediaries handled by the same RO, the RO shall also direct where and how the new application should be reviewed, and serve as the coordinator for the CHOW in a manner similar to being the lead RO for a multi-regional CHOW. 2005 E4 change of owners, but not CHOW. A partnership provider sometimes experiences an addition or deletion of personnel, but a CHOW does not occur. For example, a provider may add or delete owners without experiencing a CHOW. In these situations, the provider should complete Section 10 ownership information on the Form CMS 855A or CMS 855B. It should also complete identifying information in Section 1 applicant information and Section 19 certification statement. The rest of the form does not need to be completed. Advise the provider/supplier to submit the Form CMS 855A or CMS 855B directly to the intermediary/carrier. The intermediary/carrier will send a copy of the Form CMS 855A or CMS 855B to the SA/RO when it has completed its verification. In certain situations, based on the review of a submitted Form CMS 855A or CMS 855B, the intermediary/carrier may suspect that a CHOW has occurred that the RO may not be aware of. In these cases, the intermediary/carrier may notify the state survey agency and RO and request a determination. The intermediary/carrier will send a letter to the state survey agency and RO, along with a copy of the Form CMS 855 or CMS 855B and any supporting documentation. The RO will determine whether a CHOW has actually occurred and report its findings to the intermediary and the state survey agency. Section 2005 F. Voluntary terminations. A provider agreement may be voluntarily terminated in accordance with the regulations at 42 CFR Section 489.52. The provider must send written notice of its intention, a letter on. Letterhead with an authorized signature to its RO or SA within the timeframes addressed in Section 489.52. Suppliers must provide notice in accordance with the regulatory requirements specific for the supplier type. Additionally, a provider/supplier must properly complete and submit the applicable Form CMS 855A or CMS 855B to the MAC. If the provider/supplier sends the Form CMS 855A or CMS 855B for voluntary termination directly to the MAC, then the MAC will notify the RO and SA via email within 3 days from the receipt. Note, in a change of ownership situation, the rejection of automatic assignment of the existing provider/supplier agreement by the new owner is a voluntary termination of the agreement/approval, including its associated CCNs, in accordance with 42 CFR 489.52. Further, if the new owner rejects automatic assignment of the acquired facility's existing provider/supplier agreement, and that facility previously was deemed to meet the applicable conditions based on its accreditation under a CMS-approved Medicare accreditation program, the accrediting organization may not extend the facility's prior deemed status to the new owner. Instead, the AO must conduct a full initial accreditation survey of the facility under its new ownership after the acquisition date. The effective date of the new owner's Medicare provider agreement or supplier approval is established in accordance with the provisions of 42 CFR 489.13. For complete information on CHOWs, see Psalm 32:10. Note, a cessation of business is a voluntary termination under 42 CFR 489.5, 2B3. Section 2008. Prioritizing SA survey workload, initial surveys, and recertifications. Section 2008A. Surveys of new providers and suppliers. New providers/suppliers, including providers/suppliers whose previous Medicare agreement was terminated and are now seeking initial certification, must be in full operation and providing services to patients when surveyed. This means that at the time of survey, the institution must have opened its doors to admissions, be furnishing all services necessary to meet the applicable provider or supplier definition, and demonstrate the operational capability of all facets of its operations. To be considered fully operational, initial applicants must be serving a sufficient number of patients so that compliance with all requirements can be determined. A survey evaluates the manner and degree to which the provider or supplier satisfies the various requirements or standards within each condition. Surveyors must directly observe the provision of care and services to patients and the effects of that care, in addition to interviewing staff and patients and reviewing medical records to assess whether the care provided meets the needs of individual patients and is in compliance with all requirements. Surveyors also review selected provider/supplier policy and procedure. Documents if needed to support or clarify observations suggesting deficiencies. When the provider/supplier notifies the SA of full operation, the SA documents the file with the date of notification. The SA conducts the survey in a timeframe consistent with CMS policy regarding budget and workload priorities. Section 2008B. Initial surveys of HHAs. In addition to an on-site survey to determine compliance with the health and safety conditions of participation, COP, an HHA applicant must now meet capitalization requirements and complete the enrollment information contained on the Form CMS 855A or CMS 855B, which includes the HHA's ownership information. Also, the Centers for Medicare and Medicaid Services, CMS, is now requiring each HHA applicant to have provided skilled home health services to a minimum of 10 patients before a survey is conducted. At least 7 of the 10 required patients should be receiving care from the HHA at the time of the initial Medicare survey. Section 2008D. Effective date of Medicare provider agreement or approval for suppliers. In accordance with 42 CFR 489.13, the effective date of participation in the Medicare program, i.e. the effective date indicated on the provider or supplier agreement issued by the RO, may not be earlier than the date on which the provider or supplier meets all federal requirements. Federal requirements include, but are not limited to, meeting all Medicare enrollment requirements addressed in 42 CFR 424, meeting all Medicare provider agreement requirements addressed in 42 CFR 489.10 and 42 CFR 489.12, and compliance with Medicare health and safety standards, i.e., the conditions of participation, conditions for coverage, conditions for certification, or long-term care requirements, as applicable. For an agreement with a federally qualified health center, FQHC, no survey is required to determine compliance. The effective date is the date on which CMS accepts a signed agreement in which the FQHC attests that it meets all federal requirements. For FQHCs, the RO uses as the effective date of the supplier approval the date that the MAC indicates it determined that the FQHC's enrollment application was complete and approvable. A Medicare supplier approval of a laboratory is effective only while the laboratory has in effect a valid CLIA certificate issued under 42 CFR Part 493, and only for the specialty and subspecialty tests it is authorized to perform. Other types of providers and suppliers demonstrate compliance with applicable conditions or requirements via a standard survey by the SA or federal surveyors/contractors, or by an AO with a CMS-approved Medicare accreditation program. If on that survey the provider or supplier meets all health and safety standards including elements, where applicable, then the effective date of the Medicare agreement is the last day of the survey, unless there are other federal requirements, such as providing evidence of compliance with civil rights requirements, that the provider or supplier has not yet met. The date when all other federal requirements have been met is the effective date of the Medicare agreement. If on that survey the provider or supplier does not meet all health and safety standards including elements, if applicable, then, assuming all other federal requirements have been met, the effective date of the Medicare agreement would be. For SNFs, the date the SNF has been found to be in substantial compliance with the requirements for participation and, if applicable, has submitted an approvable waiver request. See 42 CFR 488.301. For non-long-term care providers/suppliers, the date when the provider/supplier has met all applicable conditions, or has been found to be in substantial compliance, but has standard level or element level, where applicable deficiencies and the RO in the case of surveys conducted by contractors, SA or AO, has received an acceptable plan of correction POC, and or CMS receives an approvable waiver request. If a provider or supplier submits both a POC and an approvable waiver request, the later of the dates of the two submissions would be the effective date. Section 2008E, Administrative Considerations. The SA will schedule more frequent surveys and follow-up visits for providers and suppliers with a history of poor performance. Keep in mind geographical considerations and the scheduling of licensure visits and coordinate visits whenever possible. Changes of ownership CHOWs may necessitate adjustment of the survey interval. See Section 2702. Section 2008F, SA Scheduling of Resurveys. Sections 1819 G2A Roman III and 1919 G2A Roman III of the Act require that each SNF and NF respectively be subject to a standard survey no later than 15 months after the previous standard survey, and that the statewide average interval between such surveys not exceed 12 months. Section 1890 1C2A requires that each HHA be subject to a standard survey within a 36-month interval. Since the law also prohibits the announcing of such surveys, utilize flexible survey schedules to ensure that these surveys are as unpredictable as possible. Sections 1819 G2AI, 1919 G2AI, and 1890 1C1 of the Act establish civil money penalties CMPs for any individual who notifies a SNF, NF, or HHA of a survey. A facility should not be surveyed during the same month each year. The SA may conduct surveys of these providers as frequently as it deems necessary, but no more than 15 months after the last standard survey of any SNF or NF, or 36 months for any HHA. In developing the SA survey schedule for HHAs, SNFs, and NFs at a minimum, the SA utilizes information from SA files, the online survey certification and reporting system OSCAR, and other sources at its disposal to identify those providers with poor performance records who should be resurveyed more frequently. Conversely, the SA utilizes the same information to identify those providers that have established a history of good performance, who could be resurveyed less frequently. See Section 2702. For example, the SA may find that some facilities should be resurveyed within 4 months of the prior standard survey, while others may not require a resurvey for up to 15 months from the prior standard survey. The statewide average for SNFs and NFs may not exceed 12 months in a given federal fiscal year. Schedule surveys to provide a cushion against any unforeseeable events, such as staff turnover. Section 1890, 1C2B Roman II of the Act also requires conducting a standard survey or abbreviated standard survey of any HHA, against which a significant number of complaints have been reported. Sections 1819 G2A Roman III, 1919 G2A Roman III, and 1890 1C2BI of the Act also state that such surveys of SNFs, NFs, and HHAs may be conducted within 2 months of any change in ownership, administration, management. And for SNFs and NFs Director of Nursing, dawn to determine whether the change has caused any decline in the quality of care furnished. Based on documented evidence of current accreditation, the SA recertifies accredited entities on a schedule consistent with their accreditation interval. For example, for hospitals, that interval may be only every 3 years. The timing of the Life Safety Code LSC survey is at the discretion of the SA. It may occur before, after, or simultaneously with the health portion of the survey. See Section 7410 for more guidance on LSC for SNFs and NFs. Section 2010, ascertaining compliance with civil rights requirements. Before an agreement is executed with a provider to participate in the Medicare program, or with a provider undergoing a change in ownership CHOW, there must be a determination of compliance with civil rights requirements. OCR conducts necessary investigations and makes determinations related to compliance with the requirements. If the RO cannot secure an OCR clearance within 20 calendar days, it issues a restricted provider agreement with a contingency clause, which states that if OCR approval is not obtained, payment will be recouped as of the date the provider agreement is effective. The SA provides potential providers with the required OCR civil rights certification information request packet for clearance. The SA collects the completed packet, including the signed questionnaire, signed HHS 690 form, and policies and procedures from potential providers, and forwards them to the RO. SAs should take the following steps. Include the packet with the initial enrollment package that is sent to a potential provider or to a provider undergoing a CHOW. Ask the potential provider or provider undergoing a CHOW to return the completed signed questionnaire, HHS 690 form, and civil rights policies and procedures to the SA with the rest of the Medicare application package. Ensure that completed OCR documents are included in the Medicare package before forwarding to the CMS RO, and inform the potential provider or provider undergoing a CHOW that the Medicare application will not be forwarded to CMS, until the civil rights documents and forms have been completed and returned to the SA. Note: OCR has civil rights corporate agreements with certain healthcare corporations. Providers that belong to those corporations need to submit only the signed certification sheets, as specified in the corporation's agreements. Processing OCR documents. Upon receipt of the OCR documents, the CMS RO forwards them to the OCR for processing and clearance. The role of the SA and CMS is limited to obtaining the documents and forwarding them to OCR. Copies of the current version of the packet can be downloaded from http://www.hhs.gov/ocr/civilrights/providers/Medicare providers/index.html. SAs must include this link with their initial certification and CHOW packages. Regarding Medicaid-only providers, the states themselves are recipients of the federal funds and may be considered to have a direct obligation to assure OCR of their compliance by assuring that funds go to providers who are in compliance. As with Medicare, potential providers or providers undergoing a CHOW must be determined to be in compliance with civil rights laws by OCR as a condition for approving the provider's participation in the Medicaid program. Section 2012. SA identifying eligible providers and suppliers. Initial certifications of providers or suppliers involve steps, including enrollment, to survey applying providers/suppliers and confirm their eligibility. These steps are not repeated on cyclical recertification if the basic eligibility factors have not changed. Since the requirements in the statute and regulations differ for specific provider/supplier categories, the initial identification and screening procedures are unique to each type of provider or supplier. For Medicare purposes, the SA initial certification of compliance occurs before the RO makes its official determination that the provider/supplier meets all necessary requirements. The SA may contact the RO for advice if some aspect of Medicare eligibility is in dispute. Ordinarily, the SA develops as much information on the issue as is appropriate, completes the certification, and forwards the documentation to the RO for its decision. The SA should use the following criteria. If the provider/supplier meets the COPTCS, conditions for coverage, or in substantial compliance with the requirements for SNFs, and is in full compliance with all other requirements, i.e., no deficiencies, send the certification and transmittal form CMS 1539 and all other documents to the RO within 10 calendar days of the survey. Or, when the provider/supplier meets the COPTCS or conditions for coverage, but it fails to meet other requirements, i.e., it has deficiencies below the condition level, transmit all documentation to the RO within 45 calendar days of the survey. A provider/supplier found to be deficient with one or more standards, or other requirements below the condition level, may participate if it has submitted an approved POC for achieving compliance within a reasonable period of time. A POC must be submitted within 10 calendar days of the facility's receipt of the official form CMS 2567. The entity may be granted additional time if the plan is complex. See Chapter 7 for SNFs and NFs. Provider institutions are often complex healthcare delivery institutions centered around primary short-term hospitals. Although a totally new hospital may be rare, provider complexes frequently recombine and reform or merge. This may or may not create new certification entities. In general, if the statute or regulations provide for separate certification of related or satellite components, they must be separately certified, e.g., a distinct part SNF in a hospital. In some instances, a satellite certification depends upon the primary provider being approved to participate, e.g., a hospital-based hospice or an ESID transplant center. The SA should recognize and act upon organizational combinations and complete Form CMS 1539 to reflect a change. A provider is the party having ultimate responsibility and liability for the operational decisions of the institution. Consequently, the SA should know what components are under the control of the provider's governing body as opposed to being loosely affiliated, and when the governing body's control of a component has changed. Section 2016. Readmission to Medicare or Medicaid program after involuntary termination, reasonable assurance. See also Chapter 7 for SNFs and NFs. Section 2016A. Readmission criteria. After involuntary termination of a provider's agreement, an institution cannot participate in the Medicare or Medicaid program again, unless the provider submits with its request for readmission sufficient justification to indicate that the reasons for termination no longer exist, and all of the applicable statutory and regulatory requirements are met, or there is reasonable assurance for Medicare entities or Medicaid ICFs/IID terminated under Section 1910B of the Act by CMS that the deficiencies that cause the termination will not recur. Section 2016B. Reasonable assurance concept. A Medicare provider terminated under 42 CFR 489.53 and reinstated under 42 CFR 489.57, or a Medicaid ICF/IID provider terminated pursuant to Section 1910B1 of the Act is required to operate for a certain period of time without recurrence of the deficiencies which were the basis for the termination. The reasonable assurance concept also applies to terminated Medicare suppliers, such as ASC's 42 CFR 416.35e, FQHC's 42 CFR 405.2440, RHC's 42 CFR 405.2404e, and ESID facilities 42 CFR 405.2180c. The length of this reasonable assurance period is determined by the RO after an evaluation of the provider or supplier's previous compliance history. Reasonable assurance periods are usually 30 to 120 days, but depending on the circumstances, can be for a shorter or longer period of time. Participation can only resume following that period if the provider or supplier has maintained compliance with program requirements. The RO determines the reasonable assurance period for Medicare suppliers. Medicare providers, including a SNF in a dually participating facility, terminated pursuant to Section 1866b2 of the Act, and ICFs/IID, terminated by CMS pursuant to Section 1910b1 of the Act. In considering the decision to readmit a previously terminated provider/supplier to the Medicare or Medicaid program, the RO takes into account not only certification, but also the intermediary's statement concerning the institution's financial responsibility and the ACR's report on compliance with civil rights requirements. Note, there is no statutory or regulatory requirement that states must establish a reasonable assurance period for Medicaid-only facilities or a NF in a dually participating facility that has been terminated by the SMA under Section 1902I and 1919H1 of the Act. The reasonable assurance decision is an administrative action, not an initial determination, and is not subject to the appeals process at 42 CFR Part 498.3d5. Note, these provisions do not apply where a termination action was the result of a sanction imposed by the OIG. The RO forwards reinstatement requests involving these provisions to the OIG for appropriate action. To determine the reasonable assurance period, the RO will evaluate the following. 1. Providers or suppliers' compliance history. When the provider/supplier previously participated in either Medicare or Medicaid ICF/EID, was compliance maintained historically? Were post-CTCS implemented on time? Does the provider/supplier have a history of making good faith efforts to correct deficiencies and to maintain compliance? Does it have a record of being cited repeatedly for essentially the same problems. Were previous adverse actions initiated, but not put into effect? 2. Previous adverse action. Has the applicant/institution previously been terminated and readmitted to the Medicare program? If yes, how long was compliance maintained after being readmitted? Have all deficiencies been corrected? Are corrective actions permanent, i.e., is compliance likely to continue? 3. Other factors impacting continued compliance. Is the facility located in an area that is underserved by health professionals, meaning that staffing deficiencies may continue? Does the applicant's pay scale or the facility's location deter the hiring and retention of staff? Does it have inherent problems that are likely to cause recurrence of significant deficiencies? Has there been a change in staff or services furnished that might affect continued compliance? The following are examples using these criteria to determine reasonable assurance periods. See Chapter 7 for examples for SNFs/NFs. Example A. Green Acres Community Hospital was terminated on November 1, 1996. The provider was cited as not meeting several co-PTCAS. On December 1, 1996, the hospital board alleged to have corrected all deficiencies the SA found. While reviewing the provider's compliance history, the RO notes that one or more co-PTCAS were cited in previous surveys, but the provider usually managed to achieve compliance just before termination. Reasonable assurance, the RO establishes 90 days from December 1, 1996, as reasonable based on the provider's history of not maintaining compliance. Example B. Fox Chase General Hospital was terminated on December 21, 1996, for its failure to maintain required staffing in nursing, dietary, and medical records. On January 2, 1997, the provider alleged that he hired the necessary staff and requested readmission. Upon review, the RO finds that the provider is located in a remote, underserved rural area and has been unable to maintain staff since participation began in 1989. Reasonable assurance, the RO establishes 90 days from January 2, 1997, as reasonable on the grounds that the location of the provider has militated against staff retention, and that 3 months of continued compliance would evidence the provider's ability to retain qualified health professionals. Example C. The XYZ Home Health Agency was terminated on September 15, 1997. On the 4 prior surveys, the agency had been cited for failure to meet several of the co-PTCAS, but had, until the most recent survey, achieved compliance before termination action was completed. On October 1, 1997, the agency alleged compliance. Reasonable assurance, the RO establishes a 120-day reasonable assurance period based on the provider's repeated failure to meet the co-PTCAS necessary to ensure the health and safety of patients. Example D. The Visiting Nurses, Inc. was readmitted following a 60-day reasonable assurance period. On the next survey, the Visiting Nurses, Inc. is found not to meet one or more co-PTCAS and is again terminated. The provider corrects the deficiencies and requests readmission. Reasonable assurance, the RO establishes a 120-day waiting period based on prior termination and failure to maintain compliance following a 2-month reasonable assurance period. Example E. Pleasant Plains ICF/IID was terminated by CMS on January 10, 1996. The provider was terminated for deficiencies that posed a threat to client health or safety. The provider corrected its deficiencies and requested readmission on February 1, 1996. The SA surveyed the facility on February 10, 1996, and determined that the deficiencies that were the reason for the termination had been corrected and certified compliance. The documentation was forwarded to the RO on February 21, 1996. While reviewing all available documentation, the RO finds that the provider has a history of serious deficiencies. Moreover, the deficiencies that led to termination have been cited repeatedly. Reasonable assurance, the RO establishes a 180-day waiting period based on the provider's history of serious deficiencies and disregard for the health and safety of patients. Section 2016C, Request for Readmission. A terminated provider or supplier may reapply for certification at any time. Upon receipt of a request from an involuntarily terminated entity that desires readmission to the program, the SA immediately contacts the entity and informs it of the requirements for readmission. If the reasonable assurance time period was not established at the time of termination, the SA contacts the RO and requests that it establish the reasonable assurance period so that it may be included in the letter to the facility informing it of the requirements for readmission to the program. The RO may choose to delay establishment of the reasonable assurance period pending the results of the first survey. Use Exhibit 41 to inform the provider or supplier of the reasonable assurance provisions and to transmit the required documents necessary for future participation. See the applicable initial certification section in Exhibit 63 for the required documents. If the institution then indicates that it meets the requirements for participation and returns the initial application packet, forward the application packet to the RO via a Form CMS 1539. The RO will contact the previous servicing intermediary. The intermediary, in turn, advises the RO whether there are any outstanding financial problems, such as overpayments, that need to be resolved before the institution is readmitted. In addition, the RO takes immediate action to obtain Title VI clearance. Section 2016D, Reasonable Assurance Surveys. Upon receipt of the initial application packet from the SA, the RO will provide the SA with instructions concerning how to conduct the necessary reasonable assurance surveys. 2 surveys are required for Medicare certification to verify that the reason for termination no longer exists and that the provider/supplier has maintained continued compliance. At least one of these surveys must be a full/standard survey to ensure that all co-PTCS/CF CTCS are met or the SNF is in substantial compliance. The RO has the discretion to determine whether both surveys will be full/standard surveys, or whether one may be a partial survey to document compliance with requirements for which there were previous deficiencies. If the RO decides that one survey will be a partial survey, the RO also decides whether the partial survey will be the first or the second survey. CMS, at its discretion, conducts the survey for a ICF/IID it originally surveyed and terminated pursuant to Section 1910B1 of the Act. The reasonable assurance period of time begins on the date of completion of the first survey documenting compliance with requirements for which there were prior deficiencies. The SA conducts the first of the reasonable assurance surveys as instructed by the RO and submits the results of the survey. This may be submitted on Form CMS 2567 to the RO within 10 working days of the survey. Based on the results of this first survey, the RO determines if the reasons for termination no longer exist, or for SNFs, the deficiencies that caused their termination are at the level of substantial compliance. The RO notifies the SA and the provider/supplier of its determination. If the RO determines that the reasons for termination no longer exist, or for SNFs that the deficiencies that cause the termination are at the level of substantial compliance, the reasonable assurance period begins effective with the last day of this first survey. If not, the provider must reapply. Once the RO determines that the reasonable assurance period has begun, the SA will schedule a second survey to coincide with the end of the reasonable assurance period. The SA informs the RO of the scheduled survey date. The SA conducts the survey, completes the survey report as applicable, and prepares a statement to accompany Form CMS 1539 that includes the finding that the deficiencies which led to termination of the provider agreement have or have not been corrected, the evidence showing that compliance has been maintained, and the reasons for concluding that the deficiencies will not recur, and a description of any other deficiencies, and, if appropriate, an explanation as to why the facility is nevertheless in compliance with all co-PTCS or the SNF, is in substantial compliance C, Section 7203, B and 7300C. If the RO determines after the second survey that the reasons for termination continues to exist and or determines that the provider/supplier does not meet the co-PTCS or the SNF is not in substantial compliance, the provider/supplier must again begin the reasonable assurance process to gain re-entry into the Program S. C, Section 7203, B and 7300C for the exception for SNFs and NFs. If an involuntarily terminated provider/supplier attempts to re-enter the Medicare program via deemed status accreditation under a CMS-approved Medicare accreditation program, it must still satisfy the reasonable assurance requirements at 42 CFR 489.57. The RO has the discretion to deny Medicare re-entry based solely on deemed status accreditation surveys, and may instead require 2 surveys be performed by the SA if it is not reasonably assured the provider/supplier meets the Medicare conditions. The RO also has the discretion to accept an accreditation survey for either the first or second of the reasonable assurance surveys. Generally, an AO would not conduct both reasonable assurance surveys, but if it is willing to do so, and the RO is reasonably assured that the provider/supplier meets the Medicare conditions, the RO may permit the AO to conduct both reasonable assurance surveys. In cases involving readmission of an involuntarily terminated provider seeking deemed status, the RO will determine the IF when it is reasonably assured that the reason for the termination will not occur, the when, the reinstatement effective date, and the how, e.g. a survey by the SA of the providers/suppliers' re-entry into the Medicare program. The RO will make an analysis of the facts in the case and issue a decision, because receiving deemed status is a separate issue from reinstatement reasonable assurance following involuntary termination by CMS under 42 CFR 489.57. The regulation at 42 CFR 489.57 does not apply to a provider's voluntary termination of its agreement under the provisions of the regulation at 42 CFR 489.52. In a scenario similar to the situation described above except that the provider's termination from Medicare was voluntary, CMS the RO would still be responsible for the if, when, and how of the provider agreement under 42 CFR 489.12. However, the provider's accreditation by a recognized accrediting body and subsequent deemed status would mean that compliance with the COP would not be one of the unmet requirements under Title Roman 18 of the Act that could be invoked under 42 CFR 489.12A3. This is pointed out because some providers voluntarily withdraw from Medicare in the face of a proposed involuntary termination. A RO could decide to process an involuntary termination in such a case. In the absence of having processed an involuntary termination, the RO could apply 42 CFR 488.6C2 in concert with 42 CFR 489.12A3. In a case where a provider facing involuntary termination voluntarily withdrew from Medicare and subsequently attempted to re-enter the program through accreditation under a CMS-approved Medicare accreditation program. The regulation at 42 CFR 489.57 also does not apply to a provider's initial application for Medicare participation. Again, as with a voluntary termination, the CMS RO is responsible for the if, when, and how of the provider agreement and a decision to deny the provider an agreement must be in accordance with 42 CFR 489.12. Also, if an accrediting organization has determined that the provider is accredited, the provider is deemed to meet the Medicare conditions, and we would have satisfactory assurance of compliance with the conditions under 42 CFR 489.12A3. However, as with a voluntary termination, we might look at 42 CFR 488.6C2 in tandem with 42 CFR 489.12A3 in an individual case. This means that we should notify accrediting bodies if and when we deny a provider entry into Medicare based on a state survey agency survey. This includes providers that are surveyed by the state but do not respond to a statement of deficiencies. Section 2016E. Effective date of provider agreement after reasonable assurance. If the provider or supplier has maintained compliance throughout the reasonable assurance period, it may re-enter the program and be issued a new provider agreement or supplier approval. The effective date of the new Medicare agreement and Medicaid FFP is calculated based on the date of completion of the second reasonable assurance survey. See Section 2008D for details on the calculation of the effective date. Section 2016F. Readmission of ICF/IID after termination. Before the SMA readmits an ICF/IID to the Medicaid program after termination by CMS pursuant to Section 1910B1 of the Act, the RO must determine that the facility has provided the SA reasonable assurance that the deficiencies that were the cause for termination will not recur. The RO will determine the reasonable assurance period, and the RO or the SA, at the RO's request, will monitor the facility to determine that it remains in compliance for the period of time designated by the RO as the reasonable assurance period. The SA or the RO will monitor the facility by conducting the necessary survey and revisits. The reasonable assurance period must be satisfied before the SMA issues an agreement to that facility, and before that facility can qualify for FFP. Failure to provide reasonable assurance is a basis for CMS to continue to disallow FFP for services furnished by that facility. See 42 CFR Part 442.30 and 431.610F1. Section 2016G. Under LSC at time of readmission. 1. Termination based on LSC or health conditions. Upon readmission, an institution that was terminated for noncompliance with the LSC must be surveyed under the addition of the code in effect under current regulations. Section 2017. Readmission following voluntary termination of program participation. If termination action has been initiated, but the entity is allowed to terminate Medicare participation voluntarily before the action is made effective, the reasonable assurance provision will be applied. If there is not a SA certification of noncompliance at the time a provider/supplier notifies the RO of voluntary termination, the reasonable assurance provision does not apply. Section 2018. Reinstatement following termination of swing bed approval. If swing bed approval has been terminated for any reason, there is a statutory 2-year minimum waiting period for reinstatement. Do not apply the reasonable assurance concept in these situations. See Section 1883C of the Act. Hospitals. Section 2020. Hospitals definition and citations. A hospital is defined in Section 1861E1 of the Act. A hospital is an institution primarily engaged in providing, by or under the supervision of physicians, inpatient diagnostic and therapeutic services or rehabilitation services. The remainder of Section 1861E defines a hospital eligible for Medicare participation. Section 1861F defines Medicare-eligible psychiatric hospitals. 42 CFR 482 sets forth the co-PTCS for hospitals, including psychiatric hospitals. The interpretive guidelines for hospitals appear in Appendix A and Appendix AA. Section 2021. Non-deemed hospitals. Section 2021A, Recertification of Non-Deemed Hospitals. Hospitals that are certified for Medicare participation based on a SA survey should be recertified on a schedule consistent with the survey guidelines for non-deemed hospitals issued by CMS each fiscal year. A recertification packet for each hospital is to be sent to the RO by the SA. Exhibit 63 has a complete list of documents to be completed and included in the recertification packet. The certification and transmittal form, CMS 1539C&T, which is part of the recertification packet, should indicate in the remarks section that the C&T is transmitting a non-deemed hospital recertification. If the hospital has undergone a change of ownership with acceptance of assignment of the Medicare provider agreement by the new owner since the last recertification survey, also indicate if a change of ownership CHOW package was forwarded to the hospital by the SA. In addition, the SA also updates Exhibit 286, the Hospital/CAH Medicare Database worksheet, with any new information regarding the hospital. It is not permissible to forward the Hospital/CAH Medicare Database worksheet to the hospital for completion. The SAs are not expected to conduct an on-site visit of the hospital solely to obtain information for the worksheet. However, the SAs may be able to use state licensure data to update the worksheet. The updated Hospital/CAH Medicare Database worksheet should be forwarded with the recertification packet to the RO. The Aspen system must also be updated to reflect any changes to the information on the Hospital/CAH Medicare Database worksheet. This policy applies to all non-deemed hospitals. 2022 Deemed Status. Hospitals accredited by an accrediting organization with a CMS-approved Medicare hospital or Medicare Psychiatric Hospital Accreditation Program. Section 2022A. Notice that a participating hospital has been accredited and recommended for deemed status. A hospital accredited and recommended for deemed status by a national accreditation organization with a CMS-approved Medicare Hospital Accreditation Program may be deemed to meet all co-PTCS for hospitals, except the SNF requirements for swing bed designation and any higher than national standards approved by the Secretary for a state under Section 1863 of the Act. Additionally, a psychiatric hospital accredited and recommended for deemed status by a national accreditation organization with a CMS-approved Medicare Psychiatric Hospital Accreditation Program may be deemed to meet all co-PTCS for psychiatric hospitals. When notified that a participating hospital or psychiatric hospital has been accredited and recommended for deemed status, the RO verifies the accreditation and recommendation for deemed status and notifies the SA. The SA executes Form CMS 1539 to report the accreditation and recommendation for deemed status. Section 2022B, Recertification. Hospitals or psychiatric hospitals that receive their Medicare certification via deemed status based on accreditation by a CMS-approved accreditation organization, AO should be recertified by the State Survey Agency, SAW, on a schedule consistent with the accreditation interval of the AO. Upon receipt of a notice from the AO indicating that it has renewed a hospital's accreditation and is recommending continued deemed status, a recertification kit should be created in the Automated Survey Processing Environment Aspen or recertification packet for each deemed hospital or psychiatric hospital is to be sent to the RO by the SA. Exhibit 63 has a complete list of documents to be completed and included in the recertification packet. The certification and transmittal form, CMS 1539C&T, which is part of the recertification packet, should indicate in the remarks section that the C&T is transmitting an accredited hospital recertification. In addition, the SA also updates the Hospital/CAH Medicare Database worksheet, Exhibit 286, with any new information regarding the hospital. It is not permissible to forward the Hospital/CAH Medicare Database worksheet to the hospital for completion. the SAs are not expected to conduct an on-site visit of a deemed hospital solely to obtain information for the worksheet. However, the SAs may be able to use state licensure data to update the worksheet. The updated hospital/CAH Medicare database worksheet must be entered into Aspen and be included in the recertification kit forwarded to the RO. The recertification kit will not upload to the national database unless a hospital/CAH Medicare database worksheet has been completed. Section 2022C. Notification of withdrawal or loss of accreditation. See Section 2005B. Section 2024. Hospital merger/multiple campus criteria. When two or more hospitals merge, the SA ascertains whether to continue to certify the hospitals separately or to certify them as a single hospital, i.e., hospital with a main campus and an additional location. Also, when a hospital establishes an additional hospital facility, geographically separate but in the same metropolitan area, the SA determines whether the additional hospital facility will be certified as a separate hospital or whether it can be considered a single hospital. A hospital may establish an additional hospital facility, so organizationally or geographically separate, as to make it impossible to operate as a multi-campus hospital. Each location of a single hospital must meet the applicable COE-PTCAS. A certification of noncompliance at the COE-P level at any of the hospital locations affects the certification of the hospital as a whole. Consequently, when noncompliance at the COE-P level is found, the hospital will either be denied participation or terminated from participation in the Medicare/Medicaid program. When a hospital is to be terminated, the SA follows the termination procedures contained in Section 3010 and 3012. In addition, all locations of a single hospital must comply with applicable state licensure laws. When it is determined that any of the hospital locations does not comply with state licensure laws, the hospital as a whole will either be denied participation or terminated from participation in the Medicare/Medicaid program. Where two or more previously separate hospitals merge, all locations of the surviving hospital must meet the criteria found in Section 2004. In addition, all non-hospital providers of service under Medicare that state they are part of a single hospital must meet the criteria for provider-based designation in Section 2004 in order to be treated as a single hospital for payment purposes. Section 2026. Certification of parts of institutions as hospitals. Section 2026A. Hospitals other than psychiatric hospitals. The SA evaluates each general hospital as a whole for compliance with the COE-PTCAS and certify it as a single provider institution including all components. Under the legal control of the hospital governing body and part of the same corporation or governmental administrative entity, and subject to the direction of the hospital administrator and medical staff organization. The SA evaluates and certifies the whole hospital even when the components are separately housed. It is not permissible to certify only part of a general hospital. However, the following are not considered parts of the hospital and are not to be included in the evaluation of the hospital's compliance. Components appropriately certified as other kinds of providers or suppliers, i.e., a distinct part SNF and / or distinct part NF, HHA, RHC, or hospice, and excluded residential, custodial, and non-service units not meeting the definitions in Section 1861E1 or J1 of the Act. Section 2026B. Excluded non-service units may be appropriate. The hospital ordinarily requests exclusion of a unit by a letter to the RO through the fiscal intermediary. The RO may then ask the SA to certify information it needs to make the exclusion. Otherwise, the SA excludes from any regular certification those portions of a hospital that are separately identifiable units that do not meet the Section 1861E1 or J1 definitions. Section 2030. Temporary waivers applicable to rural hospitals. If a hospital is found to be out of compliance with the 24-hour registered nurse RN requirement, a temporary waiver may be granted by the RO. This waiver, however, may be approved only to the extent that it would not jeopardize or adversely affect the health and safety of patients. The waiver may be issued for any 1-year period or less under certain circumstances, and may be withdrawn earlier if this action is necessary to protect the health and safety of patients. The hospital must meet all co-PTCS except for the waived requirement. In determining whether a hospital qualifies for a waiver, the SA verifies that these additional criteria are met. The hospital is located in a rural region. The Census Bureau in the most recent census defines rural as all areas not delineated as an urbanized areas. Use the material in Appendix G, Standard Roman 2A, and tabs AC of Appendix G to ascertain whether the area is rural or urbanized. The hospital has 50 or fewer beds. Exclude from the bed count newborn and intensive care beds. The character and seriousness of the deficiencies do not adversely affect the health and safety of patients. The hospital has made and continues to make a good faith effort to comply with personnel requirements consistent with the waiver. Record information concerning the hospital's effort to employ additional RNs. Document the recruitment efforts of the hospital and whether the wage level offered is consistent with other hospitals in the area. Hospitals that pay below the wage level for the area might not be able to attract new personnel. Therefore, the RO might determine that they are not making a good faith effort to attract new nurses. The hospital's failure to comply with the 24-hour nursing requirement is attributable to a temporary shortage of qualified nursing personnel in the area in which the hospital is located. Obtain and include any information substantiating the prediction that the shortage is temporary, e.g., names of personnel scheduled to complete qualifying training or scheduled to be engaged and anticipated dates of arrival on duty. An RN is present on the premises to furnish or supervise nursing services during at least the daytime shift, 7 days a week. On all tours of duty not covered by an RN, a licensed practical vocational nurse, LPN, is in charge. The SA includes in the certification package documentation of the above requirements for waiver and the most recent 2-week duty roster for RNs and LPNs. Section 2034. Time limit on temporary waiver. A temporary waiver of the hospital 24-hour RN coverage requirement may not exceed a 12-month period and may not be renewed. A shorter period may be recommended. The RO notifies the hospital of the duration of the waiver, a list of deficiencies, and a statement indicating that the waiver may be removed prior to its stated expiration date if the hospital fails to maintain its effort to correct its nursing deficiencies. Regardless of the approved duration of the waiver, it may be withdrawn at any time patient health and safety are adversely affected. Therefore, the SA should plan frequent revisits, make telephone contacts, and request nurse staffing duty rosters to monitor the hospital's progress and to determine that patient health and safety are not jeopardized. The frequency of SA monitoring efforts depends on the hospital's efforts to make corrections, the number and types of patients served, functional arrangement and design of the patient care facility, and the number and qualifications of the RNs and auxiliary nursing personnel. If the SA finds that continuation of the waiver is not appropriate, it documents the case for termination of the provider agreement. Conversely, if it finds that the hospital has corrected its nursing deficiency, it certifies the hospital without reference to the prior waiver. Section 2036. Definition, authority, and requirements for hospital providers of extended care services, swing beds. Swing bed is a reimbursement term that means the care and reimbursement for the care of a patient in a small rural hospital, or CAH, swings from acute care to post-hospital skilled nursing care, SNF. A swing bed hospital means a hospital or CAH participating in Medicare that has an approval from CMS to provide post-hospital SNF care and meets the requirements specified in Section 482.66 for a hospital or Section 485.645 for a CAH. Certification to provide swing beds is an approval separate from the certification to operate as a hospital or CAH. When a survey of swing beds is completed, any deficiencies and plans of correction POC must be documented on a separate Form CMS 2567. If the swing beds are voluntary terminated or terminated by CMS, that action does not affect the continuing operation of the provider as a hospital or CAH. It terminates the approval to operate and receive reimbursement for the swing beds. The swing beds in a hospital or CAH do not have to be separated from the acute patients, although the facility may choose to do so. The patients do not have to move to a different location in the facility when changing from acute care status to swing bed status, unless the facility requires it. There is no length of stay restriction for a swing bed patient whether they are in a hospital or a CAH. There is no required discharge to a nursing home and no transfer agreement. Patients may be discharged to a nursing home as part of discharge planning, but it is not required. A medical order in the chart by the physician is required to change status from acute care to swing bed because the patient is being discharged from acute care status and admitted to swing bed status. This is necessary for reimbursement purposes because the billing and reimbursement change, or swing. Accordingly, the facility is given a subprovider number for billing swing bed services. For Medicare patients, a 3-day qualifying stay in any hospital or CAH is required prior to admission to a swing bed, and the admission must be for treatment of the same condition. This 3-day qualifying stay only applies to a Medicare patient. Section 1883 of the Act authorizes payment under Medicare for post-hospital SNF services provided by any hospital that meets the following requirements at 42 CFR 482.66. These requirements include the following. The hospital has a Medicare provider agreement. The facility has fewer than 100 hospital beds, excluding beds for newborns and beds in intensive care type inpatient units. The hospital is located in a rural area. This includes all areas not delineated as urbanized areas by the Census Bureau, based on the most recent census. The hospital does not have in effect a 24-hour nursing waiver, granted under 42 CFR 488.5, 4C. The hospital has not had a swing bed approval terminated within the 2 years previous to application. The hospital meets the swing bed co-PTCS C42 CFR 482.66 on resident rights, admission, transfer, and discharge rights, resident behavior and facility practices, patient activities, social services, discharge planning, specialized rehabilitative services, and dental services. Note, the 30-day patient transfer notice requirement at 42 CFR Part 483.1, 2A5 does not apply to swing bed hospitals. Section 2037. Requirements assessed prior to survey for swing bed approval. Section 2037A. Request from a Medicare participating hospital to add swing bed approval. The request can be initiated on the provider's letterhead stationery and sent to the SA. Acknowledgement and request for further information can be sent from the SA to the provider in a letter. See Exhibit 81. Letter transmitting materials to a hospital requesting swing bed approval. Section 2037B. Screening. Prior to scheduling a survey, the SA reviews the provider file as well as any other information maintained on the hospital to ascertain whether the 6 basic requirements are met. If these requirements are met and the hospital has begun to provide swing bed services, the SA schedules a survey. No hospital may receive initial swing bed approval without an on-site survey of the actual provision of such services. The SA may send a letter to the provider notifying them of the required documents for a future survey. See Exhibit 82. Notification to a hospital regarding an initial survey for swing bed approval. This notice acknowledges that a survey is required and the expectation for certain information that will be needed, but it does not disclose the date of the survey. Section 2037C, Provider Agreement. Prior to survey, the SA verifies that the hospital has a valid Medicare provider agreement. Section 2037D, Calculation of bed count. Exclude from the bed count newborn and intensive care beds. A hospital licensed for more than 100 beds may be eligible for swing bed approval if it utilizes and staffs for fewer than 100 beds. The SA forwards to the RO documentation that the hospital is operating within the bed category. Include in the packet floor plans, bed assignments by room number, staffing schedules, and census information for the previous 12 months. The SA obtains written assurance from appropriate hospital officials that the hospital will not operate with a greater number of inpatient hospital beds than permitted by the category for which approval is requested. Section 2037E, Rural Area. The SA includes as eligible those facilities that are not located in an urbanized area based on the most recent census of the Census Bureau. Before concluding that a hospital is ineligible on the basis of location, the SA telephones the Census Bureau RO for verification. Section 2037F, Certificate of Need Con Approval. States that have a con requirement for the initiation or expansion of long-term care services may require a con for a limited number of beds for LTC use. There is no federal requirement for a con, but CMS will not intervene if there is a state requirement. Section 2038, Survey Procedures for Swing Bed Approval. The SA surveys any hospital that meets the 6 items listed in Section 2036, and that has begun to provide post-hospital SNF and NF care services. The SA may choose to use the optional swing bed survey report that can be found with the Appendix T to record survey findings. The survey for swing bed approval may be conducted at the same time as a survey of the hospital Co-P at 42 CFR Part 482, although the findings must be documented on a separate form CMS 2567. Section 2039, Post-Survey Procedures for Swing Bed Hospitals. To receive swing bed approval, a hospital must be found in compliance with the provisions of 42 CFR Part 482.66 and the specific skilled nursing requirements in 42 CFR 483 that apply to swing bed hospitals. See Appendix T. If a plan of correction is required following the survey, send a copy of Exhibit 162. Request for a plan of correction following an initial survey for swing bed approval in a hospital to the provider. Effective dates for all swing bed approvals are based on the provisions at 42 CFR 489.13 that state the agreements will be effective on the date the on-site survey is completed if all federal requirements are met on the date of the survey. If the provider fails to meet any of the requirements, the approval will be effective on the earlier of the following dates: the date on which the hospital meets all requirements, or the date the hospital submits a correction plan acceptable to CMS. Section 2040, RO Approval Procedures for Swing Bed Approval. The RO prepares a formal determination and notifies the hospital of its approval or denial. For approvals, see Exhibit 83, Approval Notification for Swing Beds in a Hospital, or denials, see Exhibit 83B, Denial for Swing Bed Approval in a Hospital. If the provider is found to be in noncompliance after they have started to provide swinged services, a termination of the approval can be accomplished through a termination letter. See Exhibit 163, Termination Letter for Hospital Swing Bed Services. Failure to satisfy requirements for swing bed approval does not affect Medicare approval as a provider of hospital services, but it does withdraw the approval to provide SNF-level services at the hospital. Section 2042, Psychiatric Hospitals. The statutory requirements for psychiatric hospitals are found in Section 1861F of the Social Security Act. The Act. The regulatory requirements are found at 42 CFR 482.60, Section 42 CFR 482.62. The term psychiatric hospital means an institution which is primarily engaged in providing, by or under the supervision of a doctor of medicine or osteopathy, psychiatric services for the diagnosis and treatment of mentally ill persons. Satisfies the requirements of Section 1861E3 through E9 of the Act. General Hospital Requirements. Maintains clinical and other records on all patients as the Secretary finds necessary. To determine the degree and intensity of the treatment provided to individuals entitled to hospital insurance benefits under Part A, and meet such staffing requirements as the Secretary finds necessary for the institution to carry out an active program of treatment for individuals receiving services in the institution. In the case of an institution that satisfies the first two criteria and contains a distinct part that also satisfies the last two criteria, the distinct part is considered to be a psychiatric hospital. There are some psychiatric hospitals that are designated as forensic hospitals. These hospitals focus on serving individuals who are in the custody of penal authorities. As a general rule, institutions that house only prisoners are excluded from Medicare payment. However, in accordance with 42 CFR 411.4b, payment may be made for services furnished to individuals who are in the custody of penal authorities if one state or local law requires such individuals to repay the cost of the medical services they receive while in custody, and 2, the state or local government entity enforces the requirement by billing individuals who are prisoners whether or not they are insured by Medicare on any other insurance program. The pursuit of repayment from the prisoners for medical services must be done with the same vigor as would be done for the collection of any other debts owed the state. The determination of payment eligibility in these cases is made by the FI and CMS financial personnel. Regardless of whether a state meets the payment requirements for prisoners housed in these hospitals, the hospital must apply the COP, including the restraint and seclusion rules, to all patients including the prisoners. If a hospital wants to apply different health and safety rules to prisoners, it may want to consider establishing a distinct part. Medicaid rules for institutionalized individuals are found at 42 CFR 435.1008, Section 435.1009. If there is an issue concerning a Medicaid prisoner, contact the RO account representative for the particular state for resolution. Section 2044, Psychiatric Hospitals and Deemed Status. Psychiatric hospitals have a Medicare accreditation option available to them. Prior to this being the case, however, CMS permitted a psychiatric hospital to have deemed status with respect to all hospital conditions identified as A tags in Aspen, except the special psychiatric co-PTCS at 42 CFR 482.60-62, identified as B tags in Aspen. Under this arrangement, the AO was responsible for assessing the psychiatric hospital's compliance with all other hospital co-PTCS, i.e., those provisions with the tags, and either the SA or CMS contract surveyors assessed compliance with the special psychiatric co-PTCS, i.e., the B tags. Currently, almost all deemed status psychiatric hospitals are accredited under the approved Medicare Psychiatric Hospital Accreditation Program, and their AO is responsible for assessing compliance under both the A and B tags. Any psychiatric hospital seeking initial participation in Medicare through deemed status must be accredited under a CMS-approved Medicare Psychiatric Hospital Accreditation Program. This also is the case for any non-accredited participating psychiatric hospital seeking to switch to deemed status. CMS no longer permits a psychiatric hospital to seek participation through deemed status for the tags only. However, there are a small number of participating psychiatric hospitals that were deemed to meet the requirements for the tags only prior to CMS approving a psychiatric hospital Medicare accreditation program. CMS considers these hospitals to have grandfathered deemed status for the tags only, and SAs or CMS contract surveyors remain responsible for B-tag surveys in these facilities. If a psychiatric hospital currently has deemed status for the tags through accreditation by an AO, which has a CMS-approved Medicare hospital accreditation program, but does not have a CMS-approved Medicare psychiatric hospital accreditation program, and the psychiatric hospital wishes to be deemed for the Special Psychiatric Hospital Co-PTCS, it must seek accreditation from an AO with a CMS-approved Medicare psychiatric hospital accreditation program. In this instance, the psychiatric hospital may not choose to continue its current Medicare hospital accreditation with one AO, in addition to obtaining its new Medicare psychiatric hospital accreditation with another AO. It must withdraw from its current Medicare hospital accreditation program and seek or maintain accreditation under a CMS-approved Medicare psychiatric hospital accreditation program only. It is not permissible for the psychiatric hospital to both be accredited by one AO under its hospital program and by another AO for the Special Psychiatric Co-PTCS only. When the SA is responsible for surveying the Special Psychiatric Co-PTCS of an otherwise deemed psychiatric hospital, the SA completes the Medicare/Medicaid Psychiatric Hospital Survey Data, Form CMS 724, and all other relevant survey documents, Form CMS 2567, etc. for the survey. Section 2048, Distinct Part Psychiatric Hospital. Section 2048A, General. A psychiatric hospital may elect to participate in its entirety, or it may designate a distinct part and apply for Medicare participation of that portion, only see Section 1880-60. The distinct part provisions of the law are designed to permit the participation of those identifiable sections of psychiatric hospitals that are adequately staffed, supervised, and equipped to provide active treatment on a continuing basis. The participating distinct part must meet the hospital co-PTCS and the two special co-PTCS and have appropriate treatment services available. Patients in the distinct part must be provided treatment that may reasonably be expected to improve their condition. The provisions for certification of distinct parts of psychiatric hospitals apply only where the entire institution is primarily for the treatment of mental illness. Thus, a psychiatric wing or building of a general hospital or of a large medical center or complex may not be certified as a distinct part psychiatric hospital. Such facilities are included in the certification of the institution of which they are an integral part. Section 2048B, Physical Identification. To qualify for participation as a distinct part psychiatric hospital, the distinct part must be physically distinguishable from the larger institution or institutional complex. That is, a group of beds specifically for patients who need active treatment. The Section S or Unit S to be included in the distinct part certification must be clearly defined. An institution or institutional complex can only be certified with one distinct part. Multiple certifications within the institution or institutional complex are strictly prohibited. The distinct part can be a wing, separate building, a floor, a hallway, or one side of a corridor. The beds in the certified distinct part area must be physically separate from that is, not commingled with the beds of the institution or institutional complex in which it is located. However, the distinct part need not be confined to a single location within the institution or institutional complex's physical plant. It may, for example, consist of several floors or wards in a single building or floors or wards that are located throughout several different buildings within the institutional complex. Where an institution or institutional complex owns and operates a distinct part, that distinct part is a single distinct part, even if it is operated at various locations throughout the institution or institutional complex. The aggregate of the locations represents a single distinct part subprovider, not multiple subproviders, and must be assigned a single provider number. Specialized services such as physical therapy and occupational therapy services may be included in the distinct part certification. If any specialized services are included in the distinct part, the SA surveys the service and identifies them on Form CMS 1539. Section 2048C, Documentation of Findings. In the documentation on the survey report, the SA includes its observations about the distinct part and an assessment of the overall ability of the hospital to provide the services required. As appropriate, the SA must provide information about the entire hospital's staffing pattern, such as the number, kind, and location of patient care personnel, including physicians, nursing personnel in all categories, social workers, and occupational and other therapists. The non-participating portion of an institution is required to meet the co-PTCS only insofar as it affects the health and safety of patients in the distinct part or provides facilities or services used by such patients. In certifying the distinct part, the SA considers the impact of non-participating sections of the institution to ascertain whether there are any hazardous conditions which might endanger patients in the distinct part. For example, the lack of adequate fire or sanitation safeguards, particularly where the distinct part is attached to the rest of the institution. It is rare that a distinct part of a hospital is completely self-contained. Therefore, the SA evaluates services, facilities, and activities of the overall institution that are provided or made available to patients throughout the institution. Inpatients of the distinct part may receive specialized services such as physical therapy or occupational therapy in a portion of the hospital not included in the distinct part. Services and facilities that may be shared vary with the type and size of the institution and the size of the distinct part. However, in most instances, the distinct part shares with the rest of the institution such central support services as dietary, housekeeping, maintenance, administration and supervision, and some medical and therapeutic services. The primary consideration in evaluation of shared services is whether the sharing can be done without sacrifice to the quality of care given the patients in the distinct part and without endangering their health and safety. Where personnel assignments are shared, the SA should show the extent of sharing. The SA verifies copies of staffing patterns and assignments furnished by the institution through personal observation, interviews with various personnel, examination of job descriptions and personnel records, and inspection of patient clinical records. The SA reviews medical records for an indication of the extent to which patients of the distinct part receive the services of skilled personnel. In general, the distinct part, either by itself or in conjunction with the overall institution of which it is a part, must be able to demonstrate the capacity to provide the services, facilities, and supervision required by the co-PTCS to patients of the distinct part. Section 2050, Medical Surgical Unit of Psychiatric Hospitals. A medical surgical unit of a psychiatric hospital may qualify for participation as a general hospital independent of the institution as a whole, regardless of whether the remainder of the institution is participating. The unit is regarded as a separate institution for this purpose, since the law does not provide for the participation of a distinct part general hospital. It must be a separate, functioning entity that is a distinct and identifiable unit within the institutional complex and be in compliance with all the co-PTCS for hospitals. Although a medical surgical unit may find it necessary to share some services with the non-participating part of the institution, The location of shared services in relation to the medical surgical unit must clearly show that the latter meets the co-PTCAS. Section 2052. Non-participating emergency hospitals. Section 2052A. Emergency hospital services. Any non-participating hospital meeting the definition of an emergency hospital for Medicare purposes may claim payment for emergency inpatient and outpatient diagnostic services furnished to Medicare patients. There are 6 statutory requirements that a hospital must meet to qualify as an emergency hospital. Section 1861E1, 2, 3, 4, 5, and 7. The hospital must be primarily engaged in providing, by or under the supervision of physicians, to inpatients, diagnostic and therapeutic services or rehabilitation services. Maintain clinical records on all patients. Have bylaws in effect with respect to its staff of physicians. Have a requirement that every patient must be under the care of a physician. Provide 24-hour nursing service rendered or supervised by a registered professional nurse, and have a licensed, practical, or registered professional nurse on duty at all times. And be licensed or meet standards for licensing pursuant to state and local law. Section 2052B. Preparation of initial certification. For the initial certification, the SA obtains a completed hospital request to establish eligibility, Form CMS 1514. The SA annotates at the top, emergency hospital services only. When possible, the SA evaluates the capability of an institution to meet the statutory requirements from information contained in state licensure files and other available state records, or through previous contacts with the hospital. The SA prepares a Form CMS 1539, completing items 3, 4, 6, 7, 9, 12, 13, and 16, 18. Section 2052C. Recertification and follow-up. The SA maintains an emergency hospital listing on a continuous basis and annually recheck it to ensure that the certifications are still correct. If a hospital no longer meets the definition of an emergency hospital, the SA prepares a new Form CMS 1539. Section 2053. Medicaid-only hospitals. Many hospitals choose to participate in both the Medicare and Medicaid programs. However, a hospital may choose to only participate in Medicaid. Medicaid regulations at 42 CFR 440.10 and 42 CFR 440.140A require a hospital or psychiatric hospital, also referred to in Medicaid as an institution for mental disease, which is defined at 42 435.1010, participating in Medicaid to meet the requirements for participation in Medicare in order to receive Medicaid payment. These regulations do not require a hospital or psychiatric hospital to enroll in the Medicare program in order to demonstrate compliance with Medicare participation requirements. The provider agreement rules at 42 CFR 489.10 establish the basic Medicare participation requirements for providers, including requirements for hospital participation. These requirements include, but are not limited to, complying with the following: applicable hospital conditions of participation, co-Ps at 42 CFR Part 482. Specified Office of Civil Rights requirements, and the Advanced Directive requirements at 42 CFR 489.100 and 42 CFR 489.102. Section 2053A. Initial certification of Medicaid-only hospitals. Hospitals seeking initial certification to participate in the Medicaid program only must contact the state agency SAW, in accordance with Section 1902A9A and 1902A33 of the Act, to initiate the certification process. Requirements for this process are established in the Medicaid state plans, required written agreement, or formal written intra-agency arrangement between the state Medicaid agency SMA and the SAC 42 CFR 431.610F. The SMA must approve the hospital's request for enrollment into the Medicaid program prior to the initiation of the certification process by the SA. Section 2053B, Certification Surveys of Medicaid-only hospitals. Following verification by the SMA that the enrollment application process has been initiated by the hospital, the SA must determine if the hospital seeking Medicaid-only certification demonstrates compliance with requirements for Medicare participation, including all applicable co-PTCS, through the completion of an on-site survey. Hospitals have the option of establishing compliance with applicable co-PTCS through accreditation under 42 CFR 488.6b by a nationally recognized accreditation organization, AO, with a CMS-approved Medicare hospital or psychiatric hospital program. Hospitals choosing this option must provide the SA with a letter issued by the AO confirming its accreditation under a CMS-approved Medicare accreditation program and recommending deemed status as a Medicaid-only hospital. As with Medicare participating hospitals, it is possible that a hospital might be accredited, but not of deemed status. The AO letter must indicate the hospital is recommended for deemed status. However, regardless of whether the survey is conducted by the SA or a CMS-approved AO, the SA must issue a determination to the SMA as to whether the hospital has met all Medicare participation requirements for Medicaid-only hospital participation. Upon receipt of the SA's determination, the SMA issues an effective date for the hospital's participation in the state Medicaid program. The SA then compiles and forwards a Medicaid-only certification packet to the RO. This packet consists of the hospital's request for an applicable Medicaid-only hospital or psychiatric hospital CMS certification number CCN, the SA's certification of compliance with Medicare co-PTCS, and the SMA-issued state Medicaid program effective date. After review of all documentation, the RO issues the appropriate Medicaid-only hospital CCN. Section 2053C, Change in Certification. If the hospital decides to seek participation in Medicare as well as Medicaid, see Section 2777 D3. Section 2053D, Termination. The SMA must terminate the hospital's Medicaid agreement when the SA determines that the hospital does not meet the applicable requirements. See Section 3005 C3. Section 2053E, Complaint Investigation. All allegations of noncompliance with federal or state requirements in Medicaid-only hospitals must be referred to the SA. Under 42 CFR 431.610, the SA, in collaboration with the SMA, must determine the policies and procedures for the intake, triage, and investigation of all allegations of noncompliance in both deemed and non-deemed Medicaid-only hospitals. The SA is solely responsible for reporting complaint investigation findings to the SMA, including a determination whether a Medicaid-only hospital meets Medicare co-PTCS and other federal requirements in accordance with Section 1902A33B of the Act. Section 2054, Religious Non-Medical Health Care Institutions, RNHCI. Section 4454 of the Balanced Budget Act of 1997 BBA 97, Public Law No. 105-33, enacted August 5, 1997, deletes statutory references to Christian Science sanatoria and amended the following sections of the Act. Section 1821, 1861E, Y and SS, 1869, and 1878 Medicare provisions, 1902A, and 1122H, and 1162 conforming provisions. Additionally, Section 4454 provides for coverage of inpatient services furnished in qualified RNHCI under Medicare and as a state plan option under Medicaid. The new amendments make it possible for RNHCI meeting the defining criteria in Section 4454 of BBA 97 or Section 1861 SS1 to participate in the Medicare and or Medicaid program. The RNHCI provider is responsible for meeting both conditions of coverage and conditions of participation to qualify as a Medicare provider, and that portion of the conditions of coverage that define an RNHCI and the conditions of participation to qualify as a Medicaid provider. Section 2054.1, Certification of Religious Non-Medical Healthcare Institutions, RNHCI. The Boston Regional Office has the primary responsibility for the approval and certification process to ensure and verify that the RNHCI conforms to specific conditions of coverage and all of the conditions of participation. An RNHCI is a provider that meets the definition as described in Section 1861 SS1 of the Act and meets the following qualifying Medicare conditions of coverage provisions as specified in 42 CFR 403.720. To qualify as a Medicare or Medicaid RNHCI, an institution must meet all 10 of the following requirements. Is described in subsection C3 of Section 501 of the Internal Revenue Code of 1986 and is exempt from taxes under subsection 501A. Is lawfully operated under all applicable federal, state, and local laws and regulations. Furnishes only non-medical nursing items and services to beneficiaries who choose to rely solely upon a religious method of healing, and for whom the acceptance of medical services would be inconsistent with their religious beliefs. Note, religious components of the healing are not covered. Furnishes non-medical items and services exclusively through non-medical nursing personnel who are experienced in caring for the physical needs of non-medical patients. For example, caring for the physical needs such as assistance with activities of daily living, assistance in moving, positioning, and ambulation, nutritional needs, and comfort and support measures. Furnishes non-medical items and services to inpatients on a 24-hour basis. Does not furnish, on the basis of religious beliefs, through its personnel or otherwise, medical items and services including any medical screening, examination, diagnosis, prognosis, treatment, or the administration of drugs for its patients. Is not owned by, under common ownership with, or has an ownership interest of 5% or more in a provider of medical treatment or services, and is not affiliated with a provider of medical treatment or services, or with an individual who has an ownership interest of 5% or more in a provider of medical treatment or services, permissible affiliations are described in Section 403.738C. Has in effect a utilization review plan that meets the requirements of Section 403.720A8. Provides information CMS may require to implement Section 1821 of the Act, including information relating to quality of care and coverage determinations, and meets other requirements CMS finds necessary in the interest of the health and safety of the patients who receive services in the institution. Section 2054.1A, Other Medicare Conditions of Coverage. The remaining conditions of coverage are specific to Medicare. However, a state may elect to employ any or all of these requirements within their optional Medicaid state plan amendment. Section 2054.1b, Valid Election Requirements. The regulations at 42 CFR 403.724 present the elements necessary for a Medicare beneficiary to complete an election to receive care in an RNHCI. The RO determines whether or not the RNHCI has adequately ensured that the Medicare beneficiary's valid election statement has been included with the RNHCI administrative records and or patient care records. Note, the facility is to provide the fiscal intermediary the original of the election statement, which will be used for each Medicare beneficiary in the RNHCI and retain a copy in its files. The provisions for valid elections include the following general requirements. The election statement must be made by the Medicare beneficiary or by his or her legal representative. It must include written statements that the beneficiary is conscientiously opposed to acceptance of non-accepted medical treatment. The beneficiary acknowledges that acceptance of non-accepted medical treatment is inconsistent with his or her sincere religious beliefs. The beneficiary acknowledges that receipt of non-accepted medical care constitutes a revocation of the election and may limit further receipt of services in an RNHCI. The beneficiary acknowledges that the election may be revoked by submitting a written statement to CMS. And the beneficiary acknowledges that the revocation will not prevent or delay access to medical services available under Medicare Part in other types of facilities. A valid election must also be signed and dated by the beneficiary or by his or her legal representative, not prior to reaching Medicare eligibility and beneficiary status. Be notarized. Include an original copy submitted on file to CMS. CMS is represented for this purpose by the intermediary. And include any other information obtained regarding prior elections or revocations. A beneficiary's election is revoked by one of the following. The beneficiary receives non-accepted medical treatment for which Medicare payment is made, or the beneficiary voluntarily revokes the election and notifies CMS in writing. Note: accepted and non-accepted medical care are defined in 42 CFR 403.702. The receipt of accepted medical care or treatment as defined in 403.702 does not revoke the election made by a beneficiary. The beneficiary's ability to elect is limited once the election has been made and revoked twice. See Section 403.724C. Organ transplant programs. Section 2060, Organ transplant programs. Section 2060A, citations. The conditions of participation (COPs) for transplant programs were established under several statutory authorities. Section 1102 of the Social Security Act. The Act authorizes the Secretary to publish rules and regulations necessary for the efficient administration of the functions with which the Secretary is charged under the Act. Section 1870, 1A of the Act authorizes the Secretary to prescribe such regulations as may be necessary to carry out the administration of the insurance programs under this title. Section 1880, 1B1 of the Act contains specific authority for prescribing the health and safety requirements for facilities, including renal transplant programs, that furnish end-stage renal disease ESID care to beneficiaries. Section 1861E9 of the Act authorizes developing standards necessary for the health and safety of individuals furnished services in hospitals. Organ transplant programs are required to be in compliance with the federal requirements set forth in the Medicare COPTCS in order to be eligible to receive Medicare payment. In addition to meeting the COPTCS for transplant programs in 42 CFR Part 482, Subpart E, transplant programs must also meet the hospital COPTCS specified in Section 482.1 through 482.57. Section 2060B, definitions. Section 2060B, 1 Organ Procurement and Transplantation Network opt-in. The opt-in is a public-private partnership that links all professionals involved in the donation and transplantation system. The opt-in operates the national network for organ procurement and allocation and works to promote organ donation. The opt-in was established by the National Organ Transplant Act of 1984 and is operated by United Network for Organ Sharing UNOs under a contract from the Health Resources and Services Administration, HRSA, in accordance with Section 372 of the Public Health Service PHS Act. Through its policies, the opt-in works to increase the number of transplants, provide equity and access to transplants, improve outcomes for waitlisted patients, living donors, and transplant recipients, and promote living donor and transplant recipient safety. 2060B.2 Scientific Registry of Transplant Recipients, SRTR. The SRTR, founded in 1987, is a national database of transplant statistics that provides analytic support for the ongoing evaluation of the scientific and clinical status of solid organ transplantation in the United States. It was established pursuant to Section 373 of the PHS Act. The SRTR produces program-specific reports (PSR) to provide statistics on organ transplants. The reports contain information about candidates waiting for a transplant, outcomes on the waiting list, the transplant recipients, the donors, and the outcomes after a transplant. PSRs are produced twice each year for each organ transplant program, i.e., heart, intestine, kidney, liver, lung, and pancreas. More information on finding and comparing transplant programs can be obtained through the SRTR website at https://www.srtr.org/. More information on the PSRs can be found here. https://www.srtr.org/reports/program-specific reports/. 2060B.3 United Network for Organ Sharing UNOS. UNOS is a private, non-profit membership organization that coordinates the nation's transplant system under the opt-in federal contract. UNOS assists the transplant community and the patients it serves by maintaining the national organ transplant waiting list, coordinating the matching and distribution of donated organs, increasing public awareness of the need for donated organs, serving as a forum to create and define organ-sharing policies that maximize the use of donated organs, producing professional education tools, and providing extensive information about organ transplantation to patients and the public. Section 2060C, Regulatory Background. The conditions of participation for transplant programs were published in the Federal Register on March 30, 2007-72, FR 15198, and became effective 90 days after publication on June 28, 2007. For the first time, this final rule established Medicare conditions of participation for heart, intestine, kidney, liver, lung, and pancreas transplant centers. This rule set forth clear expectations for safe, high-quality transplant services delivered in Medicare participating facilities. Effective July 16, 2012, the Medicare and Medicaid programs, Reform of Hospital and Critical Access Hospital Conditions of Participation Final Rule 77, FR 29034, May 16, 2012, revised the requirement at Section 482.92. This final rule eliminated a duplicative requirement for an organ recovery team that is working for the transplant center to conduct a blood type and other vital data verification before organ recovery when the recipient is known. The verification continued to be completed at 2 separate times in the transplant process. Effective July 11, 2014, the Medicare and Medicaid programs, regulatory provisions to promote program efficiency, transparency, and burden reduction. Part Roman II Rule 79, FR 27106, May 12, 2014 finalized changes to the transplant program conditions of participation. Specifically, it removed redundant data submission requirements and eliminated the automatic 3-year reapproval cycle. Thereafter, the Omnibus Burden Reduction Final Rule, published September 30, 2019-84, FR 51732, removed the requirements at Section 482.82 that transplant programs must meet all data submission, clinical experience, and outcome requirements in order to obtain Medicare reapproval. This final rule became effective on November 29, 2019. Transplant programs are still required to comply with the COPTCS at Section 482.72 through 482.104, and the data submission, clinical experience, and outcome requirements for initial Medicare approval under Section 482.80. Section 2061. Request for Medicare approval of an organ transplant program. Hospitals seeking initial approval for a new organ transplant program must submit a revised CMS 855A to its Medicare Administrative Contractor MAC to indicate the addition of service. The applicant transplant program must also submit a request for Medicare approval to the applicable state survey agency, SAW, and copy CMS Baltimore QSOG transplant team at cmshhs.gov. Upon receipt of the applicant transplant program's written request seeking initial approval, the SA will provide a packet of information to the applicant, including a list of documents that must be submitted to the SA. CMS Baltimore will provide the applicant transplant program's report specific to clinical experience, data submission, and outcomes requirements to the appropriate state survey agency and CMS location. This will be reviewed prior to the on-site survey to determine compliance with initial approval requirements under Section 482.80. See Section 2062B.1 for additional guidance for determining compliance with the clinical experience, data submission, and outcome requirements at Section 482.80. The SA should confirm receipt of all necessary documents with the applicant and inform the applicant that the initial survey will be scheduled upon notification from the MAC that the revised CMS 855A has been approved. Office of Civil Rights Clearance is not required separately for the transplant program located within the Medicare Certified Hospital. Section 2061A, Transplant Services. Medicare Certified Transplant Programs. A transplant program located within a Medicare-approved hospital must meet the conditions of participation for transplant programs to be granted CMS approval to provide transplant services. These requirements apply to the following programs: Heart Transplant Program, Lung Transplant Program, Kidney Transplant Program, Liver Transplant Program, Pancreas Transplant Program, Intestine Transplant Program, in order to perform pancreas transplants, a hospital must have an approved kidney transplant program. In order to perform intestinal transplants, a hospital must have an approved liver transplant program. Pediatric or adult pancreas and intestine transplant programs that apply for initial Medicare approval must operate as a component of an existing Medicare-approved kidney or liver transplant program, respectively, which is in compliance with the Co-PTCS, Section 482.72 to 482.104. An on-site survey for initial approval of an adult or pediatric pancreas or intestine transplant program is not required, and compliance with applicable requirements listed at Section 482.80 must be verified prior to approval using procedures specified in Section 2062B.1 of this chapter. Enforcement action taken by CMS against a kidney or liver transplant program may impact the Medicare approval of the hospital's pancreas and intestine transplant program. Programs serving both adult and pediatric populations. Transplant hospitals may perform both adult and pediatric transplants, either under separate program approval or under a single transplant program approval. If a transplant program is seeking separate approval of its adult and pediatric programs, the programs will be surveyed separately. If a program plans to perform both adult and pediatric transplants under a single transplant program, e.g. adult kidney transplant program, the program must seek approval for the primary age group, either adult or pediatric, that it serves and perform the majority of its transplants within that age group. That is, a program that provides more than 50% of its transplants in a 12-month period to pediatric patients must apply as a pediatric program. A a program that provides more than 50% of its transplants in a 12-month period to adults must apply as an adult program. Transplant programs performing living donation. CMS does not require separate approval for transplant programs that may also provide living donor services. If living donor services are provided by a hospital other than the transplanting hospital, these services are considered to be provided under arrangement. As such, there must be a formal arrangement between the hospital in which the transplant program is located and any other hospital which provides living donor services for the transplant program. It is the transplant program's responsibility to ensure that the co-PTCS applicable to living donors are met by the associated hospital providing the living donor services. The medical record of the living donor must confirm that all the requirements of the co-PTCS were met. Combined or simultaneous transplants. In order for combined transplants to be performed in a transplant hospital, the Medicare-certified hospital must have separate approvals of transplant programs for each organ type to provide transplant services and meet the conditions of participation specified in Section 482.72 through 482.104. For example, to perform a combined heart-lung transplant, the hospital must have an approved heart transplant program and a separately approved lung transplant program. Note, Section 482.70 defines a heart-lung program as a transplant program that is located in a hospital with an existing Medicare-approved heart transplant program and an existing Medicare-approved lung program that performs combined heart-lung transplants. To perform combined or simultaneous heart-lung transplants, a transplant hospital must have a Medicare-approved lung and a Medicare-approved heart transplant program. Separate approval as a heart-lung transplant program is not required. Combined transplants will be reviewed during the on-site survey of a transplant program. The transplant program survey protocol includes a review of individuals who received combined or simultaneous transplants during the survey process. See State Operations Manual, Appendix X for more information on the transplant program, survey protocols, and procedures. 2061. B. Organ Procurement and Transplantation Network Membership. Membership in the opt-in by the transplant hospital in which the transplant program is located is a requirement for Medicare approval. Opt-in membership means that the transplant hospital meets opt-in requirements and that it plays an active role in forming the policies that govern the transplant community. If a transplant program is determined to be non-compliant by the opt-in board, it may deem the program A member not in good standing and refer the case to the secretary for review. The opt-in maintains a member directory of transplant programs on its website, which can be accessed here. Opt-in member directory. Key personnel for transplant programs can be searched on the opt-in website through the following link: Transplant Program, Key Personnel Member Directory. Use the Transplant Center by Organ search option and choose the specific organ. Section 2062. Survey and Approval Procedures for Organ Transplant Programs. Section 2062A. Survey Composition and Scope. Survey team composition (SAs) should schedule a minimum of 2 surveyors for review of abdominal transplant programs' kidney, liver, intestine, and pancreas, and a minimum of 2 surveyors for thoracic transplant programs' heart and lung. These are separate survey teams and should not be combined, even if the programs are all surveyed simultaneously. Refer to the Transplant Program Survey Protocol in Appendix X for additional discussion on team composition. When more than one transplant program is surveyed at a hospital, all deficiency citations from all the programs may be entered onto one form CMS 2567. However, the deficiencies cited for each program must be separate and clearly identifiable for the applicable program. The CMS survey database allows for the selection of distinct programs. Scope. A transplant program must be located within a Medicare-certified hospital. In addition to meeting the transplant conditions of participation at Section 482.72 through 482.104, the transplant program must also be in compliance with Hospital Co-PTCS at Section 482.1 through 482.57. Most hospitals seek Medicare certification through private, CMS-approved accrediting organizations. Unlike hospitals, there are currently no CMS-approved accrediting organizations that are authorized to deem transplant programs, and therefore, transplant programs remain under the oversight of the state survey agency. If a state survey agency conducts a hospital survey in conjunction with a transplant program survey, the transplant program and hospital survey findings are documented on separate CMS 2567 forms, even though the surveys may be conducted together. During a standalone transplant program survey, a surveyor may also identify possible noncompliance with the hospital regulations. When hospital requirements are thought to be out of compliance and in need of investigation, the transplant program survey team must contact their supervisor to consult with the CMS location. Non-deemed hospital. If the hospital in which the transplant program is located is not a deemed hospital, these concerns may be investigated by the state survey agency as a hospital complaint investigation. Findings of noncompliance should be cited on a separate Form CMS 2567 under the name and CCN of the hospital in which the transplant program is located. Deemed hospital. If the hospital in which the transplant program is located is a deemed facility, the surveyor must contact his or her office and receive authorization from CMS to conduct a hospital complaint investigation. Any deficiencies cited under the hospital requirements must be entered onto a separate CMS 2567. Chapter 5, Section 5100 of the SOM provides additional information for handling complaints of deemed facilities. 2062b, Types of Surveys and Related Guidance. 2062b.1, Initial Survey for Medicare Approval. See Section 2061, above, for instructions on requesting initial approval. Once the MAC notifies the SA of its approval of the updated CMS 855A, a survey may be scheduled. Initial surveys are unannounced. If the applicant transplant program is found to be in compliance with the Co-PTCS, it is assigned a CCN. The program will not be issued a separate provider agreement. Once transplant program approval is completed, the CMS location will forward a Form CMS 2007 provider tie-in notice to the MAC. The ESID networks must also be notified for the initial approval of a kidney transplant program. Approved transplant programs operating within a single hospital are issued a CCN in the 9800 series. All approved programs that operate within a hospital fall under this transplant CCN. No separate or additional transplant CCN is issued for approved transplant programs under a single transplant center. Data submission, clinical experience, and outcome requirements for initial approval. Transplant programs must meet requirements for data submission, clinical experience, and outcomes at Section 482.80 to receive their initial Medicare approval, or may seek mitigating factors review for noncompliance associated with this requirement, in accordance with Section 488.61. Surveyors will need to request and obtain CMS Initial Transplant Report ITR to determine whether the applicant program meets the criteria determined by Section 482.80. Upon receipt of a transplant program's request for initial approval, CMS Baltimore will provide the CMS location and SA with the ITR. This report contains data that measures the program's data submission rate, volume clinical experience, patient/graft survival rates outcomes, and whether the transplant program under review has met these requirements. Provisions under Section 488.61 Authorize CMS to consider mitigating factors when determining approval for a transplant program that has not met the data submission, clinical experience, or outcome requirements if the program submits a formal written request for such a review. If the applicant does not wish to apply for mitigating factors consideration for noncompliance at Section 482.80, the initial application will be denied, and the provider will be notified of the denial in writing. If the applicant is determined to be out of compliance with any condition of participation other than Section 482.80, the initial application should be denied, and all usual certification processes for denials should be followed. Determining the level of the deficiency for non-compliance. Clinical experience requirements at 42 CFR Section 482.80b. Compliance with the clinical experience volume standards at 42 CFR Section 482.80b is determined by reviewing the program's performance compared to the objective standards outlined in the regulation. The goal of this section is to achieve consistency in determining the level of a deficiency citation, i.e., condition level or standard level under these co-PTCAS. To be considered for initial approval, a transplant program must generally perform 10 transplants over a 12-month period, Section 482.80b. If the program performs at least 8 transplants over a 12-month period, it may be approved with an acceptable plan of correction. If a transplant program other than a kidney transplant program has not performed at least 8 transplants in the most recent 12 months at the time of the program's request for initial approval, an initial approval survey cannot be conducted. Kidney programs that have not performed at least 3 transplants over a 12-month period may not be surveyed for initial approval. The program should be instructed to notify the SA when it has met the minimum requirement to initiate an on-site survey. If the program has performed at least 8, but less than 10 transplants in that 12-month time period, noncompliance at X033 will be cited as a standard-level deficiency. The program may still be approved with a standard-level citation for clinical experience if an acceptable plan of correction is received, and the program is in substantial compliance with all remaining co-PTCAS. During an on-site survey, transplant programs may provide evidence of conducting additional transplants, which are more recent than the information provided in the ITR. Surveyors should use this information when reviewing a program's compliance with CMS clinical experience requirement. The determination of condition-level noncompliance is made based upon the extent of any noncompliance findings with the standards under a co-P. A finding of noncompliance with the clinical experience standard, alone with no other noncompliance with standards under the condition, would generally not result in condition-level noncompliance determination at Section 482.80. Note, a program's inactivity does not create an exception to the clinical experience requirement. See Section 2062, B.5, for more information on transplant program inactivity. Outcome requirements at 42 CFR Section 482.80c. Transplant programs must meet or exceed national thresholds for 1 year post-transplant patient and graft survival to be in compliance with CMS outcome requirements for initial certification at 482.80c. Determining compliance with this requirement is made using data from the initial transplant report, which is provided to the CMS location and SA by CMS Baltimore. If there is no outcome data available, this may mean that not enough time has passed to determine 1 year patient and graft survival rates, or the program has not performed enough transplant surgeries to generate a report. Outcomes data must be available in order to determine compliance with the requirement at 482.80c. If the data is not yet available, an on-site survey cannot be initiated, and the SA should notify the provider that the initial survey will occur once the data becomes available. The following transplant program types are subject to the outcome requirements, i.e., 1-year patient and graft survival. Adult kidney, adult heart, adult lung, adult liver. Pediatric kidney includes only 1-year graft survival. Pediatric heart, pediatric lung, pediatric liver. The following transplant program types are not subject to the outcome requirements. Adult pancreas, pediatric pancreas, adult intestine/multivisceral, pediatric intestine/multivisceral. Initial surveys after outcomes data becomes available. The SA will conduct a full on-site survey for initial approval once they verify that all required certification materials have been submitted, received, and determined complete, including data required to determine compliance with the data submission, clinical experience and outcome requirements at Section 482.80. Once this verification is completed, the state agency will proceed with scheduling an on-site survey to determine compliance with the co-PTCS at Section 482.72 through 482.76 and Section 482.90 through 482.104. Results of the initial on-site survey for transplant programs. Initial approval. If the SA determines that the transplant hospital is in substantial compliance with all co-PTCS or has standard-level deficiencies with an accepted plan of correction, CMS will notify the transplant hospital in writing of its approval and the effective date of the approval. The effective date of Medicare approval is determined using existing procedures in the State Operations Manual, CH2, Section 2008D. Initial denial. If the SA determines that the transplant program has failed to meet co-PTCS other than Section 482.80, CMS will notify the transplant hospital in writing of the denial. Mitigating factors will not be considered for condition-level deficiencies. The transplant hospital may reapply for Medicare approval after correcting any deficiencies. If the transplant hospital reapplies for initial Medicare approval, it will undergo a new initial on-site survey. Initial approval or denial based on mitigating factors. If CMS determines that the transplant hospital is in substantial compliance with all co-PTCS, i.e., no condition-level deficiencies, except for Section 482.80, or has standard-level deficiencies with an accepted plan of correction. CMS will consider mitigating factors using procedures specified in Section 488.61e in its consideration of initial approval. Upon review of the program's request to consider mitigating factors for failure to meet the outcome requirements, CMS will make a determination of Medicare approval or denial. For more information on the mitigating factors process, see Section 2066. 2062, B.2, Reapproval Surveys. Once a transplant program has been approved to participate, it will be periodically resurveyed for compliance with the co-PTCS. Reapproval surveys are unannounced surveys and are performed at a frequency consistent with the CMS Mission and Priority Document (MPD). SAs may follow usual recertification procedures for non-deemed hospitals SOM Chapter 2, Section 2021, A, in cases where the survey results in a determination of substantial compliance with all conditions of participation. 2062, B.3 Complaint Surveys. Transplant program complaints may involve hospital co-PTCS, in addition to any transplant program co-PTCS. Additionally, most hospitals with transplant programs are deemed to meet CMS requirements based upon accreditation through an accrediting organization AO with a CMS-approved hospital program. If a transplant program complaint survey results in possible deficiencies with the hospital requirements at Section 482.1 through 482.57, the CMS location must approve any investigation of the hospital co-PTCS. A transplant program is an integral part of the hospital and must meet all applicable hospital conditions of participation. Transplant programs and hospitals share most operations, including nursing staff and nursing administration, rules for the operating room, credentialing, and quality of patient care. While the transplant program co-PTCS includes specific requirements for evaluation for transplant, wait listing, and allocation of organs, the requirements for many of the shared services, such as surgical services and nursing services, are specified in the hospital co-PTCS rather than the transplant program co-PTCS. All complaints against a Medicare-certified transplant program will be referred to the applicable SA for triage and investigation by the SA hospital survey staff or applicable AO if the hospital is deemed. If the nature of the allegations suggests noncompliance with any hospital co-PTCS, a hospital complaint survey would be performed. See SOM, Chapter 5, for a description of the general complaint investigation process. For complaint investigations of a transplant program, the scope of survey activities is generally limited to the specific transplant co-PTCS associated with the allegation S. If allegations are substantiated, the scope may be expanded to review any associated co-PTCS. Complaints related to disease transmission via an organ from a deceased donor should be communicated to the RO for their determination of the need for an OPO complaint investigation. Section 2063. Relationship between the transplant co-PTCS and hospital co-PTCS. The transplant program must be in compliance with all hospital co-PTCS as well as all transplant program co-PTCS. Certain hospital requirements are inherently included in the transplant program's survey process. When hospital requirements are thought to be out of compliance and in need of investigation, the transplant program survey team must contact their supervisor to consult with the CMS RO for further instructions on citing the hospital deficiencies and must notify the hospital administration of any such citation. The transplant program and hospital survey findings are documented on separate CMS 2567 forms, even though the surveys are conducted together. Section 2064. Notification to CMS. Under Section 482.74, approved transplant programs must immediately notify CMS of any significant changes related to the hospital's transplant program that could affect its compliance with the conditions of participation. These changes include, but are not limited to, changes in the primary transplant surgeon as designated to the opt-in, changes in the primary transplant physician as designated to the opt-in, and inactivation of the transplant program. Beginning January 1, 2019, the applicable SA has received these notifications on CMS's behalf. Due to the nature of the information being reported and its relationship to survey activities, the SA must maintain these notifications for reference at the time of reapproval surveys. If the surveyor determines that the transplant program failed to notify the SA of these key changes, a deficiency should be cited at Section 482.74. Section 2065. Transplant Program Inactivation. A transplant program may voluntarily declare an inactive status with CMS and may remain inactive and retain its Medicare approval for a period not to exceed 12 consecutive calendar months. See Section 488.61d. Transplant programs that have declared inactive status are not receiving organ offers and or performing transplants. Transplant programs must notify their waitlist patients of any inactivation or plan to inactivate their program, as this affects their ability to receive a transplant. See Section 482.102c for more information. The program must provide written notification to its SA on behalf of CMS of the anticipated inactivity period, as required at Section 482.74a3. Notification to the SA and to the potential recipients must occur prior to the start of any planned inactivity period. During its inactivity period, the program must continue to comply with all Medicare co-PTCS. Once the SA receives notice of the transplant program's intent to inactivate, a letter or electronic communication should be sent acknowledging receipt of the notification, ensuring the transplant program is aware of its responsibility to notify the SA when the inactivation ends, and that the voluntary inactivation may be no longer than 12 consecutive calendar months for the program to retain its approval. The SA should enter the transplant program's inactivation start date in the Provider Details table of the National Surveyor Database. Routine surveys or complaint investigations will continue and should not be delayed based on a transplant program's inactive status. Prior to going on site for a reapproval survey, the survey team should determine if the program has had any voluntary inactivation since the last survey. If so, confirm during the survey that patients on the program's waitlist were notified of the inactivation and that assistance was provided as discussed above. If during a survey it is determined that the transplant program implemented a voluntary inactivation but did not notify CMS through the SA, a deficiency should be cited for Section 482.74A3. If a surveyor finds that patients were not notified properly of an activation or were not provided requested assistance, a deficiency should be cited for Section 482.102C3. Notification to patients is expected to occur within 30 calendar days of the planned inactivation. Documentation of the notification may be evidenced in the patient's medical record or a separate record maintained by the program. The SA must monitor all inactive transplant programs to ensure that the inactivation does not exceed the 12-month limitation. Once the program reaches its 11th month of voluntary inactivation, the SA should contact the program again to inquire as to the intentions of the program. A model letter for transplant program notification can be found in the SOM, Chapter 9, Exhibit 357. Once a transplant program voluntarily withdraws or is terminated following their inactive period, they must apply for initial approval and meet all applicable co-PTCS, including the data submission, clinical experience, and outcome requirements at 482.80. Section 2066, Mitigating Factors. Background under 42 CFR Section 488.61e. A transplant program may request that the CMS consider mitigating factors for the initial approval of a transplant program that does not meet the COP at Section 482.80 for data submission, clinical experience, or outcome requirements. Mitigating factors will not be considered in situations of immediate jeopardy or any other cited deficiency. The regulation describes general considerations that will be reviewed in determining whether a program can be approved based on mitigating factors at 42 CFR Section 488.61E1. These areas include, but are not limited to: 1. The extent to which outcome measures are not met or exceeded. 2. Availability of Medicare-approved transplant programs in the area. 3. Extenuating circumstances, for example, natural disasters that have a temporary effect on meeting the co-PTCS. 4. Program improvements that substantially address root causes of graft failures or patient deaths that have been implemented and institutionalized on a sustainable basis, and that are supported by outcomes more recent than the latest available scientific registry of transplant recipients SRTR report, for which there is a sufficient post-transplant patient and graft survival period, and a sufficient number of transplants, such that CMS finds that the program demonstrates present-day compliance with the requirements at Section 482.80 C2 Roman 2. 5. Whether the program has made extensive use of innovative transplantation practices relative to other transplant programs, such as a high rate of transplantation of individuals who are highly sensitized or children who have undergone a Fontan procedure. where CMS finds that the innovative practices are supported by evidence-based published research literature, or nationally recognized standards, or institution review board herb approvals, and the SRTR risk adjustment methodology does not take the relevant key factors into consideration. And 6. Whether the program's performance, based on the Organ Procurement and Transplantation Network opt-in method of calculating patient and graft survival, is within the opt-in's thresholds for acceptable performance and does not flag opt-in performance review under the applicable opt-in policy. Requesting initial approval based on mitigating factors once a survey has been performed and the applicant transplant program is determined to be out of compliance with Section 482.80, it may request consideration of mitigating factors to address this noncompliance. A transplant program requesting initial approval based on the presence of mitigating factors must complete the following steps. 1. Send timely letter of intent to apply for mitigating factors. If CMS determines a transplant program has not met the data submission, clinical experience, or outcome requirements for initial approval, CMS may deny the request for initial approval. The program will receive a letter notifying the program of its denial. The transplant program must respond to CMS's letter with its intent to apply for mitigating factors review. Within 14 calendar days after CMS has issued to the program a formal written notice of a condition level deficiency under Section 482.80, CMS must receive notification of the program's intent to seek mitigating factors review. All requests for consideration of mitigating factors should be sent electronically to the CMS location where the hospital is certified and CMS Baltimore at QSOG Transplant Team at CMSHHS.gov. 2. Send timely and complete mitigating factors application. All information necessary for consideration must be received within 120 calendar days of CMS written notification of noncompliance at Section 482.80. See the Mitigating Factors web instructions in the Downloads section of the CMS transplant page for additional information on the required contents to deem an application complete. The complete Mitigating Factors application should be sent electronically to both the CMS location, where the hospital is certified, and CMS Baltimore at QSOG Transplant Team at CMSHHS.gov. Failure to meet any of these timeframes may be the basis for denial of mitigating factors. Preparing the mitigating factors application. A request for consideration of mitigating factors must include sufficient information to permit an adequate review and understanding of the transplant program, the factors that have contributed to outcomes, program improvements, or innovations that have been implemented or planned, and in the case of extenuating circumstances, such as a natural disaster, fire, or a pandemic, the recovery actions planned. In order to ensure a complete and thorough application, the following criteria should be followed. The application must include all elements noted in the Mitigating Factors application checklist. See the Mitigating Factors web instructions in the Downloads section of the CMS transplant page for additional information on the required contents to deem an application complete and ready for submission to CMS. The Mitigating Factors application checklist that was used must also be submitted as part of the application record. The pages of application documents should be sequentially numbered and sent as a single Adobe portable document format, PDF or Microsoft Word, Doc, or DocX file. CMS strongly suggests the Mitigating Factors application be sent electronically without the use of encryption or password protection. This will ensure that CMS is aware of all supporting documentation provided and will help facilitate the review process. Mitigating Factors application materials must have all personally identifiable information (PI) removed prior to submission to ensure a timely review. The application narrative should be concise and the supporting documentation relevant to the rationale and mitigating factors requested. See the Mitigating Factors web instructions in the Downloads section of the CMS transplant page for more information on mitigating factors. Areas for consideration. The program should limit the file size to a maximum of 200 pages. Outcomes of a mitigating factors application. Review all mitigating factors applications will be reviewed by CMS Baltimore. The CMS review will include analysis by CMS staff and technical experts with programmatic and clinical expertise for each transplant program on a case-by-case basis. Following the review, CMS Baltimore will provide a recommendation to the respective CMS location for approval or denial of the mitigating factors application based on review criteria and elements for approval. Following the recommendation, the respective CMS location may take the following actions. 1. Grant initial approval of a program's Medicare participation based upon mitigating factors. 2. Deny the program's request for Medicare approval based on mitigating factors. 3. Offer a time-limited systems improvement agreement, JA, in accordance with 42 CFR Section 488.61G. When a transplant program has waived its appeal rights, has implemented substantial program improvements that address root causes, and are institutionally supported by the hospital's governing body on a sustainable basis, and has requested more time to design or implement additional improvements or demonstrate compliance with CMS outcome requirements. Upon completion of the SIA or a CMS finding that the hospital has failed to meet the terms of the SIA, CMS makes a final determination of whether to approve or deny a program's request for Medicare approval based on mitigating factors. Section 2067, Transplant Resources. It is recommended that SAs maintain the following transplant program information on their websites. Current conditions of participation, Section 482.68 through 482.104. Note, the Medicare regulations for transplant programs are in Subpart E, Requirements for Specialty Hospitals. Current interpretive guidance and transplant survey protocol. List of information and materials that must be submitted for initial applications. Contact person or mailbox for O. Submission of changes in information and inactivation. O. Requests for verification of Medicare approval. O. Submission of questions by transplant providers. Survey training hyperlink for transplant basic course. And procedures for submission of request for consideration of mitigating factors. Surveyor training. The transplant program basic surveyor course may be accessed via https://qcepcms.gov/welcomeasks. Hospices. Section 2080, Hospice Citations and Description. Section 2080A, Citations. Section 1861U of the Act establishes hospices as a provider of services. Section 1861DD of the Social Security Act, the Act defines hospice care and the hospice program. 42 CFR 418 sets forth the conditions of participation co-Ps that hospices must meet and applies to a hospice as an entity, as well as to the services provided to each individual under hospice care. 42 CFR Part 418.110 is a condition applicable only to hospices that provide short-term inpatient care and respite care directly, rather than under arrangements with other participating providers. Section 1866A1Q of the Act requires hospices, among other providers, to file an agreement with the Secretary to comply with the requirements found in Section 1860, 6F of the Act regarding advance directives. The Centers for Medicare and Medicaid Services, CMS, has a website for survey and certification information including hospice policy memos, the State Operations Manual, Section 2080 to 2089 relating to hospices, and Appendix M, Hospice Survey Procedures and Interpretive Guidelines. This information is available at http:// www.cmshhs.gov/survey certification geninfo/. Definition. A hospice is a public agency or private organization, or a subdivision of either of these that is primarily engaged in providing care and services to terminally ill individuals, meets the co-PTCS for hospices, and has a valid Medicare provider agreement. The law governing the provision of Medicare hospice services is found at Section 1861dd of the Act. The law further clarifies that terminally ill individuals are individuals having a medical prognosis that the individual's life expectancy is 6 months or less. This definition is further clarified at 42 CFR 418.3 to provide for a life expectancy of 6 months or less if the illness runs its normal course. Although the law does not explicitly define its expectations for primarily engaged, CMS has interpreted it to mean exactly what it says, that a hospice provider must be primarily engaged in providing hospice care and services, Section 1861dd2ai. Primarily does not mean exclusively. This requirement does not preclude the hospice from providing services to terminally ill individuals who have not elected the hospice benefit, or providing services to individuals who are not terminally ill. As long as the primary activity of the hospice is the provision of hospice services to terminally ill individuals, and the hospice meets all requirements for participation in Medicare. Hospice benefit periods. An individual may elect to receive Medicare hospice benefits for 2 periods of 90 days and an unlimited amount of periods for 60 days each. See 42 CFR 418.21. Eligibility requirements. In order to be eligible to elect hospice care under Medicare, an individual must be entitled to part of Medicare and be certified as being terminally ill. See 42 CFR 418.20. An individual is considered to be terminally ill if the individual has a medical prognosis that his or her life expectancy is 6 months or less if the illness runs its normal course. Referrals may come from any source, but patients must be assessed by the hospice medical director for appropriateness of admission in consultation with the patient's attending physician if the individual has one. The hospice medical director must consider the diagnosis of the terminal condition of the patient, other health conditions, whether related or unrelated to the terminal illness, and current clinically relevant information supporting all diagnoses. The medical director may consult with the attending physician directly or through information obtained indirectly. Information could be obtained through the hospice nurse or others who would bring the attending physician's knowledge of the patient to the medical director when the admission decision is being made. The hospice must obtain written certification of terminal illness within 2 calendar days for each of the benefit periods listed in 42 CFR 418.21, even if a single election continues in effect for an unlimited number of periods. If the hospice cannot obtain the written certification within 2 calendar days, after a period begins, it must obtain oral certification within 2 calendar days and written certification before a claim for payment is submitted. For the initial 90-day period, certification of terminal illness must be obtained from the medical director of the hospice or the physician member of the Hospice Interdisciplinary Group (IGE) and the individual's attending physician if the individual has one. Recertification for subsequent periods only requires the certification of the hospice medical director or the physician member of the IDG. Certification statements must be on file and dated by the physician before the hospice submits a claim for payment. See 42 CFR 418.22. Section 2080B. Description. Hospice care means a comprehensive set of services described in Section 1860 1DD1 of the Act, identified and coordinated by the individual's attending physician, medical director, and by an interdisciplinary group to provide for the physical, psychosocial, spiritual, and emotional needs of a terminally ill patient and family members, as delineated in a specific patient plan of care. Hospice uses an interdisciplinary approach to caring for terminally ill individuals that stresses palliative care as opposed to curative care. Palliative care means patient and family-centered care that optimizes quality of life by anticipating, preventing, and treating suffering. Palliative care throughout the continuum of illness involves addressing physical, intellectual, emotional, social, and spiritual needs, and facilitating patient autonomy, access to information, and choice. The emphasis of hospice care is on effective symptom management, with the goal of making the patient as physically and emotionally comfortable as possible, and enabling the patient to remain at home as long as possible, with minimal disruption to normal activities. Counseling and respite services are available to the family of the hospice patient. Hospice considers both the patient and the family as the unit of care. Although some hospices are located as part of a hospital, skilled nursing facility, SNF, and home health agency, HHA, hospices must meet specific co-PTCS and be separately certified and approved for Medicare participation as a hospice provider of services. See Exhibit 129 for Hospice Survey and Deficiencies Report, Form CMS 643, and Exhibit 72 for Hospice Request for Certification in the Medicare Program, Form CMS 417. Section 2080C, Hospice Core Services. With the exception of physician services, substantially all core services must be provided directly by hospice employees on a routine basis. These services must be provided in a manner consistent with acceptable standards of practice. The following are hospice core services. Physician services. Nursing services, routinely available and or on call on a 24-hour basis. 7 days a week provided by or under the supervision of a registered nurse, RN, functioning within a plan of care developed by the hospice IGE in consultation with the patient's attending physician, if the patient has one. Medical social services by a qualified social worker under the direction of a physician, and counseling including, but not limited to, bereavement, dietary, and spiritual counseling with respect to care of the terminally ill individual and adjustment to death. The hospice must make bereavement services available to the family and other individuals identified in the bereavement plan of care up to 1 year following the death of the patient. The hospice may contract for physician services, as specified in 42 CFR 418.64a. A hospice may use contracted staff, if necessary, to supplement hospice employees in order to meet the needs of patients under extraordinary or other non-routine circumstances. 2080 C.1 Waiver of certain staffing requirements. Hospices are prohibited from contracting with other hospices and non-hospice agencies on a routine basis for the provision of the core services of nursing, medical social services, and counseling to hospice patients. A hospice may, however, enter into arrangements with another hospice program or other entity for the provision of these core services in extraordinary, exigent, or other non-routine circumstances. An extraordinary circumstance generally would be a short-term temporary event that was unanticipated. Examples of such circumstances might include unanticipated periods of high patient loads, caused by an unexpectedly large number of patients requiring continuous care simultaneously, temporary staffing shortages due to illness, receiving patients evacuated from a disaster such as a hurricane or a wildfire, or temporary travel of a patient outside the hospice's service area. The hospice that contracts for services must maintain professional management responsibility for all services provided under arrangement or contract at all times and in all settings. Regulations at 42 CFR 418.100e discuss the professional management responsibilities of the hospice for services provided under arrangement. Hospices must maintain evidence of the extraordinary circumstances that required them to contract for the core services and comply with the following. The hospice must assure that contracted staff is providing care that is consistent with the hospice philosophy and the patient's plan of care, and is actively participating in the coordination of all aspects of the patient's hospice care. And hospices may not routinely contract for a specific level of care, e.g., continuous care, or during specific hours of care, e.g., evenings and weekends. 2080C.2 Contracting for highly specialized services. A hospice may contract for the services of a registered nurse if the services are highly specialized, provided non-routinely, and so infrequently that the provision of such services directly would be impracticable and prohibitively expensive. Highly specialized services are determined by the nature of the service and the nursing skill level required to be proficient in the service. For example, a hospice may need to contract with a pediatric nurse if it cares for pediatric patients infrequently, and employing a pediatric nurse would be impracticable and expensive. Continuous care is not a highly specialized service because while time-intensive, it does not require highly specialized nursing skills. 2080C.3 Hospice Nursing Shortage Provision. CMS has instituted a temporary measure for hospices that are unable to hire a sufficient number of nurses directly due to the nursing shortage. During the time period from October 1, 2010, September 30, 2012, in order to qualify for an extraordinary circumstance exemption, a hospice must notify the state agency responsible for licensing and certification that it intends to elect an exception under the Extraordinary Circumstance Authority. This may be accomplished by providing written notification to the SA when it believes that the nursing shortage has become an extraordinary circumstance in its ability to hire nurses directly, and it must estimate the number of nurses it believes it will currently need to employ under contract. Notification may be made prior to September 30, 2012, and should address the following: an estimate of the number of potential patients that the hospice has not been able to admit during the past 3 months due to the nursing shortage, and provide the current and desired patient/nurse ratio for the agency. Evidence that the hospice has made a good faith effort to hire and retain nurses, including copies of recent advertisements, e.g., in local newspapers, websites, etc., that demonstrate recruitment efforts, copies of reports of telephone contacts with potential hires, professional schools and organizations, recruiting services, etc., and job descriptions for nurse employees. Evidence that salary and benefits are competitive for the area. Evidence of any other recruiting activities, e.g., recruiting efforts at health fairs, educational institutions, healthcare facilities, and contacts with nurses at other providers in the area. Ongoing self-analyses of the hospices, trends in hiring and retaining qualified staff, and evidence that the hospice has a training program in place to ensure that contracted staff are trained in the hospice philosophy and able to provide palliative care prior to patient contact. Contracted nurses may only be used to supplement the hospice nurses employed directly and should not be used solely to provide the continuous nursing level of care or on-call service. The hospice is expected to continue its recruitment efforts during the period that it is contracting for nurses. No approval action is required on the SA's part when it receives written notification from a hospice for an exemption, as long as the hospice provides the appropriate information. The SA will maintain copies of each exception notification and validate the hospice's stated need for an exemption during complaint and recertification surveys. Of particular importance will be the extent to which the hospice nurses have been trained in the hospice philosophy and are able to effectively provide care to the patients consistent with the patient-specific plan of care established by the IDG. Note: CMS has instituted a temporary measure to allow individual hospices to contract for nurses until September 30, 2012, if the hospice can demonstrate that the nursing shortage is creating an extraordinary circumstance that prevents it from hiring an adequate number of nurses. Section 2080D, Hospice Required Services. Requirement for 24-hour services. The hospice is required by the COPTCS at 42 CFR 418.100 to make nursing services, physician services, drugs, and biologicals routinely available on a 24-hour basis, 7 days a week. It also has to make all other covered services available on a 24-hour basis, 7 days a week, when reasonable and necessary to meet the needs of the patient and family. In addition to the hospice core services, physician services, nursing services, medical social services, and counseling, the following services must be provided by the hospice, either directly or under arrangements, to meet the needs of the patient and family. Physical and occupational therapy and speech-language pathology services. Hospice aid services. A hospice aide employed by a hospice, either directly or under contract, must meet the qualifications required by Section 1891A3 of the Act and implemented at 42 CFR 418.76. Homemaker services. Volunteers. Medical supplies including drugs and biologicals on a 24-hour basis, and the use of medical appliances related to the terminal diagnosis and related conditions. Short-term inpatient care including respite care and interventions necessary for pain control and acute and chronic symptom management in a Medicare/Medicaid participating facility, and continuous home care provided during a period of crisis. Nursing care may be covered on a continuous basis for as much as 24 hours a day during periods of crisis, as necessary to maintain the patient at home. 42 CFR 418.204A defines a crisis as the period in which an individual requires continuous care for as much as 24 hours to achieve palliation or management of acute medical symptoms. The care provided must require at least 8 hours of care in a 24-hour period, and the care must be provided predominantly by a licensed nurse RN, LVN, LPN. Homemaker or hospice aid services, or both, may also be covered if needed. Section 1861D-5 of the Act allows CMS to permit certain waivers of the requirements that the hospice make physical therapy, occupational therapy, speech-language pathology services, and dietary counseling available as needed on a 24-hour basis. CMS is also allowed to waive the requirement that hospices provide dietary counseling directly. These waivers are available only to an agency or organization that is located in an area which is not an urbanized area as defined by the Bureau of Census, and that can demonstrate to CMS that it has been unable, despite diligent efforts, to recruit appropriate personnel. These waivers are codified at 42 CFR 418.74. 2080 D.1 Hospice Interdisciplinary Group IGE. Hospices participating in the Medicare program must use an interdisciplinary approach to assessing and meeting the physical, medical, psychosocial, emotional, and spiritual needs of the hospice patients and families facing terminal illness and bereavement. The hospice IDG members include, but are not limited to, the hospice physician doctor of medicine or osteopathy who must be an employee of or under contract with the hospice, registered nurse, social worker, and pastoral or other counselor. The IDG is required to conduct a comprehensive assessment of the patient and update the assessment at required time points. In addition, the group, in consultation with the patient's attending physician, if the patient has one, must prepare a written plan of care for each patient that reflects patient and family goals and interventions based on the needs identified in the initial, comprehensive, and updated assessments. The plan of care must include all services necessary for the palliation and management of the terminal illness and related conditions. The attending physician may either be a doctor of medicine or osteopathy or a nurse practitioner. This person is identified by the individual at the time he or she elects to receive hospice care as having the most significant role in the determination and delivery of the individual's medical care. In the event that a beneficiary's attending physician is a nurse practitioner, the hospice medical director and / or physician designee must certify or recertify the terminal illness. Nurse practitioners cannot certify a terminal diagnosis or the prognosis of 6 months or less if the illness or disease runs its normal course, or recertify a terminal diagnosis or prognosis. The hospice IDG is responsible for developing and maintaining a system of communication, coordination, and integration of services that ensures that the plan of care is reviewed and updated no less frequently than every 15 calendar days. It is not permissible for either the attending physician or the hospice medical director to provide the sole guidance for the plan of care. The law and regulations require that it be the combined work of the IDG. Section 2081, Revoking Election of Hospice Care. The hospice patient or representative may revoke the patient's election of hospice care at any time during the election period, according to 42 CFR 418.28. Revocation is a voluntary action taken by the patient or representative. The election of the hospice benefit is the beneficiary's choice rather than the hospice's choice, and the hospice cannot revoke the beneficiary's election. It is important for the hospice to educate the patient and family before the start of care that hospice entails certain limits in the way care will be provided, including restrictions on obtaining care outside the care arranged for or provided by the hospice, and the patient's liability for care received without the hospice's involvement. The hospice should neither request nor pressure the patient / family or representative in any way to revoke his or her election. Section 2082, Discharge from Hospice Care. Once a hospice chooses to admit a Medicare beneficiary, it may not automatically or routinely discharge the beneficiary at its discretion, even if the care promises to be costly, inconvenient, or the state allows for discharge under state law. The situations under which a hospice may discharge a patient are addressed in the regulation at 42 CFR 418.26 and include the following situations. The patient moves out of the hospice's service area or transfers to another hospice. The hospice determines that the patient is no longer terminally ill, and the hospice determines under a policy set by the hospice for the purpose of addressing discharge for cause that the patient's or other person's in the patient's home behavior is disruptive, abusive, or uncooperative to the extent that delivery of care to the patient or the ability of the hospice to operate effectively is seriously impaired. The hospice must do the following before it seeks to discharge a patient for cause. Advise the patient that a discharge for cause is being considered. Make a serious effort to resolve the problem presented by the patient's or other persons in the patient's home behavior or situation. Ascertain that the patient's proposed discharge is not due to the patient's use of necessary hospice services, and document in the clinical record the problem and efforts made to resolve the problem. Prior to discharging a patient for any reason stated above, the hospice IDG must obtain a written physician's discharge order from the hospice medical director. If a patient has an attending physician involved in his or her care, this physician should be consulted before discharge, and his or her review and decision included in the discharge note. The hospice notifies its Medicare Administrative Contractor MAC and SA of the circumstances surrounding the impending discharge. The hospice should also consider referrals to other appropriate and / or relevant state / community agencies, i.e., adult protective services or healthcare facilities before discharge. Section 2083, Hospice Regulations and Non-Medicare Patients. The Hospice Co-PTCS apply to all patients of the hospice Medicare and non-Medicare, with the exception of the following regulations, which apply only to Medicare beneficiaries. 42 CFR 418.100D, the continuation of care requirement, and Section 42 CFR 418.108D, the 80 to 20 inpatient care limitation. In addition, the following co-PTCS regarding the certification and recertification of terminal illness are necessary to determine eligibility for Medicare and Medicaid patients, and may or may not be a requirement by other payment sources. 42 CFR 418.102C, Section 42 CFR 418.104A5, and Section 42 CFR 418.112 E3 Roman 3. Section 2084, Hospice Inpatient Services. Hospices must make inpatient care available for pain control, symptom management, and respite purposes. This inpatient care may be provided directly by the hospice or indirectly under arrangements made by the hospice. If services are provided under arrangements, the hospice must ensure that the services are in full compliance with all applicable standards relating to inpatient care found at 42 CFR 418.110 and 42 CFR 418.108. Section 2084A. Hospice provides inpatient care directly. When the hospice provides inpatient care directly, it may do so either in space that it owns or leases or in space shared with a Medicare-certified hospital, SNF, or Medicaid-certified nursing facility, NF. If the hospice provides care in its own inpatient facility, the care may be provided in space that the hospice either owns or leases from another facility or building. The inpatient unit may consist of several beds, a group of beds, or a wing, and must meet all applicable federal and state requirements, and be surveyed for compliance with 42 CFR 418.110 prior to providing inpatient care to patients. This survey includes a Life Safety Code survey, which has currently adopted the 2000 edition of the Life Safety Code of the National Fire Protection Association, that must be done both at the time of initial certification of the inpatient facility and at the time of recertification surveys. If the hospice provides care directly with hospice staff in space shared with a Medicare-certified hospital, SNF, or a Medicaid-certified NF for respite care only, the SA reviews the agreement and patient files for compliance with 42 CFR 418.110B and 42 CFR 418.110E, since the location already meets the remaining requirements of 42 CFR 418.110 as a Medicare/Medicaid participating facility. Section 2084B. Hospice provides inpatient services under arrangements. When the hospice provides inpatient services under arrangements with a Medicare participating hospital, or SNF, a Medicaid participating NF for respite care only, or an inpatient unit of another Medicare-certified hospice, a separate survey of each site is not required. In these cases, the SA reviews the agreement and patient files to assure that the standards in 42 CFR 418.110B regarding 24-hour nursing service and 42 CFR 418.110E regarding comfort and privacy of patient and family members are satisfied. However, if in reviewing contracts and other documentation, e.g., clinical records, plans of care, questions arise concerning the contract arrangements, the SA conducts an on-site visit to the institution providing the inpatient services to review the care provided under arrangements, not to inspect the facility. This includes hospitals that are accredited by the Joint Commission or the American Osteopathic Association that are providing inpatient services under arrangements. Applicability of inpatient care, Co. P. 42, CFR 418.110. Location, where inpatient care is provided hospice freestanding inpatient facility. Medicare-certified hospital, or SNF, and / or Medicaid certified NF for respite care only. Applicability of condition survey for compliance with 42 CFR 418.110. Survey for compliance with 42 CFR 418.110b and 42 CFR 418.110e. The institution already meets the remaining requirements of 42 CFR 418.110 as a Medicare/Medicaid certified hospital. A hospice freestanding inpatient facility is defined in this context as a facility that is not a part of another Medicare/Medicaid certified facility, e.g., hospital or SNF/NF. Section 2085. Operation of hospice across state lines. When a hospice provides services across state lines, each respective state agency must be aware of and approve the action. Each SA must verify that applicable state licensure, personnel licensure, and other state requirements are met in its respective state. The provision of services across state lines is appropriate in most circumstances. Areas in which community services, such as hospitals, public transportation, and personnel services are shared on both sides of state boundaries are most likely to generate an extension of hospice services. When a hospice provides services across state lines, it must be certified by the state in which its CMS certification number CCN is based, and its personnel must be qualified in all states in which they provide services. The appropriate SA completes the certification activities. The involved states must have a written reciprocal agreement permitting the hospice to provide services in this manner. The reciprocal agreement must indicate that both states are aware of their respective responsibilities for assessing the hospice's compliance with the COP within their state. The agreement should assure that home visits are conducted to a sample of all patients in all states served by the hospice. The CMS Regional Office RO will review the required reciprocal agreement between the states to assure that the SA, where the practice location resides, is assuming responsibility for any necessary surveys of the location. If the SAs are unable to come to a reciprocal agreement on assuring the necessary surveys of the location should not be approved as a part of the hospice. The provision of interstate service without a written reciprocal agreement could severely undermine the state's ability to fulfill its statutory responsibilities under Section 1864 of the Act to enforce Medicare's health and safety requirements. It is at the discretion of the states to decide whether entering into reciprocal agreements is in the best interest of their residents, provider markets, and quality assurance and oversight systems. Exhibit 289, Model Reciprocal Agreement Survey and Certification, contains a model reciprocal agreement document for states to use to assist them in fulfilling their statutory responsibility to enforce Medicare's health and safety requirements when a hospice provides services across state lines. In states that have a reciprocal agreement in place, providers are not required to be separately approved in each state. Consequently, they would not have to obtain a separate Medicare provider agreement/certification number in each state. Providers residing in a state that does not have a reciprocal agreement with a contiguous state are precluded from providing services across state lines. In the event that the hospice operates in two CMS ROs, the RO responsible for the state in which the hospice provider agreement/certification number is based should take the lead in assuring that the required survey and certification activities are met. Section 2086. Hospice change of address. It is inherent in the provider certification process that a provider notifies CMS of its intent to change the location or site from which it provides services. Absent such notification, CMS has no way of carrying out its statutorily mandated obligation of determining whether the provider is complying with applicable participation requirements at the new site or location. It is a long-standing CMS policy that there is no basis for a provider to bill Medicare for services provided from a site or location that has not been determined to meet applicable requirements of participation. This guidance is contained in Chapter 3, Section 3224 of Publication 100-07. When an existing hospice intends to move from its surveyed, certified location to a new site or location, it notifies CMS either directly or through the SA, and, if deemed, it notifies its approved National Accreditation Organization (AO) in writing of the proposed change of location. The provider also notifies its MAC and submits all required documentation, including an amended Form CMS 855A, before CMS approval can be granted. The provider obtains CMS approval of the new address before it provides Medicare services from the new address. Upon receipt of a provider's notice and request for approval of the move to the new site or location, the RO will carefully evaluate the information, together with any supporting documentation from the provider and any other relevant information known to the RO in making its decision. If a decision can be made on the written application and supporting documentation, CMS will grant or deny an approval without requiring a survey. If, however, the RO concludes that circumstances warrant a survey to establish whether the new address complies with all applicable requirements, CMS will advise the provider and will make no further findings until a survey has been completed and submitted to CMS for its review. In either event, CMS will notify the provider of its decision in writing, as appropriate. CMS generally will not approve a change of location of a primary hospice with one or more previously approved multiple locations if the new location increases the distance between the primary hospice location and its previously approved multiple location S, to a point that prevents the hospice from exerting the supervision and control necessary. Each multiple location to assure that all hospice care and services continue to be responsive to the needs of the patient/family at all times and in all settings. In that event, the application for approval of the new location would usually be denied without a survey, and the provider would apply for a new certification number for the new location. Request for approval of a proposed change of location of an approved multiple location is handled as a request for approval of a new multiple location, in accordance with the regulations and guidelines at 42 CFR 418.100F. Note: CMS will not approve a change of location for a hospice's own inpatient facility without a survey to assure that the facility meets all requirements specified at 42 CFR 418.110. Section 2086A, Effective Date. A hospice may not bill for services provided from the new site or location and should not bill Medicare until the new site or location has been approved by CMS. The effective date of coverage for services provided from the new location is the date CMS grants approval to the hospice's request to change locations. The fact that a national AO has approved a new site or location will not affect CMS decision. CMS determination will be based on its independent application of its regulations to the facts in the case. Services provided before the effective date of approval should not be billed to Medicare. Section 2086B, Administrative Review. CMS's decision on a request for approval of a change of address does not qualify as an initial determination subject to administrative review under 42 CFR 498.3. Such a determination does not affect the existing provider agreement, which continues in effect at the surveyed, certified location until voluntarily terminated by the provider pursuant to 42 CFR 489.52, or involuntarily terminated by CMS pursuant to 42 CFR 489.53. In the event approval of the new change of address is denied, the provider has the option of formally applying for initial certification of the new site or location as a separate Medicare provider of hospice services. In that event, an initial certification survey by CMS or the SA, or accreditation based on survey by a national AO with deeming authority, would be required. Section 2086C. Move after certification survey. Requests for initial certification cannot be processed to completion if a prospective provider moves to a new location after it is surveyed and or deemed to meet the co-PTCS by a national AO with deeming authority. If a prospective provider moves after its location has been surveyed and or accredited, but prior to a certification determination by CMS, the prospective provider's application for certification becomes incomplete. Absent a survey of the new location to which the prospective provider has moved, CMS is unable to determine whether applicable program requirements are met at the new location, and therefore is prevented from completing its review of the pending application. In these circumstances, CMS advises the prospective provider that its application is incomplete. Such an incomplete application is held in abeyance pending receipt of a report of survey of the current location from the SA or a national AO with deeming authority meeting the requirements of and approved by CMS. The decision to hold an incomplete application in abeyance does not qualify as an initial determination, as defined in 42 CFR 498.3. Section 2087. Simultaneous surveys. If a hospice is established by an entity which participates in the Medicare program as another type of provider hospital, SNF, HHA, the SA should attempt to coordinate simultaneous certification surveys of these entities, i.e., for compliance with hospice co-PTCS and for compliance with the other appropriate co-PTCS requirements. Note, Section 1860 1D-D4A of the Act states that if a hospice is approved as being part of another type of provider, with a separate certification number, it shall be considered to meet those co-PTCS that are common to both the hospice and the other type of provider. Section 2088. Multiple locations. When an existing hospice intends to add a multiple location, it must notify CMS, the SA, and, if deemed, it should notify its approved national AO, in writing, of the proposed location if it expects this location to participate in Medicare or Medicaid. The hospice must also submit a Form CMS 855, a change of information request, including all supporting documentation to its MAC, before CMS approval can be granted. The provider must obtain CMS approval of the new location before it is permitted to bill Medicare for services provided from the new location. Upon receipt of a hospice's notice and request for approval of a multiple location, the CMS RO will carefully evaluate the information, together with any supporting documentation from the hospice and any other relevant information known to the RO in making its decision. If a decision can be made based on the written application and supporting documentation, CMS will grant or deny an approval without requiring a survey. If, however, the RO concludes that circumstances warrant a survey to establish whether the new location complies with all applicable requirements, CMS will advise the provider and will make no further findings until a Medicare certification survey has been completed and submitted to CMS for its review. In either event, CMS will notify the provider of its decision in writing, as appropriate. In evaluating a hospice's request for approval of a multiple location, the SA and RO should consider the following in determining whether the new location meets all applicable Medicare requirements. Ability of the governing body to manage the location. Any changes made to the lines of authority and professional and administrative control. Ability of the medical director to assume responsibility for the medical component of the hospice's patient care at all locations. Ability of the hospice to monitor and exercise control over services provided by personnel under arrangements or contracts at the multiple location. Changes in the IDGS providing hospice services. Changes in staffing or the client population, or both. Changes in the way clinical records are maintained, protected and safeguarded against loss, destruction, or unauthorized use, and ability of the hospice to provide all hospice services at the multiple location. A hospice may not bill Medicare for services provided from a multiple location until the new site or location has been approved by CMS. The fact that a national AO with deeming authority has approved a new site or location will not affect CMS decision. CMS determination will be based on its independent application of its regulations to the facts in the case. Services provided before the effective date of approval should not be billed to Medicare. If the hospice does operate at multiple locations, a deficiency found at any location will result in a compliance issue for the entire hospice. For further information on hospice multiple locations, see 42 CFR 418.100F and 418.116. Section 2089. Survey requirements when the hospice provides care to residents of a SNF/NF or ICF/IID. When a SNF or NF is the hospice patient's residence for purposes of the hospice benefit, the SNF or NF must comply with the requirements for participation in Medicare or Medicaid. The Medicare/Medicaid regulations for long-term care facilities regarding the completion and submission of the Resident Assessment Instrument/minimum data, set RISE/MDS data, do not change when the resident elects the Medicare hospice benefit. This means the SNF or NF must assess the hospice resident using the RAI and have a care plan and provide the services required under the plan of care. This can be achieved through cooperation between the hospice and facility staff with the consent of the resident. In these situations, the hospice IDG should participate with the facility in completing the RAI. Similarly, the SNF/NF must complete the RAI for any hospice patient who receives short-term inpatient care in a Medicare/Medicaid participating SNF/NF if the hospice patient resides in the facility for more than 14 days. For further information on the hospice requirements when it provides care in these settings, see 42 CFR 418.112. Intermediate care facilities. Section 2130. ICF/EID, Citations and Description. Section 2130A, Citations. An ICF/IID is defined in Section 1905D of the Act. The ICF/IID co-PTCS appear in 42 CFR Part 483 Subpart I. Regulatory requirements for ICF/IID services, which appear in 42 CFR 435, Subpart K Federal Financial Participation, and Part 440 Subpart A definitions, augment the co-PTCS. Section 2130B, Definitions. An ICF/IID is an institution that meets federal co-PTCS and has as its primary purpose the provision of health or rehabilitation services to individuals with intellectual disabilities or related conditions receiving care and services under the Medicaid program. The ICF/IID co-PTCS recognize the developmental, social, and behavioral needs of individuals with intellectual disabilities who live in residential settings by requiring that each individual both require and receive active treatment for the ICF/IID care to be eligible for Medicaid funding. Active treatment means the aggressive, consistent implementation of a program of specialized and generic training, treatment, health, and related services directed toward the acquisition of the behaviors necessary for the individual to function with as much self-determination and independence as possible. It includes the prevention or deceleration of regression or loss of current optimal functional status. An injury should be reported as an injury of unknown source when 1. The source of the injury was not witnessed by any person, and the source of the injury could not be explained by the client, and 2. The injury raises suspicions of possible abuse or neglect because of the extent of the injury or the location of the injury, e.g. The injury is located in an area not generally vulnerable to trauma or the number of injuries observed at one particular point in time, or the incidence of injuries over time. The definition of immediately means there should be no delay between staff awareness of the allegation and reporting to the administrator or other officials in accordance with state law, unless the situation is unstable at the time the allegation comes to the attention of the staff. In this case, reporting should occur as soon as the safety of all clients is assured and all necessary emergency measures have been taken. Section 42, CFR Section 483.42, 0D2 of the ICS/IID regulations, addresses the obligation of the facility staff to report allegations of mistreatment, neglect, or abuse, and injuries of unknown source immediately to the administrator of the facility or to other officials in accordance with state law through established procedures. An injury should be reported as an injury of unknown source when 1. The source of the injury was not witnessed by any person, and the source of the injury could not be explained by the client, and 2. The injury raises suspicions of possible abuse or neglect because of the extent of the injury or the location of the injury, e.g. the injury is located in an area not generally vulnerable to trauma, or the number of injuries observed at one particular point in time, or the incidence of injuries over time. It is important to note that members of the ICF/IID population are a mobile population and lead active lives. Therefore, they experience normal day-to-day bumps and minor abrasions as they go about their lives. These minor occurrences, which are not of serious consequence to the individual and do not present as a suspicious or repetitive injury, as discussed above, should be recorded by the facility staff once they are aware of them, and follow-up should be conducted as indicated. For injuries that do not rise to the level of reportable injuries of unknown source, the facility should follow its policies and procedures for incident recording, investigation, and tracking. 42 CFR Section 483.42, 0D2, further requires that allegations of mistreatment, neglect, or abuse and injuries of unknown source must be reported immediately to the administrator or to other officials in accordance with state law through established procedures. For the purpose of this regulation, immediately means there should be no delay between staff awareness of the allegation and reporting to the administrator or other officials in accordance with state law, unless the situation is unstable at the time the allegation comes to the attention of the staff. In this case, reporting should occur as soon as the safety of all clients is assured and all necessary emergency measures have been taken. This reporting must be done on a 24/7 basis. Conformity with this definition will necessitate that the facility administration have procedures in place to receive reports, even on off-duty hours, e.g. electronic mail, answering machine, voicemail, and fax. It is critical that the administrator, as designated by the governing body under 42 CFR Section 483.410A23, be notified of such occurrences as quickly as possible to ensure the safety of all residents. There must also be evidence that the information was received in a timely manner by that facility administrator. When the administrator is not on duty, the facility policies and procedures should detail who, either by name or title, will be acting in the administrator's absence. The person acting for the administrator must have the authority to immediately take whatever corrective action is necessary to ensure client health and safety. For example, if an employee is to be removed from client contact pending an investigation, the acting administrator must have the authority to take this action without approval from another official. CMS expects that such reporting is always made to the administrator of the facility, unless the administrator is suspected to be involved in the mistreatment, neglect, or injury, and that the administrator then ensures that the appropriate state officials are notified. In any instance where a staff member is concerned that the administrator of the facility may have been involved in an incident of mistreatment, neglect, abuse, or injury, The staff member should follow the facility policy for reporting to the appropriate person above the level of the administrator. The facility should have a written policy that directs the staff in these situations. Section 2134, Distinct Part ICF/IID. Neither the law nor federal regulations define or require ICF/IID services in terms of distinct parts. However, as a state Medicaid program requirement, states may provide for distinct part ICF/IID approvals. Where the SMA elects to define the ICF/IID program in terms of distinct parts, these additional federal provisions must be met. The distinct part must be a clearly identified unit, such as an entire ward, wing, floor, building, or a number of designated rooms. The distinct part consists of all beds and related facilities in the unit, and the institution does not need require transfer of patients or individuals to or from the distinct part, where, in the opinion of the attending physician, transfer might be harmful to the physical or mental health of the patient or individual. Otherwise, the unit houses all ICF/IID residents in the institution. Section 2138, Approval Procedures for ICF/IID. Section 2138A, Initial Certification of ICF/IID. Initial certification of ICF/IID may be granted by the SA only as a result of a complete survey which has found the agency to comply with all of the co-PTCS specified in 42 CFR 483, Subpart I. A facility must be operational prior to scheduling an initial survey. Even though a facility may be part of a larger corporation, the fact that it is separately certified means that it is an independent institution and must be capable of providing all of the services necessary to meet the client's needs. Therefore, the survey of each separately certified ICF/IID must ensure that any evidence used in the determination of compliance for the requirements stands on its own. A facility may request that the SA review relevant aspects of its existing immediate track record as part of the initial survey process if the following is true. A facility must have been fully operational as a licensed group home or a distinct part that was never certified because of physical plant limitations, yet it provided treatment comparable to that required by a certified ICF/IID. For example, if the entity claims that it has provided active treatment to the same clients who will be certified, with the same staff, and consistent with the components of active treatment described in the federal regulations, then an initial survey may be scheduled immediately. To the extent that a survey determines that the agency's current and immediate past practices comply with the ICF/IID requirements, the SA surveyor may utilize this information in making a compliance determination as part of the survey, but not as a substitution for the survey. There is no specific number of days that an ICF/IID must be operational prior to its initial survey, but in most cases, approximately 30 to 35 days, except as described above, would be a general safety measure. This timeframe, however, is only a recommendation since 42 CFR Part 483.44, 0C4, only requires that the client's initial individual program plan IP must be developed within 30 days after admission. 42 CFR Part 483.440D1 requires that as soon as the IPP is developed, each client receives a continuous active treatment program. Therefore, should the facility wish to have its initial survey prior to being operational for 30 to 35 days, it should identify the date by which it will be able to demonstrate its compliance with 42 CFR Part 483.440A for each of its clients. Additionally, for an initial survey, a facility may not demonstrate its compliance with active treatment based primarily on its policies and procedures. Policies and procedures are designed to describe how a facility intends to provide active treatment. This is inconsistent with Section 1905D2 of the Act, which requires that each individual with intellectual disabilities for whom a request for payment is made is receiving active treatment. For purposes of the initial survey of an agency in which clients have just moved to the agency, the following key components of the active treatment process that are most relevant to the survey methodology for the COP Active Treatment Services Data Tag W195. Appendix JR. The Comprehensive Functional Assessment, 42 CFR Part 483.440C3. The IP 42 CFR Part 483.440C4. Program Implementation, 42 CFR Part 483.440D. And Program Documentation, 42 CFR Part 483.440E. It would not be necessary to measure the component of active treatment dealing with program monitoring and change 42 CFR Part 483.440F, unless it is determined through the survey that the initial program clearly does not meet the client's needs, and there is no evidence of appropriate oversight and attention. Section 2138B. Multiple certification of dispersed locations. When surveying ICF/IID with more than one unit at dispersed locations, either for an initial certification or recertification, the SA surveys each unit. Even if a group of small ICF/IID is centrally administered, the SA prepares a certification package for each unit. Section 2138C. Minimum size of ICF/IID. An ICF/IID is defined as a facility that furnishes food, shelter, treatment, or services to 4 or more individuals unrelated to the proprietor. ICF/IID vary in size from very large multi-unit, multi-level facilities with sophisticated programs to very small, home-like settings with required services provided through an arrangement with community organizations. Satellite facilities off the main grounds of an institution are certified as separate ICF/IID. Each must meet the 4-individual minimum. Notwithstanding common ownership or unified administration, a cluster of separate facilities in the community cannot be considered as one establishment meeting the definition of institution. Separate cluster facilities in the community must be viewed as separate establishments. Each must meet the 4-individual minimum to qualify as an institution. An individual living unit that is part of an overall ICF/IID may be separately certified under its own provider number if the living unit meets the criteria for a freestanding ICF/IID. Each separately certified facility, at any point in time, must be able to independently meet all standards and co-PTCS. This includes, among other things, maintaining independent staffing and management. Any services which are not provided directly by the separately certified facility would have to be provided through a written agreement with outside sources as required by 42 CFR Part 483.410D. It is unlikely that, for example, a facility with several units housed within one building sharing common corridors and utilizing a common kitchen/dining area could meet the requirements for maintaining independent staffing and management to meet the criteria for a freestanding ICF/IID. There is no minimum number of individuals who must be in residence at the time of the initial survey. The facility must have enough individuals in residence to demonstrate that it is able to, and does in fact, provide services to the total number of individuals it proposes to serve. For example, a facility established to serve 4 individuals would need to show capacity to serve 4 people, even though not all 4 people would be required to have actually moved in at the time of the initial survey. 42 CFR Part 435.1009B2 requires that a facility serve a minimum of 4 persons in order to meet the definition of an institution. Section 2138D. Interpretive Guidelines for ICF/IID. Guidelines for surveying ICF/IID are located in Appendix J. They provide an Interpretation of the ICF/IID regulations that are applicable to all sizes of facilities that provide services. They focus on individual and staff performance rather than on compliance with process and paper requirements, and reflect current philosophies and practices in training individuals with intellectual disabilities and related conditions. Section 2138E, Survey Report Form CMS 3070 GI. To survey ICFs/EID, the SA must use the interpretive guidelines and survey procedures, see Appendix J, in conjunction with Forms CMS 3070 GI. The forms and optional worksheet permit the SA to summarize pertinent facility, individual, and survey data, record observations about active treatment provided for individuals by staff, and summarize deficiency-related data on the standards and co-PTCS. In an effort to monitor the number of allegations of abuse and neglect investigated, and the number of deaths related to restraints and unusual incidents, CMS revised Form CMS 3070G, the ICF/IID survey report form, to now include an item M, allegations of abuse and neglect, to capture this information. All surveys, including initials, recertifications, complaints, and follow-ups, occurring after January 2, 2002, must be entered into the online survey and certification system OSCAR. Section 2138F, Application of LSC to ICFs/IID of 16 beds or less. When conducting a LSC survey, the SA applies the appropriate occupancy Chapter C Appendix I of the LSC of the National Fire Protection Association NFPA, 2000 edition. Section 2138G, Schedule for Recertification. The SA completes a recertification survey an average of every 12 months, and at least once every 15-month see Section 2141. Section 2139, Assessment of ICFs/IID based on co-PTCS for active treatment. To be certified as a Medicaid provider of ICF/IID services, a facility is required by Section 1905D of the Act to provide active treatment services for each individual for whom payment is claimed. Federal regulations in 42 CFR Part 435.1009 and 483, Subpart I outline the requirements for active treatment in ICFs/IID. While a facility must comply with the co-PTCS to be certified, the SA must place particular emphasis on an assessment of whether active treatment is in fact received by individuals for whom payment is claimed. Appendix J contains a basic methodology for surveying these requirements. The definition of active treatment in intermediate care facilities for individuals with intellectual disabilities in 42 CFR Part 435.1009 refers to treatment that meets the requirements specified in the co-PTCS for active treatment in 42 CFR Part 483.440A. The components of the active treatment process most relevant to this survey methodology are Section 2139A, Comprehensive Functional Assessment. Within 30 days of admission, the individual's interdisciplinary team must produce accurate comprehensive functional assessment data that identifies all her/his present problems and disabilities. Also, when possible, their causes, specific developmental strengths and needs, behavioral management needs, and the need for services without regard to the availability of those services. 1. Money Management Program. Citing deficiencies. Surveyors currently cite a deficiency during the ICF/IID survey process if every client in the facility does not have a formal money management program in place. Regulatory provisions. The regulations at 42 CFR 483.42 0A4 state that clients in the ICF/IID must be allowed to manage their financial affairs and be taught to do so to the extent of their capabilities. Determination of compliance. The determination as to the appropriateness of a formal money management program for an ICF/IID client is based upon the results of a comprehensive functional assessment and a consensus by the interdisciplinary team. The need for a formal money management program must be addressed in every client's IPP by the IDT on an annual basis. The determination of the appropriateness of a formal money management program is made by the IDT and must be based upon a CFA. The IDT discussions resulting in that determination must be established through documentation in the client's IPP. Surveyors will question and cite any IDT team decision that a formal money management program is not appropriate when the client clearly exhibits, and the CFA supports the skills needed to implement such a program. 2. Self-administration of medications. It has been the expectation of ICF/IID surveyors, pursuant to previous Centers for Medicare and Medicaid Services interpretations of Section 483.460K4, that every client residing in an ICF/IID must participate at some level in a formal self-administration program for medications. Regulatory requirement for self-administration programs. There is no regulation that requires every client to have a formal self-administration program for medications. The appropriateness of such a program for a client is determined by the interdisciplinary team in consideration of the comprehensive functional assessment data. Regulatory requirement for those clients not in self-administration programs. The concept of continuous active treatment at Section 483.440D1 requires that the facility utilize the time during medication administration by staff as a teaching opportunity for clients who have formal training programs for the development of skills that are transferable to the drug administration process. Self-administration of medication refers to the intentional, independent application or ingestion of over-the-counter or prescribed medications by an individual without assistance, instruction, or direction. The regulation at Section 483.460K4 requires the interdisciplinary team to develop and implement training objectives for individuals determined to be appropriate for self-administration of medications unless the client's physician specifies otherwise. The interdisciplinary team must determine, based on comprehensive assessment, whether an individual possesses or has the potential to develop the requisite skill set needed to safely self-administer medications and individually tailor training objectives to advance the individual toward the goal of self-administration. 483.460K4 does not require that all individuals in an ICF/IID be engaged in self-administration training programs. The interdisciplinary team decision that a self-administration program is appropriate, as is the case for all formal training objectives, must be based upon accurate, current, valid assessment of the individual's skills and potential. The determination as to the appropriateness of a self-administration program must never be made singularly on the individual's diagnosis or current functional abilities. For individuals assessed to be inappropriate for a self-administration program, but determined by the interdisciplinary team to possess the capacity to functionally, cognitively, emotionally, or developmentally benefit from participation in the drug administration process. It is expected that the facility will provide opportunities for the client to participate in the medication administration process under direct supervision. This participation can include, but is not limited to, identifying the medication taken, reaching/grasping a cup of water during the process, and placing oral medications in the mouth, etc. During drug passes, observe whether clients are offered the opportunity to participate consistent with their functional skill level, and verify that the programs are being carried out consistently and in accordance with the written objective. For individuals not in need of formal self-administration programs, who are not provided opportunities to participate in administration process, Cite a deficiency at section 483.44, 0C6 Roman 6. If, as a result of observations and interviews, there are any concerns as to why a client is not on a formal program, the surveyor should review the associated assessments and interdisciplinary discussions. During this review, look for evidence that the interdisciplinary team documented a justification as to why the client was not appropriate for a formal self-administration program, and that the justification provided was based on an evaluation of the assessment results. Deficiencies for a failure by the facility to properly assess, to develop written self-administration objectives, or to carry out the self-administration programs consistently should be cited at section 483.460K4. Section 2139B, Individual Program Plan IP. The individual's interdisciplinary team must prepare an IPP which identifies the discrete, measurable, criterion-based objectives the individual is to achieve, the timetables for expected mastery, and the specific individualized program of specialized and generic strategies and techniques to be employed. The IPP must be directed toward the acquisition of the behaviors necessary for the individual to function with as much self-determination and independence as possible, and the prevention or deceleration of regression or loss of current optimal functional status. Section 2139C, Program Implementation. Each individual must receive continuous active treatment consisting of needed interventions and services in sufficient number and frequency to achieve the IPP objectives. Each individual's IPP must be implemented by all staff working with the individual, except where only licensed personnel may implement certain areas of the program. Section 2139D, Program Documentation. Accurate, systematic, behaviorally stated data about an individual's performance toward meeting the criteria in the IPP objectives must be documented and serve as the basis for changes and revisions whenever necessary. Section 2139E, Program Monitoring and Review. At least annually, the comprehensive functional assessment of each individual is reviewed by the interdisciplinary team for relevancy and updated as needed. The IPP is revised as appropriate. The IPP must also be reviewed by a qualified intellectual disabilities professional and revised as necessary. Approximately one-third of the ICF/IID Co. PTCS 42, CFR Part 483, Subpart I deals with the sufficiency and adequacy of staff to deliver each service. The regulations provide guidance about what constitutes active treatment and enable the SA to assess these. Standards from the standpoint of whether active treatment is being provided in a consistent and aggressive manner. SA entries on both Forms CMS 3070 GI and Form CMS 2567 should reflect this approach. Of greatest importance in determining if active treatment is being provided is whether the facility provides competently trained staff of all types and at all levels who, in fact, do implement individually identified objectives established for each individual. A correct certification addresses these objectives in terms of whether the services are being delivered to each individual, whose IPP indicates that they are needed, and whether adequate staff and facilities are engaged in furnishing them. A certification which affirms no more than that the services, staff, and facilities are available is incorrect and unacceptable. A provider agreement may be held invalid under 42 CFR Part 483.440A of the Co. PTCS if the regulation is not correctly applied. If a facility has the necessary resources available, but does not actually provide active treatment to individuals in accordance with identified needs, or does not conduct the comprehensive functional assessment evaluations to identify individuals' needs, the SA denial, non-renewal, cancellation, or termination of the agreement is supportable. The SA carefully explains the deficiency in the SA Notice of Determination. Section 2140. Waiver and / or variance of ICF/IID requirements. Section 2140A. ICF/IID room size and occupancy. No waivers are available to an ICF/IID to change the square footage requirements for bedrooms. 42 CFR Part 483.470b allows as little as 80 square feet for individual bedrooms and 60 square feet for multiple individual bedrooms. However, the SA may grant a variance to the requirement in 42 CFR Part 483.470b Roman 3 of no more than 4 individuals per room, if a physician who meets the qualifications for a qualified intellectual disabilities professional in 42 CFR Part 483.430a, and is also a member of the individual's interdisciplinary team has justified, in each IPP, the following: how the individual is so medically impaired as to require direct and continuous monitoring during sleeping hours, whether the individual is on a medical care plan, as described in 42 CFR Part 483.460A2. The extent of life support services needed to meet the individual's medical needs, and the specific reason why housing the individual in a room of 4 or fewer individuals would not meet the individual's medical needs. The variance must not adversely affect the health or safety of the individual. The variance must assure that the minimum square footage requirements specified in 42 CFR Part 483.470b have been met. The variance expires unless renewed each time the ICF/IID is certified. It is not meant to justify the long-term continued use of open wards or nominally partitioned wards for housing individuals. The only acceptable reason for individuals being housed in bedrooms serving more than 4 individuals is that the individual is in very fragile health and needs extensive life support services, such as posturing for clearing the airway, monitoring for uncontrolled seizures, etc. Each individual placed in the grouping must have such a high level of medical monitoring need as to require supervision, which is possible only through the use of bedrooms housing more than 4 individuals. Section 2140b. Waiver of LSC. See Section 2472. Section 2141. Recertification ICF/IID. The regulation at Section 442.15 provides that provider agreements for ICF/EIDs would remain in effect as long as the facility remains in compliance with the conditions of participation COPS. Regulations at Section 442.109 through Section 442.111. Beginning on May 16, 2012, ICF/EIDs are no longer subject to time-limited agreements. However, they are to be surveyed for recertification an average of every 12 months and at least once every 15 months. If during a survey the survey agency finds a facility does not meet the standards for participation, the facility may remain certified. If the survey agency makes 2 determinations, the facility may maintain its certification if the survey agency finds immediate jeopardy doesn't exist, and if the facility provides an acceptable plan of correction. An ICF/IID may be decertified under procedures outlined in Section 3012 of the State Operations Manual. More specifically, a facility may be decertified if an immediate jeopardy finding remains unabated after 23 days, or if it fails to regain compliance with conditions of participation after 90 days. ICF/EIDs will be subject to survey an average of every 12 months and at least every 15 months, the same period that is applied to nursing homes. If a survey agency finds a facility deficient in meeting the standards for ICF/IID, as specified under Subpart I of Part 483 of Chapter 42, the agency may continue certification of the facility for Medicaid purposes as long as the agency finds that facilities' deficiencies do not constitute immediate jeopardy or seriously limit the facility's capacity to provide adequate care. In addition, The agency must find the facility's plan of correction is acceptable. The survey agency may conduct a revisit to assure the conditions for continued certification are maintained. A facility's certification may be terminated according to procedures set out in Section 3012 of the State Operations Manual. Section 2142. Evacuation drills for ICFS/IID certified under the Life Safety Code, NFPA 101, 2000 edition. Self-evacuation during an emergency. Clients residing in ICFS/IID certified under Chapter 32/33 of the Life Safety Code, NFPA 101, 2000 edition LSC are expected to be capable of self-evacuation during an emergency. Full evacuation drills. All drills under this chapter must be full evacuation drills unless the facility is designated as evacuation capability. Impractical. Exceptions to full evacuation drills with a designation of evacuation capability. Impractical. The facility must meet the requirements of Chapter 18/19 of the LSC as regards to evacuation drills. ICF/IID facilities that are certified under Section 32.7.3 or Section 33.7.3 of the LSC must conduct emergency drills no less than six times per year on a bi-monthly basis. These drills must all be full evacuation drills, and all clients residing in the facility must participate in each drill. At least 2 of these drills must take place during sleeping hours. This requirement is consistent with the requirements of 42 CFR 483.470I2I, which require actual evacuation of clients during at least one emergency drill each year on each shift. ICF/IID facilities certified under Section 32.7.3 or Section 33.7.3 of the LSC with a capability classification of impractical must meet the emergency drill requirements found at Section 18.7 or Section 19.7 of the LSC. These sections require that the facility conduct fire drills, which simulate emergency fire conditions, on a quarterly basis. Since these drills are conducted to train staff rather than clients, the code does not require full evacuation. However, the facility must also meet the ICF/IID regulations at 42 CFR 483.470I2I, which do require the actual evacuation of clients during at least one emergency drill each year on each shift. These drills are conducted primarily to prepare and train staff, and it is critical that the staff from each shift participate in these drills. The facility may not elect to conduct night shift drills during another shift. The LSC requires that the facility make the determination of impractical utilizing the criteria of the code found in Sections 32/33.2.1.2.2 concerning the characteristics of the client population. The LSC surveyor verifies that the determination was correctly made at the time of the annual survey. The requirements of full evacuation during a drill is not intended to address the requirements for frequency of evacuation drills. The regulation at Section 483.470I requires that evacuation/fire drills be conducted at all ICF/IID facilities on a quarterly basis on each shift. This requirement supersedes the number of evacuation drills required by the LSC under Chapters 32/33. It does not impact the requirements for full evacuation during such drills. Section 2143. The use of video cameras in common areas in ICF/IID. Use of video cameras in ICF/IID. To ensure that clients' rights are protected, the use of video cameras in the ICF/IID must be reviewed, approved, and monitored by the specially constituted Committee SCC of the facility, as constituted per 42 CFR 483.440F3I Roman 3. Informed consent. If approved by the SCC, written informed consent must be obtained from every affected client or designated guardian prior to the implementation of video cameras. Video cameras may be used in common areas within the ICF/IID facility. Prohibitions. Video cameras may never be used for any reason in areas where there are the highest expectations of privacy, such as bathrooms, areas for private visitation, or areas for private phone calls. Video cameras may not be used as a substitute for or supplement to adequate staffing or supervision protocols. The cost of the video cameras must be incurred by the facility and not the clients. The Condition of Participation section 483.420 requires that the facility must ensure the rights of all clients. Specifically, the facility must ensure that clients are not subjected to physical, verbal, sexual or psychological abuse or punishment section 483.420A5. Provide each client with the opportunity for personal privacy and ensure privacy during treatment and care of personal needs section 483.420A7. And ensure clients the opportunity to communicate, associate, and meet privately with individuals of their choice section 483.420A9. The above referenced regulations do not unilaterally prohibit the use of video cameras within the ICF/IID. There may be instances where the use of video cameras may be helpful in ensuring that the clients are free from physical, verbal, sexual, or psychological abuse, mistreatment, or punishment. However, great care must be exercised to prevent any unintended violation of an individual's rights and privacy when such equipment is used in the facility. Consistent with the regulations, which require that the ICF/IID provider protect the privacy and rights of the clients in the facility, video cameras may only be used in the common areas or shared spaces of the ICF/IID where clients have lower expectations of privacy, and where, in the normal course of their day, they may encounter visitors, staff, other clients, or medical personnel. Conversely, video cameras may never be used in areas where the clients have the highest expectations of privacy, such as client bathrooms, or areas where residents meet privately with visitors or make personal phone calls. To ensure that any use of video cameras complies with regulatory requirements that client rights are fully protected, any use of video cameras in the ICF/IID must be approved by the specially constituted committee SCC of the facility, as constituted per section 483.440F3. Affected clients and their families or guardians must be informed of the SCC's approval to use video cameras in a specified area. Written informed consent must be obtained from every client or designated guardian living in the physical unit prior to the implementation of video cameras. If an ICF/IID consists of several physically separate living units, and the clients and guardians, if applicable, of a single unit, have consented to the implementation of video cameras, it is not required that the clients residing in the other units and their guardians, as applicable, provide informed consent, since they would be considered guests when visiting this unit. However, the facility administration should still inform all clients living on the grounds and their guardians, if applicable, that camera use is in place on this specific unit. To ensure the confidential use of the camera recordings, the facility must have policies and procedures in place that A. Limit who has access to video viewing or use of the videos. B. Ensure that all staff with video viewing access are properly trained in the facility policies and the protection of client rights. And C. Ensure that adherence to the facility policies is monitored and that risks or breaches of the facility policies are promptly addressed. The ICF/IID may not utilize video cameras in lieu of adequate staffing or supervision protocols. The use of video cameras must not replace or otherwise substitute for trained and available direct care staff at a sufficient level to provide active treatment and ensure client safety. The ICF/IID must incur the entire cost of any video camera usage in the facility. Clients or their families may not be charged. Spell of illness certifications. Section 2160. Purpose of certifying. Section 1861E1 and 1819A1 of the Act status of hospitals and SNFs. Section 2160A. Benefit period provision. A Medicare beneficiary is limited to a specific maximum number of days of covered inpatient hospital care and covered post-hospital extended care in a SNF within a period of time known as a spell of illness or benefit period. Once these benefit days have been used, additional benefit days are not available until the spell of illness ends and a new benefit period begins. Section 1861A of the Act defines the term spell of illness and states that to end a spell of illness, a beneficiary must not have been an inpatient of any hospital, as defined in Section 1861E1 of the Act, or a resident of a facility described in Section 1819A1, formerly Section 1860, 1J1 of the Act, for 60 consecutive days. Note, Section 1819A1 of the Act's basic definition of a SNF for spell of illness purposes was formerly contained in Section 1860, 1J1 of the Act. Thus, a reference to Section 1860, 1J1 of the Act in older material should be read as a reference to Section 1819A of the Act. Therefore, to enable beneficiaries, providers, and intermediaries to ascertain eligibility for additional benefits, classify institutions to which a beneficiary may have been removed on the basis of whether the institutions meet the Section 1861E1 or 1819A definitions. 2160B, defining Medicare-eligible individuals. Home, for purposes of durable medical equipment DME and home health benefits. Sections 1861S6 and 1861N of the Act provide that purchase or rental of DME such as iron lungs, oxygen tents, hospital beds, or wheelchairs may be covered under Part B of the Medicare program if used in the patient's home. Similarly, home health benefits can be paid for certain services that are furnished in a patient's home. An institution that meets the requirements of Section 1861E1 or Section 1819A1 of the Act cannot be considered a patient's home for purposes of this benefit. If a facility is certified as a hospital, a Medicare SNF, or any other facility that meets the requirements of Section 1861E1 or Section 1819A1 of the Act, it is not considered the patient's home. Therefore, the institution's Section 1861E1 or Section 1819A1 status is used for these purposes also. Section 2160C, defining institution for ambulance benefit. Another use of Section 1861E1 or Section 1819A1 of the Act's definitions is to help determine whether ambulance benefits can be paid. The benefit requires that transportation be to or from an institution, i.e., other than the patient's home. Section 2162, defining hospital for spell of illness, DME, and home health benefit purposes. The term hospital, as used in Section 1861E of the Act and state licensure laws, has a generally accepted meaning that is seldom questioned. A problem arises, however, with respect to distinct parts of hospitals that render types of care other than hospital care, e.g., LTC. For example, a hospital may have separate wings or buildings for services ranging from residential to skilled nursing services. The SA evaluates these non-hospital parts in terms of whether they meet the definition of hospital in Section 1861E1 of the Act. The SA also states whether these parts meet the definition of skilled nursing facility in Section 1819A1 of the Act. Although a psychiatric hospital is precluded from participating in the Medicare program as a SNF, the spell of illness test is applied to such institution, and any non-hospital portions must be certified for spell of illness purposes. Section 2164, when to make spell of illness certification. It is not necessary that the SA makes Section 1861E1 or Section 1819A1 determinations for Medicare-certified hospitals or Medicare-certified SNFs. Section 1861E1 of the Act contains a basic definition that all hospitals meet. Similarly, Section 1819A1 of the Act contains the statutory definition of a SNF, which is the basis for Medicare certification requirements of SNFs in 42 CFR 483, Subpart B. In many states, licensing laws for all nursing homes have incorporated the requirements of Section 1819A or Section 1919A of the Act or the criteria contained in Section 2166. When this is the case, any nursing home licensed in such states cannot be considered a residence home for purposes of spell of illness, DME, ambulance, and HHA benefits. In other states, it may be necessary for the SA to make Section 1861E1 or Section 1819A1 certifications, as appropriate in the following instances. Non-participating parts of newly certified Medicare, distinct part SNFs. Non-participating parts of Medicare SNFs that change from complete to distinct part certifications, or that change the size or location of the participating distinct part. Terminated, denied, or withdrawn Medicare SNFs. New institutions offering any level of nursing care or rehabilitation which do not intend to participate in Medicare. Changes in the Section 1819A1 status of facilities that come to the SA's attention through licensure, surveys, or other means, and parts of hospitals providing patient care but not rendering hospital services. Routine periodic recertifications of spell of illness requirements are not required. Section 2166. Criteria for certifying Section 1819A1 of the Act status of LTC facilities other than SNFs. As indicated above, SNFs meet Section 1819A1 requirements, as do LTC facilities in states where licensure laws require it. In other situations, a facility or a part of a facility meets the standards set forth in Section 1819A1 of the Act for purposes of determining spell of illness status if it meets each of the following. See Exhibit 10, Form CMS 1539, A. Certification and transmittal for spell of illness determination. Section 2166A. Nursing services. Nursing services are provided under the direction or supervision of one or more RNs or licensed practical or vocational nurses, without regard to whether the facility has the nurse staffing requirement waived. The SA considers this condition met even if the nurse is also the administrator of the facility or is employed on a part-time basis. Section 2166B. 24-hour nursing services. Nursing personnel are on duty 24 hours a day. The term nursing personnel includes RNs, licensed practical or vocational nurses without regard to whether they are waived, practical nurses, student nurses, nurse aides, and orderlies. Section 2166C. Nurse bed ratio. The number of full-time equivalent nursing personnel to the number of beds is not less than an average ratio of 1 to 15 per shift. Note, generally, there will be a close equivalency between the number of beds and the average number of patients in an institution. When circumstances indicate a significant discrepancy in these factors, the ratio of nurses to the average patient census should be used in certifying Section 1819A1 status. A facility that has 3 8-hour shifts must have a minimum of the equivalent of 3 full-time nursing personnel during a 24-hour period for each 15 beds. It is not necessary that the 1 to 15 ratio be maintained for each shift, but the average of all shifts must be at least 1 to 15. In determining the ratio, the SA counts nurses who are also administrators as nursing personnel. Section 2166D. Other services. Bed and board are provided to inpatients in connection with the furnishing of nursing care, plus one or more medically related health services such as physician services, physical, occupational or speech therapy, diagnostic and laboratory services, and administration of medication. social, diversional, or recreational services provided by the institution are not considered medically related health services. Section 2168. Additional development required for spell of illness certifications. Ordinarily, the SA has sufficient information available in certification, licensure, welfare, or other records to certify the spell of illness status of an institution under the rules and criteria set forth in the previous sections. If the facility assigns staff specifically to separate patient care units, the SA records separate data for each such unit on the appropriate survey report, i.e. Page 12 of Form CMS 1537 for hospitals or Form CMS 671 for LTC facilities, identifying the location of the units or the room numbers of each unit. A. Additional development. Where existing records are inadequate, the SA uses any reliable method, e.g., letters and phone calls to obtain additional evidence to determine spell of illness status. If any doubts exist, the SA visits to verify. B. Institution consists of single building. If an institution consists of a single building, the SA completes separate spell of illness determinations for the non-participating partes of the institution. C. Institution consists of more than one building. If an institution consists of more than one building, the SA completes separate spell of illness determination for the non-participating parts of the institution in each building. Home Health Agencies, HHA. Section 2180. HHA, Citations and Description. Section 2180A, Citations. The statutory authority for applying co-PTCS to HHAs is found in Section 1861(0) and 1891 of the Act. The regulations are found in 42 CFR Part 484, Section 484. Appendix B contains investigative procedures and interpretive guidance for surveyors. The CMS has a website for information pertaining to HHA survey and certification, including links to HHA policy memos, HHA-related information in the State Operations Manual, Section 2182,202.19, and Appendix B. Part I Investigative Procedures and Part II Interpretive Guidelines available at http://www.cms.gov/medicare/provider enrollment and certification/survey certification geninfo/index.html. Redirect =/survey certification geninfo/. Additional information can also be found at the Home Health Agency HHA Center at http://www.cms.gov/center/provider type/Home Health Agency HHA Center HTML. Redirect =/center/HHA ASP. Section 2180B. Types of agencies. An HHA may be a public, non-profit, or proprietary agency, or a subdivision of such an agency or organization. 1. Public agency is an agency operated by a state or local government. Examples include state-operated HHAs and county hospitals. For regulatory purposes, public means governmental. 2. Non-profit agency is a private, i.e., non-governmental agency exempt from federal income taxation under Section 501 of the Internal Revenue Code of 1954. These HHAs are often supported in part by private contributions or other philanthropic sources, such as foundations. Examples would include nonprofit visiting nurse associations or nonprofit hospitals. 3. Proprietary agency is a private, profit-making agency or profit-making hospital. Section 2180C. General Requirements. Section 1860(10) of the Act defines an HHA as an agency or organization which is primarily engaged in providing skilled nursing services and other therapeutic services, has policies established by a group of professionals associated with the agency or organization, including one or more physicians and one or more registered professional nurses, to govern the services which it provides. Provides for supervision of above-mentioned services by a physician or registered professional nurse. Maintains clinical records on all patients. Is licensed pursuant to state or local law, or has approval as meeting the standards established for licensing by the state or locality. Has in effect an overall plan and budget for institutional planning. Meets the co-PTCS in the interest of the health and safety of individuals who are furnished services by the HHA, and meets additional requirements as the Secretary finds necessary for the effective and efficient operation of the program. For purposes of Part A Home Health Services under Title Roman 18, the term Home Health Agency does not include any agency or organization which is primarily for the care and treatment of mental diseases. The co-PTCS for a Medicare-approved HHA found in 42 CFR Part 484 are also based on Section 1891 of the Act. These co-PTCS are listed in Appendix B, Interpretive Guidelines for HHAs. Section 1891 of the Act requires, among other things, that the HHA protect and promote the rights of each individual under its care. Disclose ownership and management information required under the Act. Not use as a home health aide on a full-time, temporary, per diem, or other basis any individual to provide items and services described in Section 1861M of the Act, unless the individual has completed a Training and Competency Evaluation Program (CEP) or a CEP that meets minimum standards established by the Secretary, and is competent to provide such items and services. Operate and provide services in compliance with all applicable federal, state, and local laws and regulations, including the requirements of Section 1124 of the Act. Operate and provide services in compliance with accepted professional standards and principles, which apply to professionals providing items and services for the HHA. Include an individual's plan of care (POC) required under Section 1861M of the Act as part of the clinical record described in Section 186103 of the Act, and comply with the requirements of Section 1866F of the Act relating to maintaining written policies and procedures respecting advance directives. Section 2180D, Services Provided. All HHAs must provide skilled nursing services and at least one of the following other therapeutic services: physical therapy, speech-language pathology, or occupational therapy, medical social services, or home health aid services in a place of residence used as a patient's home. The HHA must provide at least one of these services, i.e., skilled nursing, physical therapy, speech-language pathology, occupational therapy, medical social services, or home health aid services directly and in its entirety by employees of the HHA. The other therapeutic services and any additional services may be provided either directly or under arrangement. An HHA is considered to provide a service directly when the person providing the service for the HHA is an HHA employee. For the purpose of meeting Section 484.14a, an individual who works for the HHA on an hourly or per visit basis may be considered an agency employee if the HHA is required to issue a Form W-2 on his or her behalf. An HHA is considered to provide a service under arrangements when the HHA provides the service through contractual or affiliation arrangements with other agencies or organizations, or with an individual S who is not an HHA employee. The HHA is responsible for ensuring that the applicable co-PTCS are met, as though the HHA was furnishing the services directly. When hourly or per visit contracts are used, or when services are provided under arrangement, there must be a written agreement or contract between such personnel or this agency or organization and the HHA which specifies. Patients are accepted for care only by the primary HHA. The services to be furnished under the contract or agreement. the necessity to conform to all applicable agency policies, including personnel qualifications, the responsibility for participating in development of plans of care, the manner in which services will be controlled, coordinated, and evaluated by the primary HHA, the procedures for submitting clinical and progress notes, scheduling of visits, periodic patient evaluation, and the procedures for payment for services furnished under the agreement or contract. Section 2180E. Application of home health agency conditions of participation to patients receiving CHOR services exclusively. In addition to the home health services listed in Section 1861M of the Act and Medicaid state plan services identified in Section 1905A of the Act, some HHAs choose to offer additional services which are clearly non-medical in nature. Such services are typically comprised of housekeeping, chore, or companion services. The HHA makes these services available to individuals who choose to pay for them privately, and or individuals who are provided these services from other programs, such as a state Medicaid home and community-based services HCBS waiver program under Section 1915C of the Social Security Act. The HHA may offer these services to current patients of the HHA to supplement the skilled services available, to previous patients who have been discharged from skilled care, and to other individuals in the community who request them. Many individuals who receive these non-medical services are frail, elderly, or disabled, and request these services because they are unable to perform them independently and need this kind of assistance to remain in the home environment. In addition to promoting the health and safety of individuals, Section 1890, 1B of the Social Security Act also directs the Secretary to ensure that requirements promote the effective and efficient use of public monies. This statutory direction is especially pertinent in the question of whether expenses ought always to be incurred for a comprehensive assessment and care plan when the only service requested from an HHA by an individual is a chore or other clearly non-medical service. When this is the case, we will not consider the individual to be a patient of the HHA in the traditional sense of the term, and requirements that must apply to patients will not be required in such limited situations, e.g., the requirement for a comprehensive assessment under Section 484.55 will not apply. The Medicare HHA co-PTCS do not apply to those individuals who receive only chore services or other clearly non-medical services from the HHA. Non-medical services include chore services, companion services, household maintenance and repair services, lawn and tree services, and clearing walkways. To the extent that there is ambiguity as to whether a service is non-medical or medical, we will incline towards the medical interpretation and consider the co-PTCS to apply. CMS considers as a medical service any hands-on service, personal care service, queuing, or activity that is in any way involved in monitoring the patient's health condition. As soon as the HHA provides any Medicare service to an individual, or any standard service permitted by federal law under the Medicaid state plan, such as personal care, we will consider the individual to be receiving medical care. The co-PTCS will apply for all services rendered to such an individual. For example, the co-PTCS would apply in the case of an individual who received both chore services and personal care regardless of funding source, but would not apply in the case of an individual receiving only chore services from the HHA. HHAs are required as a part of the patient rights co-P to advise the patient of the extent to which payment for HHA services may be expected from Medicare or other sources, and the extent to which payment may be required from the patient. The HHA should explain to a beneficiary who is ending a Medicare episode and continuing to receive chore services that Medicare does not pay for those services. HHAs may develop their own comprehensive assessment for each required time point under the regulations at Section 484.55, for those patients receiving personal care services only regardless of payer source. The assessment may be performed any time up to and including the 60th day from the most recently completed assessment. The HHA must continue to meet all state licensure and state practice regulations governing the provision of service to this population. Where state law is more restrictive than Medicare, e.g., state law or state Medicaid HCBS requires the HHA to comply with co-PTCS when providing only chore services. The provider needs to apply the state law standard as well. Note that this instruction does not supersede any current policy related to Medicare coverage and eligibility rules or instructions from the Medicare Administrative Contractors MACs. The HHAs that provide non-medical services must also ensure that fiscal accounts are structured and maintained in conformance with CMS regulations and generally accepted accounting standards. Section 2182, Organization of HHA. It is permissible for an HHA to be located at a single site or have a parent site with services available at other approved locations, unless prohibited by state law or regulation. If there is more than one site, there must be a designated parent site with any other designated sites branches and / or subunits being part of that agency as described in more detail below. The parent, branch, or subunit must be operational during normal business hours as defined by the parent or subunit. Subdivisions. A subdivision is a component of a multifunction health agency, such as a hospital-based HHA or the nursing division of a health department, which independently meets the co-PTCS for HHAs. A subdivision would need to meet all requirements for the initial survey, including completing the CMS Form 855A and having this form verified by the assigned MAC. A subdivision may have subunits and / or branch offices, and if so, is regarded as a parent agency. Parent HHA. The parent HHA is that part of the HHA that develops and maintains administrative control of all approved locations. The parent is listed on the Medicare Enrollment Application Form CMS-855A. The parent HHA is responsible for all services provided at the parent and those provided at any of its approved branch locations. The parent HHA must also submit any relevant updates for all approved locations on the Form CMS 855A. Branch offices. A branch office is a location or site from which an HHA provides services within a portion of the total geographic area served by the parent agency. The branch office is part of the HHA and is located sufficiently close to the parent agency so that it shares administration, supervision, and services with the parent agency on a daily basis. The branch office is not required to independently meet the co-PTCS as an HHA. When the surveyor is conducting a survey of an HHA with branch offices, ascertain from HHA records whether the branch offices are provided adequate supervision by the parent agency, and whether they are, in fact, sufficiently close to the parent agency to be considered branch offices rather than subunits. If this judgment cannot be made without direct observation, the surveyor should visit the branch office to make this determination. When reviewing records and conducting visits to patients' homes, the surveyor selects some records and / or schedules some home visits to patients who are served by each branch office. The surveyor may also conduct a standard survey of the HHA at a branch office. When conducting a survey at a branch, the surveyor may request that all necessary documentation for review be transported to the branch. This may include, but not be limited to, a sample of clinical records from the parent and any other branches, governing body minutes, personnel records, etc. Subunits. A subunit is associated with the parent HHA, but is a semi-autonomous organization that 1. Serves patients in a geographic area different from that of the parent agency, and 2. Must independently meet the conditions of participation for HHAs, because it is too far from the parent agency to share administration, supervision, and services on a daily basis. The standards on governing body, administrator, and under the circumstances noted here, the group of professional personnel will be found met by subunits if they are met by the parent agency. The parent agency's group of professional personnel may serve as the subunit's group of professional personnel if that group is effectively pursuing its responsibilities for the HHA and its subunits. The parent agency's and subunits' records, i.e., policy statements and minutes of group meetings, must establish that attention is being paid to the subunit's operation in delivering services. The subunit may establish its own group, or the parent HHA may have a subcommittee of its group deal specifically with the subunit's policies and procedures. The subunit must submit an Initial Enrollment Application Form, CMS, 855A, and undergo an on-site initial survey from the state agency SAW or a national accreditation organization AO with deeming authority before it is approved to participate in Medicare. The SA completes the Form CMS 2567, or the AO completes the equivalent, and all other applicable documents for the parent organization and each subunit. The SA or AO does not conduct the initial survey of a subunit prior to the initial survey of the parent agency. The CMS certification, numbers CCNs, are assigned numerically by the regional office row. Note, some states do not allow HHAs to operate subunits. If an HHA resides in a state with this prohibition, the HHA must comply with the more stringent state requirement. Section 2182.1. Characteristics differentiating branches from subunits of HHAs. The comparisons on the following pages identify and clarify policies that assist in making a distinction between a branch and a subunit. The surveyor discusses any discrepancies with the administrator or his or her designee and alerts the SA supervisor, who then notifies the CMS RO. Administrative functions, relationship with parent agency. Branch not autonomous, is part of the HHA and shares administration, supervision, and services with the parent agency on a daily basis. The administration at the parent agency is aware of the staffing, patient census, and any issues/matters affecting the operation of any given branch. The branch location provides the same services as the parent within a portion of the total geographic area served by the parent agency. Subunit semi-autonomous and located at such a distance from the parent agency that it is incapable of sharing administration, supervision, and services on a daily basis. Serves patients in a geographic area different from that of the parent. A subunit may have a branch. Compliance with Co-PTCS. Branch does not have to independently meet the Co-PTCS as an HHA. Subunit independently meets all Co-PTCS as an HHA. Organizational structure, see Section 484.14. Branch the lines of authority and professional and administrative control are clearly delineated in both organizational structure and in practice, and can be traced to the parent agency. Subunit the lines of authority and professional and administrative control are clearly delineated in both organizational structure and in practice. Supervision, see Section 484.2. Branch supervision is shared between the parent agency and the branch. However, if the branch is so large, i.e., has a large staff and serves many patients, or is so distant that it is impossible for a supervisor of a specific discipline to accomplish adequate supervision, the branch must convert to a subunit. Subunit, it is too far from the parent agency to share supervision on a daily basis. The subunit functions independently of the parent, and consequently, supervision is provided by staff designated by the subunit. Administrator, see Section 484.4. Branch, the administrator of the HHA, maintains an ongoing management of the branch staff and liaison with the group of professional personnel. In order to accomplish this activity, sufficient time must be allocated for sharing information with all the parties mentioned. The branch is located sufficiently close to the parent to share administration. The administrator is apprised of and resolves issues affecting patients in branchees as well as the service areas covered by the parent. Subunit: it is too far from the parent agency to share administration on a daily basis. Is semi-autonomous and maintains its own administrative staff, e.g., supervising physician or registered nurse. It functions as an independent entity. Supervising physician, or RNC section 484.14d. Branch: the location of the branch, in relation to the parent, is such that the parent is able to assure adequate supervision during all operating hours. See Section 2182.4b. Subunit: supervisory, MD, or RN, is available during all operating hours. Personnel policies, see Section 484.14e. Branch: the parent office maintains current personnel records on all staff. A statement of personnel policies is maintained in each branch for staff usage. Subunit: personnel policies and records must be maintained at the subunit. Coordination of patient services, see Section 484.14g. Branch information concerning care provided to patients is communicated to staff in branches and parent agency, particularly when staff of one organizational unit, e.g., branch, does not base its practice at that site. Example: a physical therapist PT provides services to patients managed by the parent agency as well as patients managed by the branch. Most of the PT's time is spent with patients from the branch, although occasionally a patient followed by the parent agency is included in his or her workload. The PT is expected to coordinate care with staff in each organizational unit, i.e., branch or parent, as required by the patient's needs and as practice dictates. Subunit: since the subunit is a semi-autonomous entity, coordination is simplified because staff is generally available on a regular basis or can easily be reached to discuss and implement the coordination of patient care. Services under arrangements, see Section 484.1, 4H. Branch contracted arrangements with various entities are the responsibility of the parent agency, even when the contracted services are used exclusively by the branch. Subunit maintains contracts with various entities to provide services. The subunit is responsible for the administration and supervision of those services. Parent agency monitors subunit services provided under arrangements. Group of professional personnel, see Section 484.16. Branch: the annual review of the agency's policies is conducted by a group of professional personnel. Their focus is directed on service delivery throughout the entire agency, including the parent agency and branchees. Subunit: the subunit may establish its own group of professional personnel, or it may form a subcommittee of the parent HHA's group, which deals specifically with the subunit's policies and procedures at that subunit. The parent agency and subunit's policy statements and minutes of group meetings must include specific references to issues addressed in the delivery of home health services. Clinical records, see Section 484.48. Branch should retain the clinical records for its patients, since the branch site is where the professionals providing the services are located. Duplicate records need not be maintained at the parent agency, but must be made available to the surveyor upon request. Subunit maintains clinical records on all its patients. Section 2182.2. Guidelines for determining parent, branch, or subunit. The following guidelines should be used when making a determination as to whether a proposed HHA unit is a parent, branch, or subunit, as defined at 42 CFR Part 484.2. A. Supervision. Supervision of the branch staff is critical to the provision of quality care for patients. The regulations require the branch to be within the parent's geographical service area and close enough to the parent to share supervision, administration, and services on a daily basis. Supervision means authoritative procedural guidance by a qualified person for the accomplishment of a function or activity. Supervision at the branch must be adequate to support the care needs of the patients. Supervision of services requires that a qualified person be physically present to directly supervise the provision of services by any individual who does not meet the qualifications specified at 42 CFR Part 484.4. For individuals that do meet the qualifications specified at 42 CFR Part 484.4, the supervisor does not have to be physically present during the provision of all services. The use of telephones, pagers, facsimile machines, or other electronic devices does not eliminate the requirement for the physical presence of the supervisor. The parent may appoint an effective full-time branch supervisor or manager as long as this individual is and remains under the supervision of the parent. B. Distance. Mileage and travel times from the parent to the branch are significant factors to consider because they are implicitly referenced in the regulations. However, each alone would not be the single issue in determining appropriateness. The regulations require that a branch be sufficiently close to share administration, supervision, and services in a manner that makes it unnecessary for the branch to meet the co-PTCAS on its own. To accomplish this, the parent agency must be physically located so that sharing of administration, supervision, and services with the branch can occur on a daily basis. If the parent is not capable of sharing such functions with the branch on a daily basis, then the non-parent office or location must independently meet the co-PTCAS. C. Geographic area. Geographic area generally means the location, i.e., address of the clients served by the parent and non-parent. If the non-parent office is located within a portion of the total geographic area served by the parent, but serves patients outside the geographic area, then the non-parent should not be a branch and would be classified as a subunit. If the state does not recognize subunits, the HHA would seek a new provider number and establish a parent location. This is consistent with the subunit definition that applies to a non-parent office that serves patients in a geographic location different from the parent. D. Sharing administration, supervision, and services. In addition, consider that the sharing of HHA administration, supervision, and services may occur at any time and could flow in either direction, i.e., parent to branch or branch to parent. If an entity within the HHA's organizational structure reports directly to the home or corporate office or some other office other than the alleged parent HHA, it is more likely a subunit rather than a branch. As a subunit, it would need to independently meet the co-PTCAS. If the parent HHA and the non-parent use totally different staffs, it is less likely they are sharing functions on a daily basis, and it is therefore less likely that a parent/branch relationship exists. The fact that the non-parent office is located in a different metropolitan statistical area, MSA, from that of the parent is a consideration in making determinations about geographic areas. Commuting patterns are one consideration in the establishment of MSAs. If the parent and non-parent are in different MSAs, it may reflect that the non-parent is not within sufficient proximity to the parent to share functions on a daily basis. This is especially true if the parent and non-parent are in non-contiguous MSAs. If the parent and non-parent are incapable of sharing emergency functions, including services, on a daily basis, the non-parent is probably not a branch. State licensure laws that define parent, branch, and / or subunit are a consideration in making non-parent determinations, but it is the definitions in the federal regulations 42 CFR Part 484.2 that must be satisfied in making parent, branch, or subunit determinations. If an HHA operates across state lines, follow the instructions in Section 2184 of the State Operations Manual. The SA in the state in which the parent is located should take the lead in coordinating with the adjacent state to resolve parent and non-parent issues. The fact that the Joint Commission on the Accreditation of Healthcare Organizations, or the Community Health Accreditation Program, has awarded branch status to a location will not affect CMS parent/non-parent decision. CMS determination will be based on its independent application of its regulations to the facts in the case. Section 2182.3. Processing a change from branch to subunit. When a determination is made that a previously approved branch should become a subunit, either through a request from an existing provider or through a determination by CMS, an initial survey and certification is required, as with any new provider. In such a situation, follow the existing survey and certification rules for conducting an initial survey and issuing a provider agreement and CCN to the subunit. Similarly, if a location is discovered that has never been identified to the SA or CMS that is subsequently determined to be a subunit, an on-site survey in accordance with the usual survey and certification rules will apply. The subunit, as a new provider, must also meet all requirements for initial certification, including completing the CMS 855A and having this form verified by the assigned MAC. Note that a subunit may have branches. See Medicare Program Integrity Manual, Chapter 15, Medicare Enrollment, Section 15.19. Section 2182.4. CMS approval necessary for non-parent locations. As part of the provider certification process, an existing Medicare-approved HHA must provide notification to CMS through the SA of its proposal to add a non-parent location, i.e., branch or subunit. See Section 3224. In the absence of notification by the HHA to add a branch office, CMS cannot determine whether the requirements critical to health and safety are met at the non-parent location. A provider may not bill Medicare for services provided by either a branch or subunit, where the branch or subunit is not a part of an approved HHA, or where the branch or subunit has not been determined to meet the applicable co-PTCS. The Form CMS 855A applications are used to gather information on providers for the purpose establishing eligibility to furnish services to Medicare beneficiaries. 42 CFR 424.54082 requires a provider or supplier to update its enrollment information and recertify its accuracy when any changes are made. Additionally, Section 424.515 requires revalidation of the enrollment information by providers and suppliers every 5 years and every 3 years for suppliers of durable medical equipment, prosthetics, orthotics, and suppliers, or when determined by CMS policy. See also Chapter 10 and 15 of the Program Integrity Manual, which can be found at http://www.cms.gov/regulations and guidance/manuals/downloads/PIM83C10 PDF and http://www.cms.gov/regulations and guidance/manuals/downloads/PIM83C15 PDF. Before a subunit can be approved, it must seek initial certification and apply to CMS to receive a separate provider agreement and CCN. These steps are outlined in Part I of Appendix B of the SOM under the section on initial surveys. Section 2182.4a. Notification by HHA to add a branch. When an HHA requests approval to add a branch location, it should contact the SA and provide the following information: address and phone number of the branch, organizational chart delineating lines of authority, professional and administrative control for the HHA, including the branch, defined geographic service area counties, cities, zip codes, and any intention to cross state lines, which would require a reciprocal agreement between the affected states as well as RO approval. Services shared with the HHA parent. Services provided directly and under arrangement. Contracts for any services provided under arrangement. Identification of any high-tech services provided, e.g., infusion therapies such as artificial nutrition and hydration, or chemotherapy, mechanical ventilation, tracheostomy care, etc. Names of all branch staff and their job descriptions. Proof of branch staff qualifications, resume, licensure, aid training, etc. Explanation of how supervision by the HHA parent will occur. Identification of the person who will resolve patient care issues at the branch. Explanation of how staff will coordinate care and services. Policies for addressing clinical and other emergency situations. Plans for addressing staff absenteeism, and state-issued certificate of need, if applicable. Section 2182.4b. Essay review of request for branch determination. The decision to approve a branch should be based on the HHA's ability to adequately supervise the branch and monitor all services to assure that the quality and scope of items and services provided to all patients promotes the highest practicable functional capacity for each patient so as to meet their medical, nursing, and rehabilitative needs. The essay reviews the ability of the branch location to meet the definition of a branch as provided in Section 484.2. The regulations require the branch to be within the HHA parent's geographical service area and sufficiently close enough to the HHA parent to share administration, supervision, and services on a daily basis. The essay should review the HHA's request to open a branch and consider the HHA's ability to comply with the following: administration, supervision, and services. The HHA's governing body is responsible for the overall operations of the parent and branch. The lines of authority and professional and administrative control are clearly delineated in the HHA's organizational structure and in practice, and are traced to the HHA parent. Supervision means authoritative procedural guidance by a qualified person for the accomplishment of a function or activity. Supervision at the branch must be adequate to support the care needs of the patients. The HHA's supervising nurse or physician, as required by Section 484.14d, is available at all times by phone or other means of communication during operating hours for individuals who meet the qualifications specified at Section 484.4. Supervision of services requires that a qualified person be physically present to directly supervise the provision of services by any individual who does not meet the qualifications specified at Section 484.4. The HHA may formally appoint a supervisor or manager who is under the direct supervision of the HHA parent to assist with supervision at the branch. The HHA parent may use technological means for supervision in conjunction with periodic on-site visits. However, the use of telephones, pagers, facsimile machines, or other technological or electronic devices does not eliminate the requirement for the physical presence of the supervisor when required. The group of professional personnel required by Section 484.16 reviews the agency's policies and service delivery throughout the entire agency, both parent and any branchees. The HHA parent is aware of the staffing, patient census, and any issues/matters affecting the operation of the branch. The HHA administrator maintains an ongoing liaison with the branch to ensure that staff is competent and able to provide appropriate, adequate, effective, and efficient patient care, and to ensure that any clinical and/or other emergencies are immediately addressed and resolved. The HHA maintains a system of communication and integration of services throughout the agency, whether provided directly or under arrangement, that ensures the identification of patient needs, an ongoing liaison between all disciplines providing care, and physician availability when necessary for relevant medical issues. The HHA parent has a system in place to review patient records and care at the branch to ensure that the branch is implementing all policies and procedures and complying with the co-PTCS for all patients. The HHA parent monitors branch activities, clinical and administrative, and the management of services, as well as personnel and administrative issues. Depending on the organization, the administrator, quality improvement personnel, supervisory personnel, etc., should conduct periodic on-site visits to the branch to ensure the delivery of quality care. The HHA parent provides ongoing in-service training to ensure that all staff are competent to provide care and services. The HHA parent is responsible for any contracted arrangements with any individuals or organizations, even when the contracted services are used exclusively by the branch. Services offered by the HHA parent are also offered by the branch. Distance. While mileage and travel times from the parent to the branch are significant factors to consider because they are implicitly referenced in the regulations, each factor alone should not be the single issue in determining approval or denial of the branch. The HHA may use current technology to meet the requirement for shared supervision, administration, and services with the branch where on-site supervision is not required. A detailed description, including examples, of the application of this technology must be included in the HHA's request to add a branch. If the parent and non-parent location are incapable of sharing functions, including services on a daily or emergency basis, the non-parent location is probably not a branch. Geographic area. Geographic area generally means the location, i.e., address of the clients served by the parent and non-parent location S. The branch and its service area are located within the HHA parent's geographic service area. If the branch is extending the current geographic service area, the new geographic area must be contiguous. If the non-parent location is located within a portion of the total geographic area served by the parent, but serves patients which are located outside of and non-contiguous to that geographic area, then the non-parent would be classified as a subunit, not a branch, and be required to submit an enrollment application and to seek a separate CCN. If the state does not recognize subunits, the HHA would not be classified as a subunit and would seek a new CCN and become a separate HHA provider. The fact that the non-parent office is located in a different core-based statistical area, CBSA, from that of the parent is a consideration in making determinations about geographic areas. Commuting patterns are one consideration in the establishment of CBSA. If the parent and non-parent locations are in different CBSA, it may reflect that the non-parent is not within sufficient proximity to the parent to share functions on a daily basis. This is especially true if the parent and non-parent locations are in non-contiguous CBSA. If the state has a certificate of need requirement or other restrictions on geographic area or expansion of areas, the state rules apply. If the HHA intends to operate across state lines, follow the instructions in Section 2184 of the State Operations Manual. The SA in the state in which the parent is located should take the lead in coordinating with the adjacent state to resolve parent and non-parent issues. In addition, the SA should review the HHA's past compliance history, including prior complaints, survey results, number of co-PTCS and standards out of compliance, and length of participation in Medicare. While the HHA may notify the SA or AO as applicable of its proposal to establish a branch, and the SA or AO may make a recommendation to the CMS RO in a particular case, it is the CMS RO, not the SA or AO, that has the authority for approving the request for a Medicare-approved branch. The CMS RO will review each HHA's request for a branch office on a case-by-case basis and consider all the CMS guidance. The CMS RO will communicate its final decision in writing to the parent HHA with a copy to the SA or AO and the HHA's Medicare Administrative Contractor MAC. The approval letter should include notification of the branch approval and the assigned federal branch ID number and effective date, if approved. The effective date of coverage for services provided from the branch is the date RO determines that the branch meets all CMS requirements. The RO should enter the branch ID number into the Automated Survey Processing Environment, ASPEN, prior to sending the approval letter to the HHA, so that the branch can begin providing services and collect and submit OASIS data. Any decision to deny the request for a branch office should include the full range of the reasons supporting the denial and include discussion of the above criteria. Use the Model Denial Letter, Exhibit 284, as appropriate and copy the SA. Section 2182.4c. On-site monitoring of approved branches by the SA. During a survey of an HHA with approved branch offices, the surveyor will ascertain from HHA records whether the branch office is provided adequate supervision by the parent agency, and whether they are, in fact, sufficiently close to the parent agency to be considered a branch office rather than subunit. When reviewing records and conducting visits to patients' homes, the surveyor will select records and or, if possible, schedule home visits to patients who are served by each branch office. The surveyor may conduct a standard survey of the HHA at a branch office instead of the parent location. When conducting a survey at a branch location, the surveyor may request that all necessary documentation for review, such as a sample of clinical records from the parent and any other branches, governing body minutes, personnel records, etc., be transported to the branch. When reviewing branches during the survey process, the operations of an approved branch must demonstrate that a copy of the HHA's policies and procedures is maintained in each branch. Branch office personnel should be knowledgeable of the policies and consistently apply them. Methods of communication between HHA parent and branch assure that all patients receive the necessary care and services identified through the comprehensive assessment and plan of care. The branch retains the active clinical records for its patients. Duplicate clinical records need not be maintained at the HHA parent, but must be available to the surveyor upon request. Patients are receiving appropriate care and services at the branch, and the HHA is in compliance with OASIS submission requirements. To assist in the decision-making process of determining adequate branch supervision by the parent, and whether the branch is sufficiently close to the parent. The surveyors may review and utilize the HHA's branch-specific outcome-based reports during the survey and determine if the co-PTCS continue to be met with the inclusion of the additional location. Section 2182.4d. Drop sites. Where permitted by state and local law, an HHA may utilize a drop site for field staff convenience. These drop sites are not considered branches and should not meet the Medicare definition of a branch or operate as such. HHAs that allow these locations to cross the line from drop site to branch are out of compliance with the Medicare requirements. The HHA should not assign staff to these locations, accept referrals at these locations, advertise them as a part of the HHA, or operate them in any other way as branches of the HHA. HHAs that are unsure if the location meets the definition of a branch may seek advice from the SA. If the location does meet the definition of a branch, it must request CMS approval before providing services from this location. The HHA's policies on drop sites should reflect current federal and state requirements, including compliance with the Health Insurance Portability and Accountability Act of 1996 privacy requirements. While these sites would not be subject to routine surveys, they may be subject to state or RO inspection at any time. Any violation would be addressed by the SA and referred to the CMS RO for any necessary program integrity investigation and follow-up. Section 2182.5. Branch identification numbers. CMS assigns an identification number to every Medicare-approved HHA branch of either a parent or subunit. The identification system uniquely identifies every branch of every HHA certified to participate in the Medicare Home Health Program. It also links the parent or subunit to the branch. Having a system to identify branches gives CMS the capability of associating quality outcome results with individual HHA branches. Also, submission of branch identification numbers on outcome and assessment information, set OASIS assessments, provides the capability of developing outcome reports that will help HHAs differentiate and monitor the quality of care delivered by their agencies down to the branch level. ROs are responsible for assigning branch identification numbers according to the RO's existing policies and HHAs, and their respective branches are informed of their assigned branch identification number S. A sample letter is available at Exhibit 290. HHAs will need to enter this branch identification number on OASIS item M0016 branch ID. Detailed instructions for completion of M0016 by parent HHAs, subunits, branches, and HHAs, and subunits without branches are included in M0016 branch ID in Chapter 3 of the OASIS Guidance Manual. Each branch is numbered with the same federally assigned CCN as the parent or subunit with two modifications. There is a Q between the state code and 4-digit provider designation, plus 3 more digits for a 10-character branch identifier. Branch identification numbers are to be used only once. In the event that an HHA branch closes, its unique branch identification number is terminated and not reused to identify another branch of that HHA or subunit. Example: ABC Home Health Agency in Alabama has 3 branches. ABC Home Health Agency in Alabama equals CCN number 017001. ABC's branches would be assigned the branch identification numbers 01Q7001001, 01Q7001002, and 01Q7001003. Collection of branch information during survey. The Form CMS 1572, the Home Health Agency Survey and Deficiencies Report, captures survey and deficiency information and requests branch information at Field G17 that includes the HHA's total number of branches and name and address of each branch location. This information should be entered into Aspen after every survey as part of the survey kit. As surveys are conducted, SAs should verify that the information they have on branch locations is current and accurate. Branch identification numbers and MACs. The RO notifies the MACs of the branch identification information when it is assigned. This communication may occur electronically or through a written letter to the provider. Section 2183. Separate entities, separate lines of business. The surveyor must be able to identify the corporate, when applicable, and organizational boundaries of the entity seeking certification or recertification. The Medicare Co-PTCS apply to the HHA as an entire entity, and in accordance with Section 186106 of the Act, are applicable to all individuals served by the HHA, and not just to Medicare beneficiaries. While the purpose of the Co-PTCS is to help ensure proper care for Medicare beneficiaries, the Co-PTCS do this by defining the standards for an HHA in which Medicare beneficiaries may be treated, instead of establishing requirements applicable only to Medicare beneficiaries served by the HHA. If, however, the HHA is able to demonstrate that it operates a separate entity or separate line of business to which the Co-PTCS do not apply, it must provide the surveyor with the information to differentiate the separate line of business from the HHA. Neither the Act nor the Medicare regulations define a separate entity with respect to HHAs that Medicare approves as an HHA in accordance with the Act and the Co-PTCS. When an HHA alleges that it is operating a separate line of business to which the Co-PTCS do not apply, ask the HHA to produce information to enable the surveyor to differentiate between it and the HHA. Use the following guidelines on a case-by-case basis to assist in determining if a separate entity exists. The following criteria should be considered in making a decision regarding a separate entity. Operation of the HHA, consumer awareness, and staff awareness. Section 2183.1, Operation of the HHA. Ask the HHA administrator to describe the organizational, functional, and clinical boundaries of the Medicare Certified program in relation to any other programs the larger organization offers. Other programs should be separate and distinct from the HHA. Ensure that the HHA has separate policies and procedures for admission to the HHA, including separate consent forms, separate clinical records for all patients receiving HHA services, current licensure in accordance with state requirements. In states which license HHAs, review if the state has licensed separately the approved HHA and the separate entity, or has licensed the separate entity as another type of provider or supplier. Current listing of staff employed by or contracted to the HHA. Personnel records. Time sheets or other records to demonstrate distinct assignment of personnel to the HHA. And separate budgets. Section 2183.2, Consumer Awareness. The organization should differentiate the services of the HHA from other services offered by the larger organization. Ask the HHA for a copy of any brochure the HHA uses to describe itself to the community. Any applicable brochures should identify the HHA services as separate and distinct from other programs, departments, or entities operated by the HHA. The HHA should be differentiated from other programs, departments, or entities of the organization in listings, advertisements, etc. Written material should clearly identify the HHA as separate and distinct from other programs, departments, or entities of the organization. Section 2183.3, Staff Awareness. The HHA staff should be knowledgeable about the HHA's policies and procedures, the regulatory requirements related to their role in the delivery of care in an HHA, and be able to identify the difference in services they provide for the HHA and other programs, departments, or entities of the organization. Personnel who divide time between the separate entity and the HHA must be appropriately trained to deliver HHA services. The HHA maintains separate time sheets for each individual's assigned time to the HHA. If the SA determines, based on the information provided by the HHA, or for other reasons, that the HHA does not have a separate entity, or if the HHA or parent organization is unable or unwilling to provide the information, inform the HHA that it is in violation of the provisions of Section 1861.0 and 1891 of the Act, which require compliance with the CMS, particularly those conditions that relate to clinical records and disclosure of the ownership of the HHA. It is in violation of its agreement with the Secretary under Section 1866 of the Act, and the regulations related to this agreement, Section 489.53a, because it has failed to provide information about ownership and information concerning clinical records. It is in violation of Section 1128b12a of the Act because it has denied access to records to determine compliance with the CMS, including those that relate to the OASIS requirements. And it may be in violation of various requirements related to its Medicare cost reports, which mandate information about all of the HHA's clients in order to properly pay Medicare costs, and that the HHA's MAC must be notified about the allegation of separate entities. See Section 413.5b3, Section 413.9, Section 413.1 3F2 Roman 2, Section 413.17, Section 413.50b, Section 413.53a, and Section 413.80d. The SA must report these separate entity situations to the CMS RO, along with any recommendations the state has concerning the operation of two distinct entities. The state must also indicate whether the HHA refused access to records or information that make it impossible for the surveyor to make a determination concerning whether the applicant or approved HHA complies with the HHA Co-PTCS. The surveyor will inform the approved HHA that the SA must report the alleged separate entity to the CMS RO, that in turn must report this information to the MAC and, if necessary, to the state Medicaid director. Section 2184. Operation of HHAs cross state lines. When an HHA provides services across state lines, whether through its own personnel or a branch or subunit, each respective SA must be aware of and approve the action. Each SA must verify that applicable state licensure, personnel licensure, and other requirements are met in its respective state. Any branch or subunit of the HHA must meet applicable state and local laws in the state that it is serving. The provision of services across state lines is appropriate in most circumstances. Areas in which community services, such as hospitals, public transportation, and personnel services are shared on both sides of state boundaries, are most likely to generate an extension of HHA services. When an HHA provides services across state lines, it must be certified by the state in which its CCN is based, and its personnel must be qualified in all states in which they provide services. The appropriate SA completes the certification activities. The involved states must have a written reciprocal agreement permitting the HHA to provide services in this manner. The reciprocal agreement must indicate that both states are aware of their respective responsibilities for assessing the HHA's compliance with the Co-PTCS within their state. The agreement should assure that home visits are conducted to a sample of all patients in all states served by the HHA. The CMS RO will review the required reciprocal agreement between the states to assure that the SA in which the branch resides is assuming responsibility for any necessary surveys of the branch. If the SAs involved are unable to come to an acceptable arrangement on assuring the necessary surveys of the branch, even though there may be an existing reciprocal agreement between the states, or if the reciprocal agreement cannot assure the necessary surveys, the branch should not be approved. The provision of interstate service without a written reciprocal agreement could severely undermine a state's ability to fulfill its statutory responsibilities under Section 1864 of the Act to enforce Medicare's health and safety requirements. It is at the discretion of the states to decide whether entering into reciprocal agreements is in the best interest of their residents, provider markets, and quality assurance and oversight systems. Exhibit 289 contains a model reciprocal agreement document that states may use to assist them in fulfilling their statutory responsibilities under Section 1864 of the Act to enforce Medicare's health and safety requirements when an HHA provides services across state lines. In those states that have a reciprocal agreement, providers are not required to be separately approved in each state. Consequently, they would not have to obtain a separate Medicare provider agreement /number in each state. Providers residing in a state that does not have a written reciprocal survey agreement with a contiguous state are precluded from providing services across state lines. If a state does not have a written reciprocal agreement with other states, the HHA must establish a separate parent agency or subunit in the state in which it wishes to provide services. In the event that an HHA operates in two CMS ROs, the RO responsible for the state in which the HHA provider agreement and CCN is based should take the lead in assuring that the required survey and certification activities are met. A CMS-approved branch office may be physically located in a neighboring state if the SAs responsible for certification in each state approve the operation. Subunits of an HHA may be physically located in more than one state. A separate certification is made by the SA where each subunit is located. While the HHA may notify the SA of its proposal to provide services on an interstate basis, and the SA may make a recommendation to the CMS RO in a particular case, it is the CMS RO that has the Medicare approval authority of the parent HHA and assumes final responsibility for approval of the operation across state lines. Section 2185, HHA Change of Address. It is inherent in the provider certification process that a provider notifies CMS of its intent to change the location or site from which it provides services. Absent such notification, CMS has no way of carrying out its statutorily mandated obligation of determining whether the provider is complying with applicable participation requirements at the new site or location. It is long-standing CMS policy that there is no basis for a provider to bill Medicare for services provided from a site or location that has not been determined to meet applicable requirements of participation. This guidance is contained in Section 3224. When an existing HHA intends to move from its surveyed and certified location to a new site or location that is within the current approved geographic area, it notifies its MAC within 90 days of the move and submits all required documentation including an amended Form CMS-855A. The RHHI reviews the form and makes a recommendation to the RO. The RO then makes the final decision to approve the change of location. The provider notifies CMS either directly or through the SA, and, if it is a provider deemed to meet the requirements, it notifies its AO in writing of the change of location. Upon receipt of the MAC's approval notice, the RO will carefully evaluate the information, together with any supporting documentation from the provider and any other relevant information known to the RO in making its decision. If a decision can be made on the written application and supporting documentation, CMS may grant or deny an approval without requiring an on-site survey. See Section 2702(b) regarding when a resurvey is necessary based on change of a provider's size or location. CMS generally will not approve a change of location of an HHA with one or more previously approved branches if the new location increases the distance between the parent HHA and its previously approved branches to a point that prevents the HHA from exerting the supervision and control necessary to assure the provision of quality care for the patients served by the branch. If the location change is not approved, the provider may consider applying for a new provider number at the new location. CMS will consider the information contained in Section 2182.4b in its assessment of the parent's ability to supervise the branch before approving or denying the request. Section 2185.1. Move after certification survey and before final Medicare approval. Requests for initial certification cannot be processed to completion if a prospective provider moves to a new location after it has been surveyed, but before the entity receives a determination from the RO to participate in Medicare. If a prospective provider moves from its reported location after that location has been surveyed and or accredited, but prior to signing a provider agreement with CMS, the prospective provider's application for initial certification becomes incomplete. Absent a survey of the new location to which the prospective provider has moved, CMS is unable to determine whether applicable program requirements are met at the new location, and therefore is prevented from completing its review of the pending application. In these circumstances, CMS advises the prospective provider that its application is incomplete and is denied. Section 2186. Health facility-based HHAs. An HHA based to a hospital, SNF, hospice, or rehabilitation facility is expected to be an integral but subordinate part of the institution. Administrative and fiscal controls may be exercised over the HHA. However, the HHA's policies, personnel files, and clinical records must be separate and identifiable. Time records must be maintained for all personnel who provide home health services and must be identifiable as home health regardless of whether they are part-time or full-time. The HHA's use of personnel who are also concurrently employed by a hospital, SNF, hospice, or rehabilitation facility is acceptable provided the HHA's operating hours are definite and not arbitrarily subject to the operation of the other institution. And provided the other institution's operation does not interfere with the HHA's maintaining compliance with the co-PTCAS. An HHA's services must be supervised by an employee of the HHA. If members of the institution's governing body serve the HHA as the group of professional personnel, minutes must reflect meetings of this group. Clinical records may be maintained in the record room or department. However, the clinical records must contain information pertinent only to the delivery of home health services and should be readily available for either claims review or review by the SA. In surveying the health facility-based HHA, the SA or AO considers the institution's ability to share its administrative structure and personnel in fulfilling the needs and requirements of the HHA on a continuing basis. The co-PTCAS for HHAs must be applied and met independently. Section 2188, Survey of State-Operated HHAs. The same general procedures applicable to surveying other types of HHAs apply to HHAs operated by a state. However, individuals associated with the HHA in an administrative, supervisory, or service capacity must not be involved in the certification and consultation functions of the SA. 2194, Surveying Health Maintenance Organization, HMO-operated home health agencies, HHA, providing home health services through Medicare survey and certification process. The HMO Medicare Plus Choice, which contract with Medicare to furnish HHA services, may provide such services either directly by the HMO or through Medicare-approved HHAs that have a provider agreement/number with Medicare. See 42 CFR Part 417.416A and 42 CFR Part 422.20B3. If an HMO provides home health services directly as an integral part of the HMO, the HHA is still required to meet the HHA co-PTCAS, including the OASIS requirements, have a Medicare provider number, enter into a provider agreement with the Secretary, and meet other survey and certification requirements, including Office of Civil Rights and Enrollment requirements, that an HHA approved under 42 CFR Part 484.1 would have to comply with. When the SA receives a request to survey an HMO-operated HHA for compliance with the HHA co-PTCAS, it schedules an unannounced standard survey. The SA conducts the survey and documents its findings on Form CMS 1572. The SA completes Form CMS 2567, obtains a PO-C when necessary, and sends this information along with a completed Form CMS 1539 to the CMS RO. The SA resurveys approved HMO-operated HHAs according to the survey frequency allowed by the Secretary and determined by the SA to assure quality care and to ascertain whether they continue to meet the HHA co-PTCAS. In essence, these HHAs are surveyed and certified the same as any other Medicare-approved HHAs. Section 2195, Guidelines for Determining Standard Survey Frequency. Section 1890, 1C2A of the Act states that standard surveys will occur not later than 36 months after the previous standard survey, and that the Secretary shall establish a frequency for surveys within this 36-month interval commensurate with the need to assure the delivery of quality home health services. CMS will identify HHAs to be surveyed each fiscal year according to specific criteria and budget allowances. This list will contain the names of HHAs that have not been surveyed for 24 months or longer, and that are due for survey during the coming fiscal year. CMS will send this list to the state survey agencies each year. The annual budget criteria also specify the priority for complaint surveys, validation surveys, and any other targeted surveys for the upcoming fiscal year. Note, the survey process guidance is now found in Part I of Appendix B. Section 2197, Surveyor Worksheets. The following surveyor worksheets are used during each home health survey to assist the surveyor's determination of the agency's compliance with the home health conditions of participation. HHA Survey Investigation Worksheet 1, Patient Sample. Complete one patient sample investigation worksheet for each patient record and home visit selected. Use the worksheet to collect and record patient information and findings related to record review and home visit information to determine the appropriateness of care or services being furnished. Note interviews with clinicians, record review findings and observations. In addition to completing the worksheet, it may be appropriate to request the HHA to copy the most current plan of care for each patient in the survey sample that identifies baseline medical information for attachment to the patient's worksheet. Additional documentation, including assessments, medication profiles, visit notes, aid plans, or orders, may be copied to support findings. Complete each section with comments related to potential tags identified or indicate not applicable/NA. HHA Survey Investigation Worksheet 2, Agency Summary. Use the Survey Investigation Worksheet 2 to record a summary of any deficient practices identified during the survey. Also record the type of survey as performed, the number of agency admissions in the previous 12 months, as well as the number of records reviewed and home visits completed. HHA Survey Investigation Calendar Worksheet. Use the calendar worksheet to determine compliance with Section 484.1 8A and B and Section 484.55 regarding compliance with orders for service and the findings of the comprehensive assessment. Services ordered can be compared to services provided to determine compliance with visits. Section 2202, Outcome and Assessment Information set OASIS requirements. The Home Health Regulations at Section 484.55 require that each patient receive from the HHA a patient-specific, comprehensive assessment. As part of the comprehensive assessment of adult skilled patients, HHAs are required to use a standard core assessment data set, the OASIS. See note below for information regarding collection of OASIS data on the non-Medicare/non-Medicaid patients of an HHA. The regulations also require that OASIS data be electronically transmitted to the SA or CMS OASIS contractor. These requirements are detailed at Section 484.20. This regulation is referred to as the Reporting Regulation. The CMS uses the data to achieve broad-based improvements in the quality of care furnished through measurement of that care, as well as to maintain a home health prospective payment system. In addition to requiring the reporting of OASIS data, the OASIS regulations at Section 484.11 require HHAs to maintain privacy of their OASIS data and not release patient-identifiable OASIS information to the public. Regulations concerning state survey, certification, and enforcement responsibilities are found at Section 488.68. Effective July 19, 1999, all HHAs participating in the Medicare/Medicaid program have been required to comply with the Comprehensive Assessment and OASIS reporting regulations. Note, HHAs must comply with the Comprehensive Assessment Regulation at Section 484.55 for all its patients. However, until further notice, HHAs are not required to incorporate OASIS items into their patient-specific comprehensive assessment for the HHAs, 1 non-Medicare/non-Medicaid patients, 2 patients under the age of 18, 3 patients receiving maternity services, or 4 patients receiving personal care services only regardless of payer source. See additional information in Section 2180E. The collection of OASIS data on the non-Medicare/non-Medicaid patients of an HHA was temporarily suspended on December 8, 2003, as a provision of the Medicare Prescription Drug Improvement and Modernization Act of 2003. HHAs must continue to comply with the aspects of the regulation at Section 484.5 regarding the comprehensive assessment of patients. HHAs must provide each agency patient, regardless of payment source, with a patient-specific comprehensive assessment that accurately reflects the patient's current health status and includes information that may be used to demonstrate the patient's progress toward the achievement of desired outcomes. The comprehensive assessment must also identify the patient's continuing need for home care, medical, nursing, rehabilitative, social, and discharge planning needs. HHAs may continue to collect OASIS data on their non-Medicare/non-Medicaid patients for their own use. Surveyors must continue to examine the completeness of the comprehensive assessment for all patients during a survey. However, surveyors must not investigate whether the HHA included the specific OASIS items in its patient. Specific comprehensive assessments of non-Medicare/non-Medicaid patients, nor cite deficiencies based solely on this finding. HHAs must continue to collect, encode, and transmit OASIS data for their non-maternity Medicare and Medicaid patients that are age 18 and over and receiving skilled services. Section 2202.1, OASIS-related definitions. OASIS, outcome and assessment information, set scientifically tested data items developed for the purpose of measuring outcomes and patient risk factors that affect outcomes for HHA patients. These data items alone do not constitute a comprehensive assessment. They must be collected as part of the assessment process at various time points during a patient's admission to an HHA. CMS, formerly known as Medicare Data Communications, Network MDCN, a private communications network CMS purchased to ensure the security of OASIS and minimum data, set MDS data transmissions to the state. This system replaces the previous process of direct dial-up by public telephone lines to the SA and reflects the latest technology available for securing the privacy of data during transmission. In addition to increased security, another benefit of the CMS is that it is provided at no cost to the HHAs. HHAs may also apply for a CMS user identification and password for each of their branches for direct transmissions from their branches. Use of the CMS allows for all data submitted to the CMS OASIS state system to be encrypted during the transmission process, precluding any unauthorized sources from intercepting identifiable data. Similarly, data reports, which are sent by the OASIS state system to the HHA across the CMS are also automatically encrypted and decoded. This network encryption occurs automatically when the HHA uses the CMS and requires no special action on the part of the HHA other than using browser software that supports industry standard encryption. Comprehensive assessment, an assessment of a patient's condition that accurately and completely reflects the patient's current health status at the time of the evaluation. This assessment must identify the patient's continuing need for home care and must meet the patient's medical, nursing, rehabilitative, social, and discharge planning needs. An HHA must include the collection of specific OASIS data items at specific time points during a patient's admission as part of its comprehensive assessment process for all adult Medicare and Medicaid patients receiving skilled care unrelated to pregnancy or delivery. The specific OASIS items associated with each assessment time point are summarized in each version of the OASIS data set. The required OASIS data set and its time point related versions include 1 start of care SOC/resumption of care ROC, 2 follow-up, 3 transfer, and 4 discharge. HHAs must use the most current version of the OASIS. The most current version of OASIS is available on the OASIS website. Encode to enter OASIS data into a computer using the home assessment and validation entry Haven software provided by CMS or other Haven-like software. Developed by private vendors, Haven-like software must meet CMS data and edit specification requirements. Encryption, a system to translate plain text into scrambled code. Encryption offers a higher level of security when electronically transmitting information. The sender locks the data before transmitting. The receiver unlocks the data upon receipt. Haven, Home Assessment and Validation Entry, a software program provided by CMS, free of charge, for use by HHAs to encode their OASIS data and save as electronic files for electronic transmission to the SA. The Haven software automatically applies date range and consistency checks according to CMS published data specifications, which serve as an electronic safety net to preclude the transmission of erroneous or inconsistent information. Header record contains basic information that identifies the HHA submitting OASIS data, as well as contact persons and telephone numbers to be used in the event the file is in error. Initial assessment, the HHA's first visit to the patient after referral. In the absence of a specified start of care date, the initial visit is the first visit made to the patient within 48 hours of the referral. If the physician specifies a particular start of care date, then the initial visit is the date specified by the physician and includes performance of the skilled care ordered. In accordance with the regulations, the initial visit must be made by a registered nurse, except for therapy-only cases, in which the initial assessment visit can be made by a qualified therapist. Incorporate/integrate integrating the OASIS data items into an agency's assessment process means replacing similar questions on the agency's existing assessment tool with the corresponding OASIS data items. Agencies must merge the OASIS data items into their existing assessment process rather than simply appending them, without considering which OASIS items could replace similar items on the agency's assessment tool. Simply appending the OASIS items adds time to the assessment process and renders it burdensome and duplicative. Since the OASIS items are not intended to constitute a complete comprehensive assessment, agencies should gather other pertinent assessment information not included in the OASIS data items in order to create a comprehensive assessment. Except as required to meet other federal, state, or accreditation standards, agencies are at liberty to determine what other information they require as part of the comprehensive assessment. Late assessment, an assessment transmitted after the specific time frames defined in the regulations. 42 CFR 484.20a requires the HHA to transmit the assessment within 30 days of completing the assessment. Masking, a term used to describe software that conceals individually identifiable data elements. When required, HHAs will mask these data elements prior to transmission and keep the masked identifiers and the original data in their records. Private pay assessments are no longer accepted by the state system. If M0150 items 1, 2, 3, and 4 are all equal to 0 unchecked, the state system rejects the record. Any private pay assessment entered into Haven will be marked as complete and is excluded from the export process in Haven. Outcome changes in a patient's health status between 2 or more time points. Outcome-based quality improvement, OBQI performance improvement, based on outcome measurement and reporting. Outcome-based quality monitoring OBCOM. Reports. The OBCOM reports include the agency, patient-related characteristics report, and potentially avoidable events outcome reports. Overdue OASIS assessments, not received by the OASIS system within the specific time frames defined by the regulations. See also late assessment. Process-based quality improvement PBQI evaluating or investigating the use of specific best care processes, such as conducting falls risk assessments or providing drug education by reviewing the care provided to determine any needed changes in care delivery. Quality Improvement and Evaluation System, CAI, is an online system that supports the CMS mission and initiatives to improve the quality of care for Medicare beneficiaries providers, skilled nursing home health agencies, as well as state survey agencies. Includes Casper, MDS, Oasis, Raven, Haven, and Aspen. Reason for assessment RFA reason for conducting the assessment, e.g. start of care SOC, resumption of care ROC, and follow-up found in M0100. Resumption of care ROC, the day that care resumes after an inpatient stay. The HHA must complete an OASIS assessment and obtain the necessary physician change orders reflecting the change in the treatment approach in the patient's plan of care. The ROC is to be done within 48 hours of the patient's return home. If the physician's order requests that the HHA resume care at a point later than 48 hours, or if the patient refuses a visit within this 48-hour period, a note to this effect should be documented in the patient's chart for future reference. Significant change in condition. SIC. A SIC is defined as a significant change in the patient's condition during a 60-day episode that was not envisioned in the original plan of care. While this no longer creates a new case mix for payment, the HHA must complete an OASIS assessment and obtain the necessary physician change orders reflecting the significant change in the treatment approach in the patient's plan of care. The SIC relates to the OASIS data set Other Follow-up RFA 5. Start of care SOC, the day care begins after the referral is received. SOC currently relates to the first billable visit. The first billable visit approach was selected largely because of the Medicare payment requirements and the fact that the first billable visit defines SOC and start of the episode for Medicare purposes. Time points specific times during an episode of care when collection of OASIS data items is required as part of a comprehensive assessment. They are start of care, resumption of care, recertification, follow-up, and transfer to an inpatient facility, death at home, and discharge from agency. Trailer record indicates the end of the submission file. The trailer record includes a count of the total records in the file, including the header and trailer records. Section 2202.2, History of OASIS. The OASIS is a group of data items developed, tested, and refined over the past decade for the purpose of enabling the systematic measurement of HHA patient care outcomes. Initially, the OASIS was a 79-item data set first published in 1994 by the Center for Health Services and Policy Research at the University of Colorado. Over the years, it has been modified as a result of input from a variety of home care experts, including representatives of all home health care disciplines. Future modifications to the OASIS are expected as we learn more about outcome measurement, as well as determine what information would best serve the continued maintenance of a case mix, adjusted home health PPS. Relative to OASIS, the definition of outcomes is very specific. Outcomes measure changes in a patient's health status between 2 or more time points. The data are collected at specific time points following a patient's admission to an HHA to determine whether appropriate progress toward desired outcomes is being achieved. These data items must be incorporated into the agency's overall patient assessment process, as OASIS was not developed to be a complete comprehensive assessment instrument. HHAs will find it necessary to integrate the OASIS items into their own process in order to comprehensively assess the health status and care needs of their own patient population. Effective January 1, 2010, the OASIS data set was significantly modified to include process measures. Some points to remember about the uses of OASIS data items into an HHA's assessment process can be found in Appendix C of the OASIS C Guidance Manual. Section 2202.2a, Current version of OASIS. The current version of OASIS and the guidance manual is found on the CMS website at http://www.cms.gov/Medicare/Quality Initiatives Patient Assessment Instruments/Home Health Quality in its /HHGOC's user manual HTML. Section 2202.2b. OASIS as part of the HHA's comprehensive assessment. OASIS data items are not meant to be the only items included in an agency's assessment process for Medicare and Medicaid patients. They are standardized assessment items that must be incorporated into an agency's own existing assessment policies process. An example of a comprehensive assessment showing an integration of the OASIS data items with other agency assessment items can be found in Appendix C. Sample clinical records incorporating OASIS data set in the OASIS User's Manual. For a therapy-only case, the comprehensive assessment should include OASIS data items as well as other assessment data items the agency currently collects for therapy-only cases. 2202.2c Incorporation of OASIS data items into the comprehensive assessment refer to Section 484.55e Rev. 125, issued 10-31-14, effective 10-31-14, implementation 10-31-14. In accordance with the regulations, agencies must incorporate the language of OASIS data items exactly as they are written into their own assessment process. Agencies are expected to replace similar items/questions on their current assessment, as opposed to simply adding the OASIS items at the end of their existing assessment tool. For agencies electronically collecting assessment data, using software that does not accommodate bolding or underlining for emphasis of words in the same manner as the current OASIS data set, capitalizing these words is acceptable. It is also recommended that HHAs include the data set numbers M numbers when incorporating the OASIS. In this way, the clinician will know that the M-labeled items are items that must be assessed, completed, and reported. This will minimize delays in encoding due to incomplete OASIS data items. Agencies may wish to incorporate the assessment categories, e.g., activities of daily living adults/instrumental activities of daily living IADLs, medications, etc. into their own assessment process in a different order than presented on the OASIS form. While HHAs are encouraged to integrate the OASIS data items into their own assessment instrument in the sequence presented on the OASIS form for efficiency in data entry, they are not precluded from doing so in a sequence other than that presented on the OASIS form. However, this is not recommended because of the skip patterns built into the OASIS form. Section 2202.3, Applicability. Section 2202.3a, Medicare and Medicaid patients. In general, the comprehensive assessment and reporting regulations apply to any HHA required to meet the Medicare co-PTCS for any reason, and are applied to all patients of that HHA unless otherwise specified. This includes Medicare, Medicaid, Medicare and Medicaid managed care, and private pay patients served by the agency. It also includes Medicaid waiver and state plan patients to the extent they do not fall into one of the exception categories listed below and are required by the state to meet Medicare co-PTCS. HHAs providing services under Medicaid's home health benefit must meet the co-PTCS for Medicare, as specified at 42 CFR 440.70d. As such, HHAs servicing only Medicaid patients, Medicaid only, HHAs, must meet Medicare co-PTCS, including the comprehensive assessment and OASIS reporting requirements. Health maintenance organizations serving Medicare/Medicaid patients can either provide home health services themselves or can contract out for those services. If they provide home health services themselves, they must meet the Medicare Home Health co-PTCS. If they contract out for home health services, they must contract with a Medicare-approved HHA in order to serve Medicare/Medicaid patients. See 42 CFR 417.416 and Section 2194. The HHA's requirement to conduct comprehensive assessments that include OASIS data items applies to each patient of the agency receiving home health services, with certain exceptions. Patients under the age of 18. Patients receiving maternity services. Patients receiving housekeeping or chore services only, and patients receiving personal care services only. Patients for whom Medicare or Medicaid insurance is not billed. The comprehensive assessment and reporting regulations to patients receiving personal care only services, regardless of payer source, is not applicable. Section 2202.3b, OASIS and the Medicare Home Health Benefit. The comprehensive assessment and OASIS data collection requirements apply to Medicare beneficiaries as described below. Medicare beneficiaries using the Medicare Home Health Benefit provided under either Part A, Part B, or Part C. Medicare beneficiaries who require therapy services provided outside the home for special equipment needs, and who are using the Medicare Home Health Benefit. If a Medicare beneficiary is under a home health plan of care, all therapy services, that is physical therapy, occupational therapy, speech-language pathology PT, OT, SLP, delivered under the home health benefit, whether they are furnished directly by the HHA or under arrangement on behalf of the HHA, are bundled into the PPS payment rate as part of the consolidated billing requirements. The consolidated billing governs Medicare Home Health PPS effective October 1, 2000, and requires that payment for home health services, including medical supplies, described in Section 1861M5 of the Act, but excluding DME to the extent provided for in Section 1861M5, furnished to an individual who, at the time the item or service was furnished, is under a plan of care of a HHA, be made to the agency, without regard to whether or not the item or service was furnished by the agency, by others under arrangement with them made by the agency, or under any other contracting or consulting arrangement, or otherwise. The services included in the consolidated billing governing home health PPS are part-time or intermittent skilled nursing services, part-time or intermittent home health aid services, physical therapy, speech-language pathology services, occupational therapy, medical social services, routine and non-routine medical supplies, covered osteoporosis drug as defined in Section 1861KK of the Act, but excluding other drugs and biologicals, and home health services defined in Section 1861M, provided under arrangement at hospitals, SNFs, or rehabilitation centers, when they involve equipment too cumbersome to bring to the home, or are furnished while the patient is at the facility to receive such services. If a Medicare beneficiary under a home health plan of care is receiving therapy services from another provider, either an inpatient or outpatient provider under arrangement made by the HHA, as part of the home health benefit simply because the required equipment cannot be made available at the patient's home, the Medicare co-PTCS apply, including the comprehensive assessment and collection and reporting of OASIS data by the HHA. 1. Medicare Advantage plans. Medicare Advantage plans are health plan options that are part of the Medicare program. Medicare beneficiaries who elect to have Medicare services provided by a Medicare Advantage plan are entitled to all the Medicare-covered services that are available to beneficiaries residing in the plan's geographic area. Medicare Advantage plans, like a Medicare Health Maintenance Organization, HMO, or Preferred Provider Organization, PPO, which contract with Medicare to furnish HHA services, may provide such services either directly by the plan or through Medicare-approved HHAs that have a provider agreement and CCN with Medicare. See Section 417.416a. If the Medicare Advantage plan provides home health services directly as an integral part of the plan, the HHA is still required to meet the HHA co-PTCS, including the OASIS requirements, have a Medicare CCN, enter into a provider agreement with the Secretary, and meet other survey and certification requirements, including Office of Civil Rights and Enrollment requirements, with which an HHA certified under Section 484.1 would have to comply. When the SA receives a request to survey an HMO-operated HHA for compliance with the HHA co-PTCS, it schedules an unannounced standard survey. The SA conducts the survey, completes the Form CMS 2567, obtains a PO-C when necessary, and sends this information along with a completed Form CMS 1539 to the CMS RO. The SA resurveys approved HMO-operated HHAs according to the survey frequency allowed by the Secretary and determined by the SA to assure quality care and to ascertain whether they continue to meet the HHA co-PTCS. In essence, these HHAs are surveyed and certified the same as any other Medicare-approved HHAs. 2. Medicaid Home Health Programs/Medicaid Waiver Programs. The comprehensive assessment regulations apply to HHAs that are required to meet the Medicare Home Health co-PTCS. An HHA that currently must meet the Medicare co-PTCS under federal and / or state law must meet the Medicare co-PTCS related to OASIS and comprehensive assessment and reporting. If an HHA provides skilled services to individuals under Medicaid, then OASIS applies. If the patient is not receiving skilled nursing, physical therapy, occupational therapy, or speech-language pathology services, then OASIS does not apply. The requirement to collect OASIS on patients receiving only personal care services has been delayed until further notice. 3. Medicare Hospice benefit. The comprehensive assessment and OASIS data collection requirements do not apply to any individual receiving hospice services from a Medicare-approved hospice. A hospice patient may receive covered home health services for a condition unrelated to the treatment of the terminal condition for which hospice care was elected. This type of patient would be subject to the regulations governing the HHA services, including OASIS collection and reporting. 4. Outpatient therapy benefit. If a Medicare beneficiary, not under a home health plan of care, is receiving therapy services under the Medicare Part B outpatient benefit from another Medicare provider, the OASIS collection and reporting requirements do not apply. 5. SNF or inpatient hospital benefit. The comprehensive assessment and OASIS data collection requirements do not apply to Medicare beneficiaries who are inpatients at a SNF or a hospital because these services are not considered home health services and the OASIS comprehensive assessment does not need to be conducted. The MDS is required in certified skilled nursing facilities. The following table summarizes the type of Medicare/Medicaid service and the application of the federal OASIS requirements. Type of Medicare/Medicaid service: home health benefit. Home health benefit. Home health benefit. Further description. Part A Part B terminal care. Application of OASIS. Yes. Home health benefit. Medicare home health, under a Medicare Advantage plan, Medicaid home health benefit. Medicaid home health benefit. Medicare hospice benefit. Therapy services provided either directly or under arrangement while under a home health PO-C during an open episode. The selected HHA must be Medicare approved. Skilled services provided including expanded home health services that are skilled provided under a home and community based waiver service or home no health aid services only provided without skilled services inpatient or at home no outpatient therapy benefit provided in a clinic no Patient not under a home rehabilitation agency. A. Health plan of care. Public health agency or other provider of services. Skilled nursing facility, inpatient services. No. Hospital. The guidance above applies to all HHAs that participate in Medicare and to HHAs that are required to meet the Medicare co-PTCAS, including Medicaid HHAs. Section 2202.3c. Non-Medicare/non-Medicaid patients. The collection, encoding, and transmission requirement for non-Medicare and non-Medicaid patients receiving skilled care is temporarily suspended. While HHAs are not required to collect OASIS for non-Medicare/non-Medicaid patients, HHAs may continue to collect OASIS data for their own use, but they may not submit the data for these patients to the state. The state system will reject any assessment with a M0150 value of 0 unchecked for items 1, 2, 3, and 4. Also, Haven will not include these assessments in the submission file, but will mark them as complete. Section 2202.3d. Skilled versus non-skilled care. Until the comprehensive assessment and reporting requirement resumes for all patients, regardless of type of care provided, the following definitions apply for determining skilled versus non-skilled care for comprehensive assessment purposes only. Skilled services for Medicare patients. The provision of skilled service is a precondition for Medicare payment for home health care. Therefore, all patients receiving Medicare traditional home health services are, by definition, receiving skilled care. Skilled services for non-Medicare patients for comprehensive assessment purposes. Skilled services are services which can only be provided by a registered nurse RN or a licensed practical nurse under the supervision of an RN, a physical therapist PT, occupational therapist OT, or a speech-language pathologist SLP, licensed by the state. Most states define the kind of care that is allowed by these practitioners under state practice acts. The former requirement to conduct an initial evaluation of a patient is expanded in the Comprehensive Assessment Regulations. The regulations now require that, in addition to an initial evaluation, the agency must also conduct a comprehensive assessment of a patient with updates at certain time points. These updates include different combinations of OASIS data items. An agency that currently must meet the Medicare co-PTCAS under federal and or state law will need to meet the comprehensive assessment and OASIS encoding and reporting co-PTCAS and apply them to each patient of the agency for whom home health services are rendered, with the exceptions listed in A. above. Section 2202.3e. Agencies serving Medicaid waiver and state plan patients. If home care is provided by an entity required to meet the Medicare co-PTCAS for any reason, then the entity must apply all the requirements of the co-PTCAS, including the comprehensive assessment and OASIS data reporting requirements, to all patients of the agency, including patients treated under a Medicaid waiver or state plan, as applicable. The same exceptions apply as listed in A. above, i.e., patients under the age of 18, patients receiving maternity services, patients receiving housekeeping or chore services only, and until sometime in the future, patients receiving personal care services only. If home care is provided by an entity that is not required to meet the Medicare co-PTCAS, then the provider must comply with only those requirements imposed under state or local law. In this case, if the provider treats patients under a Medicaid waiver or state plan, then none of the Medicare co-PTCAS for HHAs, including the comprehensive assessment and OASIS data reporting requirements, apply. See Section 2183 for information on separate entities. Section 2202.3f. Patients turning 18. A patient who is under age 18 and turns 18 while under the care of an HHA is to receive a comprehensive assessment including OASIS, if Medicare or Medicaid is billed at the next appropriate time point. Any assessments due under the regulations at the time the patient turns 18 would be conducted, including the collection and reporting of OASIS data if Medicare or Medicaid is billed. Example: if on 1/5/2013, a patient under the care of the agency turns 18 and is transferred to an inpatient facility on or after 1/5/2013, a transfer assessment with the corresponding OASIS data items must be collected. If the patient was discharged on his or her 18th birthday, a discharge assessment with the corresponding OASIS data items must be collected. From the day the patient turns 18, any assessment required per the regulations at the next particular time point is required. Agencies are not expected to collect and report start-of-care OASIS data on patients admitted to the agency prior to turning 18. Section 2202.3G. Patients receiving maternity services. The HHA should not collect data on patients receiving maternity services, i.e., prenatal, antepartum, and postpartum. The patient is not exempt from OASIS data collection if under the care of a physician for a condition unrelated to pregnancy or delivery. Section 2202.4. Comprehensive assessment and OASIS reporting refer to Section 484.20 and Section 484.55. All HHAs participating in the Medicare/Medicaid program are required to comply with the comprehensive assessment and OASIS reporting regulations as summarized in the following chart. Patient classification. Skilled Medicare Traditional Fee-for-Service Medicare HMO/Managed Care Medicaid Traditional Fee-for-Service Medicaid HMO/Managed Care. Skilled Non-Medicare/Non-Medicaid. Collect, encode, transmit. Yes. 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 No. 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 Patient classification. Workers' compensation title programs, other government private insurance, private pay patients under a HMO/PPO/managed care plan. Self-pay, other, unknown. Collect, encode, transmit. Temporarily suspended. Personal care only. No. 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 Medicaid Traditional Fee-for-Service. Non-Medicaid. Workers' compensation. Title programs. Other government. Private insurance. Private HMO/managed care. Self-pay, other, unknown. Patients under age 18. No. 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 Patients receiving pre- and postpartum. Maternity services, patients receiving only. Chore and housekeeping services. Section 2202.4a. Comprehensive assessment and OASIS collection. The comprehensive assessment regulations require a comprehensive assessment that includes certain OASIS data items be conducted at specific time points during a patient's admission. Those specific times are: 1. SOC. After admission to the HHA, the SOC comprehensive assessment should be completed in a timely manner consistent with the patient's immediate needs, but no later than 5 calendar days after the SOC. 2. ROC. The comprehensive assessment is completed within 48 hours of the patient's return to the place of residence or of the HHA's knowledge of the patient's return after an inpatient admission of 24 hours or more for any reason other than diagnostic tests. This applies when the patient was not discharged from the HHA during the inpatient admission. If the physician's order requests that the HHA resume care at a point later than 48 hours, or if the patient refuses a visit within this 48-hour period, a note to this effect should be documented in the patient's chart for future reference. 3. Follow up the comprehensive assessment that is performed at the end of the current 60-day period. This assessment must be performed within the last 5 days of the current 60-day episode. For example, start of care certification period. Follow-up assessment due. 1/15/20XX, 1/15/20, XX3/14/20XX, 3/10/20, XX3/14/20XX, 1/15/20XX, 3/15/20, XX5/13/20XX, 5/09/20 XX5/13/20XX, 1/15/20XX, 5/14/20, XX7/12/20XX, 7/08/20, XX7/12/20XX. 4. Transfer to an inpatient facility. An assessment update is performed when a patient is transferred to an inpatient facility for 24 hours or more for any reason, except diagnostic testing, regardless of whether the patient is discharged from the HHA at that time. The update must be completed within 48 hours of the patient's transfer to the inpatient facility, or within 48 hours after the HHA becomes aware of the transfer, and includes a limited number of OASIS items. 5. Discharge. The comprehensive assessment is performed when a patient is discharged from home care. These updates must be completed within 48 hours of the discharge/death, or within 48 hours after the HHA becomes aware of the discharge/death. Section 2202.4b. OASIS encoding and locking. HHAs should use Haven or Haven-like software to encode or enter OASIS data into their computers. Haven will accommodate data entry of OASIS items from all required time points. Regardless of the time point, OASIS data items should be encoded and checked for errors using Haven or Haven-like software and made export/transmission ready. 1. Availability of Haven. The Haven software is available for downloading free of charge from the CMS OASIS and CAI's technical support QTSO website. See https://www.qtso.com/Haven download HTML. The Haven helpline can be reached at 1-877-201-40-721. Specific information describing how to operate the Haven software can be found at https://www.qtso.com/download/haven/hhelp32 PDF. 2. Errors and warnings in encoding. See error messages and description guide https://www.qtso.com/download/guides/hha/errors/errors. Sec 2. PDF HHAs may experience two types of messages at completion of data entry. A. Error message. If the HHA uses Haven for data entry, an error message may occur if a mandatory field is left blank. The HHA will receive an error that the field must be filled in before the assessment can be marked as complete. HHAs should correct their errors before an assessment may be exported to the OASIS data management system. Along with the error message is the name of the window tab where the error was detected. B. Warning message. If the HHA uses Haven for data entry, a warning message may occur if timing criteria for date fields do not match OASIS data specifications. These messages are informational only and do not preclude an HHA's assessment from being exported. Along with the warning message is an explanation of that message and direction on where the discrepancy was detected. Section 2202.4c. OASIS reporting, refer to Section 484.20. 1. HHA submissions. HHAs must submit their OASIS data within 30 days of the M0090 date assessment completed. Data received outside of this time frame is considered overdue. Specific information describing how HHAs are to transmit OASIS data to the SA is in the OASIS System User's Guide. 2. Errors and warnings in OASIS reporting. When submitting OASIS records, a fatal error message may occur if the HHA's data record layout does not follow OASIS data specifications. This message should not occur if the HHA is using the Haven software to encode the OASIS items. 3. SA access. In states where the non-long-term care agency is in a location separate from the OASIS state system, where the MDS data system resides, and is not under the direct jurisdiction of the Home Health Survey Agency, CMS provides access to the OASIS state system by installing a computer workstation at the Home Health Survey Agency. Address to link to the OASIS state system. The CMS will provide additional support to the SA to access and operate the off-site server by providing appropriate software and technical assistance from CMS and the CMS OASIS contractors. Section 2202.5. Outcome-based quality improvement OBQI. OBQI is a systematic approach that HHAs can implement and follow in order to continuously improve the quality of care they provide. OBQI manuals are available on the CMS Home Health Quality website. Under OBQI, quality is measured against the ultimate yardstick patient outcomes. OBQI is fundamentally a two-stage process that requires the collection of OASIS data for all patients in the agency, except those excluded by exemption. The first stage of OBQI is outcome analysis based on the OASIS data. The analysis is based on an agency-level report showing the agency's present performance regarding patient outcomes relative to a national measure of HHA patients. Outcome reports are generated at the SA and retrieved by the HHA through the same communication process the HHA uses to transmit OASIS data. Subsequent outcome reports contain comparisons of an agency's present patient outcomes, performance relative to the preceding time period for the agency, and relative to a national measure of HHA patients. From these reports, HHAs can target areas for improvement as part of their overall quality assurance process. The second stage of OBQI is outcome enhancement, whereby the agency, using the data from its outcome analysis, identifies opportunities to improve care and develops plans. HHAs are provided with reports on a series of outcomes for their patients in the current year that compares its performance to the prior year and to the national reference, i.e., benchmarking values. Section 2202.5a. Using outcome-based quality monitoring OBCOM and risk-adjusted OBQI reports in the survey process. The OBCOM reports consist of the patient-related characteristics and potentially avoidable event outcome reports, which are derived from the OASIS data that HHAs submit to the state. The agency patient-related characteristics and potentially avoidable event reports can be used by HHAs for quality monitoring and improvement purposes. The risk-adjusted OBQI reports provide measures of patient care based on all of the OASIS data items. These reports allow an HHA to proceed to outcome enhancement. It is the outcome enhancement activities that allow an HHA to focus its quality or performance improvement activities on select target outcomes, to investigate the care processes that contributed to these outcomes, and to make agency-specific changes in clinical actions that will lead to improved patient outcomes. Using these reports is a first step toward full implementation of the OBQI program. As a part of the pre-survey preparation, surveyors should access and review the OBCOM and OBQI reports before surveying an HHA. These reports contain valuable information that may assist surveyors in identifying areas to review during the survey and possibly identify individuals or types of patients to include in the sample selection when on site following guidance provided in the Home Health Survey Protocol enhancements. Effective May 1, 2003, published February 13. 2003, as S&C Memorandum 03-13. The OBCOM Manual, titled Quality Monitoring Using Case Mix and Adverse Event Outcome Report, available on the OASIS website, provides examples of possible surveyor actions related to adverse event outcomes. The OBQI manual, titled Outcome-Based Quality Improvement Implementation Manual, provides guidance to HHAs for establishing a quality improvement program using the risk-adjusted OBKI reports. This manual is also available on the OASIS website. 1. Agency Patient-Related Characteristics Report. The Agency Patient-Related Characteristics Report presents a picture, or snapshot, of an HHA's patients at the beginning of a care episode for the time period selected for the report. The beginning of a care episode is marked by either a SOC assessment or a ROC assessment. The body of the case mix report describes the characteristics of an HHA's Medicare and Medicaid patients receiving skilled services compared to the rest of the Medicare and Medicaid patients receiving skilled home health services across the country during the same time period. Surveyors should review the case mix outcome report as described in the OBCOM manual and the appendix titled Guidelines for Reviewing Agency, Patient-Related Characteristics, and Potentially Avoidable Event Reports. Any significant results should be identified after reviewing the report and highlights noted. This will allow surveyors to begin to identify potential clinical groups of patients that can be included in the case mix stratified sample for record review and home visits as part of the on-site survey. 2. Potentially Avoidable Event Reports. The Potentially Avoidable Event Report displays incidence rates for untoward events or outcomes comparing one HHA's patients to patients in the CMS OASIS National Repository for the same time period. Potentially avoidable events serve as markers for potential problems in care because of their negative nature and relatively low frequency. The patient listing can be used to investigate the care processes that contributed to these outcomes and to make agency-specific changes in clinical actions that will lead to improved patient outcomes. As a part of the pre-survey preparation, surveyors should access and review the OBCOM and OBKI reports before surveying an HHA. These reports contain valuable information that may assist surveyors in identifying areas to review during the survey. Surveyors do not look at the potentially avoidable event report in a vacuum. They review this report in light of the actual circumstances surrounding the delivery of care to the specific patients. As a part of the Co-PTCS section 484.16, Group of Professional Personnel and section 484.52, Evaluation of the Agency's Program, HHAs are required to conduct an annual evaluation of their total program, including patient services. HHAs are also required to conduct quarterly clinical record reviews to evaluate the care provided under the HHA's policies. The Co-PTCS require an agency to have policies and procedures to promote patient care that are appropriate, adequate, effective, and efficient. HHAs have access to the OBCOM reports and the OBKI reports, and may incorporate a review and investigation of these reports into their evaluation and patient care review programs, and include them as part of their quarterly record review. 3. Risk-adjusted OBKI reports. The risk-adjusted OBKI reports are the third and final of the OASIS-based reports. These agency-level reports allow individual HHAs to assess their own performance with respect to patient outcomes and compare their performance to a national reference or benchmark. In addition, HHAs can use the OBKI data to target and develop plans of action to improve or maintain HHA performance and patient outcomes. The risk-adjusted OBKI reports became available to all HHAs in February 2002. CMS anticipates that HHAs will choose to use the OBKI reports for quality improvement and for consumer education. In CMS-sponsored demonstrations where the OBKI process has been tested, many HHAs have demonstrated significant improvements in targeted patient outcomes. These data-rich reports now represent a decade of benchmarking that is risk-adjusted for each HHA. This means that every HHA can be compared to the national reference values, regardless of the types of patients it serves, when compared to another HHA. Therefore, an HHA that strives to provide quality care services to its patients will be able to determine its performance and to identify areas for improvement or reinforcement with the quality reports available to them. Process measures were added to the OASIS in 2010. For further information, refer to the PBQI manual, which is located at http://www.cms.gov/Medicare/Quality Initiatives Patient Assessment Instruments/Home Health Quality in its/PBQI process measures HTML. The OASIS C process measure reports are now available in the CASPR reporting system. The reports are located in the OASIS C Quality Improvement Report category. Resources are located on the following CMS websites: PBQI, http://www.cms.gov/Medicare/Quality Initiatives Patient Assessment Instruments/Home Health Quality in its/PBQI process measures HTML. OBKey http://www.cms.gov/Medicare/Quality Initiatives Patient Assessment Instruments/Home Health Quality in its/HHGOSIS OBKey HTML. Section 2202.5a. Using outcome-based quality monitoring OBCOM and risk-adjusted OBKey reports in the survey process. The OBCOM reports consist of the patient-related characteristics and potentially avoidable event outcome reports, which are derived from the OASIS data that HHAs submit to the state. The agency patient-related characteristics and potentially avoidable event reports can be used by HHAs for quality monitoring and improvement purposes. The risk-adjusted OBKey reports provide measures of patient care based on all of the OASIS data items. These reports allow an HHA to proceed to outcome enhancement. It is the outcome enhancement activities that allow an HHA to focus its quality or performance improvement activities on select target outcomes, to investigate the care processes that contributed to these outcomes, and to make agency-specific changes in clinical actions that will lead to improved patient outcomes. Using these reports is a first step toward full implementation of the OBKey program. As a part of the pre-survey preparation, surveyors should access and review the OBCOM and OBKey reports before surveying an HHA. These reports contain valuable information that may assist surveyors in identifying areas to review during the survey and possibly identify individuals or types of patients to include in the sample selection when on site following guidance provided in the Home Health Survey Protocol Enhancements. Effective May 1, 2003, published February 13. 2003, as S&C Memorandums 03-13. The OBCOM Manual, titled Quality Monitoring Using Case Mix and Adverse Event Outcome Report, available on the OASIS website, provides examples of possible surveyor actions related to adverse event outcomes. The OBKey Manual, titled Outcome-Based Quality Improvement Implementation Manual, provides guidance to HHAs for establishing a quality improvement program using the risk-adjusted OBKey reports. This manual is also available on the OASIS website. 1. Agency Patient-Related Characteristics Report. The Agency Patient-Related Characteristics Report presents a picture, or snapshot, of an HHA's patients at the beginning of a care episode for the time period selected for the report. The beginning of a care episode is marked by either a SOC assessment or a ROC assessment. The body of the case mix report describes the characteristics of an HHA's Medicare and Medicaid patients receiving skilled services compared to the rest of the Medicare and Medicaid patients receiving skilled home health services across the country during the same time period. Surveyors should review the case mix outcome report as described in the OBCOM manual and the appendix titled Guidelines for Reviewing Agency, Patient-Related Characteristics, and Potentially Avoidable Event Reports. Any significant results should be identified after reviewing the report and highlights noted. This will allow surveyors to begin to identify potential clinical groups of patients that can be included in the case mix stratified sample for record review and home visits as part of the on-site survey. 2. Potentially avoidable event reports. The potentially avoidable event report displays incidence rates for untoward events or outcomes, comparing one HHA's patients to patients in the CMS OASIS National Repository for the same time period. Potentially avoidable events serve as markers for potential problems in care because of their negative nature and relatively low frequency. The patient listing can be used to investigate the care processes that contributed to these outcomes and to make agency-specific changes in clinical actions that will lead to improved patient outcomes. As a part of the pre-survey preparation, surveyors should access and review the OBCOM and OBKey reports before surveying an HHA. These reports contain valuable information that may assist surveyors in identifying areas to review during the survey. Surveyors do not look at the potentially avoidable event report in a vacuum. They review this report in light of the actual circumstances surrounding the delivery of care to the specific patients. As a part of the Co-PTCS section 484.16, Group of Professional Personnel and section 484.52, Evaluation of the Agency's Program, HHAs are required to conduct an annual evaluation of their total program, including patient services. HHAs are also required to conduct quarterly clinical record reviews to evaluate the care provided under the HHA's policies. The Co-PTCS require an agency to have policies and procedures to promote patient care that are appropriate, adequate, effective, and efficient. HHAs have access to the OBCOM reports and the OBKey reports and may incorporate a review and investigation of these reports into their evaluation and patient care review programs and include them as part of their quarterly record review. 3. Risk-adjusted OBKey reports. The risk-adjusted OBKey reports are the third and final of the OASIS-based reports. These agency-level reports allow individual HHAs to assess their own performance with respect to patient outcomes and compare their performance to a national reference or benchmark. In addition, HHAs can use the OBKey data to target and develop plans of action to improve or maintain HHA performance and patient outcomes. The risk-adjusted OBKey reports became available to all HHAs in February 2002. CMS anticipates that HHAs will choose to use the OBKey reports for quality improvement and for consumer education. In CMS-sponsored demonstrations where the OBKey process has been tested, many HHAs have demonstrated significant improvements in targeted patient outcomes. These data-rich reports now represent a decade of benchmarking that is risk-adjusted for each HHA. This means that every HHA can be compared to the national reference values, regardless of the types of patients it serves, when compared to another HHA. Therefore, an HHA that strives to provide quality care services to its patients will be able to determine its performance and to identify areas for improvement or reinforcement with the quality reports available to them. Process measures were added to the OASIS in 2010. For further information, refer to the PBQI manual, which is located at http://www.cms.gov/medicare/quality initiatives patient assessment instruments/home health quality in its /PBQI process measures HTML. The OASIS C process measure reports are now available in the CASPER reporting system. The reports are located in the OASIS C Quality Improvement Report category. Resources are located on the following CMS websites. PBQI, http://www.cms.gov/medicare/quality initiatives patient assessment instruments/home health quality in its /PBQI process measures HTML. OBKey http://www.cms.gov/medicare/quality initiatives patient assessment instruments/home health quality in its /HHGOSIS OBKey HTML. OBCOM http://www.cms.gov/medicare/quality initiatives patient assessment instruments/home health quality in its /HHGOSISOBCOM-HTML. Section 2202.5b, Case Mix Stratified Sample. Surveyors will continue to select a case mix stratified sample for record reviews and home visits, since this requirement is explicitly referenced in Section 1891 of the Act. For example, surveyors will continue to routinely assess the ability of the HHA to provide quality care by conducting the following activities: evaluating the current status of the patient as reflected in the comprehensive assessment, plan of care, and visit notes; verifying that all drugs and treatments are provided according to a physician's order, and that the HHA has reviewed all drugs for potential adverse effects and drug reactions; reviewing the plan of care to identify whether the HHA used the comprehensive assessment to make sound care planning decisions appropriate to the patient's needs; reviewing the timeliness of services provided to the patient; evaluating the HHA's ability to coordinate care and services; reviewing the patient's progress toward the achievement of desired outcomes; verifying that any changes in the patient's medical condition were reported to the physician and recorded, including documentation of verbal orders with written confirmation; and evaluating the appropriateness of patient's continuation of services or discharge at the time of record review. However, the scope of patients eligible for the case mix stratified sample may include both current and discharged patients. Surveyors may also identify clinical areas and select patients for review on-site as part of their off-site survey preparation. The outcome reports may point to concerns that surveyors need to address during the survey, and surveyors will now be able to include in the sample patients representing the identified concerns. The surveyor should continue to use the HHA's current visit schedule or plans for visits during the week that the surveyoress is on-site to develop the sample for clinical record. Review with home visits. The sample for clinical record review without home visits may include records of patients that have been discharged by the HHA. Section 2202.5c, Privacy Act Requirements. 1. SAW/RO use of OASIS data. Each SA or RO user authorized to access and use the OASIS data, or reports derived from OASIS data, must comply with the provisions governing the privacy and security of this federal information system. Each user with authorized access to the system, records, and reports must agree to effectively maintain CMS-approved administrative, technical, procedural, and physical safeguards to ensure protection of the confidentiality of the patient-identifiable data and to prevent unauthorized access to the data. Each user is required to have individual valid user identification and a secure password. Each user is obligated to protect the confidentiality of the OASIS data. As noted in the June 18, 1999, December 27, 2001, and November 13, 2007, Federal Register, Notices of the OASIS System of Records. No user shall disclose, release, reveal, show, sell, rent, lease, loan, or otherwise grant access to the data to any person. The Federal Privacy Act of 1974 provides criminal penalties and fines for certain violations. The November 13, 2007 notice describes routine uses. 2. HHA use of OASIS data. The HHAs are required, as a part of the co-PTCS, to maintain the confidentiality of all patient-identifiable information contained in the clinical record, including OASIS data and reports, and may not release patient-identifiable OASIS information to the public. Therefore, neither the state nor the HHA may release any of the OBCOM or OBCI reports or the information contained in them. Section 2202.5d. Accessing the OBCOM, OBCI, and process-based quality improvement PBQI reports. The authorized SA and RO user needing access to these reports must have a valid user identification and a secure password. These are obtained by submitting a request to the CMS Central Office via the State System Coordinator through the CMS RO. Approved requests will be assigned the required user identification and password. SAs and ROs will access the OBKey, PQBI, and OBCOM reports from the Certification and Survey Provider Enhanced Reports Casper link located under the Casper title on the Kais to Success website. The Casper homepage will display, requiring entry of the login ID and password necessary to access the reporting tool. For most SA and RO users, this login ID and password are the same that are currently used when accessing the OBCOM reports. HHAs access their OBKey and OBCOM reports in the same way they access their OASIS validation reports, by connecting to the OASIS state system via the CMS and selecting the applicable menu option. The Casper Reporting User's Guide is located on the State OASIS Welcome page. Section 2202.5e. Role of the OASIS Coordinators in OBKey. The OASIS Coordinators work directly with the HHAs to help them access and review the OBCOM, risk-adjusted OBKey, and data management system reports. In addition, the OASIS Coordinators support and train state surveyors to access, review, and interpret the reports as needed. States do not advise HHAs on which outcomes to target, nor do they provide advice on care practices. Section 2202.6. OASIS Instructions. Section 2202.6a. OASIS Guidance Manual. The OASIS Manual was intended for use by HHAs in implementing the regulations for comprehensive patient assessments, including data collection and reporting using the OASIS. The original OASIS User's Manual, implementing OASIS at an HHA to improve patient outcomes, has been archived and can be found at the following web address: http://www.cms.gov/Medicare/Quality Initiatives Patient Assessment Instruments/Home Health Quality init/HHQI archives HTML. The current OASIS manual is the OASIS Guidance Manual and can be found at http://www.cms.gov/Medicare/Quality Initiatives Patient Assessment Instruments/Home Health Quality init/HHGOCs User Manual HTML. The OASIS Guidance Manual provides guidance for HHAs on how to ensure the collection of high-quality, accurate OASIS-C data. It includes both general data collection conventions and item-specific guidance, as well as links to quality-related resources for agencies. It is a streamlined and updated version of the original OASIS implementation manual. It covers the overall OASIS implementation process from a clinical and management perspective and includes detailed information needed to train HHA clinical staff to use OASIS as part of the comprehensive assessment and materials to assist operationally in the implementation of OASIS data collection and data reporting. While the manual has been revised several times over the past decade to reflect changes to the OASIS, the basic structure of the manual has not changed. It provides specific item-by-item information on completion of each OASIS item, general information relevant to OASIS data collection versions of OASIS-C for each OASIS data collection time point, sample pages of clinical record forms for OASIS data time points illustrating how the relevant OASIS items can be integrated, relevant resources for HHAs with hyperlinks when available, information on OBKey, home healthcare regulations related to OASIS data collection, and recommendations for ensuring accuracy of OASIS data. Additional manuals associated with OASIS. The Outcome-Based Quality Monitoring OBCOM Manual can be used in the agency's Quality Improvement Program. The two reports discussed in this manual have been renamed. The Agency Patient-Related Characteristics Report, formerly the Case Mix Report, presents characteristics of the agency's patients at the start or resumption of care. Potentially Avoidable Event Reports, formerly The Adverse Event Outcome Report displays incidence rates for infrequently occurring untoward events outcomes. The Outcome-Based Quality Improvement OBQI Manual is written for agencies wishing to implement activities to improve or maintain OASIS outcomes. The Process-Based Quality Improvement PBQI Manual is written to assist agencies with the use of the process measure reports, which can be used in their annual program evaluation or internal quality improvement activities. This could include the development of and use of best practices within the agency. OASIS National Automation Project. HHA System User's Guide covers the data submission process for HHAs, including how they are to access the OASIS state system, procedures for electronically submitting data including corrections of previously submitted data, and interpretation of feedback reports from the OASIS state system. Materials are updated as needed. Updates are posted on both the CMS and the CAI's Technical Support Office QTSO websites. OASIS Haven System Reference Manual covers the use of Haven software, which was developed to provide HHAs with software for data entry, editing, and validation of OASIS data. It includes information on setting up the software, defining agency and employee information, entering patient and assessment data, and data management functions. This manual, in electronic form, is also included with the Haven software. These are updated as needed, and updates are posted on both the CMS and QTSO websites. As updates are made to the OASIS manuals, states are notified through the CMS contractor of any updates. In addition, all updates to the manuals are posted on the CMS and QTSO website. Section 2202.6b. Other manuals. For SAs only, there is a detailed user's manual for SA system administrators who, pursuant to the regulations, are required to administer and maintain the OASIS system at the state level. This manual includes an overview of the components of the OASIS state system and provides the instructions necessary to administer and maintain them. OASIS Validation Report Messages and Descriptions, December 2009. This updated manual provides the HHAs with guidance which describes the types of reports and messages they can expect to see in response to their electronic submission of OASIS data. This manual is based on version 2.00 data specifications, available in Haven 10.0. This manual assists HHAs in interpreting their feedback reports. OASIS B1 Haven System Reference Manual, December 2007. This manual addresses the use of the current recommended version of the Home Assessment Validation and Entry Haven System software, which is available online. This manual includes information on setting up the software, defining agency and employee information, entering patient and assessment data, and data management functions. Section 2202.6c. Other teaching tools. In addition to the OASIS Guidance Manual for HHAs, there are other sources of information available to help states implement OASIS. They are OASIS-C Educational Resources, http://www.cms.gov/Medicare/Quality Initiatives Patient Assessment Instruments/Home Health Quality in its/Educational Resources HTML. CMS Sponsored Calls http://www.cms.gov/Medicare/Quality Initiatives Patient Assessment Instruments/Home Health Quality in its/Educational Resources HTML. OASIS Training http://www.cms.gov/Medicare/Quality Initiatives Patient Assessment Instruments/OASIS/Training HTML and http://Surveyor Training CMS/HHS.gov/IndexASPs. CAI's QTSO website, in addition to the above sources of information available to help states implement OASIS, IFMC's QTSO website contains current and relative OASIS information, training manuals, Haven software, software patches, slides from past OASIS conferences, and video files that can be viewed online at http:// //www.cutesocom/ Oasis website http://www.cms.gov/Medicare/Quality Initiatives Patient Assessment Instruments /Oasis/index.html. The CMS Oasis website stores and disseminates policy and technical information related to Oasis for use by the home health community. The information posted on the Oasis website is intended to assist HHAs, software vendors, professional associations, and other federal agencies in implementing and maintaining Oasis as efficiently as possible. CMS continually updates and modifies the Oasis website in an effort to provide HHAs and other principals with information necessary to understand and implement Oasis. Oasis helplines, in addition to the Oasis website, CuteSo website, Oasis User's Manual, Oasis Training Manual, and CBT modules available through each SA. HHAs can access help through telephone and email hotlines. The telephone hotline for assistance with Haven and Oasis data submission is 1-877-201-4721. This is a toll-free number available from 7 a.m., 7 p.m. Central Time. After hours, a voicemail box is available to record inquiries. The email address for assistance with Haven and Oasis data submission is help@cutesocom. SA and RO Oasis staff have different telephone, fax, and email hotlines in place for assistance with their clinical questions concerning Haven and Oasis data submission. These hotlines are designed for use by SA and RO staff only. SA personnel should contact their state Oasis coordinator, RO Oasis coordinator, or central office Oasis staff for this information. Haven System Reference Manual. This manual includes information on setting up the software and data management functions. http://www.cms.gov/Medicare/Quality Initiatives Patient Assessment Instruments /Oasis/Haven HTML or https://www.cutesocom/Haven Download HTML. Section 2202.7 Oasis and the Home Health Prospective Payment System, PPS. The Home Health PPS helps to ensure appropriate reimbursements for quality, efficient home health care. Under prospective payments, Medicare pays HHAs a predetermined base payment. This payment is adjusted for the health condition and care needs of the beneficiary. The payment is also adjusted for the geographic differences in wages for HHAs across the country. This and other PPS information is available on the CMS website at http://www.cms.gov/Medicare/Medicare Fee-for-Service Payment/Home Health PPS/index.html. The following are highlights of the Home Health PPS system. Episode Medicare pays HHAs for each covered 60-day episode of care. As long as beneficiaries continue to remain eligible for home health services and episodes are not overlapping and are medically necessary, they may receive an unlimited number of episodes of care. Payments cover skilled nursing, home health aid visits, covered therapy, medical social services, and routine and non-routine. Medical supplies. Home Health Resource Group's HHRG a case mix methodology adjusts payment rates based on characteristics of the patient and his or her corresponding resource needs, e.g., diagnosis, clinical factors, functional factors, and service needs, etc. The 60-day episode rates are adjusted by case mix methodology based on payment policy data elements from the Oasis. The data elements of the case mix adjustment methodology are organized into several dimensions such as clinical severity factors, functional severity factors, and service utilization factors, resulting in Home Health Resource Group's HHRG, a patient payment classification described as case mix. Request for anticipated payment wrap to ensure adequate cash flow to HHAs. The Home Health PPS has set forth a split percentage payment approach to the 60-day episode. The split percentage occurs through the request for anticipated payment wrap at the start of the episode and the final claim at the end of the episode. For the initial episode, there is a 60/40 split percentage payment. An initial percentage payment of 60% of the episode is paid at the beginning of the episode, and a final percentage payment of 40% will be paid at the end of the episode, unless there is an applicable adjustment. For all subsequent episodes for beneficiaries who receive continuous home health care, the episodes are paid at a 50/50 percentage payment split. Outlier additional payments will be made to the 60-day case mix adjusted episode payments for beneficiaries who incur unusually large costs. These outlier payments will be made for episodes whose imputed cost exceeds a threshold amount for each case mix group. The amount of the outlier payment will be a proportion of the amount of imputed costs beyond the threshold. Total national outlier payments for home health services annually will be no more than a fixed percent of estimated total payments under Home Health PPS. Partial episode payment. PEP. The partial episode payment allows the 60-day episode clock to end and a new clock to begin if a beneficiary transfers to another HHA or is discharged with goals met, but returns because of a decline in their condition to the same HHA within the 60-day episode. When a new 60-day episode begins, a new plan of care and a new assessment are necessary. The original 60-day episode payment is proportionally adjusted to reflect the length of time the beneficiary remained under the agency's care before the intervening event. The new episode is paid an initial episode payment rate. The 60-day clock is restarted. Consolidated billing under the PPS. A HHA must bill for all Medicare home health services, which includes nursing and therapy services, routine and non-routine medical supplies, home health aid and medical social services, except durable medical equipment DME. DME is excluded from the consolidated billing requirement. The law requires that all home health services paid on a cost basis be included in the PPS rate. Therefore, the PPS rate will include all nursing and therapy services, routine and non-routine medical supplies, and home health aid and medical social services. Low utilization payment adjustment. LUPA. An episode with 4 or fewer visits is paid as a LUPA, which is the national per-visit amount by discipline adjusted by the appropriate wage index based on the site of service of the beneficiary. Such episodes of 4 or fewer visits are paid the wage-adjusted per-visit amount for each of the visits rendered instead of the full episode amount. Beginning January 1, 2008, an additional payment is made for the first visit in a LUPA episode. Payment rule refinements often impact policy and are published annually at http://www.cms.gov/center/provider-type/home-health-agency HHA Center HTML. Exceptions to OASIS collection and reporting procedures under PPS. There are some exceptions to the general OASIS collection and reporting procedures that are unique to Medicare PPS patients. There is information on the OASIS website that is provided to help HHAs integrate the home health PPS into their existing OASIS data collection procedures. A summary of that information with regard to OASIS data collection and the appropriate M0100 reason for assessment and M2200 therapy need response selection is provided below. A PPS startup. For new patients after October 1, 2000, any applicable skilled care patients, not just Medicare patients accepted for care on or after October 1, 2000, are assessed according to the established time points at Section 484. Example: a patient whose SOC date is October 15 would be reassessed for the need to continue services for another certification period during the last 5 days of the current 60-day certification period. In this example, the follow-up assessment would be conducted during the period 12/9/00 through 12/13/00. B. First 60-day episode. SOC M0100 equals RFA 1 and M2200 equals 0 no or 1 yes. C. New 60-day episode resulting from discharge with all goals met and return to same HHA during the 60-day episode. PEP adjustment. SOC M0100 equals RFA 1 and M2200 equals 0 no or 1 yes. D. New 60-day episode resulting from transfer to HHA with no common ownership PEP adjustment to original HHA. PEP adjustment does not apply if patient transfers to HHA with common ownership during a 60-day episode. Receiving HHA completes OASIS, as applicable, on behalf of transferring HHA. Transferring HHA serves as the billing agent for the receiving HHA. Transferring HHA may continue to serve as the billing agent for receiving HHA or conduct a discharge assessment at end of episode. Receiving HHA starts new episode with SOC if original HHA discharges at end of episode. M0100 equals RFA 1 and M0825 equals 0 no. E. Subsequent 60-day episode, due to the need for continuous home health care after an initial 60-day episode. Recertification follow-up. M0100 equals RFA 4 and M2200. Select 0 no or 1 yes. F. Patient's inpatient stay extends beyond the end of the current certification period. Patient returns to agency after day 60 of the previous certification period. SOC M0100 equals RFA 1 and M2200 equals 0 no or 1 yes. When patient returns home, new orders and plan of care are necessary. At time of transfer to an inpatient facility, the HHA completes the transfer. If transferred without discharging, a new episode is started and a new SOC assessment is completed when the patient returns home. Section 2202.8. Surveying for the OASIS requirements. The Comprehensive Assessment Regulation requires that HHAs use a standard core data set, i.e., OASIS, when evaluating adult, non-maternity Medicare and Medicaid patients, except those receiving exclusively homemaker or chore services. The OASIS meets the conditions specified in Section 1890, 1D of the Act, which requires the Secretary to designate an assessment instrument in order to evaluate the extent to which the quality and scope of services furnished by the HHA attained, and maintain the highest practicable functional capacity of the patient as reflected in the plan of care. These regulatory changes are an integral part of CMS efforts to achieve broad-based improvements in the quality of care furnished through federal programs and in the measurement of that care. Since the requirement to report OASIS data to the OASIS state system is not part of the standard survey process, while determining compliance with the comprehensive assessment of patients is, both off-site and on-site monitoring are required to determine compliance with the OASIS Co-PTCS. The state OASIS educational and automation coordinators can assist with the off-site monitoring for OASIS compliance and in providing available OASIS reports, e.g., data management, quality monitoring, and quality improvement reports to surveyors. HHAs that do not collect and report accurate and complete OASIS data for all applicable HHA patients risk citations at the standard and condition levels. HHAs found not to be in compliance may be subject to enforcement actions and / or termination from the Medicare program. Section 2202.8a. Condition of participation, comprehensive assessment of patient C-section 484.55. This Co-P states that a comprehensive assessment of the patient, in which patient needs are identified, is a crucial step in the establishment of a plan of care. In addition, a comprehensive assessment identifies patient progress toward desired outcomes or goals of the care plan. HHAs complete the OASIS items as part of the clinician's total assessment process. This process is not based solely on interviewing the patient. Conducting a patient's comprehensive assessment involves both observation and interview. These data collection techniques complement each other. Many HHA clinicians begin the assessment process with an interview by sequencing questions to build rapport and trust. Others choose to begin the assessment process with a familiar procedure, such as taking vital signs, in order to demonstrate clinical competence to the patient before proceeding to the interview. HHAs are expected to complete all OASIS items as accurately as possible, while minimizing burden and intrusion on the patient. HHAs should not force patients to cooperate with the assessment process. Rather, they must do the best they can to assess patients who do not fully cooperate with the assessment process. Since collecting OASIS information rarely depends solely on patient interview, HHAs are expected to complete, encode, and transmit all OASIS data items. If patients refuse to answer some questions that are part of the OASIS assessment, HHAs may still deliver care to the patient as long as they complete and submit the OASIS assessment to the best of their ability. States may advise HHAs that seem to report difficulty with specific OASIS items to review the processes of performing a comprehensive assessment with their staff. Sometimes such difficulties indicate that staff might benefit from additional training or retraining in assessment skills. The OASIS web-based training internet site provides additional guidance on OASIS and the comprehensive assessment and how to effectively conduct a comprehensive assessment for clinicians who are challenged by these activities. As stated in the co-PTCS, each patient except those under 18, receiving maternity services, receiving only services such as homemaker or chore services, or, until sometime in the future, receive personal care services only, regardless of payer source, is expected to receive from the HHA a comprehensive assessment that accurately reflects the patient's current health status and incorporates the exact language of the OASIS data items required for the time points specified in this condition. The requirement to collect OASIS data as part of the comprehensive assessment for non-Medicare/non-Medicaid patients is temporarily suspended, effective December 8, 2003, as a provision of the Medicare Prescription Drug Improvement and Modernization Act of 2003. HHAs must continue to comply with the aspects of the regulation at Section 484.5 regarding the comprehensive assessment of patients. HHAs must provide each agency patient, regardless of payment source, with a patient-specific comprehensive assessment that accurately reflects the patient's current health status and includes information that may be used to demonstrate the patient's progress toward the achievement of desired outcomes. The comprehensive assessment must also identify the patient's continuing need for home care, medical, nursing, rehabilitative, social, and discharge planning needs. HHAs may continue to collect OASIS data on their non-Medicare/non-Medicaid patients for their own use. Surveyors must continue to examine the completeness of the comprehensive assessment for all patients during a survey. However, surveyors must not investigate whether the HHA included the specific OASIS items in its patient-specific comprehensive assessments of non-Medicare/non-Medicaid patients, nor cite deficiencies based solely on this finding. The COPE is comprised of the following 5 standards. 1. Initial assessment visit. This standard requires that an initial visit be performed to determine the immediate care and support needs of the patient. The initial assessment visit requirement is intended to confirm beneficiary eligibility, to ensure that the patient's most critical needs for home care services are identified and met in a timely fashion, and to perform the skilled care that was ordered. It is not required that a SOC comprehensive assessment be completed at this visit, although the HHA may choose to do so. If the HHA does not complete the SOC comprehensive assessment during the initial visit, then the comprehensive assessment must be completed and updated according to the required time points. The initial assessment visit is conducted by a registered nurse and must occur either within 48 hours of referral or within 48 hours of the patient's return home from a hospital stay of 24 hours or more for any reason other than diagnostic testing, or on the SOC date ordered by the physician. For Medicare patients, the initial assessment visit must include a determination of the patient's eligibility for the home health benefit. Verification of a patient's eligibility for the Medicare home health benefit, including homebound status, does not apply to Medicaid patients, beneficiaries receiving Medicare outpatient services, or private pay patients. When rehabilitation therapy, speech-language pathology, physical therapy, or occupational therapy is the only service ordered by the physician, and if the need for that service establishes program eligibility, the initial assessment visit may be made by the appropriate rehabilitation professional. For the purpose of the initial visit, a therapy case that includes knowledge of skilled nursing for a one-time visit to remove sutures or draw blood is not considered a therapy-only case. The initial visit must be conducted by the qualified registered nurse. Note, while Medicare pays for occupational therapy, eligibility for the Medicare home health benefit cannot be established based solely on the need for that service. The need for occupational therapy does not establish eligibility for the Medicare home health benefit. However, the Medicare home health patient with multiple service needs can retain eligibility if, over time, the only remaining need is for occupational therapy. Therefore, under the Medicare benefit, the occupational therapist cannot conduct the initial assessment. An OT can conduct the follow-up assessment and those associated with transfers and discharges. Occupational therapy could, however, establish eligibility in some states under the Medicaid program. In the case of Medicaid patients or Medicare patients receiving therapy services, if the need for a single therapy service either establishes eligibility or allows eligibility to continue once it is otherwise established, the corresponding practitioner, including a PT, SLP, or OT, can conduct any of the designated assessments. 2. Completion of the comprehensive assessment. When a patient is first admitted to the HHA, a comprehensive assessment must be completed no later than 5 calendar days after the SOC date. The comprehensive assessment for all Medicare and Medicaid patients receiving skilled services must include OASIS data. OASIS data is not required for non-Medicare/non-Medicaid patients at this time. However, HHAs may include OASIS data if they choose. Additional comprehensive assessments are required throughout a patient's course of treatment. A registered nurse must complete the comprehensive assessment and, for Medicare patients, confirm eligibility for the Medicare home health benefit. When physical therapy or speech-language pathology is the only service ordered by the physician, the PT or SLP may complete the comprehensive assessment. For the purpose of the SOC comprehensive assessment, a therapy case that includes skilled nursing for a one-time visit to remove sutures is not considered a therapy-only case. The SOC assessment in this case should be conducted by the qualified registered nurse, but may be completed by the qualified therapist at subsequent time points. The same discipline is not required to complete the subsequent assessments at every required time point. The HHA can decide how best to approach the assessment process at the required time points. For other than Medicare, OTS may complete the SOC assessment when the need for occupational therapy establishes program eligibility. See note above concerning eligibility for the home health benefit and occupational therapy services. The SOC comprehensive assessment may be completed in more than one visit, as long as it is completed within the 5-day time frame required by the regulations. Non-clinical staff, i.e., those not qualified by current regulation, may not assess patients or complete assessment items. However, non-clinical staff or data entry operators may enter the OASIS data collected by the qualified skilled professional into the computer. Many elements in the clinical records items section which identifies the patient of each OASIS data set, may be completed initially by clerical staff as part of the intake/referral process, but should be verified by the qualified clinician doing the assessment. Master of Social Work, only evaluations. Visits for medical social work assistants only are frequently requested by case managers. A visit for medical social work, in order to evaluate the patient's need or eligibility for community services generally, is not considered a visit to conduct a comprehensive assessment of the patient and would not solely qualify a patient for Medicare home care eligibility. If a physical assessment of the patient is conducted, as is required by the comprehensive assessment regulations, it must be done by a qualified person. In this case, that qualified person must be an RN, PT, SLP, or OT as applicable. Drug Regimen Review. The drug regimen review requirement was moved from the previous plan of care requirements to the new comprehensive assessment requirement to reflect the true nature and purpose of this activity. The comprehensive assessment must include a review of all medications the patient is currently using in order to determine compliance with drug therapy, significant side effects and drug interactions, potential adverse effects and drug interactions, ineffective drug therapy, and duplicate drug therapy. The previous requirements for drug regimen review were modified by eliminating the actual identification of adverse actions and contraindicated medications, and substituting the requirement to review drug therapy compliance, drug interactions, and duplicative drug therapy. 3. Update of the comprehensive assessment. In order to have data that is comparable across HHAs, OASIS data must be collected at uniformly defined time points, including recertification. This requirement is not expected to add to the number of skilled visits provided by the HHA. Many HHAs arrange visit schedules to accommodate home health aid supervisory requirements and patient and caregiver schedules. HHAs are expected to similarly adjust the patient's visit schedule in order to accommodate OASIS time points. OASIS reassessment visits that are not part of a treatment visit are overhead/administrative costs and not separately billable visits. They do not require a physician order. The comprehensive assessment, which includes the OASIS data items for Medicare and Medicaid patients, should be updated and revised no less frequently than. During the last 5 calendar days of the current 60-day certification period, beginning with the SOC date follow-up OASIS data set, or within 48 hours of or knowledge of the patient's return home from a hospital stay of 24 hours or more for any reason, except diagnostic tests ROC OASIS data set. If these 2 assessment time periods fall within the 5-day window, only the ROC assessment must be completed. Within 48 hours of or knowledge of transfer to an inpatient facility, transfer to an inpatient facility OASIS data set, with or without agency discharge. Within 48 hours of or knowledge of the patient's return home from an inpatient stay other than a hospital, see major decline or improvement in the patient's health at 4. Below. Within 48 hours of or knowledge of discharge to the community or death at home discharge OASIS data set, and for non-Medicare/non-Medicaid patients, HHAs must provide each agency patient with a patient-specific comprehensive assessment at the above time points to accurately reflect the patient's current health status and the patient's progress toward achievement of desired outcomes. In a case involving more than one discipline, the SOC assessment should be conducted by the qualified registered nurse, but may be conducted by the qualified therapist at subsequent time points. The same discipline is not required to complete the subsequent assessments at every required time point. The comprehensive assessment updates should include the appropriate OASIS items as indicated on the data set for the respective time points, i.e., SOC, ROC, follow-up, transfer to inpatient facility with or without discharge, and death at home. If home health care is resumed after an inpatient stay, The comprehensive assessment must include the OASIS items appropriate for assessment after an inpatient stay. If the patient is not formally discharged at the time of transfer to an inpatient facility, the agency completes a comprehensive assessment that includes the ROC OASIS data items. If the patient is formally discharged from the HHA, the data collection proceeds on the basis of a new agency SOC date that follows the inpatient stay. Therefore, a SOC comprehensive assessment is conducted. The ROC and SOC minus the patient tracking sheet OASIS data sets are actually the same data set. For purposes of OASIS data collection, the HHA can establish its own internal policies regarding criteria for formal discharge versus interrupting home care services, but maintaining the patient on the HHA admission roster, i.e., placing the patient on hold status. See OASIS and the Home Health Prospective Payment System for exceptions to this general rule. If the patient is under the care of the HHA and is not formally discharged prior to the end of the current 60-day period, the HHA conducts the next comprehensive assessment during the last 5 days of the current 60-day period, beginning with the original SOC date. For example, if the SOC date were June 25, 2014, the patient would be reassessed between August 18 and August 22, 2014. If the HHA transfers a patient to an inpatient facility and places the patient on hold status, no further assessments are conducted and no data is collected while the patient is in the inpatient facility. The HHA is not providing care while the patient is on hold during the inpatient stay. At the time the patient is transferred to the inpatient facility, a Transfer Assessment Response 6 selected for M0100 is completed. When the patient returns to home care, the HHA completes the ROC Assessment Response 3 selected for M0100. See OASIS and Home Health Prospective Payment System for exceptions to this general rule. The ROC assessment is required within 48 hours of the patient's return home from the inpatient facility, unless otherwise determined by physician's orders. The follow-up assessment is required during the last 5 days of the current 60-day recertification period. It is possible for these 2 time periods to overlap. If they do, M0100, ROC Response 3, should be marked. If these 2 periods do not overlap, 2 comprehensive assessments should be completed in accordance with the regulations. One assessment is done for the ROC, while the other is done for the follow-up time point. See OASIS and Home Health Prospective Payment System for exceptions to this general rule. 4. Major decline or improvement in the patient's health status. The OASIS regulations require that assessments with OASIS data collection be performed at certain time points. In the event an HHA determines that a patient's condition has improved or deteriorated significantly at a point in the episode of care that is not already captured at a required time point, the HHA should collect and report additional assessment information. Each HHA should define major declines or improvements in the patient's health status. Thus, the term major decline or improvement in the patient's health status is the impetus for collecting and reporting OASIS data to assess a patient on return from an inpatient facility other than a hospital if the patient was not discharged upon transfer ROC OASIS data set, and, as defined by the HHA, other follow-up OASIS data set. 5. Incorporation of OASIS data items. Integrating the OASIS items into the HHA's own assessment system in the order presented on the OASIS data set facilitates data entry of the items into the data collection and reporting software. Agencies may integrate the items in such a way that best suits their assessment system. Some agencies may wish to electronically collect their OASIS data and upload it for transmission to the state. As long as the HHA can format an output file for transmission to the state that is, in the 1440 8-byte data string format specified by CMS, it doesn't matter in what order it is collected. However, this is not recommended because of the skip patterns that are built into the OASIS dataset. In accordance with the regulations, data must be transmitted in the sequence presented on the OASIS dataset. The Haven software will prompt HHAs to enter data in a format that will correctly sequence it and ultimately be acceptable for transmission. HHAs collecting data in hard copy or electronic form must incorporate the OASIS data items into their own assessment instrument using the exact language of the items. Agencies are expected to replace similar items/questions on their existing assessment tool, as opposed to simply adding the OASIS items at the end. For agencies using software that does not accommodate bolding or underlining, for emphasis of words in the same manner. As the current OASIS dataset, software that capitalizes these words is acceptable, including the M numbers when integrating is also recommended. In this way, the HHA will know that the M-labeled items are items that must be assessed and completed. This will minimize delays in encoding due to incomplete OASIS data items. HHAs may wish to incorporate the assessment categories e.g. ADLs/IADLs, medications, etc. into their own assessment instrument in a different order than what is presented on the OASIS dataset. However, as stated above, the agency must consider any skip instructions contained within the questions in the assessment categories and provide the proper instructions. Section 2202.8b, Record Keeping. Since the OASIS dataset is incorporated into the HHA's comprehensive assessment, the clinical record must be maintained according to existing co-PTCS for clinical records. Records of both active and discharged patients must be readily retrievable for use by SA staff. Surveyors may need to ask for orientation to the HHA electronic health record, as providers have the right to use whatever system of medical records they choose. Surveyors will cooperate and work with facilities that use electronic health records. During the entrance conference, surveyors will establish with the agency the process they will follow in order to have unrestricted access to the medical record. Electronic access to records will not eliminate the need for a surveyor to print a paper copy or to request a paper copy of certain parts of a record. However, the surveyor shall make reasonable efforts to avoid, where possible, the printing of entire records. The surveyor should print or request a paper copy of only those parts of records that are needed to support findings of noncompliance, unless protocols for particular types of surveys require otherwise. Although not required, it is recommended that the HHA print hard copies of the electronic validation records received from Casper and store the validation records in an electronic format for 12 months, until the next set of OBKey reports are available. The validation reports may be needed as evidence if the HHA receives a denial from the MAC for missing OASIS assessments. The OASIS activity report in Casper provides a list of assessments that were submitted and accepted by a HHA in the previous calendar month. Information provided in these activity reports includes patient ID, SSN, patient name, RFA, effective date, and submission date. This report is generated automatically on the 5th of each month. Rejected records are not reported within the activity report, as the patient information is not stored for rejected records. The activity reports can be found with the validation reports under the naming convention of a RMIETXT. For example, reports completed with data submitted and accepted in the month of September 2010 will display as AR092010 TXT. Note, the activity reports are deleted from the state servers on the same cycle as the validation reports. Therefore, it is essential to either save the reports to a secured network as a text file or print and save the report. Section 2202.8c, Condition of Participation, Reporting OASIS Information. Except as specified in the June 18, 1999 notice, HHAs must report OASIS data on all patients except those under 18, those receiving maternity services, and those receiving housekeeping or chore services only in a format that meets CMS specifications. HHAs or contracted entities acting on behalf of the HHA can report OASIS data to the SA using the Haven software CMS provides, or by using Haven-like software that conforms to the same specifications used to develop Haven. Once reported to a CMS central database, the compiled, aggregate OASIS data, i.e., outcome reports can be used by the HHA to determine how it is performing in terms of patient outcomes compared with other HHAs. 1. Encoding OASIS data. HHAs must encode, that is, enter OASIS data into a computer using Haven or Haven-like software, and finalize make export-ready data entry for all applicable patients in the agency within 30 days of the M0090 date of an OASIS data set. Once the OASIS data set has been collected at the specified time points described above, HHAs may take up to 30 calendar days after the M0090 date of collection to enter the assessment into their computer systems. For example, if the comprehensive assessment is completed on May 1, the data must be encoded by May 31. HHAs should consider implementing a tracking system that considers the window for correcting OASIS assessments that need corrections before submission. HHAs will enter their OASIS data into their computers using Haven or Haven-like software. Haven will automatically review the data for accuracy and consistency. It will alert the HHA to make any necessary changes in order to finalize or lock the data. The locking mechanism is necessary to ensure the accuracy of the patient assessment at the point in time that the assessment took place. The locking mechanism will prevent the override of current assessment information with future information. HHAs will be prompted by Haven to export and store encoded data into an electronic file. The export file is transmitted to the state by the HHA. 2. Accuracy of encoded OASIS data. Encoded OASIS data must accurately reflect the patient's status at the time the information was collected. In preparation for transmission to the state, the HHA should ensure that data encoded into the computer is identical to the OASIS data items completed by the skilled professional. HHAs should, therefore, develop systems to ensure that encoded data matches the OASIS data items completed by the skilled professional. Such a monitoring system could include staff appointed to audit sample OASIS records after data is encoded as part of the agency's overall quality assurance program. 3. Transmission of OASIS data. After being exported to a transmission-ready file, the export-ready data should be transmitted to the state or CMS contractor. HHAs transmit OASIS data at least monthly. By the last day of each month, HHAs should electronically transmit all OASIS data made export-ready during the previous month for each patient as applicable based on M0090 date to the SA. Note: CMS requires the encoding and transmission of OASIS information only on patients who are receiving Medicare/Medicaid benefits. This means that for patients with payer source 1 Medicare traditional fee-for-service, 2 Medicare HMO/managed care, 3 Medicaid traditional fee-for-service, or 4 Medicaid HMO/managed care on OASIS item M0150, the HHA must collect, encode, and transmit all required OASIS information to the SA. If Medicare/Medicaid is contributing to the payment of the patient's episode of care, the patient is considered a Medicare/Medicaid patient. The payer source for services provided as part of a Medicaid waiver or home and community-based waiver program by a Medicare-approved HHA are coded as 3 Medicaid traditional fee-for-service at item M0150. For non-Medicare/non-Medicaid patients with only pay sources other than M0150 response 1, 2, 3, or 4, the HHA is not required to assess and collect OASIS as part of the comprehensive assessment and agency medical record. Alternatively, The HHA must use its own comprehensive assessment, as the requirement to collect OASIS data is temporarily suspended. Non-Medicare/non-Medicaid payer sources include private insurance, private HMO/managed care, self-pay, programs funded under the Act. For example, Title Roman III, V. Roman 20, or other government programs. HHAs must have a computer system that supports transmission of OASIS data via the CMS to the SA or other designated location, transmits the export file, and receives validation information. CMS provides HHAs access to the CMS, a private communications network CMS purchased to ensure the security of OASIS data transmissions to the state. Use of the CMS allows for all data submitted to the OASIS state system to be encrypted during the transmission process, precluding any unauthorized sources from intercepting identifiable data. Similarly, data reports, which are sent by the OASIS state system to the HHA across the CMS, are also automatically encrypted and decoded. This network encryption occurs automatically when the HHA uses the CMS and requires no special action on the part of the HHA other than using browser software that supports industry-standard encryption. HHAs need two different sets of user identification numbers and passwords. One set to access the CMS and one set to access the OASIS system. User identifications and passwords to access the OASIS state system to submit assessments or obtain CASPER reports are now specific to individuals too and should not be shared. The CMS is how HHAs transmit their OASIS data. HHAs must install the communications software, which is separate from the Haven software, which will allow them to access the CMS. 1. The supported version of the dialer/CMS vendor is posted on the CMS net page on https://www.qtsocom/mdcnhtml. The help desk that supports the CMS vendor is the CMS help desk. Their phone number is 1-800-905-2069 opt2. In the event that CMS changes telecommunication vendors, updates to requirements will be made known on the All-State Technical Call and on the QTSO website. 2. Instructions for downloading and installing this software are available on the OASIS website. Alternatively, HHAs can call the Haven Help Desk at 1-877-201-4721 for help in obtaining and installing this software. When the OASIS system receives a transmission file, it validates the reported information, while the HHA remains online to ensure that some basic elements conform to CMS requirements, such as proper format and HHA information. Once these file checks are complete, a message indicating whether the file has been accepted or rejected is automatically sent back to the HHA's computer via the agency's communication link. If the submission is rejected, an informative message is sent to the HHA. A file may be rejected for a variety of reasons. For example, the HHA facility ID in the header record may be incorrect and not match the facility ID at the state, or the number of records indicated in the trailer record is different from the actual number of records submitted. The HHA needs to make the corrections and resubmit the file to the state. If the submission passes the initial validation check, the file is checked further for errors or exceptions to the data specifications, and a final validation report is generated up to 48 hours later. 4. Data format. The format used for encoding and transmitting OASIS data should conform with software available from CMS or other software that conforms to the CMS standard layout, edit specifications, and data dictionary including the OASIS data set. Details regarding these specifications are available on the OASIS website. The software must also include the most current version of the OASIS data items, which will be available on the OASIS website at all times. CMS provides registered Haven users with instructions for any revised Haven software. Haven will prompt the user to enter the data items associated with a required time point by providing the user with the correct screens for the specific type of assessment data required. HHAs will be able to use Haven to encode OASIS data, maintain agency and patient-specific OASIS information, and create export files to submit OASIS data to the OASIS system. Haven provides comprehensive online help for encoding, editing, and transmitting these data sets. Additionally, the Haven helpline 1-877-201-4721 is available to HHAs with questions concerning the installation and use of Haven. The export function in Haven produces an ASCII text file from the Haven database. The file meets the OASIS data specifications that must be transmitted to the system. The OASIS system will reject all assessments with a non-Medicare/non-Medicaid payment source. Therefore, Haven will not include these assessments in the export file. The following chart summarizes the required time points and time frames outlined in the regulations for collection, encoding, and reporting OASIS data. OASIS Assessment Reference Sheet. RFA equals Reason for Assessment. RFA Type 01. RFA Description Assessment completed. SOC Further Visits planned. Within 5 calendar days, following the SOC date M0030. 02 SOC, no further within 5 calendar days. Visits planned. Following the SOC date M0030. Locked date. Effective 6/21/2006. No required lock date. Submission timing. Effective 6/21/2006 transmission, required within 30 calendar days of completing the assessment M0090. 03 ROC, after inpatient stay. Within 2 calendar days, following the ROC date M0032. 04 Recertification, completed M0090. Follow-up. Every 60 days following. SOC, no earlier than day 56 and no later than the day 60 on which the certification period ends. 05 Other follow-up complete assessment. M0090 within 2 calendar days following. Identification of significant change of patient's condition. RFA type 06. RFA description assessment completed. Transferred to inpatient facility, not discharged from agency. Within 2 calendar days following or knowledge of DISH/TRANS/death date M0906. Locked date. Submission timing. 07. Transferred to within 2 calendar days. Inpatient facility, following or knowledge. Discharged from of DISH/TRANS/death date. Agency. M0906. 08 died at home. Within 2 calendar days following or knowledge of DISH/TRANS/death date M0906. 09 discharged from within 2 calendar days agency. Not to following or knowledge inpatient facility of DISH/TRANS/death date M0906. Section 2202.8d. Condition of participation. Release of patient identifiable OASIS information. This Co-P states that an agent acting on behalf of the agency, in accordance with a written contract, must ensure the confidentiality of all patient identifiable information contained in the clinical record, and may not release it to the public. The purpose of this provision is to ensure that access to all OASIS data hard copy, as well as electronic data, is secured and controlled by the HHA. This requirement mandates that the HHA ensures the confidentiality of all patient identifiable OASIS information contained in the clinical record, and may not release it for any reason other than for what it is intended, which is to transmit to the SA for the development of outcome reports. The HHA's policies should include assignment and maintenance of secure passwords required for encoding and transmitting OASIS data. Policies should narrowly define the qualifications of individuals having access to the OASIS software. For security reasons, passwords are required in the HHA for access to the agency's computer system. A separate password is required for transmitting the OASIS data files to the SA. Privacy and confidentiality of OASIS data are extremely important. Coverage under the Federal Privacy Act of 1974 begins when the data reaches the SA. The Privacy Act protects OASIS data from unauthorized use and disclosure, and has been effective in ensuring confidentiality of Medicare data. HHAs may choose to encode and transmit OASIS data to the SA themselves, or may contract with an outside entity agent to fulfill these requirements. Agents acting on behalf of the HHA, such as a data entry and submission vendor or contractor, guided by a written contract, are bound by the same confidentiality rules. The HHA is ultimately responsible for compliance with the confidentiality requirements and is the responsible party if the contractor does not meet the requirements. HHAs using Haven are prompted to enter agent information during setup of the Haven program. Data in the hands of an entity contracted by the HHA for data transmission is not covered by the protections of the Privacy Act. Therefore, policies related to the security of the OASIS data set are required. HHAs contracting with outside entities for data submission are ultimately responsible for the confidentiality and use of that data. Agreements between HHAs and their contractors should specify that the data is only to be used for its intended purpose, that is, to create outcome reports. As such, identifiable data must be treated in accordance with state law and must not be disclosed without patient consent. Violations of data confidentiality by an entity contracted by the HHA are the responsibility of the HHA and would constitute condition-level noncompliance. Agents must be aware of the requirements and security policies of the HHA and the SA concerning passwords, as well as the requirements of the OASIS system of records and the Privacy Act. Section 2202.9. Patient notification of OASIS collection and reporting. Under existing patient rights regulations, 42 CFR 484.10a and d, the HHA must provide the patient with a written notice of the patient's rights to confidentiality of medical records in advance of furnishing care to the patient. As part of the patient's rights, the HHA is required to notify the patient of its policies and procedures for disclosure confidentiality of clinical records at the time of admission. The HHA must maintain documentation showing that this requirement has been completed. Therefore, HHAs must develop admission policies that encourage patient compliance with assessment procedures. Failure to collect and report accurate and complete OASIS data on all applicable patients places the HHA at risk of losing its Medicare certification. States will be able to monitor whether HHAs are submitting the required OASIS information through use of data management reports. While patients have the right to refuse to answer questions posed by the HHA, very few OASIS data items rely solely on direct patient questioning. Therefore, HHAs must complete all OASIS data items as best they can, using their assessment skills. Section 2202.9a. Informing patients of OASIS collection and reporting. On or after July 19, 1999, HHAs were required to provide existing patients with privacy notifications. To properly inform patients of their rights under the Privacy Act, the provider must furnish each patient with information required by the Privacy Act. Under the authority of the Privacy Act, notices must contain the following information: the right to be informed that OASIS information will be collected and the purpose of collection. The right to have the information kept confidential and secure. The right to be informed that OASIS information will not be disclosed except for legitimate purposes allowed by the Federal Privacy Act. The right to refuse to answer questions, and the right to see, review, and request changes on their assessment. The Statements of Patient Privacy rights with regard to the OASIS collection: 1 for Medicare/Medicaid patients, 1 for all other patients served by the HHA, are available on the OASIS website as part of the June 18, 1999 Federal Register notice. HHAs must include these statements as part of their admission information. Effective December 8, 2003, HHAs who choose to collect OASIS data on their non-Medicare/non-Medicaid patients must continue to comply with informing patients with privacy notifications. HHAs that do not collect OASIS data on non-Medicare/non-Medicaid patients are no longer required to provide the Privacy Act notification. Section 2202.9b. Right to see, review, and request changes. The term Medicare Beneficiary Identifier, MBI, is a general term describing a beneficiary's Medicare identification number. For purposes of this manual, Medicare Beneficiary Identifier references both the health insurance claim number HICN and the Medicare Beneficiary Identifier, MBI, during the new Medicare card transition period, and after for certain business areas that will continue to use the HICN as part of their processes. The Federal Register notice of June 18, 1999, requires that, under the Privacy Act, Medicare/Medicaid patients have the right to see, review, and request changes in their assessments. HHAs must accommodate patients or their representative who request this review. If the patient disputes OASIS information collected as part of a comprehensive assessment, the HHA has two options. It can agree or disagree with the dispute. 1. The HHA agrees. If the HHA agrees with the patient's request, it accepts the request and changes the applicable OASIS data item S on the assessment. A corrected assessment can be submitted to the state using the terms of the OASIS correction policy. 2. The HHA disagrees. If the HHA disagrees with the patient's request, the patient should request written documentation that the disputed information will not be changed by the HHA, including the reason as why. If a patient chooses to pursue his or her request at the federal level, he/she may contact CMS at 1-800 Medicare, toll-free, for further review of the disputed issue. The individual contesting a record will be advised to write to the Privacy Officer, CMS, 7500 Security Boulevard, Baltimore, Maryland, 21244 to 1850, identify the record, and specify the information being contested. This correspondence must include the HHA's written documentation refusing the change. It must also state the corrective action sought and the reasons for the correction with supporting justification. These procedures are in accordance with the Department's Regulations 45 CFR 5B.7. To preserve the privacy of the OASIS/HHA system of records, the Privacy Act Privacy Officer may require that the individual provide the following information for verification purposes: the system name, Medicare Beneficiary Identifier, and, for verification purposes, the individual's name, woman's maiden name, if applicable, Social Security number, address, date of birth, and sex. Furnishing the Social Security number is voluntary, but it may make searching for a record easier and prevent delay. This information must be notarized to preserve the confidentiality of this process. The HHA Medicare/Medicaid patient who wants to know if there is a record belonging to him/her in the OASIS/HHA system of records, or wants to review the record contained in the CMS OASIS/HHA system of records repository, would follow the same process. The patient can contact CMS toll-free at 1-800 Medicare to get instructions for how to pursue his or her request. Section 2202.10. OASIS and HHAs seeking initial certification. Prior to receiving Medicare approval, HHAs must meet certain requirements, including enrollment and capitalization, and must provide skilled home health services to a minimum of 10 patients, not necessarily Medicare patients, that is consistent with the Medicare Home Health Co. PTCS. This includes compliance with the OASIS collection and transmission requirements. New HHAs must demonstrate that they can transmit OASIS data prior to the initial certification survey. Specifically, new HHAs must apply for a user identification number and password from the State OASIS Automation Coordinator in order to register for an individual user identification and password, which is used to electronically transmit to the OASIS system any encoded and locked SOC or ROC OASIS assessment records for applicable Medicare and Medicaid patients. In a test mode, HHA survey staff must communicate with the OASIS coordinators to determine this aspect of compliance prior to the initial on-site survey. SAs and AOs with deeming authority should not schedule initial surveys until the SA or AO has determined the HHA's status with the OASIS transmission requirement. AOs may contact the state directly to determine the status of the new HHA's activities concerning the OASIS transmission process prior to scheduling the on-site survey. The names and phone numbers of the state OASIS contacts are found on the OASIS website. To acquire an HHA personal login ID, agencies will be required to complete and submit the CMS Net Access Request Form and the OASIS Individual User Account Request Form. The forms are available on the CAI's Technical Support Office website https://www.qtso.com/. To meet the OASIS transmission requirements prior to the initial certification survey, new HHAs need 2 different sets of user identification. Numbers and passwords, one set to access the CMS Net and one set to access the OASIS system. The OASIS Automation Coordinator in each SA should assist the new HHA in obtaining the user identification numbers and passwords and guide HHAs through registration for an individual user identification and password prior to the initial certification survey. Once the communication software and access are in place, the new HHA must demonstrate that it can transmit OASIS data to the OASIS system by 1, making a test transmission of any SOC or ROC OASIS data that passes CMS edit checks, and 2, receiving validation reports back from the OASIS system confirming data transmission. Transmissions of test data prior to the OASIS system successfully uploading the certification kit in Aspen will result in any submission file being processed as a test submission. The user will receive a final validation report showing any warning and fatal error messages associated with each record. However, no data will be stored on the database until the initial certification kit has been successfully uploaded. Unless submitted as a test, once the certification kit is successfully uploaded, all assessment data will be treated as live data and stored on the database. Section 2202.10a. Determining compliance with the OASIS transmission requirements. Depending on the method of transmission the HHA chooses, the SA needs to determine compliance in one of the following ways. If the new HHA chooses to independently transmit OASIS data from its own office, the state HHA survey team and OASIS coordinator must communicate with each other to establish that the new HHA has successfully transmitted test OASIS data using the appropriate user identification numbers and passwords prior to on-site survey. The HHA should maintain all copies of validation reports for its records. If the new HHA chooses to use a software vendor to meet the OASIS encoding and / or transmission requirement on its behalf, the HHA must still establish connectivity to the OASIS system via the software vendor. The HHA should have a written contract that describes this arrangement. The vendor and / or other certified HHA will need to apply for access to this agency as a third-party submitter. Forms are available on QTSO at https www.qtsocom/access.html. The HHA or its software vendor must apply for the applicable user identification numbers and passwords from the SA in order to establish connectivity with the OASIS system. As described above, the HHA survey team and OASIS coordinator must communicate with each other to establish that the software vendor, on behalf of the new HHA, has successfully transmitted test OASIS data using the appropriate user identification numbers and passwords prior to on-site. Survey. The HHA should obtain copies of all validation reports from its software vendor for its records. If the new HHA chooses to use another certified HHA to meet its transmission requirements, for example, another established HHA in the chain or other established but non-related HHA, the HHA must still demonstrate connectivity to the OASIS system via the other established certified HHA. The new HHA or other HHA must apply for user identification numbers and passwords, unique to the new agency, from the SA, in order to establish connectivity with the OASIS system. The new HHA must have clearly written policies outlining the procedures in place with the other HHA with regard to OASIS collection, encoding and submission to the OASIS state system, and the sharing of feedback reports from the OASIS system with the new HHA. Section 2202.10b. HHAs seeking initial certification through deemed status. An HHA may choose to obtain initial Medicare certification by electing the deemed status option through an approved AO that has been granted deeming authority for Medicare requirements for HHAs. There are currently 3 AOs with deeming authority for HHAs: the Joint Commission TJC, the Community Health Accreditation Program CHAP, and the Accreditation Commission for Healthcare, Inc. HHAs seeking initial certification through the deemed status option must still apply to the SA for user identification numbers and register as an individual in order to demonstrate compliance with OASIS submission requirements prior to approval. When the SA receives a request from an HHA interested in seeking Medicare deemed status through accreditation by an AO with deeming authority, the state ensures that the HHA understands its obligation to meet the OASIS requirements, even when the AO conducts the initial certification survey. This includes compliance with the OASIS collection and transmission requirements. If the SA receives a certification packet from an HHA seeking Medicare certification based on its accreditation through a deemed status program, it is the SA's responsibility to determine that the HHA meets its OASIS transmission responsibilities. The OASIS transmission responsibility may be met in one of the 3 ways described above. Section 2202.10c. Exceptions to demonstrating compliance with OASIS submission requirements prior to approval. New HHAs that intend to admit or treat only patients to whom OASIS currently does not apply, i.e., patients under 18, maternity, and patients receiving only unskilled care or chore services, are not expected to demonstrate compliance with OASIS submission requirements prior to approval. These HHAs must attest this intention to the SA. After certification, if there is a change in the HHA's policies that includes the acceptance of patients to whom OASIS applies, the HHA is expected to install the necessary communications software and contact the SA and CMS for the applicable user identification numbers and passwords. Section 2202.10d. Compliance dates and PPS. Compliance with the rest of the co-PTCS is determined via an on-site survey by the SA and any applicable subsequent actions or revisions required of the HHA following the initial survey. After survey, the new HHA cannot bill Medicare for payment of services to Medicare beneficiaries until the effective date for Medicare participation has been determined by the CMS RO. Realistically, notification of the effective date may come many weeks after the initial survey of the HHA. In addition, the date of official compliance may vary depending on the outcome of the on-site survey. As described in Section 2780, the date of compliance is either 1. The date the on-site survey is completed if, on the date of the survey, the HHA meets all co-PTCS and any other requirements required by CMS. Or 2. If the HHA fails to meet any of the requirements as a result of the on-site survey, compliance is the earlier of the date the HHA meets all enrollment requirements, or the date the HHA meets all the co-PTCS and submits an acceptable plan of correction for standard-level deficiencies. Payment under Medicare for services provided prior to the effective date for Medicare participation is not permitted. As such, it is important that new HHAs seeking payment under Medicare establish the required 60-day episode on or after the effective date of their Medicare participation. Section 2202.10e. Instructions for handling Medicare patients in HHAs seeking initial certification. The Medicare OASIS submission and billing process cannot begin until the effective date of the HHA's CCN, which is assigned after the RO has done the review of the initial survey findings, plan of correction if one was necessary, documentation on whether the HHA has met the enrollment requirements, and documentation that the MAC has completed the second capitalization review. Enrollment requirements include completion of the CMS Form 855A, first capitalization review, completion of a survey by a SA or RO with the HHA in compliance with the co-PTCS, additional development by the MAC, and second capitalization review by the MAC. After it is assigned its CMS certification number CCN by the RO, the HHA should do a new SOC assessment, RFA1, on each of its Medicare-eligible patients. This assessment visit date should be consistent with the first billable visit date after Medicare participation becomes effective. Once the CCN has been assigned, the HHA can go back and encode the collected OASIS information, obtain the necessary payment system codes for billing under PPS, and transmit the information to the OASIS state system as production, i.e., live data. The date of this assessment will become day 1 of the HHA's first 60-day episode under Medicare, as long as the assessment was done in conjunction with a billable visit. Warning messages related to noncompliance with timing requirements are unavoidable and are to be expected in this situation. If compliance, i.e., the effective date is not the date of the on-site survey, it will be based on D.2. Above, as further outlined in Section 2780. The HHA should, again, do a new SOC assessment, RFA1, on each of its Medicare patients at the first billable visit after the anticipated date of compliance. Delay encoding and transmitting the assessment until the CCN is assigned, and continue as outlined in the paragraph above. That is, the HHA should go back and encode the collected OASIS information, obtain the necessary payment codes for billing under PPS, and transmit the information to the OASIS state system as production data. As above, warning messages related to noncompliance with timing requirements are unavoidable and are to be expected in this situation. If the new HHA did not conduct a SOC RFA1, ROC RFA3, or follow-up RFA4 OASIS assessment during the time between the effective date for Medicare participation and the date the HHA learns of its approval, the HHA should conduct a SOC assessment as soon as possible. This assessment can be used to generate the payment code used for billing under Medicare. The SOC date should reflect a date that is consistent with the first billable visit after the effective date for Medicare participation, as stated above. Section 2202.10f. Instructions to new HHAs concerning all other patients. Non-Medicare and non-Medicaid patients do not require OASIS collection or transmission. For all other patients treated by the HHA, i.e., non-Medicare or non-Medicaid patients, if a new start of care date is not required by the patient's payer source, the HHA should encode and transmit all OASIS assessments as required by current regulation that were collected after the effective date of Medicare participation. These assessments should be submitted in the production mode using the newly assigned provider number. The HHA should continue with the OASIS assessment schedule already established based on the patient's admission date. Section 2202.11, Correction Policy. HHAs have the ability to electronically correct nearly all errors found in their production OASIS submissions. SAs should not be accepting requests for manual key field changes. Instead, HHAs should use the inactivation procedures to correct assessments containing key field errors. Haven 5.0 and above will give HHAs the ability to electronically correct nearly any kind of assessment errors. CMS strongly recommends that all HHAs install the most updated version of Haven. OASIS Haven software may be adjusted over time to incorporate changes in system components as well as incorporate bug fixes. Adjustments will be posted to the Haven data entry software webpage on the CMS website at http://www.cms.gov/Medicare/Quality Initiatives Patient Assessment Instruments/OASIS/index.html. Redirect =/OASIS/ and on the OASIS state systems. Key fields and non-key fields. A description of key fields is below. Non-key fields are all other fields making up the OASIS data set that are not key fields. Patient identifiers. M0040, Pat L name M0040, Pat F name M0064, SSN M0066, Pat birth DT M0069, Pat gender. Key fields. Patient last name, patient first name, patient social security number, patient date of birth, patient gender. HHA identifiers. HHA agency ID. Unique agency ID code. Assessment event identifiers. M0100, ASNT reason, M0090, info completed DT. M0030, start care DT M0032, ROC DT M0906, DC, TRAN DTH-DT. Reason for completing assessment date assessment information. Completed. This is a key field only on recertification or follow-up assessments, where RFA equals 04 or 05 SOC date. This is a key field only on SOC assessments, where RFA equals 01 ROC date. This is a key field only on ROC assessments, where RFA equals 03 discharge, transfer. Death date. This is a key field only on transfer to inpatient facility assessments, where RFA equals 06 or 07. Death at home assessments, where RFA equals 08, and discharge assessments, where RFA equals 09. HHAs can electronically correct key field errors in production records, in addition to non-key field errors, and also remove erroneous records using an automated methodology called inactivation. With the ability to inactivate erroneous OASIS assessments, as described below, HHAs will be able to remove assessments from the OASIS state system's active database that have been submitted in error. These records are not actually deleted, but are moved from the active database to a history database that contains records that have been modified or inactivated. This approach keeps an audit trail of modified and inactivated records, but hides them from the normal OASIS state system reporting procedures. Section 2202.11a. Determining when to inactivate an assessment. If an error has been made in one or more key fields, or if an assessment was submitted in error, the HHA should electronically inactivate it. Use of the inactivation procedure is not applicable to correcting assessments with only non-key field errors. In other words, if an assessment contains errors in only non-key fields, then correction type 3 described at C.3 below should be used. In order to determine whether to submit an inactivation request, the user should apply the following rules. 1. Assessment submitted in error. If an assessment was submitted in error, i.e., it should never have been submitted, it must be inactivated. For example, if a discharge assessment was submitted by the therapist, however, the patient is still being visited by the nurse, an inactivation request must be submitted for the erroneous discharge record. Another reason to inactivate an assessment would be if the submitted assessment contained the wrong patient name. 2. Error in key field. If an assessment was submitted which contained an error in any of the key fields listed above, then an inactivation request must be submitted. Normally, the HHA will also submit a new, corrected assessment in this situation. For example, if the HHA discovers that the patient's last name on the SOC assessment is spelled Smythe, while on the follow-up assessment it is spelled Smith, it needs to make the appropriate correction. When the HHA determines the discrepancy, the incorrect record must be inactivated and a new corrected record must be submitted. 3. Submission of incorrect format. Private pay assessments are now rejected upon submission and do not require inactivation. Note, there is no automatic mechanism to reactivate a record that has been inactivated. Consider the case where a discharge assessment is submitted to the OASIS state system for a patient, but is inadvertently inactivated. There is no means to undo the inactivation and thereby reactivate this discharge. Instead, the HHA must submit the discharge record again. An inactivated record can only be undone by the resubmission of the record. Section 2202.11b. Deleting assessments. In certain infrequent situations, inactivation is not sufficient to correct assessment errors. Since inactivation alone does not remove the assessment record from the OASIS system, two situations require deletion of an erroneous assessment rather than inactivation. States will need to continue to submit deletion requests on behalf of HHAs, upon request, to the CMS Division of National Systems DNS contractor when the following situations occur. 1. Assessment deletion. The HHA submits identifiable data on patients not defined by the OASIS system of records. The OASIS repository is limited to the collection of identifiable data on patients who are Medicare and or Medicaid patients receiving skilled care with certain exceptions, i.e., under 18 and maternity patients. In instances where the OASIS system has received OASIS data on patients not included as part of the OASIS system of records, the data needs to be deleted. Example, the HHA checks response 1, 2, 3, and /4 in the current payment source M0150 field for that assessment record, and it should not have. The record is transmitted to the OASIS system and accepted. The HHA determines that the response for M0150 is in error. The patient was not a Medicare or Medicaid patient. Therefore, this data should not be stored on the OASIS database. Example, the HHA submits an incorrect birth date on a patient who is a year old, which was accepted because the birth year identified the patient as being over 18. The patient was actually under 18 and the assessment should be deleted. Deletion request forms are located on the state password protected page of the QTSO website. CMS requires the signature of the agency administrator and of the SA before the deletion will be processed. The HHA must send the deletion request form in writing to the state OASIS coordinator to request deletion of an assessment. The state will then send in writing to DNS contractor the reason this data should be removed from the state's database. Asterisk effective dates are M0030, Start Care DT for RFA types 01. M0032 ROC DT for RFA type 03. M0090 info completed DT for RFA types 04 and 05, and M0906DC tran DTH DT for RFA types 06, 07, 08, and 09. 2. File deletion. The HHA submits a file as production data instead of test data. The state must verify the HHA's claim of production data versus test data. The HHA must send the following information in writing to the state coordinator to request deletion of a file: HHA name, HHA ID, submission date/time, submission batch ID, and reason this data should be removed from the state's database. The state will then send in writing to the CMS contractor following information to request deletion of a file: HHA name, HHA ID, submission date/time, submission batch ID, and reason this data should be removed from the state's database. The following events will then take place. The CMS DNS contractor will create a report from the above listed information. This report will be sent to the state OASIS coordinator for him/her to verify the accuracy of assessment tests to be deleted from the state's database. The OASIS coordinator will notify the CMS DNS contractor that the information is accurate and should be deleted from the state's database. The CMS DNS contractor will consult with CMS on any questionable deletion requests. The CMS DNS contractor will delete the data upon approval from CMS. The CMS DNS contractor will keep a log of all deleted data from each state's database. The deletion request information should be communicated to the CMS DNS contractor by one of the following methods of communication. The deletion request form directs states to forward the signed form to the CMS DNS contractor via certified mail to the address on the form. The deletion request sheets must be submitted to the CMS DNS contractor by the state. Requests received directly from HHA will not be accepted. Note, this information must not be sent via email due to the confidentiality of the information. Section 2202.11c. Types of corrections an HHA can make in Haven. Haven offers the following menu of corrections an HHA can make. 1. Assessment was submitted to the state and was rejected. The HHA can unlock the assessment, make the necessary changes, and resubmit it. Because of the built-in edit checks, HHAs using the Haven software should not expect records to be rejected by the OASIS system for this reason. Note that the following examples are provided for illustration purposes to troubleshoot Haven-like software, but cannot occur in Haven. Example 1. The HHA agency ID field in one or more assessment records does not match the HHA agency ID in the header record of the submission file. The entire submission file is rejected and no data is loaded into the state database. Example 2. The patient's last name was missing from the assessment file data record. The HHA may have inadvertently left this field blank. The OASIS system must have the patient's last name. The data record in this example would be rejected, and no data from this record would be loaded into the state database. In these examples, the HHA would make the necessary corrections and resubmit the record. Since the OASIS system never accepted the original assessment, the correction number field is not incremented in this situation. HHAs may still receive a warning if submission/timing guidelines have been exceeded. 2. Assessment was submitted to the state and was accepted. Correction to key fields is necessary. With the implementation of the OASIS system update, this option will display in Haven but will no longer be available and is disabled in the Haven software. To correct an assessment with key field errors, first inactivate the assessment, then create a new assessment for resubmission, as applicable. See correction type 4 below. 3. Assessment was submitted to the state and was accepted. correction to non-key fields is necessary. If an HHA determines that a correction S must be made to non-key fields, only i.e. any fields in the OASIS data set not contained in the key fields listed above, the HHA should reopen the assessment, revise the targeted non-key fields, and relock and resubmit the corrected record. The lock date changes to reflect the date the correction was made. Note, correction num is a counterfield contained in the programming of the Haven software used to track corrections made to an assessment record. The counterfield is set to 00 when an assessment record is initially locked. The counterfield is incremented in this case. Both the original assessment and the corrected assessment will be stored in the state database. 4. Assessment was submitted to the state and was accepted. Inactivation of the assessment is necessary. This is an option in Haven that allows HHAs to correct key field errors by inactivating the assessment tests containing key field errors and resubmitting a new, corrected assessment. Unlike making non-key field changes, as described in correction type 3 above, the HHA does not simply unlock the assessment record, make the necessary key field changes, relock the record, and resubmit it. Instead, the HHA is taken directly to the assessment in question where it can be viewed in a read-only format. While in read-only mode, when the HHA confirms that the assessment should be inactivated, Haven will ask the HHA to commit to this selection. The correction number field on the Haven management screen displays an X, and the assessment status is set to export ready. The value of 99 indicates that this assessment has been inactivated. When the HHA selects this correction type, a copy of the original assessment record is created. To resubmit the assessment with the necessary corrections, the HHA first exports the assessment that is being inactivated. From the Haven management screen, the HHA then selects the inactivated record in question and clicks on the Correct Assessment button. A pop-up box will appear asking if the HHA wants to create a new assessment containing data from the inactivated assessment. When the HHA clicks on the OK button, a copy of the original assessment appears. The HHA makes the necessary changes and resubmits the assessment. The correction number for this assessment is reset to 00. Section 2202.11d. Documentation of corrected assessments. When a comprehensive assessment is corrected, the HHA must maintain the original assessment record as well as all subsequent corrected assessments in the patient's clinical record, in accordance with current clinical record requirements at 42 CFR 484. If maintained electronically, the HHA must be capable of retrieving and reproducing a hard copy of these assessments upon request. It is acceptable to have multiple corrected assessments for an OASIS assessment, as long as the OASIS and the clinical record are documented in accordance with the clinical record requirements at 42 CFR 484. Section 2202.11e. Clinical implications of corrected assessment records. When corrections are made to an assessment already submitted to the OASIS state system, the HHA must determine if there is an impact on the patient's current care plan. If there is an impact, in addition to the correction made to the assessment, the HHA must make corresponding changes to the current care plan. If there are any other records where the correction has an impact, for example, the Home Health Resource Group, the Plan of Treatment CMS Form 485, or the request for anticipated payment, the agency should make corresponding changes to that record, as applicable. The agency should establish a procedure to review the impact of any corrections made to assessment records and make corresponding changes to other records that are affected. Section 2202.11f. Regarding corrections in lieu of required assessments. Collection and submission of information on SOC, ROC, follow-up, other follow-up, transfer, and discharge assessments are required by the Comprehensive Assessment Requirements at 42 CFR 484. The correction process described here does not preclude the need for accurate patient assessment at the required time points. The inactivation of an assessment and subsequent correction and resubmission of a new assessment, or a correction to a non-key field, cannot be used in lieu of the appropriate OASIS assessment for documenting an unanticipated change in patient condition that was not envisioned in the original plan of care. If there is an unexpected change in the patient's clinical condition due to a major decline or improvement in health status that warrants a change in plan of treatment, the appropriate OASIS assessment is expected to document the change, i.e., the ROC or other follow-up assessment, as appropriate. This is in keeping with the regulation at 42 CFR 484.20b for accuracy of encoded OASIS data that states, the encoded OASIS data must accurately reflect the patient's status at the time of assessment. The HHA should have one document for the patient's assessment, care planning, and payment purposes. Section 2202.11g, Timeliness of Corrections. HHAs are urged to make corrections and slash or submit inactivations as quickly as possible after errors are identified, so the state system will be as current and accurate as possible prior to HHA submission of the RAP. This also affects the data used to calculate the HHA's OBGI and OBCOM reports. Section 2202.11h, Multiple corrections in a record. Correcting assessments with key field errors can only be done by inactivating the incorrect assessments and replacing them with the corrected assessments, as previously described above. Correcting assessments with non-key field errors can only be done by reopening the assessment, revising the targeted non-key fields, relocking and resubmitting the assessment, as previously described above. Correction num, the counter field is implemented in non-key field changes. For more specific information concerning the process of correction and inactivation, refer to the OASIS data specification notes on the OASIS website. See below for a flow chart depicting the most common situations necessitating corrections. Section 2202.12, OASIS State System. The purpose of the OASIS State System is to provide computerized storage, access, and analysis of the OASIS data on patients in HHAs across the nation. The OASIS State System is intended to create a standard, nationwide system for connecting HHAs to their respective SAs for the purpose of electronic interchange of data, reports, and other information. The automated OASIS system is a critical component of SA and CMS operations. It is a key part of a fully integrated system of clinical data, facility demographics, survey findings, and SA operations information. The OASIS State System also provides the means for transmission of assessment data to CMS for validating payments under prospective payment for HHAs. The OASIS State System implementation involved a CMS-funded installation of standardized computer hardware and data management software at each SA to allow electronic transfer of OASIS data elements from all HHAs to the state. The data management software validates the basic accuracy of the data and rejects submission files batches with fatal file errors, such as a missing or invalid agency ID, incorrect record length, or missing headers or trailers. Validates individual assessment records and rejects those records with fatal record errors. Stores and reports non-fatal or warning errors on records that are accepted by the database, and builds a database of OASIS information for all applicable patients of each HHA in the state. In accordance with the regulations, HHAs will collect SOC, ROC, follow-up, discharge to the community, transfer to an inpatient facility with or without discharge, and death-at-home OASIS data on all patients except those under 18, those receiving maternity services, and patients receiving only housekeeping or chore services under the care of the HHA as of July 19, 1999, as applicable. The requirements for OASIS collection, encoding, and transmission apply to all Medicare and Medicaid patients, including Medicare and Medicaid HMO/managed care patients, with the exception of those listed above receiving skilled services. The applicability of the comprehensive assessment and reporting regulations to patients receiving personal care-only services, regardless of payer. Source has been delayed until further notice. In addition, the collection, encoding, and transmission requirement for non-Medicare and non-Medicaid patients receiving skilled care is also temporarily suspended until further notice. Until collection and submission of non-Medicare/non-Medicaid patient assessments is required, HHAs must meet all other requirements of the Comprehensive Assessment Regulation, including conducting SOC comprehensive assessments, and updates at the required time points on all non-Medicare and non-Medicaid patients receiving skilled services. Although the OASIS data items are not required, this means that only the requirement to collect, encode, and transmit OASIS data is delayed. The completion of the comprehensive assessment and updates at the required time points is required in order to ensure quality of care for all patients and to encourage the use of OASIS as the basis for care planning. Effective August 24, 1999, and at least monthly thereafter, HHAs should transmit to the SA all applicable OASIS data collected and encoded from July 19, 1999, and monthly thereafter. Monthly transmissions should include all OASIS data encoded in the previous month. OASIS activities will provide enhanced analytical capabilities at the SAs, electronic transmission from the state databases to a national repository, integration with performance indicators for quality oversight and survey planning by the SA, a basis for maintaining prospective payment of HHAs, research directed at improving quality of care, feedback to providers, and dissemination of information to purchasers, beneficiaries, and others. Section 2202.12a, System Description. The CMS has provided each state with an OASIS state system composed of standardized hardware and software platforms scaled to meet each state's anticipated processing volumes and a standardized operating system. The hardware is comprised of a communication server, database server, the local area network, and other peripheral devices. The OASIS state system deployed to each state was specifically engineered and purchased to fulfill the OASIS requirements of Section 484 and Section 488, as well as to incorporate additional CMS provider assessment processes as they become effective, and operational support of Medicare and Medicaid survey and certification pursuant to Section 1864 of the Act. The system was designed with an emphasis on flexibility and integration, so that additional software components could be easily added to provide the states with new related functionality, such as outcome measures and expanded analytical reports, as well as applications that support future assessment processes for other provider types, and new capabilities to support survey and certification operations. Since each state's OASIS system was specifically sized to accommodate these planned functions, the SA should not add other non-CMS prescribed applications or databases to it. Section 2202.12b, Administration Requirements. The OASIS state system in each state is part of a comprehensive, quality improvement and evaluation system that will not only fulfill OASIS administration requirements, but also grow to support other assessment-based programs, quality and performance indicators, and new, integrated survey and certification data systems. The state should use the OASIS state system for editing, storing, and processing OASIS data to support CMS OASIS operating requirements within the state and to transmit the required OASIS data to the CMS OASIS repository. As noted above, the state may not add additional software applications to the OASIS system without a specific directive from CMS. the states are directly responsible for fulfilling requirements to operate the OASIS state system. However, the state may enter into an agreement with the state Medicaid agency, another state component, or a private contractor to perform day-to-day operations of the system. The state must obtain RO approval prior to entering into an agreement with another agency. Such agreements should address the following provisions. 1. Meets confidentiality requirements. Federal Privacy Act, 5 U.S.C. Section 522A, HIA of 1996, other applicable federal data acts. Section 1902A7 of the Act, applicable state standards and industry security standards. 2. Gives the SA real-time access to the system to fully support all OASIS-driven functions which will be required of the survey agency, e.g., quality indicator reporting, survey targeting, etc. Or if a contractor is performing analysis for SA contract, provides the details on how this is to be conducted. 3. Complies with the need for high-capacity, fault-tolerant network connections to ensure reliable support for the SAs, CMS national database, and any other daily operations, e.g., intermediary medical case review, Office of the Inspector General or Department of Justice fraud and abuse activities, which will be affected by this system. Assures hardware will be properly maintained and upgraded as necessary to meet any future CMS or SA requirements. Assures adequate backup of all data. 4. Includes SA responsibilities for reporting OASIS data to a central repository at CMS. Designates responsibilities for edits and cleanness of data. Designates responsibilities for generating and communicating facility error reports. Describes what kinds of communication will be established, e.g., a state-specific internet and / or intranet web pages, newsletters, etc., their content, and who will produce / maintain / distribute these communications. If there is a separate database, designates who is responsible for operating and maintaining the CMS-provided equipment, and who will assure the viability of the CMS database. 5. Lists responsibilities of contractor and / or state for training and support operations. Includes at least who will provide facility and OASIS software vendor startup training and ongoing customer / facility support / troubleshooting. Provide internal training and daily user support within the SA. Work with program staff to integrate the OASIS system into SA functions. Train SA staff on aspects of analytical system, e.g., Aspen upgrades and performance measure / quality indicator, linked reports. Handle system operations functions associated with transmission logging, error tracking and resolution, system archival, and process reporting. And designate who is responsible for determining facility transmission schedules. 6. Delineates how state will fund the monthly line charges associated with installation, maintenance, and transmission of the OASIS data from the facilities to the contractor and between the contractor and state, e.g., built into contract costs or is an outside ongoing cost to the SA. And 7. Specifies whether it is the contractor's or the SA's responsibility for systems maintenance for commercial, off-the-shelf, OASIS hardware and software components. Note: standardized OASIS software components that are developed and distributed by CMS will be maintained and upgraded centrally by CMS. Under any such arrangement, the state must be guaranteed real-time, priority access to this system to fully support all OASIS functions. All CMS privacy and confidentiality requirements must be met. Off-site operation of the OASIS state system will require high-capacity, fault-tolerant network connections to ensure reliable support for the state's daily operations that will be affected by this system. The state also must use the OASIS state system for reporting OASIS data to the CMS Central Repository. To promote national consistency in OASIS system operations and troubleshooting, each state should designate one individual as the OASIS Automation Project Coordinator. This person is CMS key contact within each state for managing OASIS state system issues and must be familiar with the use of the OASIS automation and transmission process. Technical knowledge of information systems is useful but far less critical than an understanding of the OASIS processes, good communication and project management skills, and the ability to educate and work with providers and vendors to ensure successful implementation of an automated process for all providers. The state should designate additional staff, including a system administrator, to manage the technical aspects of running the OASIS state system and support staff to assist in processing corrections, answering routine user questions, assigning passwords, etc. With respect to systems maintenance, the OASIS state system installed in each state is comprised of commercial, off-the-shelf hardware and software components that are generally covered under typical umbrella service agreements that the state may already have in place for maintenance of data processing equipment. Those OASIS software components that are developed and distributed by CMS will be maintained and upgraded centrally by CMS. The state will not be responsible for these software upgrades. To the extent that the state has developed customized external applications for using information obtained from the OASIS database, e.g., to support Medicaid payment, the costs of developing and maintaining these additional software applications and any related hardware components will not be funded through the survey and certification budget. Section 2202.12c. Validation and editing process. Each time an HHA accesses the OASIS state system and transmits an assessment file, it performs a series of 3 levels of validations. 1. Fatal file errors. The first check examines the basic structure and integrity of the submission file. If there are fatal flaws in the file batch of records, then the entire file is rejected, and the HHA is notified of the reason for rejection in the initial feedback report. In the event that a batch is rejected due to fatal file errors, the HHA will not receive a final validation report. Fatal file errors are listed in the data specifications, which can be found on the OASIS website. Rejected files must be corrected and retransmitted. 2. Fatal record errors. If the file structure is acceptable, then each record in the file is examined individually for fatal record errors. These errors may cause an individual assessment within a submission to be rejected. Assessments that have fatal records are not stored in the database. The HHA is informed of fatal record errors on the final validation report. OASIS data specifications outline the valid data requirements and are posted on the OASIS website. The initial feedback and final validation reports are available shortly following the submission of a file. 3. Non-fatal or warning errors. If there are no fatal record errors, the record is loaded into the state database, and the record is further examined for non-fatal errors. Any non-fatal errors are reported to the facility in the final validation report. Non-fatal errors include missing or questionable data of a non-critical nature, record sequencing, field consistency errors, invalid value, and range errors. The initial feedback report is available immediately following the submission of a file. The HHA should obtain this report before logging off to ensure the submission has been processed. Since the final validation report is not available for up to 48 hours after the initial feedback report, the HHA may, based on experience, choose to obtain this report on a subsequent log-on. The validations and edits described above fulfill all of CMS editing requirements under Section 488.68. Also, states may not modify any aspect of the CMS OASIS standard system, including these validations and edits, the standard record layout, and the software code and specifications on which the system is based. States that use OASIS data for Medicaid payment may require additional assessment information not required by CMS OASIS system. Some states may impose additional edits on Medicaid assessments. However, a state may not interfere with, modify, or delay the transmission of records meeting CMS edit standards from a Medicare-certified or Medicaid-approved agency to the CMS OASIS standard system. Furthermore, the state may not impose any requirements that modify the clinical accuracy of CMS-prescribed OASIS records, reports, or calculations. Section 2202.12d. Reports. The OASIS state system provides reports to both the state and the provider. These reports, which focus on errors in OASIS submissions, are particularly key to working with agencies to ensure successful transmission of OASIS data. Refer to the State OASIS Administration Manual, available on the QTSO website http://www.qtso.com/ for information about specific reports provided. Monthly validation of OASIS submission is highly recommended for both states and providers, as OASIS is required for payment, pay for reporting, and medical review. Section 2202.12e. Replication to the CMS repository. Each state's OASIS database will be transmitted to the CMS Central Repository at least monthly using a data replication process initiated by CMS. Since the process will be managed by CMS through an automatic polling process, the states will not actually have to transmit the data. However, the state must ensure that the CMS data line established for this purpose is accessible to CMS at all times for testing and monitoring purposes. Actual access to the Oracle assessment data tables may be controlled by the states, but in such cases, CMS recommends that a fixed schedule be established with CMS Central Office. The OASIS state system and CMS data line meet all industry security standards. However, if the state is concerned about security, it may establish a firewall and electronic block to restrict access to the state's portion of the network. Access must not be restricted to the CMS-supplied OASIS system. Section 2202.12f. System security. As distinguished from confidentiality and privacy, which primarily focuses on the rules for release of information when it is authorized, security relates to the means by which the information is protected from unauthorized access, disclosure, and misuse. As part of the new requirements under Section 488.68, states must ensure that electronic data in the OASIS state system are protected to the same degree that paper records containing any identifiable data must be safeguarded. Additionally, any printed copies of reports from the system must be maintained in a secure locked area while they are needed and properly disposed of when no longer needed. States must issue a policy that defines and limits the qualifications for an individual to access the OASIS state system. The system administrator must issue passwords and user identifications in strict adherence to those requirements. State personnel who receive passwords must be aware of the requirements of the state's security policies and those of the System of Records and the Privacy Act. Passwords must be protected by the system administrator and those receiving passwords. Passwords must be disabled at the time an individual exits a position requiring OASIS state system access. SAs are likewise reminded of the secure nature of passwords for the HHAs and must use due process to ensure the security of those passwords. State personnel should not leave the OASIS state system in a logged-in status when leaving the area. If possible, the system hardware should be located in an enclosed area, preferably with a door having interior hinges that can be locked. Keys or a combination lock should be available to only a minimum group of individuals with need for access to the system. In addition to the specific guidance above, the safeguards must provide a level of security at least equivalent to that required by the Office of Management and Budget Circular, A130 Revised, Appendix Roman 3, Security of Federal Automated Information Resources. Section 2202.12g. Security of transmission. OASIS data is encoded and transmitted from HHAs to SAs via the CMS net, a private communications network CMS purchased to ensure the security of OASIS and MDS transmissions to the state. This system replaces the previous process of direct dial-up by public telephone lines to the SA and reflects the latest technology available for securing the privacy of data during transmission. Standard industry authentication is employed at each SA. Further security is provided at the SA by isolation of the receiving communications server from the actual storage site at the state, the MDS/OASIS database server. This serves effectively as a security firewall. Transmission of OASIS data from the SAs to CMS occurs via the CMS Virtual Private Network (VPN), which allows only authorized CMS staff access within this secure CMS infrastructure. The CMS has determined that the transmission of OASIS data through the process described above is fully compliant with all current federal, Department of Health and Human Services, and CMS information systems security requirements. The applicable federal guidelines include the Computer Security Act of 1987, Federal Information Processing Standards, promulgated by the National Institute of Standards and Technology, pursuant to the Computer Security Act of 1987, the Office of Management and Budget Circular A. 130 revised, and Appendix Roman III, Security of Federal Automated Information Resources. Per CMS policy, in the CMS Information Systems Security Policy, Standards and Guidelines Handbook, it is a violation of the CMS security policy to send via email or fax patient personally identifiable information, IP addresses, and both ID and password in the same document. CMS security policy prohibits saving the login information in the Internet browser or sharing the personal login ID or the password with anyone else. Section 2202.12H, Provider Relations. With CMS technical support and guidance, the states work closely with the provider community and their OASIS software vendors in providing information on specific requirements related to the submission of OASIS assessments to the OASIS state system. The CMS expects that some vendors will provide primary support to HHAs in terms of OASIS encoding and transmission to the state repository. The state, however, must work with HHAs and software vendors in educating them about this process. The states must also provide training and technical assistance in interpretation of OASIS reports provided to HHAs. Section 2202.13, Protection of the confidentiality of OASIS data. Section 2202.13a, OASIS System of Records. The OASIS database is operated and maintained by states or CMS contractors as a federal database, and as such, is subject to the requirements of the Federal Privacy Act. In general, the only records subject to the Privacy Act are records that are maintained in a system of records SOR. The idea of a system of records is unique to the Privacy Act and requires explanation. The Act defines a record to include most personal information maintained by an agency about an individual. A record contains individually identifiable information, including but not limited to information about education, financial transactions, medical history, criminal history, or employment history. A SOR is a group of records from which information is actually retrieved by name, social security number, or other identifying symbol assigned to an individual. The text of the SOR notice for the OASIS database describes the legal requirements regarding privacy and disclosure of information by CMS or the state. The assigned identifying number for this system is System No 09 to 70 to 0522. The CMS established a new SOR, published June 18, 1999, in the Federal Register, 64 FR 32992, containing data on the physical, mental, functional, and psychosocial status of patients receiving the services of HHAs that are approved to participate in the Medicare and/or Medicaid programs. The purpose of the system is to aid in the administration of the survey and certification of Medicare/Medicaid HHAs, and to study the effectiveness and quality of care given by those agencies. This system also supports regulatory, reimbursement, policy, and research functions, and enables CMS to provide HHAs with outcome data for providers' internal quality improvement activities. The OASIS SOR was modified and published on December 27, 2001, 66 FR 66903, to allow a new routine use authorizing disclosure to national accrediting organizations that have been approved by CMS for deeming authority for Medicare requirements for home health services. This SOR notice replaces the SOR notice published June 18, 1999. The SOR was again updated November 13, 2007. The HHA SOR contains individually identifiable clinical assessment information OASIS records for all Medicare/Medicaid patients receiving the services of a Medicare and/or Medicaid-approved HHA, except prepartum and postpartum patients, patients under 18 years of age, patients receiving only housekeeping services and/or chore services exclusively, and, until sometime in the future, patients receiving only personal care services. The CMS established the system in accordance with the principles and requirements of the Privacy Act. Section 2202.13b. Protection of confidentiality under the Privacy Act of 1974. OASIS data are generally protected under the provisions of the Privacy Act of 1974. The Privacy Act of 1974 protects the confidentiality of person-specific records that are maintained by the federal government and retrieved by a unique indicator. It contains 12 conditions of disclosure under which these records may be released without the written consent of the individual. The system notice for the OASIS repository HHA OASIS was originally published in the Federal Register on June 18, 1999, and modified on December 27, 2001, and November 13, 2007. The system notice contains a listing of the prescribed limited circumstances under which person-specific records contained in that system may be released. These circumstances are called routine uses. Routine uses must be compatible with the purpose for which the records are collected and maintained. The OASIS system notice now contains 9 routine uses. Requests submitted to CMS for release of OASIS data are forwarded to the appropriate data release authority. The authority to release data from the OASIS National Repository is limited to the system manager and his or her designees. The OASIS System Manager is the director of the Survey and Certification Group at CMS, and as such has the sole authority to grant or deny a request for access to or disclosure of data contained in the HHA OASIS system of records. It is the responsibility of the Data Release Authority to review these requests for adherence to Privacy Act requirements. Release of data from any system is discretionary. Release of data from the OASIS repository follows CMS policy and procedure for data release. It is CMS policy that each requester of Privacy Act-protected data must sign a CMS-approved data use agreement DUA. A DUA is not required by the Privacy Act, however. It is one safeguard CMS has instituted in order to protect the confidentiality of identifiable data. DUAs are an integral part of the data use approval process. The agreements delineate the confidentiality requirements of the Privacy Act and CMS data use policies. The agreement serves as both a means of informing data users of these requirements and a means of obtaining their agreement to abide by these requirements. Additionally, the agreements serve as a control mechanism through which CMS can track the location of its data and the reason for the release of the data. CMS Office of Information Systems carries the functional responsibility to control guidelines and policies for the language in the agreements and coordinates the requests for release of data. Section 2202.14. SA and RO roles and responsibilities. Section 2202.14a. State. The CMS expects the SA to play a key role in providing the educational and technical resources to HHAs in each state concerning OASIS. States must designate an OASIS automation coordinator and OASIS educational coordinator to function as resources for the HHAs in each state. These positions are funded by CMS through the Medicare Survey and Certification Program. Each state automation coordinator must have the ability, through education, training, or experience, to provide for the statewide administration of the OASIS project. The state automation coordinator provides systems operations and technical support for the HHAs, vendors, and SA staff. The state OASIS educational coordinator must be a member of any professional discipline operating in the home health environment, that is, a social worker, registered nurse, occupational therapist, or physical therapist. Together, the functions of these two positions include providing training and educational support to HHAs in the administration of OASIS 4. Integrating the OASIS items into the HHA assessment process. Answering questions on the clinical aspects of OASIS. Training HHAs on the OASIS data set administration. Providing information about hardware and software requirements for HHAs to consider when automating OASIS. Training HHAs on submission of OASIS data to the state and interpreting. Validation reports, including providing support for transmission of test data during startup, supporting callers requesting technical assistance, providing passwords to HHAs, and answering questions about computer edits and reports. Submit an annual training report of the statewide OASIS training and other activities in the Home Health Training Worksheet, available in CASPER reports of the KAIS system by October 15, following each federal fiscal year. Using the outcome reports generated by the OASIS data. Using OASIS data in survey tasks. Training other SA staff, as applicable. Providing information from OASIS to determine prospective payment rates for HHA patients, and participating in training updates on OASIS and related home health issues. Section 2202.14b. Regional Office. ROs also have OASIS coordinators for the implementation, updates, and automation of OASIS. Designated RO staff provides information about OASIS in the region, act as a resource to the provider and a consultant to the SA. They also administer survey and certification funds and other aspects of the OASIS project. At least one RO staff person, knowledgeable about home health survey and certification issues, and or knowledgeable about MDS automation coordination should be assigned to these OASIS-related roles. ROs must provide the states with the program guidance and technical assistance critical to the successful implementation of OASIS and ensure that the states have the necessary resources to accomplish these goals. The following activities are performed by the RO. 1. Budget process. The RO reviews each SA's budget request and the required OASIS implementation plans in accordance with the SCG budget instructions. The RO must monitor for a reasonable and prudent expenditure of funds to ensure that states receive a fair and reasonable allocation. The RO must monitor quarterly expenditure reports against the state's allocation. 2. Review state implementation plans. The RO annually reviews all state OASIS implementation plans to ensure states have reasonable plans for assisting HHAs with the technical information, training, and assistance needed to comply with requirements for OASIS submission. Accuracy, privacy, and security. The RO must assess whether states are monitoring HHA compliance with the OASIS requirements. 3. Review contracts and agreements. The RO ensures that the SA has executed an agreement with any other entity, if that other entity is operating the OASIS system on behalf of the SA. The RO must use the criteria in Section 2202.12(b) in performing this review. 4. Provide training and technical assistance. The RO supports CO in training and technical assistance to the states in OASIS and ASPEN requirements, and supports OASIS continuing education and program requirements. 5. Perform focused reviews/federal surveys. The RO uses the OASIS repository and outcome data to select HHAs for focused reviews and in preparation for federal surveys. 6. Take enforcement action. The RO processes and carries out enforcement actions for noncompliance with OASIS requirements as reported by SAs. Section 2202.15, OASIS Education and Training. Section 2202.15a, State. The OASIS Educational and Automation Coordinators, OAK/OAK, participate in various training programs concerning OASIS, monthly all-state teleconferences to discuss OASIS issues, and meetings for OASIS updates and other matters related to home health services, as necessary. State support is provided by CMS Central Office, RO, the OASIS website, and clinical and technical help desks supported by CMS contractors. The state OAKs and OAKs are considered the subject matter experts who provide training to state agency staff and act as a resource to providers. The OASIS Education Coordinators by state can be found at http://www.cms.gov/Medicare/Quality Initiatives Patient Assessment Instruments/OASIS/Education Coord HTML. The OASIS Automation Coordinators by state can be found at http://www.cms.gov/Medicare/Quality Initiatives Patient Assessment Instruments/OASIS/Automation Coord HTML. Section 2202.15b, Row Rev. 125 issued, 10-31-14 effective, 10-31-14 implementation, 10-31-14. The RO OASIS coordinators participate in regularly scheduled teleconferences with Central Office to discuss issues concerning updates and maintaining OASIS and other related survey issues. RO staff participates in periodic meetings for OASIS updates and other matters related to home health services as scheduled. Section 2202.15c, HHA. All HHA, both existing and prospective, are trained on the implementation and automation of OASIS by each state's OASIS educational and automation coordinators. HHAs with clinical, technical, and regulations-related questions should contact the state OASIS educational or automation coordinator about OASIS. A current list of the state OASIS educational coordinators is found on the OASIS website. Support is also available for HHAs via the OASIS Help Desk. The Help Desk can be accessed toll-free by telephone on 877-201 to 4721 between the hours of 7 o'clock a.m. and 7 o'clock p.m. Central Time, and by electronic mail at havenhelp@imfcorg. The SA provides support to HHAs by providing OASIS presentations at meetings sponsored by the SA, HHA provider associations, or other entities. Updates to existing software and training manuals which support OASIS updates, Haven, and the OASIS state system are distributed via the OASIS and QTSO website. Section 2202.16, Fax transmission of OASIS or other patient identifiable information. OASIS assessment data is personal information about home health recipients that HHAs are required to collect and keep confidential in accordance with federal law. The use of electronic means of communication is acceptable in HHAs if appropriate safeguards are in place. The fax machine provides a fast and inexpensive method to send and receive patient-specific information, such as patient referrals and physician orders. However, the use of fax transmission can open up the possibility that confidential patient information can be transmitted or handled in a manner that is not secure and does not protect the patient's confidential health information. For example, the use of an incorrect fax number can allow the material being transmitted to persons who are not legally authorized to have this information. CMS takes its responsibility seriously to protect patient-specific information once it has been transmitted to the state, and CMS expects HHAs to provide the same protections to OASIS data while it is maintained at the HHA. SAs must follow federal requirements for systems that retain federal data, e.g., MDS data, OASIS data. Additional information on information security can be found on the CMS information security web pages at http://www.cms.gov/research-statistics-data systems/CMS information technology/information security/index.html. Redirect =/information security in the CMS policy for the Information Security Program PISP, and the CMS is acceptable risk safeguards Rs found under policies and standards. The Home Health Co. P at Section 484.11, Release of Patient Identifiable OASIS Information, requires that HHAs and agents acting on behalf of the HHA in accordance with a written contract must ensure the confidentiality of all patient-identifiable information contained in the clinical record, including OASIS data, and may not release patient-identifiable information to the public. It is the responsibility of the HHA to make sure that it has a written contract providing its agent with the legal authority to encode and transmit OASIS assessment data. The contract should also ensure that the agent holds all OASIS data confidential. Each HHA that uses fax transmission of OASIS information should develop its own policies and procedures to assure confidentiality of patient information, as well as comply with legal, regulatory, and accreditation requirements. It is also the responsibility of the HHA to make sure that OASIS assessment data is transmitted to its agent by a secure method. If the HHA chooses to use facsimile transmission of OASIS data, guidelines for use of facsimile transmission of OASIS data are provided below. The HHA or agent should place fax machines in a secure area and limit access to them. The HHA should identify one person in a department or unit to monitor incoming documents on a fax machine, or to deliver the document information directly into a secured database system. The HHA should outline appropriate written policies that safeguard that transmitted OASIS information is sent to the appropriate person and verify the correct facsimile number to which the OASIS data is being transmitted. This should include a use of a cover sheet, either electronic or hard copy, accompanying the faxed information that specifies that the OASIS information is confidential and limits its use to the terms of the written contract. B, that the person who is the legal authority for the receipt of the OASIS information is prohibited from disclosing this information to any other party. Any may use the data only for the purposes outlined in the written contract. And C, the HHA should contact the agent to verify the correct fax number to use prior to faxing. The HHA should develop and enforce procedures to be followed in the case of a misdirected transmission. This should include a notice on the cover sheet that prohibits the disclosure, copying, or distribution of the information by the unintentional receiver of the fax. B, a notice to the unintentional receiver of the fax to notify the sender immediately if they have received this information in error to arrange for the return of the information. And C, the name and phone number of the sender to contact. HHAs shall only use or disclose patient-identifiable records as permitted or required by law. State survey agencies should follow the CMS guidelines when sending and receiving requests to correct errors to the OASIS database. Section 2202.17. Change of ownership, merger, and termination procedures affecting HHAs and OASIS requirements. It is imperative that the Medicare CCN be accurately reported on the OASIS assessments in all reports, including when HHAs undergo change of ownership, merger, or termination. Change of ownership mergers. In accordance with Section 489.18 and Section 3210, the merger of a provider corporation into another corporation constitutes a change of ownership. In the case of the merger of Agency A into Agency B, Agency A's provider agreement and its associated CCN are terminated. Agency B retains its existing provider agreement and CCN. Agency A should provide the OASIS discharge comprehensive assessment for each discharged patient prior to or at the effective date of the merger. The surviving HHA Agency B should provide a start of care SOC comprehensive assessment for all persons it admits after the merger at the next skilled visit after the official merger date. The SOC assessment will allow eligibility for the home health benefit to be verified and care planning for the individual to proceed under Agency B. Subsequently, the assessments for all individuals being accepted for care by Agency B will be linked to the correct provider number to enable the agency to engage in quality improvement efforts with accurate OBKey reports. In accordance with Section 489.18 and Section 3210, when there is a permissible change in ownership under Section 424.550B2, as described below, and the new owner does not reject automatic assignment of the existing provider agreement under Section 489.18C. The new owner is subject to all the terms and conditions under which the existing agreement was issued, including compliance with the comprehensive assessment of patient's condition of participation. The CCN remains the same if the new HHA owner accepts assignment of the existing provider agreement. The new owner is responsible for continuing to complete updates to the comprehensive assessment at the next scheduled time points. Change of ownership without assignment. In accordance with Section 489.18 and Section 3210, when there is change of ownership and the new owner rejects this automatic assignment of the provider agreement, the provider agreement and provider number of the former owner should be terminated. The HHA that is terminating its provider agreement and provider number should provide an OASIS discharge comprehensive assessment for each patient subject to OASIS standards prior to the effective date of the termination, according to Section 484. The new HHA will not be able to participate in the Medicare program without going through the same process as any new provider, which includes an initial survey. The HHA should meet all the federal requirements, including applicable OASIS requirements as specified in the regulations, for all persons it accepts for care in order to participate in the Medicare program. This means that the HHA should provide a new SOC comprehensive assessment at the first skilled visit once it becomes Medicare approved. In addition, updates to the comprehensive assessment should be provided at the other OASIS time points, in accordance with Section 484, for all patients of the former owner it accepts for care. Note, the Medicare program, Home Health Prospective Payment System Rate Update for calendar year 2011, changes in certification requirements for home health agencies and hospices. Final Rule, 75 FR 70372, also referred to as CMS 1510F, published on November 17, 2010. Revised certain policies related to the prohibition of the sale or the transfer of HHA billing privileges at Section 424.550B1. Defined change in majority ownership at Section 424.502, and provided. Specifically, the final rule provided that, effective January 1, 2011, and in accordance with Section 424.550B1, If there is a change in majority ownership of an HHA by sale including asset sales, stock transfers, mergers, and consolidations within 36 months after the effective date of the HHA's initial enrollment in Medicare, or within 36 months after the HHA's most recent change in majority ownership, the provider agreement and Medicare billing privileges do not convey to the new owner. Section 424.502 defines the term change in majority ownership as a transaction in which an individual or organization acquires more than a 50% direct ownership interest in an HHA during the 36 months following the HHA's initial enrollment into the Medicare program, or the 36 months following the HHA's most recent change in majority. Ownership including asset sales, stock transfers, mergers, and consolidations. This includes an individual or organization that acquires majority ownership in an HHA through the cumulative effect of asset sales, stock transfers, consolidations, or mergers during the 36-month period after Medicare billing privileges are conveyed, or the 36-month period following the HHA's most recent change in majority ownership. If the CMS RO or SA receives an inquiry from the provider regarding procedures for a change in majority ownership pursuant to Section 424.550B1, it should refer the provider to its Medicare Administrative Contractor MAC. The MAC will review the applicable timeframes, exceptions, and any other pertinent enrollment requirements, and will determine if the facility has had a majority ownership change within 36 months of its initial certification or within 36 months of another majority ownership change. If the proposed HHA change of ownership meets the revised HHA change in majority ownership definition, it must enroll in the Medicare program as a new initial HHA under the provisions of Section 424.510. Obtain a state survey or an accreditation from an approved accreditation organization with deeming authority, and sign a new Medicare provider agreement and receive a newly assigned CMS certification number CCN. CMS will deactivate the HHA's old Medicare billing number if the sale has already occurred. Scheduling of an initial certification survey is initiated by a recommendation from the MAC to the RO/SA. The SAs and ROs will follow the current established processes and policies for initial certification. The initial surveys required under the change in majority ownership guidelines will be considered Tier Roman IV as per CMS's Mission Priority Document, MPD. The HHA may utilize an approved AO for an initial survey if it is seeking deemed status through accreditation. It is the responsibility of the HHA to arrange the initial Medicare survey with the AO. Upon successful completion of the enrollment and survey process, the new HHA will have a new effective date of Medicare participation and a new CCN. Questions from the provider community about the definitions for a change in majority ownership and specifics regarding participation dates, exceptions, etc., should be directed to the applicable MAC. An existing HHA that has engaged in a transaction that meets the definition of change in majority ownership is considered to have voluntarily terminated its participation under its original provider agreement. The requirements for a provider/supplier to terminate voluntarily from participation in the Medicare program are set forth at Section 489.52. The RO should follow the usual procedure regarding voluntary termination, using the date of the ownership change as determined by the MAC as the effective date of voluntary termination. There are 4 allowable exceptions to the sale or transfer prohibition at Section 424.550B2. Specifically, the provisions of Section 424.550B1 do not apply if the HHA submitted 2 consecutive years of full cost reports, which are not low utilization, or no utilization cost reports. The HHA parent company is undergoing an internal corporate restructuring, such as a merger or consolidation. The owners of an existing HHA are changing the HHA's existing business structure, and the owners remain the same. Or, an individual owner of an HHA dies. Note, Section 424.550B1 does not apply to indirect changes in majority ownership, e.g., changes to the ownership of a holding company that owns and operates HHAs through subsidiaries. Voluntary terminations. In accordance with Section 489.52 and Section 2005 and Section 3046, a Medicare-approved HHA may voluntarily terminate its provider agreement by filing a written notice of its intention to the state agency, who, in turn, notifies the RO. The provider/supplier must also submit a Form CMS 855A or CMS 855B to voluntarily terminate its Medicare billing privileges. Note, according to Pub. 100-08, Chapter 10, Section 7.3, in the event the HHA notifies the MAC of its intent to voluntarily terminate, the MAC shall notify the state and RO. This notification can be made via letter, email, or fax, no later than 3 business days after the contractor has finished processing the termination. CMS recommends that an HHA provide a discharge comprehensive assessment for each patient prior to the effective date of the termination of its provider agreement. The former HHA that meets the 2010 revised HHA CHOW definition is considered to have voluntarily terminated the original provider agreement. The state should follow usual procedures regarding voluntary termination, using the date of the CHOW as the effective date of voluntary termination. Electronic communication with the MAC should occur between all interested parties. Involuntary terminations. The RO may terminate the provider agreement with an HHA in accordance with Section 489.53. Revocation of billing privileges in the Medicare program may be initiated by the MAC at Section 424.535, which results in termination of the provider agreement. When revocation of billing privileges also results in the termination of a corresponding provider agreement, the provider may appeal CMS's decision under Section 498, where a final decision applies to both the billing privileges and the provider agreement. See Section 424.545. CMS will work with the HHA on a case-by-case basis to provide for the safe and orderly transfer of patients to another Medicare-approved HHA if appropriate. Deactivation of billing privileges. Under Section 424.540, a provider or supplier who does not submit any Medicare claims for 12 consecutive calendar months will have its Medicare billing privileges deactivated. The 12-month period begins on the first day of the first month without claim submission through the last day of the 12th month without a submitted claim. Deactivated agencies are not terminated and are still required to be surveyed every 36 months by the SA or AO, if deemed. Effective January 1, 2010, if an HHA's billing privileges are deactivated, the HHA must also undergo a Medicare survey in order for its billing privileges to be reactivated. This applies to all applications for reactivation that were received after December 31, 2009. In order for its billing privileges to be reactivated, a HHA must first submit a Form CMS 855 Update Reactivation application to the MAC. The MAC will conduct its preliminary review of the application and either deny the application or notify the RO, AO, or SA that a survey may be scheduled. The MAC will notify the provider that the preliminary review is complete and that the SA has been notified. Once the RO/SA receives notification from the MAC, surveys of deactivated HHAs are scheduled as a low survey priority. In circumstances of demonstrated access to care issues, the RO may change the survey priority and determine if an earlier recertification survey is indicated. If an HHA chooses to have a deemed status survey by an AO, it is the responsibility of the HHA to arrange the Medicare recertification or initial survey with the AO. The AO shall perform a recertification survey for existing clients when billing privileges have been deactivated and the agency has subsequently requested reactivation. In the event the HHA wishes to use the AO to conduct a reactivation survey when it formerly was under the jurisdiction of the SA, the AO would conduct this as an initial survey. The AO must notify the RO of the survey findings and the deeming recommendation. The RO retains the responsibility to notify the MAC that the agency passed the requirements of the Medicare survey. A standard survey is conducted and entered into the Aspen system as a recertification survey, along with a note that this is an early recertification due to a request for reactivation of Medicare billing. The SA must notify the RO of the survey activity. If the survey finds condition-level noncompliance, routine enforcement procedures should be followed. If the survey finds substantial compliance, the RO should forward Form CMS 2007 to the MAC with the date the provider was determined to be in compliance with the co-PTCS in the remarks section. The HHA will retain its existing CMS CCN. 2202.18 Wound Ostomy Continence Nurses Society walk-in and the National Pressure Ulcer Advisory Panel NPUEP OASIS guidance. The CMS collaborates with clinical wound care experts from the walk-in and the NPUEP to clarify OASIS wound items. The clarifications are intended to be helpful to home health agency HHA clinicians as they complete their patient assessments. For more information about the walk-in guidelines and for answers to questions about the walk-in guidelines, please contact the walk-in website at http://www.walkin.org. HHA clinicians are encouraged to use the walk-in and the NPUEP guidance to assist with clinical assessments of patient wounds. The walk-in OASIS guidance is located at http://www.walkin.org/pdfs/guidance OASIS CPDF http://www.walkin.org, and the NPUEP website is located at http://www.npu. Section 2202.19 OASIS collection on private pay non-Medicare/non-Medicaid patients. The Medicare Prescription Drug Improvement and Modernization Act of 2003 includes a provision regarding the collection of OASIS data for non-Medicare/non-Medicaid private pay patients. Specifically, Section 704 of this Act temporarily suspends the requirement that Medicare-approved HHAs collect OASIS data on non-Medicare/non-Medicaid patients, effective December 8, 2003. Ambulatory Surgical Centers asks. Section 2210. Ask citations and description. Section 1832A2F of the Social Security Act, the Act provides that, as an adjunct to outpatient surgical services, ASC facility services can be paid under Part B of the Medicare program. Though it is a supplier, an ASC must be certified and approved to enter into a written agreement with CMS. The conditions for coverage of ASC services are found in 42 CFR 416. Interpretive guidelines and surveyor procedures are in Appendix L. Participation as an ASC is limited to any distinct entity that operates exclusively for purposes of providing surgical services to patients not requiring hospitalization, i.e., an inpatient stay in a hospital. The regulatory definition of an ASC 42, CFR 416.2, does not allow the ASC and another entity to mix functions and operations in a common space during concurrent or overlapping hours of operations. Our current regulations and policy do not allow an entity to function both as an ASC and an independent diagnostic testing facility ITF, mixing unrelated functions and operations in a common space during concurrent or overlapping hours of operation. That is, the two facilities must be separated by time. Different hours of operation, or the other entity, may operate in the ASK space when the space is not operating in that space. An exception to this rule is when there is a need for imaging services during the course of a procedure in progress at an ASC. The ITF, sharing the space with the ASC but a different time, may conduct the required service outside of its normal business hours, as needed, and receive Medicare payment for those services. In this situation, our regulations and policy allow the ITF to bill and receive Medicare payment for imaging and guidance services such as angiography, venography, fluoroscopy, and ultrasonic needle guidance that are reasonable and necessary and directly related to the performance of a surgical procedure, and furnished in conjunction with a surgical procedure, despite being conducted during the ASC's designated hours. The operating room S and recovery room S are to be used only for patients having surgery. The ASC must also have a separate recovery room and waiting area. See 42 CFR 416.4 4A2. An ASC may be either hospital-operated or independent. The hospital-operated ASC must be a separately identified entity. It must be physically and administratively distinct from other operations of the hospital and be able to identify its costs separately from other hospital costs. A hospital ASC's agreement is made effective prospectively at the start of the hospital's next cost reporting year. See 42 CFR 416.30F1. The ASC may not perform a surgical procedure on a Medicare beneficiary when, before surgery, an overnight hospital stay is anticipated. There may, however, arise unanticipated medical circumstances that warrant a beneficiary's hospitalization after an ASC surgical procedure. The ASC must have procedures for the immediate transfer of these patients to a hospital 42 CFR 416.41. Such situations should be infrequent. ASC-covered procedures C42 CFR 416.65 are those that generally do not exceed 90 minutes in length and do not require more than 4 hours recovery or convalescent time. Therefore, ASC patients generally do not require extended care as a result of ASC procedures. An unanticipated medical circumstance may arise that would require an ASC patient to stay in an overnight health care setting. Such situations should also be infrequent. When extended care in a non-hospital health care setting is anticipated as a result of a particular procedure, that procedure would not be a covered ASC procedure for beneficiaries. The SA follows standard procedures for identifying interested ASCs and certifying them. If the ASC operates other activities as part of the same enterprise, the SA forwards a request for certification, Form CMS 377, Exhibit 64 with a certification and transmittal, Form CMS 1539, to the RO, together with any evidence covering the activities operated. Copies of the ASC Health Insurance Benefits Agreement, Form CMS 370 Exhibit 65, are signed and processed in the same manner as provider agreements. Rural Health Clinics RHCs. Section 2240. RHCs Citations and Description. The statutory basis for RHCs is found in Section 1861A of the Act. The conditions for certification are in 42 CFR 491, Subpart A. Appendix G contains interpretive guidelines and surveyor procedures. An RHC is a facility located in a rural area, designated as a shortage area, and is neither a rehabilitation agency nor a facility primarily for the care and treatment of mental diseases. It meets all other requirements of the RHC regulations at 42 CFR 491, Subpart A. A clinic located on an island may be eligible to be certified as an RHC even though it does not have a physician assistant, nurse practitioner, or certified nurse midwife. See Section 6213 of ABRA 1989. Section 2242. Conditions to be assessed prior to scheduling RHC survey. Section 2242A. General. Applicants seeking initial certification as an RHC must, among other requirements, satisfy certain location and staffing requirements in order to participate in Medicare. In order to facilitate an efficient survey and certification process for applicants, state survey agencies, and CMS requires an RHC applicant to complete and submit Form CMS 29, Verification of Clinic Data, Rural Health Clinic Program, as part of its application for certification. To make efficient use of survey resources, state survey agencies make a preliminary assessment of the information contained on the Form CMS 29 prior to conducting a survey, to avoid conducting a survey of an ineligible location. Likewise, SAs conduct a preliminary assessment of the information contained on the Form CMS 29 prior to forwarding a certification packet to the RO when the RHC applicant is seeking to participate via deemed status accreditation. However, since only the CMS RO may make a determination whether the RHC applicant has satisfied all federal requirements, including the location and staffing requirements, the SA must not notify the applicant of the results of the SA's preliminary assessment of the Form CMS 29. The SA or an accrediting organization may not conduct a survey before receiving a positive recommendation from the Medicare Administrative Contractor MAC, issued after the MAC has completed its review of the RHC applicant's Form CMS 855, A application to enroll in Medicare. An AO must receive a copy of the MAC's notice to the applicant that it has concluded its review before conducting an accreditation survey. CMS makes RHC location determinations only after an RHC applicant has submitted an application to enroll in Medicare and is open and operating at the site identified in the application. CMS does not provide advance or preliminary determinations about whether a location satisfies the RHC criteria, even if interested parties request one. SAs also may not issue any preliminary or final assessments about a location's potential eligibility for RHC status. 2242, A1 Location of Clinic. Subpart of 42 CFR Part 491 sets forth the conditions that RHCs must meet in order to qualify for certification under Medicare. Question I on Form CMS 29 identifies the location of the clinic and defines location as the location at which health services are furnished. In accordance with 42 CFR 491.5, the clinic must be located in a rural area that is designated as a shortage area. A rural area is defined in 42 CFR 491.2 as an area that is not delineated as an urbanized area by the U.S. Census Bureau. An urban cluster is not considered an urbanized area. CMS relies upon the information in the U.S. Census Bureau's American Fact Finder tool, http://factfinder2, census.gov/faces/nav/JSF/pages/indexxhtml, when determining whether a location falls within a rural area. Note that once a RHC is certified for Medicare participation, it may continue to participate as an RHC even if the U.S. Census Bureau subsequently changes the classification of its location to an urbanized area. A shortage area is a defined geographic area designated by the Health Resources and Services Administration, HRSA, on behalf of the Secretary, as having either a shortage of personal health services or an area or population group with a shortage of primary medical care manpower. HRSA may also designate at the request of a state governor specified areas of a state as having a shortage of personal health services. CMS uses data from HRSA Data Warehouse, http www.hrsa.gov/shortage/find HTML, supplemented as needed by information obtained via telephone or email from HRSA when determining whether a location falls within a shortage area. SAs may use these same online tools when conducting their preliminary assessments of an RHC applicant's location prior to conducting a survey, but the results of their assessments are not considered determinations by CMS. AOs may also use these tools when deciding whether to accept an application for RHC accreditation and conduct an accreditation survey. However, SAs and AOs are not authorized to provide notice to the RHC applicant of the results of their assessments. Further, the fact that the SA or an AO with a CMS-approved Medicare RHC accreditation program conducts a survey of the RHC applicant does not constitute a determination by CMS that the applicant's location satisfies the regulatory criteria. Only the CMS RO may make such a determination and notify the applicant whether or not it has been determined to meet participation requirements. Relocating an existing RHC, an existing Medicare-certified RHC that has relocated, must submit a CMS 855A. Updating the location information to the appropriate MAC within 90 days after it relocates. See Section 15.10.1 of the Medicare Program Integrity Manual, CMS Pub 100-08. CMS also does not provide advance determinations on the location eligibility of a potential relocation site. Rural and shortage area location determinations are only made after the relocation has occurred, and the CMS 855A has been submitted to the appropriate MAC. The RHC must also submit to the SA a Form CMS 29, reflecting its new location at the same time that it submits the CMS 855A update to the MAC. The SA forwards this information to the RO, which reviews it to determine whether the RHC at the new location continues to meet the location requirements. If it does not, the RO will issue a termination notice to the RHC. If the new location does continue to meet the RHC requirements, the RO does not need to take any further action beyond documenting its determination in the RHC's certification file. However, based on the information on the Form CMS 29, the RO also has the discretion to require an on-site survey of the RHC at the new location. If the RHC is only changing suites within the same building, CMS would not consider this a relocation. However, the RHC must still report the change of information to the MAC using the CMS 855A. 2242, A2 Medical Direction. Question Roman 2 on Form CMS 29 asks for the name and address of the physician S providing the clinic's medical direction. The physician S providing medical direction must be a member of the clinic staff or under agreement with the clinic to carry out the responsibilities required of a physician. If performed in the clinic, the time spent in this medical direction must be included in the answer to question Roman 3A. 2242, A3 Physician Assistant, Nurse Practitioner, and / or Certified Nurse Midwife Staff. Question Roman 3B and / or Roman 3C on Form CMS 29 indicates whether the clinic staff includes a physician assistant, nurse practitioner, and / or certified nurse midwife. A nurse practitioner, a physician assistant, or certified nurse midwife must be available to furnish patient care services at least 50% of the time the clinic operates. See Appendix G. The SA contacts the clinic for clarification if the combined full-time equivalent entries in question Roman 3B and C, and / or D, if D, is used to indicate a nurse midwife do not equal 50% of the clinic's scheduled hours of operation. In computing the full-time equivalents, the SA uses only the time personnel are present in the clinic or are providing RHC services away from the clinic site. The results of the SA's preliminary assessment of the staffing information on the Form CMS 29 do not constitute a determination by CMS, and the SA may not provide notice to the applicant of the results of its assessment. Likewise, any information or advice provided by an AO to the applicant about meeting the basic staffing eligibility requirements does not constitute a determination by CMS. The SA or AO may proceed to conduct a survey of the RHC applicant based on the results of its preliminary assessment of the applicant's staffing information, but the fact that the SA or AO conducted a survey does not constitute a determination by CMS that the RHC applicant meets the basic staffing requirements. An RHC which is already certified and participating in Medicare may request a temporary waiver of these staffing requirements for a 1-year period if it demonstrates that it has been unable to hire a physician assistant, nurse practitioner, or a certified nurse midwife in the previous 90-day period. However, staffing waivers are not available to RHC applicants seeking initial enrollment in the Medicare program. A subsequent request for a waiver cannot be made less than 6 months after the expiration date of any previous waiver of staffing requirements for the facility. Section 2242B. Clinic is determined ineligible. If the SA's preliminary assessment of the Form CMS 29 suggests that the RHC applicant's location does not satisfy the RHC eligibility requirements, the SA must notify the RO of this, forwarding the Form CMS 29. The RO will independently assess the location requirements, and if it concurs with the SA, the RO will issue a denial of initial certification to the applicant based on its determination regarding the applicant's location. Likewise, if the SA's preliminary assessment of the Form CMS 29 suggests that the applicant does not have the minimum required physician assistant, nurse practitioner, and or certified nurse/midwife staff, the SA must notify the RO of this, forwarding the Form CMS 29. The RO will independently assess the staffing information contained on the Form CMS 29, and if it concurs with the SA, the RO will issue a denial of initial certification to the applicant based on its determination regarding the applicant's self-reported staffing information. Section 2242D. Identifying clinic as provider-based. If the RHC applicant submits a Form CMS 29 indicating that it is a provider-based entity of a critical access hospital CA or eligible hospital, the SA confirms the accuracy of the CA's or hospital's CMS certification number CCN entered on the form. After conducting a survey and or receiving notice of an AO's recommendation of RHC deemed status for the applicant, the SA forwards the Form CMS 29 and other certification documentation to the RO for review and a certification determination. If the RHC meets all federal requirements for certification and has indicated on its Form CMS 29 that it is provider-based to a hospital or CAH, the RO will issue a Medicare RHC agreement with a provider-based RHC CCN. Issuance of a Medicare provider agreement with a provider-based CCN to a RHC does not constitute a CMS provider-based determination as provided for in Section 413.65b. Seeking such a provider-based determination is voluntary, and neither the SA nor the RO may require RHC applicants and their affiliated hospitals/CAs to seek such a determination as a condition to being issued a provider-based RHC CCN. However, when CMS issues a provider-based RHC CCN, the letter approving the RHC's provider agreement and issuing the CCN must contain the following disclaimer language. Issuance of a provider-based RHC CCN does not constitute a CMS provider-based determination. Section 2242E. Compliance with civil rights statutes. An RHC that only received federal funds through Medicare Part B is not required to comply with the various civil rights statutes enforced by the Department of Health and Human Services DHHS Office for Civil Rights. However, if the RHC participates in the Medicaid program or receives any other financial assistance, such as grants from DHHS, it must comply with all applicable civil rights statutes. RHCs are not subject to the pre-grant review process required of participants in Medicare Part A. Section 2242F. Laboratory services provided in RHCs. An RHC must provide primary health care, including laboratory services, to its patients. The RHC's laboratory services are subject to the Clinical Laboratory Improvement Amendments CLIA. Section 2244. Preparing for RHC survey. Prior to the survey, in addition to reviewing the information and references needed for surveys generally, the SA reviews listings of formal educational programs for physician assistants, nurse practitioners, and certified nurse midwives, and a list of formal educational programs supported under HRSA grants to prepare RNs to perform in an expanded role in the delivery of primary care, and any other educational programs that meet the requirements of the regulation. Section 2246. Clinics' request to provide visiting nurse services. An approved RHC may also seek approval to provide covered visiting nurse services. An RN, LPN, or licensed vocational nurse must furnish these services. When a request is received, the SA determines if a shortage of HHAs exists in the area. Refer to 42 CFR Part 405.2417 and consults with the RO as appropriate. If there is an existing HHA furnishing services in the RHC area, the SA contacts the HHA for a statement of its ability or inability to adequately furnish nursing services in the area. In addition, the SA obtains information from the local or state health planning organization. If there is not a shortage of home health services for the area, the SA notifies the RO. In such cases, approval to furnish visiting nursing services to homebound patients will not be granted, and the RHC must refer its homebound patients to the HHA serving the area. If there is a shortage of home health services, the SA notifies the RO and evaluates the qualifications of RHC personnel who are responsible for the delivery of nursing services. This evaluation must include compliance with applicable state licensure/certification requirements for RNs, LPNs, or licensed vocational nurses who provide services for the clinic. Section 2248. Clinics' request for waiver of staffing requirements. As provided by Section 1861A7 of the Act, the Secretary of HHS is required to grant a one-year waiver to RHCs for staffing requirements that the clinic employ a nurse practitioner, physician assistant, or certified nurse midwife, or that such disciplines furnish services 50% of the time that the clinic operates if the facility requests a waiver. The facility demonstrates that it has been unable, despite reasonable efforts, to hire a physician assistant, nurse practitioner, or certified nurse midwife in the previous 90-day period, and the facility is not making the request less than 6 months after the date of the expiration of any previous such waiver for the facility. The waiver is applicable to participating RHCs. The SA is responsible for recommending approval or disapproval of the requested waiver to the RO within 30 days of receiving it. The waiver shall be deemed granted unless the waiver request is denied by the RO within 60 days after the date the SA received the request. In such situations, the effective date of the one-year waiver is the 61st day after the date the request is received by the SA. The SA uses the date the RO approves the waiver as the effective date of the one-year waiver period. Section 2248A. Applying waiver to applicants. The initial packet of information sent to RHC applicants by the SA should include a statement that the applicant cannot request a waiver of the mid-level requirement on initial application. In Section 4205C of the BBA, the Congress amended, effective January 1, 1998, Section 1861A7B of the Act to restrict further our authority to waive the requirement that each RHC must hire a physician assistant, nurse practitioner, or certified nurse midwife. A waiver may now be granted only to a participating RHC. That is, the waiver cannot be granted before the clinic has been determined by us to meet all the requirements for Medicare participation as an RHC and is actually participating as an RHC. Section 2248B. Applying waiver to participating RHCs. A participating RHC may request a waiver either when it loses its nurse practitioner, physician assistant, or certified nurse midwife, or when it fails to meet the 50% staffing requirement regarding these disciplines. Some RHCs will probably experience an unexpected loss of staff, and therefore will not be able to demonstrate any effort to hire staff in the previous 90-day period. The SA should advise an RHC that it must comply with the staffing requirement within 90 days. From the date it informed the SA it no longer met the staffing requirements or be terminated, unless a waiver request is submitted by the facility and approved by the RO at the end of the 90-day period. Section 2248C. Documentation demonstrating efforts to meet staffing requirements. An RHC must submit written documentation to the SA demonstrating its reasonable efforts to hire the required staff. This documentation should evidence ongoing activities throughout the 90-day time period prior to making a waiver request. The following types of documentation would be acceptable: copies of reports of telephone contacts with potential hires, professional schools and organizations, recruiting services, etc. Information about trips to professional meetings, educational institutions, and health care facilities for recruiting purposes. Copies of advertisements for recruiting hires, and results of personal interviews with potential hires. Section 2248D. Monitoring waivers. The SA monitors the expiration dates of waivers. When the expiration date of an RHC's waiver is imminent, the SA must contact the RHC to determine whether the RHC will be in compliance with 42 CFR Part 491.8 as of the expiration date of the waiver. If it is determined that the RHC will not be in compliance with 42 CFR Part 491.8 as of the expiration date of the waiver, the SA notifies the RHC that it will be terminated from the Medicare program. The RHC should be given notice of the termination at least 15 days before the effective date of the termination date. The termination date cannot be earlier than the day after the expiration date of the waiver. If the RHC provides evidence that it has hired the required staff, but the staff will not be available at the clinic until after the expiration date of the waiver, the SA initiates termination action pursuant to Section 3012. The SA informs the RHC that when it meets the staffing requirement, it should notify you immediately. Section 2248E. Notification. Both the SA and the ROs should notify an RHC when an RHC's waiver has been approved and include an explanation of the above termination procedures for expired waivers. Section 2249. RO notification of RHC initial certification approval. The SA forwards to the RO its survey report or the AO's notice of accreditation and recommendation of deemed status, along with any other supporting documents required in the RHC certification packet. The RO reviews all documentation to determine whether the applicant is or is not in compliance with all RHC requirements. The RO notifies an applicant of its approval or denial of certification in writing. If the applicant is approved, the RO countersigns, dates, and issues the Form 1561A, Health Insurance Benefits Agreement, Rural Health Clinic, along with a cover letter indicating the RHC's CCN and the effective date of the agreement. See Section 2784, which governs how the RO determines the effective date of participation. The RO sends a copy of Form CMS 2007 to the Medicare Administrative Contractor MAC, and another to the State Medicaid Agency SMA that has billing jurisdiction for RHCs. The RO sends a copy of the letter issuing the clinic's agreement to the Regional Health Administrator, HRSA, so that appropriate notification may be given to components of the PHS engaged in program support for rural health service activity. The RO adds the following paragraph to the letter accepting the RHC's agreement. Your participation as an RHC under the Medicare program will also be accepted as certification as an RHC under the Medicaid program. If you need information about payment for RHC services under the state plan for medical assistance, contact name, address, and telephone number of appropriate SMA. If a provider-based CCN is being issued, the approval letter must contain the following explicit language. Issuance of a provider-based RHC CCN does not constitute a CMS provider-based determination. Community Mental Health Centers. Section 2250. Community Mental Health Centers, CMHC citations and descriptions. Note, recognition of marriages. Every psychiatric hospital/facility is expected to recognize all lawful marriages and spouses for purposes of compliance with the conditions of participation and regulatory requirements. In this guidance, and in every instance where the following terms appear. Spouse means an individual who is married to another individual as a result of a marriage that was lawful where entered into, including an individual married to an individual of the same sex. Marriage means a marriage that was lawful where entered into, including a marriage of two individuals of the same sex. Family includes, but is not limited to, an individual's spouse, see above, and relative, when used as a noun, includes, but is not limited to an individual's spouse, see above. Furthermore, wherever the text of a regulation or associated guidance includes a reference to a patient's representative, surrogate, support person, next of kin, or similar term in such a manner as would normally implicitly or explicitly include a spousal relationship, the terms are to be interpreted as indicated above. Section 2250A. Citations and definitions. Citations. Section 4162 of PL 101 to 508 Auburn 1990, amended Section 1861 FF3A and Section 1830 2A2J of the Social Security Act to include community mental health centers, CMHCs, as entities that are authorized to provide partial hospitalization services, PHP, and intensive outpatient IUP services under Part B of the Medicare program, effective October 1, 1991. Applicable regulations are found at 42 CFR Chapter Roman 4, Parts 400, 410, 424, 485, and 489. The conditions of participation co-Ps were published on October 29, 2013, and were effective on October 29, 2014. Section 41, 24B of the Consolidated Appropriations Act CA, 2023, established Medicare coverage for IOP effective for items and services furnished on or after January 1, 2024. Section 41, 24B1A of the CAA, 2023, amended Section 1830 2A2J of the Act to add IOP to the scope of covered benefits provided by CMHCs. Definitions. Community Mental Health Center, CMHC, as defined in Section 410.2, means an entity that one provides outpatient services, including specialized outpatient services for children, the elderly, individuals who are chronically mentally ill, and clients of its mental health service area who have been discharged from inpatient treatment at a mental health facility. 2. Provides 24-hour-a-day emergency care services, 3 provides day treatment or other partial hospitalization services, or intensive outpatient services, or psychosocial rehabilitation services. 4 provides screening for patients being considered for admission to state mental health facilities to determine the appropriateness of this admission. 5 meets applicable licensing or certification requirements for CMHCs in the state in which it is located. And 6 provides at least 40% of its services to individuals who are not eligible for benefits under Title Roman 18 of the Social Security Act. Active Treatment Plan, as defined in Section 485.902, means an individualized client plan that focuses on